How prepared are you for your prelims in the process? How many of you have at least completed one time all the subjects? Okay, all the subjects. I mean, there can be some pending here and there, but mostly I am asking. Okay. So if you have covered one time, I think now 2 months, almost 2 months, little less than 2 months. No, 28th of May, 25th of May. So another 55 days, which means effectively around, I would say 50 days probably. So it is good enough for you to do the revision. You can cover certain things also if you have not done it, that is all fine. But most importantly, you will have to focus on the revision also. So how many times the revision? There is no hard and fast rule. It may vary from student to student. But in general, 3 to 4 times of revision is a good thing. Along with that, previous year questions should be given the first priority. You can do multiple times previous year questions. Okay. Okay. So now coming back to the RTFQ, that is revision through 500 questions. So I will be dealing the polity part. So you might be knowing that. So how I have designed this RTFQ, revision through 500 questions, is we will be dealing with 3 sets of questions. One is at least last 20 years of PIQs. It may be little more than that also, but at least 20 years of your PIQs will be covered, so that you are not left out with any of the questions that is asked in the previous year questions. And then apart from that, questions that has been framed on the lines of previous year questions, which I would say as practice questions. And then there will be substantial amount of questions from the current affairs also. So because in some of the module that I have done, I was not able to cover for certain reasons, but in the revision through 500 questions, I will cover substantial amount of current affairs based questions. But however, you will know that in polity, strictly asking from current affairs is not how they usually ask it. Any topic that is there in current affairs, you should be aware of the conventional areas related to those current affairs. Maybe 1 or 2 statements may be picked by UPSC from the current affairs also. So that is how I frame the questions as well. So what are the 3 types of questions we will be covering? POIQs, practice questions, and the current affairs based question. So the idea is to empower the students to attend 90% of the questions that is coming from polity. If there are 15 questions, I wanted you to get 13 to 14 questions right, provided that you have done your part. So then only you will be able to achieve that. So it is not just merely by sitting here. Yes, sitting here will help you to revise and to strengthen your concepts. But if you have also done your part, 90% of the questions you can get it right. 20 questions, if you are lucky enough, 18 questions you should get it right. But at least I think 15 questions are likely to come, going by the last 5 years of trend. So this is what is the objective, all right. So now I'll just start the question. So 500 questions, I think we have got 5 classes. So I'll just take it gradually, step by step. We'll try to cover all the 500 questions. Students who have attended PMP, some of the questions might already be there, but not all the questions, but it will again strengthen your conceptual clarity, okay. And whenever you have a question, I'll give you time. So it is not that every question I'll be able to take up your questions. Just note down your questions, and sometimes if the question is so important, I'll take it up. Otherwise, at a fixed interval, I'll take up your questions also. All right. So online students, I hope you are also able to hear it. So I'll take up your doubts also, but not for every question. I'll just give certain time, allocate certain time, take up your questions. So with that, we'll go to the part 1 of the thing. So I'll divide the entire thing into maybe 5 parts. Today is part 1. And if you see that every part will have a substantial amount of content that is being covered. So in this way, in all the 5 lectures, I'll try to cover the entire polity. I'm not going to leave out on any area. So based on the UPSC, how UPSC is focusing, I'm not going to touch maybe the minor areas in a very exhaustive manner, but the major areas on an exhaustive manner. Minor areas will also be touched upon. So today, what is the topic that I'm going to cover? Today, I'm going to cover starting your Constituent Assembly, Preamble, Union and its territories, citizenship, fundamental rights. If time permits, I'll also touch upon the directive principles of state policy and the fundamental duties. So if you see, this is an area where 4 to 5 questions are likely to come. Very simple area, but 4 to 5 questions are likely to come. So that is what we are going to see today. If time permits, I'll complete all those things, otherwise I'll continue in the next class. All right. So with that, we'll get into the question number 1. Okay. So please come to the question number 1. Most of the questions, it requires you to have the conventional knowledge also, better conceptual understanding also. That is the way the question has been decided. So come to question number 1. Recently, India has exchanged. Recently means in the recent past. It is not that yesterday or day before yesterday. Recently in the entire political history of India. Okay. So recently India has exchanged some of the Indian enclaves with Bangladesh, thereby giving some of the territories to Bangladesh and acquired some of the territories from Bangladesh. In doing so, the law in India allows the people, those acquired territories, to become a citizen of India immediately through which of the following provision. So there are 4 options that I given: naturalization, registration, incorporation of territory, all of the above. So what is the right answer here? It is incorporation of territory. Okay, so when I discuss this question, it is not only related to citizenship. Most of you know it is incorporation of territory. Naturalization and registration is for the foreigners to become an Indian citizen, but not just that they have become part of India. Only the citizens of another country can become an Indian citizen. But whenever India incorporates a territory, there is a provision under the Citizenship Act that the concerned officer, the government of India, can pass an order, thereby conferring the citizenship of India to all those people from that incorporated territory. This is how when Puducherry was acquired, people got the citizenship. Whenever any territory is acquired, it is through incorporation of territory. Okay, now tell me, when India has ceded certain territory to Bangladesh, so will it make any changes in the constitution? Does it make changes in the constitution? Where does it make change in the constitution? Where does it make changes in the constitution? It does not make any changes in the articles. It makes changes only in the schedule 1 of the constitution, because we will have to change the territory of India. So when we make changes to the schedule 1 of the constitution, does it require a constitutional amendment in this case, or it can be done by a simple act of parliament? In this case, in Bangladesh case, just think about it. So when India has ceded a territory to Bangladesh, in the same question that I am asking, okay, don't discuss among yourself, please listen to me. When India has ceded a territory to a foreign country, you are all agreeing to a point that it requires changes in the schedule 1 of the constitution. So therefore it requires an amendment to the constitution. But my question is, this amendment to the constitution, that is to the schedule 1 of the constitution, does it require a constitutional amendment under article 368, or can it be done by a simple act of parliament under article 3 of the constitution? How many of you think it requires a constitutional amendment? In this question also, in general also, in both these cases, whenever India has to cede a territory, because this question is ceding a territory to a foreign country. So what is the answer? It does require a constitutional amendment under article 368. Do not make any mistake in this. If there is an internal readjustment, thereby there is a reduction in the territory of any state, it does not require a constitutional amendment. But if you have to cede a territory to a foreign country, it requires a constitutional amendment under article 368. I have already made this very clear, but subsequently also I will discuss. So whenever we take a particular question, it is not only you look into that particular question, you look into the other aspects related to that particular question also. Alright. So the answer for this particular question is option C. Okay, so come to the next question. Consider the following statements regarding the provisions of the constitution. So here I will discuss it further. Statement 1, creation of new states in India by reorganizing the existing territory can be done only by the Parliament of India. Is that true? Is it only the power of the Parliament to reorganize states in our country? Is there any other authority which has got the power to do that? No, it is only the power of the Parliament. So creation of new states in India by reorganizing the key word here is the existing territory. So the reorganizing the existing territory can be done only by the Parliament of India, but can you tell me which article in the constitution gives this power to the Parliament? Article? It is article 3 of the constitution. It is not article 2 of the constitution. Which article? Article 3 of the constitution. Because I have made it very clear what is the distinction between article 3 and article 2. Article 3 is allowing the power to the Parliament to reorganize the existing territory. But whereas article 2 is giving the same power to the Parliament to admit or to establish a new territory which is outside the territory of India. So therefore, any existing reorganization is done under Article 3, but who has the power to do that? Only the Parliament has the power to do that. It is not Article 4 which is giving the power to the Parliament, it is Article 3. But what is Article 4 is saying? Article 4 is saying that any law that will be made by the Parliament either under Article 2 or under Article 3, it can be done by a simple act of Parliament. That means Schedule 1 and Schedule 4 can be amended just by a simple act of Parliament. That is what is given under Article 4. But the power is given to the Parliament only under Article 3 of the Constitution. Is that clear? So this particular statement is right. An union territory can be conferred on the state, conferred the status, not on the status, sorry. The union territory can be conferred the status of a state by an act of Parliament, but vice versa is not possible. Is it true? Under Article 3 of the Constitution, the Parliament has a power to convert a state into a union territory into a state. All these things can be done. So when you say that vice versa is not possible, that is wrong. So therefore, this particular statement is wrong. The approval of the state legislature concerned is mandatory before reorganizing the states in India. Is it required to take the approval of the state legislature? It is only mandatory for the president to refer the bill to the concerned state legislature. But the opinion of the state legislature is not binding upon the president. Okay, what is the time limit within which the state legislature has to give its opinion? There is no time limit. In fact, the president will specify the time limit. Nothing is given in the Constitution. So therefore, it is not mandatory. So when you say mandatory, it is not mandatory. So which of the statements given above are correct? So statement 2 is incorrect, statement 3 is incorrect. So what is the answer? It is only option B. Is it clear what is Article 2, Article 3 and Article 4? So everything should be clear in your mind. Okay, so come to the next question. Consider the following statements regarding the Constituent Assembly of India. Statement 1. The Assembly was completely an elected body. If at all one area where question can come from Constituent Assemblies, this is the area. You should be very clear about it. So the Constituent Assembly of India was not completely an elected body. It was a combination of both election as well as nomination. Can you just recollect where it was through election and where it was through nomination? From the princely states, it was by election, and from the British provinces, it was through election, and from the princely states, it was by nomination. And there was also one more area, that is commissioner provinces. How about the commissioner provinces? It was also through nomination. While in case of the princely states, the nomination was done by the rulers. While in case of commissioner provinces, there were 4 commissioner provinces. It was based on the consultation with the commissioner in those provinces. There was also, it was nomination. In the British provinces, direct provinces, it was through election. But whether the election was a direct election or an indirect election, it was an indirect election. There was no system of direct election. So who were the electoral college to elect the members from the British provinces? Who constituted the electoral college? The elected members of the provincial legislature. So whoever the elected members of the provincial legislature, they constituted the electoral college. I hope by this time you should have an understanding of what is electoral college. So they are acting as the electoral college. But the most important thing is the members of the British provinces, that is the provincial legislature, they were elected directly or indirectly. They were elected, but based on limited adult franchise. So you should be aware of all these things. All right. So with that, come to this particular question. The assembly was completely an elected body. Is it true? The assembly was not completely an elected body, but rather it was partially elected or mostly elected and partially nominated. The members of the Constituent Assembly were elected through the universal adult franchise. No, it was in fact an indirect election. So there was no universal adult franchise. The Constituent Assembly had representation only from the British provinces. No, it had representation from the princely states and the commissioner provinces as well. So which of the statements given above are incorrect? The incorrect statement is all of the above. So try to give your 100% effort in the class. Why I am saying is try to make notes in the question papers also. Before the examination, for the last 2-3 days, even if you revise, your entire polity will be done. So try to give 100% effort, because it is going to cover the entire subject polity through these questions. But try to make note of each and every single word that is coming out of my mouth, whatever you want to take note. Okay. So come to question number 4. Which of the following statements regarding the preamble to the Constitution of India consider the following statements regarding the preamble to the Constitution of India. Statement 1, they are the key to unravel the minds of makers of the Indian Constitution. Is this true regarding the preamble? Do you know who has given this description about the preamble? Very good. It is the Supreme Court of India. In which case? Very good. It is in the Berubari Union case. The Supreme Court described that the preamble is key to unravel the minds of the makers of the Constitution. But what was the stand that was taken by the Supreme Court of India in the Berubari Union case? Did they say that the preamble is an integral part of the Constitution? Although they accepted, yes, the preamble is the key to unravel the minds of the makers of the Constitution, the Supreme Court categorically said that the preamble is not an integral part of the Constitution. But however, that was overcome in the next case, that is in the 𝐂𝐨𝐬𝐴 Bharati case. The Supreme Court overruled that and said that the preamble is an integral part of the Constitution. So today consistently this view has been held by the Supreme Court that the preamble is an integral part of the Constitution. Just remember that. They are an integral part of the Constitution, but neither give nor take away powers, neither give nor take away powers of the organs of the state. Is that true? Yes, this is also true. The Supreme Court has, although in the 𝐂𝐨𝐬𝐴 Bharati case, the Supreme Court said that the preamble is an integral part of the Constitution, but it has categorically said that it neither gives nor take away the powers. It is the major purpose of the preamble today is to what? Is to only to interpret the other provisions of the Constitution whenever there is any ambiguity that comes in front of the Supreme Court. That means the basic understanding you should have is, just because some word is mentioned in the Constitution, that is in the preamble, it does not give any power to any of the authorities of the state. So for example, the judiciary exercises the power of judicial review, but the preamble does not give this power to the judiciary. It comes from the respective provisions in the Constitution. The legislature have the power to make laws, but it is not coming from the preamble. There are respective provisions in the Constitution that gives the power to the legislature. So none of the organs get any power from the preamble per se, but the preamble is an integral part of the Constitution. So therefore this particular statement is also true. They can be amended without any restriction. Is that true? Not only to the preamble, but in general, any amendment to the Constitution should not violate the basic structure in the Constitution. So if at all any restriction to the preamble, it is that in the form of what is called as basic structure. Okay, if I add one more statement to whatever I discussed, the preamble is part of the basic structure of the Constitution. Is that true or false? How many of you think it is false? The preamble is part of the basic structure of the Constitution. It is false. The preamble is not part of the basic structure. There are certain provisions in the preamble that is described to be part of the basic structure, but the entire preamble is not part of the basic structure. This is what the Supreme Court has categorically said in the 𝐂𝐨𝐴𝐴 Bharati case. Okay. So there are some provisions within the preamble which constitute the basic structure, but not the entire preamble. So therefore, can the preamble be amended? Yes, it can be amended, no doubt, but without destroying what is called as the basic structure of the basic structure in the preamble. Now, the Supreme Court in the 𝐂𝐨𝐴𝐴 Bharati case said that there are some provisions like the elements like democracy, justice, they are all considered to be what is called as a basic structure. So therefore, without disturbing them, the preamble can be amended. Has the preamble been amended? How many times the preamble has been amended? Only once, and 3 keywords has been inserted, which I will subsequently discuss. There are questions I think to that extent also. So they can be amended without any restriction is wrong. So what is the answer here? So you can see that statement 1 is wrong, sorry 1 is correct, 2 is correct, statement 3 is wrong, it is asking for incorrect statement. So the answer would be C only. So that's the answer. C is the answer. Come to the next question. Which of the following ways by which a foreigner can become an Indian citizen under the Citizenship Act 1955? Now before I go into the concept of citizenship, if you look into the Constitution of India, the Constitution deals with 2 things. One is there are certain articles in the Constitution which talks about who is deemed to be the citizen at the commencement, and then apart from that, who is deemed to be the citizen of India at the commencement of the Constitution, any other matter that is related to the citizenship has to be regulated by way of the law that is to be passed by the Parliament. So who can make law with regard to the citizenship? Only the Parliament. because citizenship is also an item in the union list. So therefore, who is supposed to make law? Only the parliament. Now, which article in the constitution gives this power to the parliament to regulate matters related to citizenship? It is which article? Article 11 of the constitution, the very, very important article. Do not have any confusion. It is article 11 which is giving this power to the parliament. So based on the provisions of the article 11, the Citizenship Act has been passed and subsequently has been amended number of times. And if you look into the Citizenship Act 1955, it says that who is deemed to be the, it talks about only who can acquire the Indian citizenship subsequent to the commencement of the constitution, and how the Indian citizenship can be taken away. So for all those categories of people who are deemed to be the citizen at the commencement or after the commencement, whoever will acquire the citizenship by the Citizenship Act, for both the categories of the people, the citizenship can be taken away by the provisions of the Citizenship Act 1955, which has been amended number of times. So there are certain grounds on which the citizenship can be acquired. So what are the grounds on which the citizenship can be acquired as per the Citizenship Act 1955, which has been subsequently amended? One is citizenship by birth, descent, registration, naturalization, incorporation of territory, and based on the provisions of Assam Accord, which has also been later incorporated. Now, why I am discussing about this Assam Accord this year? It is also very important for your examination, not because of the Assam Accord. How many of you know recently the Supreme Court has upheld section 6A of the Citizenship Act? And what is that section 6A of the Citizenship Act is related to? Okay, so just think about it. I have a separate question on that. I will discuss that detail when I come to that particular question. So in this way, you should be able to connect whatever which is related to the conventional area and the current affairs. But anyways, the current affairs questions are coming little later. I will discuss that. But now coming to this particular question, which of the following ways by which a foreigner can become an Indian citizen under the Citizenship Act? Is it true citizenship by birth? Under the Citizenship Act 1955, citizenship by birth is not there. Okay, which of the ways by a foreigner? Very good. Okay, by a foreigner. So this is important word. Which of the following ways by which a foreigner can become an Indian citizen? Why citizenship by birth is not right? Because in this case, the child born to an Indian citizen. So therefore, the child may not be considered to be a foreigner. Citizenship by descent? No, in this case also at least one of the parents should be an Indian citizen. Although the child is born outside the territory of India, so again you cannot consider that child to be a complete foreigner, because the child is related to the parent by blood. So therefore, it cannot be considered to be a complete foreigner. The child is not considered to be a complete foreigner. Citizenship by registration? Citizenship by registration is only to the foreigners, but to certain categories of foreigners. So can anyone tell me what is the difference between citizenship by registration and naturalization? Naturalization is also for foreigners. Registration is also for foreigners. But what is the difference between citizenship by registration and naturalization? Of course, the time limit is less in registration, but why the time limit is less? Because it is only for certain categories of foreigners. Who are the categories of foreigners? Okay, so a person who marries an Indian citizen, if they marry an Indian citizen, yes, very good, citizen, a person of Indian origin, yes, and majorly an OCI card holder. So we will discuss about this OCI card holder also a little later. A person of Indian origin, a person marrying an Indian citizen, and OCI card holder, these are the major categories of foreigners who can become an Indian citizen. So therefore, certain special privileges given to them, so they can easily become an Indian citizen. In this case, they have to marry an Indian citizen, be in the relationship for 7 years, marital relationship, and then he should stay in India for a period of 7 years, ordinarily resident. PI also ordinarily resident, it does not have to marry, but has to reside in India for 7 years. OCI card holder, what is the position related to the OCI card holder? They have to possess this OCI card holder status for 5 years, and in addition to that, they should be resident in India for a period of 1 year. When they will satisfy simultaneously both these conditions, they will be given the Indian citizenship. Is that clear? And what about the citizenship by naturalization? What about citizenship by naturalization? Citizenship by naturalization is for any foreigner. The only exception is that that foreigner should not be an illegal migrant. Any foreigner who is not an illegal migrant can become an Indian citizen, provided they satisfy the conditions of the act, that they should reside in India for 12 years, they should know any of the Indian languages, they should be of good conduct. So these are all some of the provisions that is there in the act, but any foreigner who is not an illegal migrant can become an Indian citizen. But presently, as per the Citizenship Act 2019, there is an exception to this. What is the exception under the Citizenship Act 2019? Which also started getting implemented from 2024. So what is the exception? Certain categories of illegal migrants can become an Indian citizen, although they are an illegal migrant. So who are those categories of illegal migrants? People who have entered into India as an illegal migrant from 3 countries, that is Pakistan, Afghanistan and Bangladesh, and people who belong into 6 religious communities. What are the 6 religious communities? Hindus, Buddhists, Sikhs, Christians, Parsis and Jain, and also they have resided in India for a period of 6 years. So these are all the conditions that is given under the act. Now the Citizenship Amendment Act 2019, does it apply throughout the territory of India? Is there an exception as to where the law cannot apply? Very good. It does not apply in the Schedule 6 areas and also the areas which are covered under the inner line permit system. Please make a note, because I will tell you again and again. It will appear as if you know everything right now, but you will soon forget. Unless and until you are quite clear, just try to make a note of very small brief points of all these things. Because for you to consolidate all these information in one place is not possible before the examination. So try to consolidate your information. Citizenship by incorporation of territory, is it for the foreigners? Of course, yes, they are all subjects of another country, and of course they also can be granted the citizenship. So this is true, this is true, this is true. So what is the answer here? Answer 3, 4 and 5 only. Okay. Okay, I will take 10 questions, and then if you have any questions, I will break for some time. Okay. Okay, consider the following statements. The Constitution of India allows its citizens to possess multiple citizenship of different countries at the same time. Is that possible? It is not at all possible, because the Constitution makes it very clear that there should be only single citizenship, which is both in the Citizenship Act 1955 and also in the particular article in the Constitution. Which article in the Constitution provides for only single citizenship? Very good, Article 9 of the Constitution, which is also a principle that is followed in the Citizenship Act 1955. So therefore, the Constitution does not allow for what is called as dual citizenship. Only persons born in India can acquire Indian citizenship. Is it true? That is very quite clear from the Citizenship Act 1955, that the foreigners can also become an Indian citizen. Person who is born in India can also become, but the key word here is only persons born in India can acquire the Indian citizenship. That is wrong. Only citizens of India will have the right to vote in the general elections in India. There are certain privileges which is conferred only upon the citizens, and one such privilege is what is called as the right to vote. Can you just tell me what are the other privileges which is conferred upon only the citizen? I do ask this question always to the students, that how many of you are sure that you are an Indian citizen? First question, okay. First this question, and then I'll come to the next question. So how many of you are sure that you are an Indian citizen? Sure. So how do you know that you are an Indian citizen? Because, not just because you are having an Aadhaar card. So this is the answer that I get from the students when they are very new to the class. They say that they have an Aadhaar card. No, Aadhaar is not a proof of citizenship. And then they say that I have a voter ID. Then I say that voter ID is given to you because you are a citizen. It is not vice versa. So most of you in this class are an Indian citizen by virtue of what is called as by virtue of your birth, mostly. I am not sure, it may vary, it may be by descent also. There may be certain categories of people through registration also, but I am sure 99% of the people who are sitting here, probably attending the class online also, they are all citizens of India by virtue of what is called as birth. So now with that information, only an Indian citizen will have the right to vote in the general election. Yes, only the citizens will have the right to vote in the general election. What are the other privileges to the Indian citizen? Only to the citizen. Not just the fundamental rights. So just don't think about the fundamental right, because in fact right to vote is not a fundamental right. I am in general asking about certain privileges. Okay, so to get into certain constitutional office, most of the public employment, except for certain areas which is open to subjects of Nepal, Bhutan and other things, most of the public employment only to the citizen. The right to contest election is only to the Indian citizen. So these are all some of the privileges, and certain fundamental rights, of course, exclusively reserved only to the citizen of India, which will also subsequently discuss. So try to remember all those things. The fundamental right I will discuss. Okay, the fundamental right I will discuss, but the other privileges, which includes right to vote, right to contest election, to occupy certain constitutional office, in general in most of the public employment, these are all only the privileges of the citizens. So only the citizens will have the right to vote in the general election, that is true. Which of the statements given above are incorrect? What are the statements that is incorrect? 1 and 2 only. So these two statements are incorrect, alright. What about the Anglo-Indians or Indian citizens? If they are a citizen of India, they will have the right to vote. An Anglo-Indian who is an Indian citizen, so they will have the right. Okay, so the Anglo-Indian is only distinguished because of their lineage, but otherwise if they are an Indian citizen, they will have all the privileges of the other citizens. Okay, so come to the next question. This is a very important question. An overseas citizenship of India card holder, although does not require a visa to visit India, but may require prior permission or clearances to visit India in which one of the following cases? This is part of your current affairs. Okay, now tell me, first of all, who is an overseas citizen of India card holder? That we have already learned about. So just try to recollect who is an overseas, who is eligible to get a overseas citizenship of India card holder. All the persons of Indian origin, I have already said they are eligible to become an OCI card holder. They have to pay some fees to the government of India and they can get this card. Now, do you know what was the genesis of this overseas citizenship of India status? Initially, it was not called as OCI card holder, it was called as overseas citizenship of India. And later, this OCI, overseas citizenship of India is now designated as OCI card holder. Now, tell me, anyone who is having an OCI card holder, is he an Indian citizen? No, he is not an Indian citizen. He is a foreigner who has conferred certain privileges in our country. And what is the privilege of the foreigner who is having this OCI card holder, who is an OCI card holder, a foreigner? What is the privilege that he can have in India? Is that he can enter into India without visa, first privilege. But there are exceptions to this. He can enter into India without visa. He can enter into India without a visa and he can stay in India for any length of time. They will have certain property rights also, subject to certain exceptions. These are all some of the privileges for an OCI card holder. Now, do you know when this OCI citizenship was introduced by the government of India? In 2002 they brought in, and then subsequently when they brought in, they introduced only to certain countries, and then subsequently they have introduced to the other countries also. So presently all the countries across the world, whoever is a person of Indian origin, they can get this particular status, except a PIO from 2 countries. A PIO from 2 countries are not still eligible to become an OCI card holder. So what are the 2 countries? Except Pakistan and Pakistan and Bangladesh. Except these 2 countries, today they can get this OCI card holder status, they can enjoy these benefits. But however, as per the OCI card holder rules under the Citizenship Act, as per the rules of the OCI card holder, there are certain exceptions. Although they can enter into India without a visa, but if they are entering into India for a specific reason, then in that particular case they have to take the prior permission of the government of India. So the general rule is that they can enter into India without a visa or any permission, but if they are having an intention of doing certain activities in India, in that particular case they have to take the prior permission from the government authorities. So among this, what is the right answer? Can anyone tell me? Just apply. In which case probably do you think that the government might regulate the activities? So then I will discuss the answer. What about certain research related activities? So just try to think, it may have some impact upon our security or it may create some law and order issues. So those are all the areas probably the government wanted to regulate. The research can be adverse also to the interest of India sometimes probably. So do you think that the government has to take precaution when it related to research? Yes, so in this case it is required. So when they are entering into activities related to missionaries, journalistic, public or mountaineering activities, public is nothing but it is also a missionary activities specific to Islam religion, Muslim religion, that is basically what is called as public. So do you think in this case the government needs to regulate all these things? It may have an impact upon the law and order in our country probably, so yes, it requires regulation. Internship, any foreign diplomatic missions. Somebody is coming as an intern to any of other foreign diplomatic missions in India, it may have a potential security threat. So therefore the government has to regulate all those things. Yes, in this case, a visit to an area in India that is notified as protected, restricted or prohibited, especially those areas like the inner line permit system which affects the tribal people and their way of life. So this also requires. So what is the answer here? All of the above is the answer. Okay. So try to understand, in general they can enter, but if they are entering for a specific purpose, they require permission of the government. Okay. Okay, come to the next question. Which of the following categories of people were eligible to become an Indian citizen at the commencement of the constitution? So which of the following categories of people are eligible to become an Indian citizen at the commencement of the constitution? Persons domiciled in India, are they eligible? Yes. Which article give them this power? Very good. Article 5 of the constitution. They were eligible to become, subject to certain conditions, but UPSC will not focus on all those things. So you should also as a student know that what are all the areas probably UPSC will focus. UPSC may not go into the very specifics when they ask a question. They will try to see whether you have a broader understanding. Yes, I am not saying they may not go. Sometimes they may go, but that should not be how you should prepare in each and every case. Okay. So these are all areas you should have a broader understanding. Yes, persons domicile is there in article 5. Yes, they can become an Indian citizen subject to certain other conditions. Persons of Indian origin living outside India, were they eligible to become an Indian citizen at the commencement? Yes. Which article? Very good, article 8. Even if you do not remember the article, it is okay, but you should know the provisions. If you are remembering the article also, it is well and good. Persons returned from Pakistan to India. Yes, which article? Very good, article 6. Persons migrated to Pakistan from India but later returned to India, they are also eligible to become an Indian citizen, but all these things at the commencement of the constitution. So persons who have gone to Pakistan but later returned to India, were they eligible to become an Indian citizen? Yes, that is also possible under article 7 of the constitution, but there are certain cutoff dates, but you do not have to remember all those things. But for your understanding, here the cutoff date is persons who are returned from Pakistan, there are two before 19th of, what is the date? 19th July, I think, 1948. So that is the cutoff date, and here in this case persons who have gone to Pakistan 1st March 1947. So that cutoff date is not very important, but just remember these provisions, that is more than sufficient. So what is the answer in this case? All of the above. So D is the right answer. I think here the cutoff date is 19th July 1948. 19th July 1948. But the cutoff date is not important. Okay. Okay, come to the next question. Which of the following rights are available to an alien in India? Right to vote, is it available? Right to vote is not available. Right to contest election, okay. Right to public employment, generally it is not there. So always when there is a question on a general line, do not think about the exceptions, okay. Generally the right to public employment is not available to the alien. There can be few exceptions, that is okay, but generally it is not the case. So choose the correct answers from the codes given below. What is the answer? None of them is available to the citizens. Okay, so instead of which it should be who of the following, but the parliament is also there, but anyways, who or which of the following has the power to admit or establish a new territory into India? It is a parliament. Under which article? Article 2 of the Constitution. Can anyone tell me what is the difference? I also explained this. What is the difference between the word admit and establish? What is the difference between admit and establish? Sorry, I was just looking into some comment. Okay, what is the difference? Okay. See, the very simple difference is admit and establish. Admit means you are already allowing a already a well established political entity into India. But some territory which is not an established political entity, that is you are establishing that. I have given examples also. So, for example, if India is acquiring Sri Lanka, then that would be admit or establish. It would be admitting. Some, let us assume, a barren island which is there, which is a disputed territory, you are admitting that into, you are bringing that into India, that is establishing. So, you will have to see whether it is a politically established entity or not. Politically established entity, that is admit. Not a politically established entity, that is establish. Okay. But in both the cases, who is having the power? Article 2 of the, under Article 2, it is the Parliament. In this case, is the Parliament have to take the permission of any of the state legislature? There is no need, because there is no locus standi for any of the state legislature. Alright, so here it is not required. So in this case, does it require a constitutional amendment under Article 368 to admit or to establish? In general, there is no need to make any constitutional amendment, but here also you will have to remember one thing: whenever the Parliament is admitting or establishing any new territory into India, there is no need to make any changes to, there is no need to amend the Constitution under Article 368, provided that they are not making any changes apart from Schedule 1 and Schedule 4 of the Constitution. But however, in the process of admitting or establishing a new territory into India, if they are making changes to any of the other provisions apart from Schedule 1 and Schedule 4, then it requires a constitutional amendment under Article 368. Can you give an example of what I am talking about? For example, when Sikkim was brought in, they have brought in what is called as the 36th Constitutional Amendment Act. So that was required because they inserted a new article, that is Article 371F, which is apart from Schedule 1 and Schedule 4. So therefore, it requires a constitutional amendment. Clear? So what is the answer in this case? It is the Parliament which is under Article 2 of the Constitution. Alright, so very quickly, if you have any questions, but the more the time that you consume on question is also not good. So because you give me more time to talk, I will give you more information. If you talk more, then it will be less information. So you can understand, but yes, genuine doubts are entertained. Okay. So the answer here is the Parliament. Alright. Yes. Assam Accord I will discuss. That question is coming, that is why I did not discuss. I have a specific question on section 6A of the Citizenship Act. At the time I will discuss. If I am not making any discussion in detail, because I know that the question is coming, so there I will make the discussion, but you can ask a question from whatever I have discussed if you have any questions. Okay. I will just give me a minute, I will just look into the online students also. Okay, so why this explanation for the PDF is not given? Because that is not going to help you. In the examination, you will not be able to, before revising, you will not be able to read the entire explanation of the PDF and all those things. That is not a wise approach. So try to make note of whatever I am discussing. I do understand there is a limitation for this. To take the notes, you should have a prior knowledge. Otherwise, it is difficult for you to take a notes. But we do understand that you are appearing for the prelims examination. You are not there in the foundation course. So therefore, try to make a very short note of whatever I am talking about. Only that will help you to revise. If you have an explanation for every question can be given in one page. So that is not going to help you at the examination. Please put your mobiles in silent mode. Okay, any other questions? Okay, so one of the students thinks, sir, please speak in Hindi. There are two limitations to that. One is I am not good in Hindi. Although I can understand, that is all fine. And the second thing is I do not do that because there are some of the students who do not understand Hindi also. Because when I started preparing, there are many teachers who spoke in Hindi. Most of the time I did not understand. So then when I become a teacher, I realized that I should speak in a language that everybody can understand and comprehend. Okay, so that is the reason I did not entertain that also. And I have a limitation also in talking. I will not be able to explain well most of the concepts if I start doing in Hindi. Most of the teachers are doing it because they can do it well in Hindi. So probably for them it will work, but for me it will not work. So therefore that is not possible. Okay. What about this PDF is not uploaded in the online yet? In the Telegram? Okay. So that you can reach out to the front desk or the management. I think they will take care of that, but I will also put across a word. Alright, shall I move forward? Okay, so come to the next question, question number 11. Requires prior sanction. So which of the statements given above are true regarding the procedure to create a new state under Article 3 of the Constitution? So the question is related to Article 3. Requires prior sanction of the President of India to introduce a bill. Is it true? So any bill to reorganize the states under Article 3, it requires a prior sanction of the President under Article 3. But what about to admit or to establish under Article 2 of the Constitution? Does it require a prior recommendation of the President? How many of you think it does not require a prior recommendation under Article 2 if they have to admit or establish? Because this procedure is specifically given only in Article 3, not for Article 2. Okay, so therefore under Article 2 it does not require any prior permission, but under Article 3 for reorganization, yes, it requires a prior permission. So now we are anyways discussing about Article 3. Now come to the second statement. It requires approval of the concerned state legislature before the bill is introduced. It has to be referred to the concerned state legislature to seek the opinion, but their approval is not mandatory. We have already discussed this. Anyway, so in this case, the keyword here is the approval. Approval is not mandatory. Which of the statements given above are true regarding the procedure to create a new state? What is true? One only. So statement 2 is not the right thing. To cede a territory to a foreign country, it requires what? What is the majority that is required? Special majority, no doubt. Whenever we talk about to cede a territory to a foreign country, it can be done only under Article 368 of the Constitution, which means it requires what type of majority? Special majority of the Parliament. So can anyone tell me what is the special majority here? Two conditions has to be satisfied. What are the conditions? Not less than 2/3 of the members present and voting. Not less than 2/3 of the members present and voting, plus what? Plus the members who are supporting this should also satisfy the condition of absolute majority. Both the conditions needs to be satisfied. Okay, if there is any disputed area between India and another country, it is not the territory of India, but a disputed area. There are certain buffer zones which can turn out to be a disputed area between India and a foreign country. So if India wanted to amicably settle down that disputed area, does it require a constitutional amendment? Does it require a simple act of Parliament? How many of you think it requires a simple act of Parliament? It does not require a constitutional amendment under Article 368. It does not require a simple act of Parliament. It can be resolved through an executive action, because that is not the territory of India in the first place. Which is not a territory of India in the first place, how do you make a law? So you cannot make a law, so it does not require anything. I have given an example for this also. So for example, 𝐂𝐨𝐧𝐬𝐭 was a disputed territory, but India has given 𝐂𝐨𝐬𝐭 to Sri Lanka. But it does not require a constitutional amendment, it does not require any simple act of Parliament, it was done merely by an executive action. Okay, so that is the cabinet will give the approval by which they will say, okay, you can keep this. So this is what basically you have to understand. So this is the answer. So come to the next question. Consider the following statements. Statement 1. The preamble is an integral part of the Constitution. Is it true? Yes, presently it is an integral part of the Constitution, there is no doubt in that. The preamble is a modified version of objectives resolution introduced in the Constituent Assembly. Is that true? There is something which is called as objectives resolution, and there is also something which is called as instrument of instruction. So you should not get confused. Objectives resolution is related to the preamble. Instrument of instruction is related to the directive principles of state policy. Can anyone tell me when was this objectives resolution introduced in the Constituent Assembly and who has introduced this objectives resolution? It was Pandit Jawaharlal Nehru, and when was this introduced? It was in 13th December 1946. That is the year when the Constituent Assembly was established. But after that, nothing has happened for a long time. And what is this objectives resolution? Just an extra understanding. What is this objectives resolution? It was like a foundational framework. It was having the philosophy as to how the constitution has to be drafted, which was later modified and become the preamble to the Constitution of India. Okay, just an added information to that. When the Constituent Assembly met for the first time, 9th December 1946, 13th December objectives resolution was introduced. Some dates probably you can remember, sometimes they can randomly ask. So this is also true. So what is the answer here? So both 1 and 2. Which of the words were inserted into the preamble by the 42nd Constitutional Amendment Act 1976? Only once the preamble has been amended by the 42nd Constitutional Amendment Act. So in the nature of the state, there were two changes. One is they have inserted the word socialist, and then they have inserted the word secular, and in the overall preamble they have added one more word. What is that word? It is the word integrity. So what is the answer here? C. So sometimes students might confuse between the word, whether it is dignity, unity, integrity. Only in the examination will have all these doubts. Therefore, try to make it very clear. What is the word that has been introduced? It is integrity. Okay. So the answer is option C. Which of the following is the correct order of justice provided in the preamble? What is the correct order? Social, economic and political. Why this particular order? It is arranged in the order of difficulty. Whichever is more difficult to achieve, that was given the first preference. So it is social, economic and political. Answer is option D for this particular question. With reference to Indian history, the members of the Constituent Assembly from the provinces, when I say provinces, the British provinces, how they were elected? First of all, we have seen that in the Constituent Assembly, they were both elected as well as nominated members. While in case of British provinces, they were elected. And who are the electoral college for those members? The elected members of the provincial legislature. But however, these members were elected indirectly. So what is the answer here? Elected by the provincial legislative assemblies. The preamble in the original constitution was read as what? Sovereign Democratic Republic. Very simple. So only these three words were there in the original constitution. The Constitution Day is celebrated on 26th November of every year to promote the constitutional values among citizens. Is it true? Now, what is the significance of this 26th November? That is the day when the Constituent Assembly has adopted the Constitution of India. So you should be very clear. Although it was adopted, the Constitution did not come into force. When it came into force? It came into force on 26th January 1950. Okay. So I'll just complete few questions and then I'll take up your doubts. Okay, so this is true. Statement 1 is true. What about statement 2? On 26 November 1949, the Constituent Assembly of India set up the drafting committee. Within 2 months, they cannot enact the entire draft and complete the constitution. Anyways, you can easily do that. So see, UPSC is also asking very simple and easy questions at times. Which one of the following is correct with respect to the above statement? 1 is correct and statement 2 is incorrect. With reference to India, consider the following statements. There is only one citizenship and one domicile. Now try to understand, though the domicile certificate can be issued by various state governments, but it is always considered to be domicile of India. Although it also denotes that they are resident of a particular area, but residence is not equal to domicile. What is the difference between residence and domicile? Does anyone know? The state governments are the authority to issue, but the domicile certificate is for the entire country. Is there any difference between domicile and residence? So the basic difference is residence is a physical presence. Residence plus intention to make that particular place as a permanent place of stay will make that to be what is called as domicile. So residence is considered to be very temporary in nature, while domicile is a permanent concept, because he is not only residing there, but he is also having an intention to make that particular place as his permanent home. So that is basically what is called as domicile. Anyways, even if you have a doubt in this particular statement, come to the other statement. So whenever in UPSC, when you attempt the questions, when you have any doubt, don't go to the answer, try to solve the other statements. Okay, so come to the next question. A citizen by birth only can become the head of the state. There is no concept of what is called as natural born or naturalized citizen in our country. So therefore, this is not the right thing. The only requirement is to become the president of India, they should be a citizen of India. So this is wrong. A foreigner once granted the citizenship cannot be deprived of it under any circumstances. They can be deprived. What is the article in the constitution which talks about this? There is no article which talks about this. Of course, the Citizenship Act talks about all those things. But is there any article in the constitution which also has a reference to this? Very good. Article 10 of the constitution. Because article 10 of the constitution makes it very clear that once a citizenship is granted, that citizenship may be deprived only by a way of a law that is made by the parliament. Okay, so therefore, the concept of citizenship is not permanent. A foreigner once granted the citizenship, he can be deprived of his citizenship by 3 ways. Not only for the foreigner who becomes an Indian citizen, for any Indian citizen, they can be deprived by 3 ways. The citizenship can be lost by 3 ways, taken away by 3 ways. What are the ways? One is by renunciation, other is termination, third is deprivation. Now, what is the difference between renunciation and termination? While renunciation is voluntarily, and what is the ground on which a citizen can renounce the Indian citizenship? On any grounds. Even without taking a citizenship of some other country also, he can renounce it. On any grounds, we can renounce it. But termination happens by a way of application of law. Termination happens on only one ground. What is the ground on which termination happens? If a citizen has taken up the citizenship of some other country. So therefore, he has to renounce. If he doesn't renounce, then his citizenship is terminated. Deprivation is not because he has taken up the citizenship of some other country, but on certain conditions given in the law, that he becomes disloyal to the country, or he has traded Indian secret with a foreign country. So these are all some of the grounds which is given in the law on which his citizenship can be deprived. Anyways, now a foreigner once granted the Indian citizenship cannot be deprived of it under any circumstances. This is an absolute statement which makes it wrong, because he can be deprived. So now if you eliminate wherever there is 2 and 3, wherever there is 2 and 3 you eliminate, what you are left with is only 1. So what is the answer? A only. Yes, any citizen for that particular matter. See, a foreigner once he become an Indian citizen, he is not distinguished between a citizen who became an Indian citizen by virtue of birth. Anybody who becomes an Indian citizen, once an Indian citizenship is conferred, their citizenship can be lost by deprivation, termination, or by renunciation. Even if someone gets an Indian citizenship by virtue of birth, if they become disloyal to the country, their citizenship can also be deprived. There is no distinction in this regard. Only how one can acquire the Indian citizenship, there are some differences. Once they become an Indian citizen, everybody is same with regard to their deprivation or with regard to their taking away of the citizenship. Okay, so come to the next question. We are done with 19. Which of the following factor constitutes the best safeguard of liberty in a liberal democracy? What is the answer? This is an UPSC question. What is the answer? It is separation of powers. Now, why separation of powers? Who can take away the liberty of the citizen? It is usually the state by an arbitrary action. The state means we have already learned, which I will subsequently discuss, state under article 12 of the constitution for the purpose of because they are talking about liberty for the purpose of fundamental rights, state is defined under article 12. Is it possible for the state to make an arbitrary law, deprive the liberties of the citizen? Is it possible for the executives to take an arbitrary action to deprive the liberty of the citizen? Therefore, in all these cases, either by a way of a law or by an executive action, if the liberty of the citizen is to be affected, therefore, who will come to the help of the citizens? The judiciary, and the judiciary can function effectively only if it is an independent judiciary, and that independent judiciary is protected by way of what is called as separation of powers. Judiciary is separate from the other two organs. Okay, so therefore, what is the right answer? It is the separation of powers, that is independent judiciary is how the liberty of the citizens can be protected. Alright, so just give me a moment, I will just look into the online students if there is any question that I am supposed to take, and if you have any doubts also you can just hold on to your doubts, I will just ask you. Okay, that I will do. So, what is the topic that I am going to discuss in the next class? So, the next class I am going to do the entire executives. So, probably if you have the time, if you have the energy after this particular class, you can go and revise, but I do not think it will be completely possible for you to go and just revise it in one day unless and until you are already prepared good enough. But if you do that, that is good, but otherwise also come to the class, try to observe most of the things from the class. Okay, but anyways, the next class I am going to do the executives. Are you clear about the majority that I talked about? That if in case India has to cede a territory to a foreign country, when I say India has to cede a territory to a foreign country, that means these are all the territories that is mentioned in the Schedule 1 of the Constitution. So, if India has to cede a territory to a foreign country, that can be done only by one way. What is the way by which it can do? By a constitutional amendment under Article 368. And under Article 368, then you will have to look for the majority. And if you go and read Article 368, it is saying special majority where it has to satisfy two conditions. Not less than 2/3 of the members present and voting, as well as what is called as absolute majority. Now, if you generally look into Article 368, Article 368 also talks about ratification behalf of the state legislature also, but that is required only if it is going to disturb the federal provisions of the Constitution. So, therefore, giving a territory to a foreign country, even if it is from any state, it does not take away any of the federal provisions, because this matter is exclusively given to whom? Only to the Parliament. That is why the expression Union of States was used in the Article 1 of the Constitution rather than Federation of States. Therefore, it does not require any ratification by any of the state legislature. Who has a complete prerogative to cede a territory to a foreign country? Only the Parliament. Okay. So, come to the next question, at question number 21. The preamble to the Constitution of India is statement, what is the answer? The preamble to the Constitution of India, part of the Constitution, that is not the right thing. Sorry, okay, that is the right thing. Not a part of the Constitution is not the right thing. Part of the Constitution and has same legal effect, that is also not the right thing. So, therefore, you can rule out these two things. The confusion could be between A and D, but you will have to find the most appropriate answer, which is giving a detailed information about the preamble. So, let us see which is giving a most detailed information about the preamble. Part of the Constitution but has no legal effect, right? We cannot say that to be wrong, but read here, part of the Constitution but has no legal effect independently of the other parts, which means they are trying to say the preamble is an integral part of the Constitution, but it does not have any legal effect. But how it may have a legal effect is that by reading it with other provisions of the Constitution, or in other words, the preamble helps the court in interpreting the other provisions of the Constitution, which may have a legal effect. So, therefore, which is giving the most information about the preamble? It is D. So, in fact, UPSC has also given D as the right answer. So, sometimes more than one option could be right. So, the key is there you will have to look for what is the most appropriate answer. Which of the following objectives is not embodied in the preamble to the Constitution of India? So, which is not embodied? What about the preamble talking about liberty of thought, expression, belief, faith and worship? So, which is not there? Economic liberty is not there. So, answer is option B. The mind of the makers of the constitution is reflected in which of the following? Preamble. And who has given this observation about the preamble? The Supreme Court of India. I already discussed that. In which case? In Berubar Union case. So, the answer is option A. Economic justice as one of the objectives of the Indian constitution has been provided for in where it is given. So, the answer is okay, preamble and the fundamental rights. Definitely the preamble does not talk about that. So, always try to look into the question. So, it is fundamental right is not there, economic justice is not there in the fundamental right. The fundamental right is mostly talking about what is called as idea of political democracy and political justice, not more than that. The preamble and the directive principles of state policy, is it true? So, what is the objective of DPSP? To ensure social and economic justice. So, economic justice is anyways a philosophy that is there in the DPSP, but is it also mentioned in the preamble? Yes. So, the right answer is both preamble as well as DPSP. It is not preamble, fundamental rights and DPSP. So, you can rule out this also. What is the answer here? It is option B. Is it clear? Now, try to have this in your mind. The fundamental rights is mostly talking about protecting the individual liberty. It is not talking about the collective welfare. So, which is the provision in the constitution which is talking about the collective welfare of the society? The directive principles of state policy, which talks about social and economic justice. But you try to understand all these principles, whatever is there in DPSP, whatever is there in fundamental right, everything is enshrined where? In the preamble to the Constitution of India. So, therefore, the preamble also talks about economic justice, the DPSP specifically also talks about the economic justice. What is the answer? Option B is the answer. The members of the Constituent Assembly who drafted, not which, who drafted, okay, so who drafted the Constitution of India? What is the answer? So, they were elected by legislative assemblies of various provinces. So, the answer is option C. On whose recommendation, this is again a very important area, previously they have been asked in UPSC examination also. On whose recommendation was the Constituent Assembly was formed? Cabinet Mission Plan 1946, subsequently it was, do not make a mistake here, very easy question. Cabinet Mission Plan. Liberty, equality and fraternity, this is an inspiration that was derived from French Constitution from the French Revolution, and then subsequently they had a French Constitution also, France. So, it was from the French Constitution. So, these type of questions sometimes can be rarely asked. So, just have an idea about it also. Which of the following is part of the preamble of the Constitution of India? So, what is the answer here? Is it we the people of Constituent Assembly? We the members of the Parliament? At that point of time there was no Parliament, it was only the Constituent Assembly. Okay, so you should definitely not select B. We the people of India, who is the source behind the Constitution of India. Okay, so the right answer is option A. It is often said that the key to the minds of the makers of our constitution lies in where? It is there in the preamble. Which of the following is not a tenet of Gandhian socialism? Just think about it, because the kind of socialism that we follow today is Gandhian socialism or democratic socialism, which is there in the preamble. If you read the preamble, it talks about sovereign, socialist, secular, democratic republic. The kind of socialism is what is called as Gandhian socialism or democratic socialism. So, it enshrines certain principles. Which of the following is not a principle of that? So, that is the question, I think. So, does it wanted to ensure social justice? Yes, there is no doubt in that. So, definitely this is true. Concern for the poor but not hatred for the rich. Is it there? The idea of Gandhian socialism is that they have to do welfare to the poor, but it does not mean that they hated the rich people. That is not the idea. In fact, the Gandhian socialism believed in the concept of what is called as trusteeship, that the rich should act as a trustee of the poor. There was no hatred to the rich people, okay, but they wanted to share the resources. So concern for the poor but not hatred for the rich. Equality of opportunities for all, of course, yes, by distributing the wealth and all those things they wanted to ensure equality of opportunities. Nationalization of all means of production. When you talk of nationalism, nationalization of all means of production, then that becomes extreme socialism or communism. That is not the idea that is there in the Indian constitution. So therefore, what is the answer here? Option D is the right answer. That is not an idea, so therefore the right answer is option D. Alright, so is it clear to all of you? That is why if you see today, do you understand how India functions? Can you say India is a welfare state? Do you think that the government of India has different means of production? Do they manage certain properties? There is also simultaneous existence of private means of production and the private companies, private properties. So we do follow an idea of what is called as a mixed model, which is basically the idea of what is called as the socialism that we follow in our country. Alright, is that clear to all of you? So even if you revise all these things, whatever I discussed, 90% of your questions from these areas can be answered. So make sure that from these areas you should not make any mistakes. Unless and until UPSC comes and asks an exceptional question, again you are in a level playing field, because most of the students will not answer that. So therefore, it is not about how many questions you answer. You should not get certain questions wrong where others are doing it right. Okay, so try to play like that. Do not put a lot of effort in one particular area also. That is also not advisable. Okay, now we will move to the next topic, that is fundamental rights. So you have 2 minutes, just go through all those things. I will also look into the online students for any questions. I will take up the questions, and then if you have any, I will just move forward to the next topic, that is the fundamental rights. Any questions from the online students? Okay, so some student is asking me, is it sufficient if you can do this 500 questions? I would say that if you are prepared, these 500 questions if you revise, I am sure that 80 to 90% of the questions can be done. Because the way that I am designing the question, it includes at least last 20 years of PIQs, similar modeled previous practice questions, and also substantial amount of current affairs question. Overall, out of this 500 questions, you will get at least 50 to 75 current affairs based questions also. So therefore, the important thing, I am not taking some random current affairs. Based on my experience, I know the potential questions which may be asked. So even if you observe whatever I am discussing, this is also, suppose if you do not have the time to do further, if you do it properly, this will also help you to do well in your examination. Alright, can I move forward? Yes? Alright, so come to the next part. Right to strike in India. So somewhere you would have heard it, right to strike. So what type of right is right to strike in our country? Do we have a right to strike? No, in general, do we have a right to strike? I am not asking whether it is a fundamental right or not. Yes, there is right to strike, but it is not a fundamental right. It is merely a legal right in our country. So what difference does it make? I will discuss about the right to strike, but what difference does it make when I say right to strike is merely a legal right, not a fundamental right? Wherever there is a right, there is a remedy. That means wherever there is a right, you can get it enforced in a court of law. But how you can get it enforced in a court of law is the only difference. Fundamental right means you can directly go to the Supreme Court of India. Legal rights, you cannot directly go to the Supreme Court of India. You will have to follow the ordinary hierarchy of courts. Whatever the law says. If the law says, okay, directly go to the High Court, you can go. If the law says no, you will have to go only to the District Court, you will have to go only to the District Court. Only by way of an appeal, you can go to the Supreme Court of India. So that is the difference that you have to understand. But yes, right to strike is there, but right to strike is not a fundamental right. Right to strike is not mentioned in part 3 of the Indian Constitution. Right to strike comes from certain laws in our country like the Industrial Disputes Act, Trade Unions Act. So they all recognize all those things. So right to strike has only a statutory backing. That means it is only a legal right. So it is not a fundamental right. So right to strike in our country is what? It is only a legal right. Okay. Okay, so this is a good question. This year I think that there can be question from the detention and all those things. Last year also I expected. I am not sure whether they asked it in the last year. This year again they can ask. Because one of the issues that is happening in our country is today a lot of arbitrary detentions are happening. So therefore, as a citizen and as someone who is preparing for UPSC examination, you should be aware of the rights when it comes to the detention, both in case of what is called as preventive detention as well as what is called as punitive detention. And which article in the Constitution talks about all those things? Article 22 of the Constitution. So in this regard, we will try to understand. Come to statement number 1. Preventive detention happens only by a way of a trial in a court of law, and hence individual should be produced before the nearest magistrate within 24 hours of arrest. So this is in case of what? This is in case of punitive detention. That is, this is in case of arrest when it comes to punitive detention, not in case of preventive detention. So this particular statement is wrong, but can anyone tell me what is the difference between punitive detention and preventive detention? What is punitive detention? Can anyone tell me? Punitive detention is a detention by way of a trial. After the trial, somebody is found guilty, then only they can be put in the prison or in the jail, whatever it is. So that is basically what is called as punitive detention. So the primary condition for the punitive detention is commission of an offence. On that ground, they may be arrested, then the trial will happen, then based on the trial, they can be put in jail. That is punitive detention. But what is preventive detention? Preventive detention is a detention without trial. Why there is no trial? Because the individual has not committed any offence. There is merely an apprehension, or merely it is preventive nature, preventing an individual from committing any offence. That is preventive detention. There are different sets of rights when it comes to what is called as punitive detention as well as preventive detention. There are further questions I will discuss. Okay, now tell me what are the rights that is available to an individual in case of what is called as preventive, in case of what is called as punitive detention. There are 3 important rights which is further elaborated by the Supreme Court of India, but you should know at least what is there in the Constitution. So first of all, in case of punitive detention, the individual should be informed of the grounds of arrest. It has to be clearly informed in writing to the individual as to what is the grounds of arrest. The second thing is, he should be allowed to consult a legal practitioner of his choice. Now the third right that is given to an individual is that the individual should also be produced before the nearest magistrate within a period of 24 hours. All these things has to happen in case of arrest. But this 24 hours, you should understand, this 24 hours excludes the time of travel. It is not including the time of travel, excluding the time of travel. So why this excluding the time of travel? There are certain hilly regions in our country, even to go to the nearest magistrate, it may take half a day. So therefore, excluding the time of travel, it should be within what is called as 24 hours. Alright, so this is something that you should keep in your mind. So is there any right when it comes to what is called as preventive detention? What are the rights available in case of a preventive detention? Now in this case, the individual has not committed any offence. But even in case of preventive detention also, the general rule is that they should be informed of the grounds of detention. What is the basis on which he is detained? That should be informed. It has to be given. But he will not be allowed to consult a lawyer because there is no trial that is going to happen. But he should be informed of the grounds of detention. Why he or she is informed of the grounds of detention? Based on the grounds of detention, he can make a representation to the concerned authority that maybe whatever they think is not the right thing. And then subsequently, if the detaining authority is convinced, they can release this individual also. And whenever an individual is taken into preventive detention, how long the individual can be kept in detention? Maximum. What is given in the Constitution? For preventive detention I am talking about. Maximum they can be kept in detention for a period of 3 months, not more than that. But can they be detained beyond a period of 3 months? Yes, they can be detained provided an approval is given by the advisory board. And the preventive detention in our country can happen only by a way of a law. That means there should be some law that is authorizing individuals to be detained, and normally they can be kept under a detention for 3 months. Can it be extended beyond 3 months? Yes, with approval of the advisory board. If the detention is extended beyond a period of 3 months by the approval of the advisory board, so how long the detention can be extended? It can be extended up to a maximum period of detention that is allowed in that particular law. Whatever the law under which they are detained, whatever is a maximum detention, to that extent it can be extended. Say for example, if somebody is detained under the National Security Act, which is a preventive detention law in our country, initially under the National Security Act, how long they can be detained? 3 months. But if the detention is to be extended beyond 3 months under the National Security Act, it can be extended with the help of an approval of the advisory board. And how long it can be extended? It can be extended up to a period of 1 year. That means it is not 1 year again, it is 3 months plus another 9 months it can be extended. So beyond that the detention cannot be extended. So this is clearly given in the constitution. Now I said that the preventive detention in our country can happen only by a way of a law. So who is empowered to make law? Is it only the parliament? Is it only the state legislature? Or is it both parliament as well as the state legislature? How many of you think it is both? It is both parliament as well as the state legislature, because preventive detention is an item both in the union list as well as in the concurrent list. Whatever areas on which the laws can be made, which is mentioned in the union list, the parliament can make laws. Whatever areas on preventive detention which is mentioned in the concurrent list, who can make laws? Both the parliament as well as the state legislature. Alright, so with that information you just come here. There are a lot of other questions also related to preventive detention, but try to keep all the information. Preventive detention laws can be made only by the parliament and not by the state legislature. Is it true? It is not true, because both can make, because it is also an item in the concurrent list. So therefore this particular statement is also wrong. So what is the answer? It is neither one nor two. Very, very important. Last year also I was expecting, because there was one controversial arrest which was highlighted. The founder of, I think, the NewsClick magazine. So he was arrested and then subsequently he was released, where the Supreme Court found that there was some arbitrary detention in this particular case. UPSC may not ask the factual things. UPSC will ask the constitutional provisions related to these articles. Okay. Okay, come to the next question. Which of the following is true regarding the fundamental rights provided in the part 3 of the constitution? So this is related to part 3. They cannot be amended by the parliament. Can the parliament amend them? Of course, many times the fundamental rights can be amended. So therefore, any provision of the constitution can be amended, including the fundamental rights, but without tinkering or without taking away what is called as a basic structure in the constitution. So to say that the fundamental rights cannot be amended at all is a wrong thing. Fundamental rights can be amended without taking away the basic structure. This is what is the situation of the law today as per the 𝐂𝐨𝐬𝐴 Bharati case, where they innovated this doctrine of basic structure. But before the 𝐂𝐨𝐬𝐴 Bharati case, there was one judgment which was given by the Supreme Court, where they said that the fundamental right is sacrosanct. That means the fundamental right cannot be amended at all. Which case is that? Very good. It was the Golaknath case. But you don't have to remember that unless until UPSC asks, what is the position today? Can the fundamental rights be amended? Yes, without disturbing what is called as a basic structure. So they cannot be amended by the parliament is wrong. They check the arbitrary exercise of power by the state. The very objective of the fundamental rights is to prevent the state from arbitrarily exercising their powers. Okay, so this is true. They provide absolute protection to the citizens. The very nature of the fundamental rights in our country is qualified in nature. It's not absolute right, because when it becomes absolute, then it is giving you the freedom to do whatever you want to do, because freedom is something which is unrestrained in character. Something which is unrestrained in character is very dangerous. Why? Because then it becomes the law of the jungle. The powerful can do whatever they want to do. So because if freedom is given, that is also paving way for someone to take away the freedom of others in the society. So therefore, what the Constituent Assembly has given is only what is called as liberty. While it is giving a certain element of freedom, but it is not something which is unrestrained in character, it can be restrained. So in the constitution itself, if you see, there is a lot of reasonable restrictions for every fundamental right. So therefore, to say that the fundamental rights are absolute is a wrong thing. So they provide absolute protection to the citizen is wrong. So choose the correct options from the codes given below. What is the answer? It is B only, that is 2 only. Okay, what is the answer in this case? Okay, you will have to tell the answer and I'll ask a lot of questions. For that also, you will have to say me the answer. So this is how we will discuss this question, okay? Okay, a citizen of India belonging to a particular state feels that the chief minister who has recently assumed the office after the election to the legislative assembly does not have the necessary qualification to hold on to such an office. In such a case, he wants to challenge the appointment of chief minister in a court of law. What would be the appropriate writ by which he can challenge such an appointment? What is the writ? Writ of quo warranto. So what is this writ of quo warranto? Whenever this writ is filed, the only explanation that I am going to give. After that, all the explanation should be from your side. The writ of quo warranto basically means that whenever this writ is filed, the court is asking by what authority or by what warrant you are holding on to such an office. So basically, the court wanted to verify that whether the individual holding on to some office has all the qualifications to hold on to such an office. So therefore, yes, the writ of quo warranto is the answer here. Does the principle of locus standi applies in case of writ of quo warranto? The principle of locus standi does not apply. So what is this principle of locus standi? What is locus standi? Locus standi means that the court is asking that what is your standing in this particular case, in which way you are affected because of this particular case. So traditionally, if you see, the Indian judiciary was allowing only the affected people to knock the doors of the judiciary. Then they realized that not necessarily everybody who is affected will have the resource to fight the case. So therefore, they liberalized this particular principle of locus standi. They also allowed people to come and file public interest litigation in the court of law. So therefore, today when it comes to the writ of quo warranto, the principle of locus standi does not apply. That means not necessarily the affected individual can go to the court. Any interested person can go to the court. So that is basically what you have to understand. Is that clear? So this is the first thing that you should remember. Apart from the writ of quo warranto, there are 5 writs under Article 32 of the Constitution. The Supreme Court can issue writ of, first is habeas corpus, writ of mandamus, prohibition, certiorari and quo warranto. In all these cases, in which of the cases the principle of locus standi applies? When I say principle of locus standi applies, in that case only the affected parties can go to the court, not the others. In certain type of writs, the principle of locus standi applies. What are the writs? What are the writs? There are 2 types of writs where the principle of locus standi applies. Only 2 types of writs. One is writ of prohibition and other is writ of certiorari. In the other type of writs, the principle of locus standi does not apply. Is that clear? So in all the other cases, that is in case of habeas corpus, in case of mandamus, in case of quo warranto, not necessarily the affected individual has to go. Others can also file a PAL. But in case of prohibition and in case of certiorari, only the affected individuals can go to the court because the principle of locus standi applies. So this is something that you have to remember. Very quickly, what is writ of habeas corpus? Writ of habeas corpus means to produce a body in front of the court, whether to it is only to see whether the detention is legal or not. The court will verify that. But here the principle of locus standi does not apply. If the detention is illegal, the court would provide the remedy, allow for the release of the individual. If the detention is legal, then there is no remedy. That is writ of habeas corpus. Now, what is writ of mandamus? Writ of mandamus is the court is giving a direction to some public authorities. That is very important. The mandamus cannot lie against a private entity unless and until the private entity falls within the definition of state. So therefore, your understanding of definition of state is also very important. But in general, the writ of mandamus will lie only against a public authority, provided the public authority failed to perform its duty therefore resulting in the violation of rights of the people, that is the fundamental rights of the people. Under such a condition, the court can issue a writ of mandamus. So if a question comes, can a writ of mandamus issued against a private authority? No. If they just say private authority, no. A private authority which is performing a public duty, yes, then it may fall within the definition of state. So this is the understanding you should have. Here also the principle of locus standi does not apply. The third thing is writ of prohibition. Now writ of prohibition is where a higher court is trying to prohibit a lower court, usually the subordinate court, from entertaining cases where it does not have a jurisdiction. So this is basically what is called as writ of prohibition. So writ of prohibition is majorly preventive in character. It prevents a lower court from exceeding its jurisdiction. So here the principle of locus standi applies. But what if the lower court already exceeded its jurisdiction? So therefore there is an error. In that particular case, it has to be curated. It has to be rectified by a higher court. Under such a circumstances, the higher court will issue a writ of what is called as certiorari. That is why the writ of prohibition is preventive in nature, whereas the writ of certiorari is curative in nature. Okay, in both the cases, you will have to understand that the principle of locus standi applies. Okay, and then the last thing is writ of quo warranto, which we have just discussed. Here the principle of locus standi does not apply. So try to remember all those things. Okay, among all the 5 writs that I discussed, which do you think is at the highest level in protecting the personal liberty of an individual? Which writ among all the 5 things? Writ of habeas corpus. There should be any doubt in this. Okay. So what is the answer here? Option D. So today if you have listened the class well, try to go home and try to give 1 hour to 2 hours for whatever you have discussed. If you do like this for 5 days, I am quite sure you will be ready, but provided you touch upon and periodically revise, because I think it is still 50 days to go. If you just revise today and just leave it, then you may forget. Maybe on a regular basis, maybe once in 10 days, if you just give another 2-3 hours, once in 10 days, you will be ready. Provided you have already done your part. Just by sitting in the class, it is not possible. Okay, you already given the effort, that is important. Okay, come to the next question. Consider the following statement. Statement 1. The fundamental rights of the armed forces and other analogous forces may be restricted by an act of parliament. Can they be restricted? Yes, the part 3 of the constitution allows for it. Can it be restricted by the state legislature by making a law? Who can do this? It is only the power of the parliament for 2 reasons. One, article 33 of the constitution explicitly says that the parliament has the power, and the armed forces is an item in the union list. So therefore the state legislature has no power in this particular regard. So it can be done only by the parliament. But yes, they can be restricted, but they can be restricted only by way of a law. Under certain circumstances, the state legislature can also make laws to restrict the fundamental rights of the members of the armed forces. Not at all possible, no way. If any state is trying to do that, then what will happen? Constitutional breakdown may not happen. Yes, that's an extreme step possibility, but the center may not go to that particular extent. What they will do is they will challenge that particular law in the Supreme Court. Under which jurisdiction? Very good, under the original jurisdiction of the Supreme Court. And in determining the constitutional validity of this particular law, which doctrine will be applied by the Supreme Court? Which doctrine? Doctrine of pith and substance. Anyways, I will discuss about this when I take up the center-state relation topic. Okay. So what is the answer in this case? It is, which of the following are incorrect. So therefore it is option B. Come to the next question. Okay, so just go through this question. I wanted the answer from your question. Only students who got the understanding, they will be able to do this. Which of the following policies of the state is protected under the concept of equal protection of laws, which is given under Article 14 of the Constitution? So please solve it. Take a moment, solve it. Okay, so can we discuss the answer? Okay, first of all, tell me what is this concept idea of equal protection of law under Article 14? Does it mean that everybody has to be treated equally? It only means that the equals has to be treated equally. That is a way that you can ensure equality. That is a way that you can ensure equality in the longer run. Or in other words, that is a way that you can provide equal opportunities to all the people. So, equal protection of laws under Article 14 does not mean no discrimination. It allows for discrimination, but it should be a positive discrimination in the form of affirmative actions. Is that clear? Now, with that, which of the following is based on the principle of equal protection of laws? That means there can be some element of discrimination, but that is very much valid under the Constitution. Is there any discrimination when it comes to progressive taxation system? Yes, because people who earn more has to pay more. People who does not make certain level of income, they don't have to pay. So, it is not equally applied upon all the people, but it is equally applied to those people who are equally placed based on certain slabs. So, therefore, is it based on the principle of equal protection of laws? Yes, statement 1 is correct. Reservation in public employment, is it true? Yes, reservation in public employment, not everybody is given reservation, only certain categories of people are given the reservation. So, today who are eligible to get reservation under the Constitution? There is a reservation to the scheduled caste, scheduled tribe and the other backward caste, who are all considered to be the backward community. Apart from that, today the EWS reservation is also there, which is to the forward community. So, in all these cases reservation is allowed. So, therefore, yes, reservation is given, which is also based on the principle of what is called as equal protection of laws. Okay, anyways, the question that I am going to ask is not directly related to this particular question, but is there any difference in terms of the criteria as to how the reservation is given to the backward community and when it comes to economically weaker sections? So, can anyone tell me what is the difference in terms of the criteria as to how the reservation is given? For the backward community, when it comes to the scheduled caste, scheduled tribe and other backward caste, the underlying principle based on which a reservation is given is the social and the educational backwardness, not on economic criteria. Although there are certain economic limit, but that economic limit is just to arrive at the social and educational backwardness. That is not a primary criteria. But economically weaker sections, what is the basis on which a reservation is given? Purely on the economic basis. So, that is the difference between the economically weaker sections and the backward reservation. Anyways, the reservation in public employment is part of the concept of equal protection of laws. Criminal laws in our country, is it based on the principle of equal protection of laws? Does the punishment to the individuals vary based on their social and educational backwardness? Does the punishment to the individuals vary based on their economic well-being or economic disability? No, irrespective of their social and educational backwardness, irrespective of their economic well-being, everybody is awarded the same punishment for the punishment. So, the criminal laws is based on the principle of what is called as equal protection of laws, but yes, there is an exception, but that is not basically based on all those things. The exception is when it comes to juveniles. That is an entirely different concept, but it is not based on the principle of what is called as social and educational backwardness or on the economic backwardness of an individual. So, therefore, the criminal laws in our country is based on the principle of what? Based on the principle of equality before law, not on the principle of equal protection of law. But however, even to this there are some exceptions, not just the juveniles. We have seen exceptions of the presidents, governors and all those things under article. Which article gives exception to the president and the governors? Immunity that is given to the president and the governors. Which article? Very good, article 361 of the Constitution. But in general they are based on the principle of what? Based on the principle of equality before law, not on the principle of equal protection of law. Special rights of persons with disabilities. Yes, that is based on the principle of what is called as equal protection of laws. The disabled people have lot of reservations and lot of rights also that is given. So all these things are examples. What is the answer here? It is 1, 2, 1, 4 only. Come to the next question. Consider the following statements. A constitutional amendment can be violative of fundamental rights. Is that possible? Can a constitutional amendment can be done? Is it possible for the parliament to bring in a constitutional amendment, therefore to take away any of the fundamental rights? Yes. That's the question. When I say violative of the fundamental rights, they are taking away the fundamental rights. Is it possible? Yes or no? Of course, yes. As long as the fundamental right is not part of the basic structure. You should not have any doubt in this regard. Whenever such a question comes, you should think that the parliament has enacted the 44th Constitutional Amendment Act 1978, taken away the right to property, which was a fundamental right. So therefore, can a constitutional amendment take away a fundamental right? Yes, as long as it is not violating the basic structure in the constitution. Even if they violate the basic structure in the constitution, nothing can prevent the parliament from doing that. But then subsequently it can be struck down by the Supreme Court. But just to say, can they violate the fundamental right? Yes, as long as it is not part of the basic structure. So this is definitely true. A constitutional amendment can be challenged only on the grounds of violation of the basic structure of the constitution. Is that true? What is the only ground on which they can be challenged? Only on the violation of the basic structure. And what is basic structure? Is it well defined in the constitution? Is it well defined? It is nowhere defined in the constitution, or nowhere mentioned, not even mentioned in the constitution. Who innovated this particular doctrine? It is the Supreme Court of India in the 𝐂𝐭𝐡 and the Bagh case. So try to remember all those things. So as per the Supreme Court of India, what constitutes basic structure is that according to them, there are certain fundamental principles or foundational principles or values, which if they are tinkered or if they are taken away, that they would destroy the very fabric of the entire constitution. So therefore, they should always be part of the constitution. So the only authority to come to a conclusion that something would be part of the basic structure, who is authority? Not even the high courts, it is only the Supreme Court of India. The basic structure is well defined in the constitution. Is that true? It is nowhere defined in the constitution. Which of the statements given above are incorrect? What is the answer? It is 3 only. Okay, so just read this particular question. I wanted you to answer this question quickly. Of late, if you see, this is again part of your current affairs. Some states have already brought in law where they are reserving seats in private employment. Some states are contemplating of bringing a law with regarding reserving seats, reserving jobs only to the local residents of that particular state in private employment. So in that context, I wanted to ask you this particular question with regard to what is called as private employment. So just go through it very quickly. Okay, one student has asked me a question on schedule 1 and schedule 4. Don't worry, as I'll come, I'll explain all the schedules. I'll have questions for all the schedules. I'll discuss about the schedules also, but those areas will come in little later. So when I am coming to maybe in the last class, I'll discuss that in miscellaneous topics. I'll discuss about the amendment schedules in the form of questions. I'll discuss at that time. But since a student have asked, can anyone tell me what is there quickly in schedule 1 of the constitution? What are the information that is there in the schedule 1? It contains the name of all the states and the union territories in our country, and it also contains the territory of all the states and union territories. That is there in schedule 1. What is there about schedule? What is there in the schedule 4? Schedule 4 contains the information with regard to the number of seats that has been allocated to the Rajya Sabha, to each and every state and to the union territories. How many states in our country has got seats allocated in the Rajya Sabha? How many states do we have? presently? 28 or 29? 28. So do all the 28 states have representation in the Rajya Sabha? Now remember this as a general principle, each and every state should mandatorily have representation in the Rajya Sabha, and that is what will make our country a federal constitution, because the Rajya Sabha is representing the interest of the states. So therefore each and every state should have representation in the Rajya Sabha. That's a constitutional mandate. It can be less, it can be more, because the number of seats allocated to the Rajya Sabha is based on the principle of population. So therefore certain states can have more, certain states can have less, but states should have representation in the Rajya Sabha. But what about the union territories? Do the union territories have representation in the Rajya Sabha? Yes. Do they have representation? So if the Rajya Sabha representation is there for the union territories also, how many union territories have representation in the Rajya Sabha? Only 3 union territories, and it is not mandatory for the union territories to have representation. It is that some special status has been conferred upon some of the union territories, more or less giving them the status of a state, but they are not a full-fledged state. So what are the union territories that is having representation in the Rajya Sabha? Delhi, Puducherry and Jammu and Kashmir. These are the 3 union territories. But why there is no need for representation of union territories in the Rajya Sabha? Because the union territories are not in a federal relation with the center. The union territories are rather the territories of the union itself. So therefore there is no need for representation of the union territories. But because some union territories have been given special status, some representation has been given there. So in the future, even if the representation is taken away, that would not violate the constitutional principles. Okay. Okay, so come to this particular question. Consider the following statements. Reservation in private sector jobs to the residents of a state is violative of the fundamental right under Article 16. Reservation in private sector jobs to the residents of a state is violative of fundamental right under Article 16. For which you should know what is Article 16. So what is Article 16 is saying? No citizen shall be discriminated when it comes to employment under the state or public employment. So while a private employment cannot be considered to be what is called as a private employment. So therefore, if there is a reservation in private employment, it cannot be seen as violation of Article 16 per se. That is not possible, because Article 16 explicitly prohibits any form of discrimination, that is on the grounds of religion, race, caste, sex, place and birth. On the grounds of what? On the grounds of when it comes to only public employment, not in private employment. So therefore this article, this statement is not the right thing. So this is wrong. The Constitution empowers the Parliament to reserve jobs for the local residents of a state in public employment by law. Is it possible? Now, what is the general rule under Article 16? It is saying that there shall be no discrimination when it comes to public employment. But if you read the subclauses under Article 16, there are exceptions to that also. And can anyone specifically tell me which article is providing for this exception? Very good. Article 16 clause 3. Article 16 clause 3 allows the Parliament to make a law, and by that law they can allow reservation to the local residents to certain jobs. It can be a job related to the central government, it can be a job related to the state government, which is reserved only for the local residents. But who can make the law? Only the Parliament can make this law, not the state legislature. So to that extent, this particular statement is correct. So I have given an example also. We have seen one example is Public Employment Requirement as to Residence Act. Today a number of states, including Jammu and Kashmir and certain other states, they are reserving certain jobs to the local residents. But who can make this law? Only the Parliament, not the state legislature. And in fact, these jobs should be of subordinate post. When I say subordinate post, they should be either Group C or Group D post in the government, not to the higher services. Okay. So what is the answer here? Which of the statements given above are incorrect? It is one only is incorrect. Okay, now anyways, if a seat is reserved, some jobs are reserved in private employment for the local residents in a state, it cannot be challenged under Article 16. But can it be challenged under any of the other grounds? Can it be challenged under any of the other grounds? Under Article 14 they may be challenged because it talks about equality before law. But there also the state government may have a defense if they can prove that it is based on the principle of equal protection of laws. that the local residents are disadvantaged when it is compared with the outsiders. So therefore, they can make reasonable classifications. While it can be challenged, but the court has to decide. So some of these legislations are now pending in front of the courts. So the courts have to rule the constitutional validity, but definitely they are not violative of Article 16. So that understanding you should have. The court has struck down that. Anyways, I have not come across that particular development. So anyways, even if it has gone to the High Court, I think the decision has not come from the Supreme Court as far as I know. That matter was sub judice, I was aware of that. But whether the court has really struck down, I am not sure of this. And if it is struck down, do you know on what grounds it has been struck down? Article 19, right to freedom of profession, occupation. Let me check that. As far as my knowledge is concerned, it has not come from the Supreme Court of India, because whatever will come from the Supreme Court of India is the final thing. Okay, so right now all these matters are sub judice. So what is the answer? Anyways, now you should know that it is not violative of Article 16. Okay. Okay, come to the next thing. Advance directive was recently reported in the news. It is related to what? The concept of advance directive. How many of you have heard this advance directive? It is related to what? It is related to passive euthanasia in our country. It is not completely related to passive euthanasia. So today, do we have right to die? How many of you think we have right to die? Okay, so right to die is nothing, there is nothing exists as what is called as right to die. There is something which is called as right to die with dignity. So right to die and right to die with dignity are two different things. So there is no thing which is called as right to die. So if somebody attempts to die, then it would be considered to be suicide, which is a punishable offense. So but right to die with dignity is there, and right to die with dignity is for someone who is already in a permanent vegetative state. That means his death has already commenced because of the physical state that he is already in. It is only that his death is eased by certain procedures. So that is what is right to die with dignity. So therefore, what is allowed as per the court is right to die with dignity, which is also what is called as passive euthanasia, because today the courts in our country does not recognize active euthanasia. They recognize only what is called as passive euthanasia. A little advancement of that is what is called as advance directive. Because if you see most of the cases where euthanasia happens in our country, I am quite sure that you are all aware of what is euthanasia. Euthanasia is medically terminating the life of a patient who is terminally ill. That is what is euthanasia. An advancement that has happened over this passive euthanasia today in our country is the courts have recognized few years back in the NGO common cause case that the individuals who are undergoing medical treatment, suppose there is a possibility they may enter into coma because their situation is such, they are undergoing some operation, possibly that they may not be cured. Possibility of curing is also there, possibility of they may get into coma or some other problem. So even before all those things, they can write a living will to say that what kind of medical treatment has to be administered or whether passive euthanasia shall be administered, which shall be carried out in the future. So in advance they can write all those things and it can be executed. So which the court has recognized today. So that is basically what is called as advance directive. So therefore, what is advance directive? It is related to what? It is related to euthanasia. To be very specific, it is passive euthanasia. So the answer is option B. Anyways, I will discuss the other things also. Do we have right to privacy today in our country? Is there any advancement of this right to privacy in the recent past, the last 6 months or in the last 1 year with regard to right to privacy? Okay, I will discuss about that also, which is part of your current affairs. Last 10-15 questions are part of your current affairs. I will discuss it. Okay, legalizing the same-sex marriage. Do you have same-sex marriage which is recognized today? No. Do you have right to marry a person of one choice? Now, when I was discussing this right to marry a person of one choice, one student was asking me a question. Sir, on the one hand, you are saying that right to marry a person of one choice is a fundamental right, which is part of the right to privacy of an individual. But on the other hand, the court has struck down the right to marry a person of same sex. When you say right to marry a person of one choice, then he should also be free to marry a person of the same, anybody, which may include the same sex also. So how is it possible? Are they conflicting one another? Are they conflicting one another, these two judgments? How many of you think they are conflicting one another? Is it conflicting? It is not at all conflicting. Now try to understand, when you say that right to marry a person of one's choice, that is not an absolute right. In fact, no fundamental right in our country is an absolute right. It can come with certain reasonable restrictions according to the laws in our country. So within the laws, whatever is the valid marriage, in those areas you will have the right to marry a person of one choice. But even the right to privacy, which is a fundamental right under Article 21 of the Constitution, even your right to life and personal liberty is not an absolute right. Your right to life and personal liberty can be restricted. It can be restricted in accordance with what is called as due process of law. So therefore, the right to marry a person of one choice can also be restricted. So whatever is not restricted by the law, there you will have the right. Whatever is restricted by the law, there you will not have the right. So therefore, the courts do not recognize what is called as the right to same-sex marriage. Anyways, this is not there. Decriminalization of adultery, that is not in effect a fundamental right, but they have decriminalized this, which is again part of the right to privacy, to have sexual orientation of one's choice. But of course, that sexual orientation cannot extend to marry a person of one's choice. Now, one of the students was asking, anyways, sexual orientation is already allowed, what is the purpose of marrying? So, anyways, most of the objective is already met, so why they have to marry? So, but you will have to understand, once a person marries, then he is entitled to a lot of legal rights, which may not, he is entitled just because he is having the right to what is called a sexual orientation. A legal hire may be there, pension benefits might be there, a lot of legal recognition will come only when there is a marriage. So therefore, that the court have not gone to that extent, probably in the future they may go, but as of now that is not recognized. Okay. So this advance directive is related to what? It is related to euthanasia. Okay, so come to the next thing. The term doctrine of essentiality has sometimes been in use related to what? This is related to your religious rights, which is under Article 25 of the Constitution. So Article 25 of the Constitution gives us the right to profess, propagate, and also to practice the religion of our choice. But again, this right to freedom of religion is not an absolute right. So can anyone tell me what is the ground on which the right to freedom of religion can be restricted? On the grounds of public order, health, morality, and also on the grounds of violation of any of the other fundamental rights. So therefore, this also should be in your understanding. So today, do you think that the state can intervene in the religious rights of an individual? The state does make an intervention. Can you give me an example of intervention that is made by the state? Say for example, the Parliament has enacted a law which in fact prohibited what is called as instant triple talaq. So it's an intervention into the matters of religion. Parliament has enacted a law which prevented child marriage. In fact, child marriage was considered to be part of the Hindu religious practices. So it's an intervention into the religious practices. So therefore, yes, the state can intervene in the matters of religion. But what are the grounds on which they can intervene? On the grounds of public order, health, morality, or if the religious practice is violating any of the other fundamental rights. So that is the reason we also say that in case of India, we have what is called as positive secularism or an interventionist model. If the state is a mute spectator to what is happening within the religion, then it's a negative secularism. But in India, we did not follow that. We are following what is called as positive secularism. But however, the question is, to what extent there can be an intervention? Can the state intervene in every matters of religion? Then also it becomes problematic because religion is a very sensitive matter. So therefore, somewhere some buffer zone has to be there. Therefore, somewhere some line has to be there to what extent the state can intervene. To resolve this problem, the Supreme Court has innovated this particular doctrine of essentiality way back in 1954, I think in the Shirur Mud case, 52 or 54, you can just verify that, in Shirur Mud case. Now, what is this doctrine of essentiality? As per the Supreme Court, in every religion if you take, there are certain practices which are considered to be essential and certain practices which are non-essential, mutually exclusive. What is considered to be essential? If you take away those practices from the religion or those principles from the religion, the survival of the religion is not possible. So therefore, it is very inherent tenet of that particular religion. So such practices are called as essential practices. Apart from that, the other practices could be non-essential. Even if those practices are taken away, the religion can survive. That is non-essential practices. So therefore, whenever the state is intervening, the state is free to make an intervention in what areas? In non-essential areas, not in the essential areas. That is what this particular doctrine is saying. Okay, so this is what is doctrine of essentiality. So it is basically related to what? What is the answer here? The power of the higher courts to declare certain rituals and practices within the religion important. Is it the answer? Among the most important directive, the power of the parliament to make laws? No, it is power of the courts. And based on which the state can also make an intervention. But among the statement here, answer C is the right answer. Is it clear to all of you? Shall I proceed further? Shall I move forward? All right. Okay, come to the next question. Consider the following statements regarding the recent incidents of hate speech in our country. Okay, so before I go to this particular question, again part of the current affairs. So can anyone tell me what is hate speech? Is hate speech defined anywhere in the constitution or in any of the other laws in our country? Hate speech does not have a formal definition. So we do not have a formal definition. That is one of the biggest problem with regard to hate speech. But however, there are a number of provisions in our country which does penalize the hate speech or provide for punishment when it comes to hate speech without having a formal definition. That's one of the biggest problem that we have in tackling the issue of what is called as hate speech. So can anyone tell me based on your understanding, because the Law Commission of India has tried to define that, the Supreme Court of India has tried to define that, but we do not have a law which defines what is called as a hate speech. Can anyone tell me what in your understanding is a hate speech? Which creates, okay, which creates any form of hatred between two different sections of the society. It can be on any grounds. It can be on the grounds of religion, it can be on the grounds of language, region, sexual orientation. It can be on any grounds, but which is trying to create hatred between different sections of the society. Then such a speech can be considered to be what is called as hate speech. Now, to address this particular issue of hate speech, we do not have a single law, we do not have a standalone law, but we have number of provisions in different laws. I would say one such important law is the Indian Penal Code, which is right now renamed as the Bharatiya Nyaya Sanhita, which do have provisions related to what is called as hate speech. And then we have the Representation of People Act, which also deals with what is called as hate speech. So there are a number of provisions. Indian Police Act does have provisions related to what is called as hate speech. So there are a number of laws which is trying to deal with the issue of hate speech, providing different punishment. So with that, we just come to the question here. The Parliament has recently enacted a comprehensive law formally to deal with the issue of hate speech in our country. Is that true? What is that law? Somebody said yes. Can you tell me what is the law that is comprehensively made by the Parliament? So just now I said that there is no stand wrong. There are certain provisions in BNS which are also used by the law enforcement agencies to act against the incidents of hate speech in our society. Yes, not only in the BNS but also in the Representation of People Act and in certain other legislations. Okay, so this is definitely true. Which of the statements given above are incorrect? What is incorrect? One only is incorrect. Okay, recently the issue of forced and fraudulent religious conversion was brought to the notice of the Supreme Court in this context. Now today, number of states in our country are bringing in what is called as anti-conversion laws. Now in this regard, I have brought in this particular question. UPSC may not focus on any specific law, but UPSC wanted you to know the general provisions related to the anti-conversion laws and the constitutional framework surrounding the anti-conversion laws in our country. So now only the Parliament is empowered to make laws preventing the forced religious conversion in our country. Is it true? Okay, instead of only the Parliament, let me put the Parliament has the power to do this. Is it true? Can anyone tell me any law that is made by the Parliament related to the anti-conversion laws? So when you say instead of only Parliament, I am just making that the Parliament has the power. Can you just name one law which is made by the Parliament in this regard? In fact, the Parliament has not made any law in this regard, because already this matter has gone to the Supreme Court, and the court has said that religious conversion falls within the domain of law and order of a particular state. So because if there is a religious conversion, it is going to have an impact upon what? If there is a forced religious conversion, it will have an impact upon the law and order, and law and order is an item in which list? State list. So therefore, who has the power to regulate all those things? Only the state legislature and not the Parliament. So when I say only the Parliament, it is a wrong thing. That is wrong. That is wrong. It is the state legislatures who can do that, because it is not directly mentioned in any of the list, and therefore it is related to an item which is closely related to the state, that is law and order. It is a well settled principle by the courts that any form of conversion using force, fraud, inducement or allurement is a punishable offence and not part of the right to freedom of religion. Is it true? Is this second statement true? Is it a well settled principle by the courts that while on the one hand Article 25 of the Constitution gives us the right to freedom of conscience, which means we can convert from any religion, from one religion to another religion of our own conscience, based on our own belief and faith towards a particular religion. But what if the religious conversion is happening on the basis of force, fraud, that is a coercive force which is compelling a person to convert from one religion, or on the basis of fraud, inducement, allurement? Fraud means by giving fraudulent information, misleading the people. Inducement or allurement means giving some reward to the people for religious conversion. Can all these things considered to be valid, or the courts have already said that they are invalid? So it is it should be very clear in your mind that it is a well settled principle that an individual can convert from one religion to another religion based on his own conscience, but any other form of religious conversion, especially religious conversion by coercion, force, fraud, inducement or allurement, is not a valid conversion. That can also be punished by way of a law that is made by the concerned state legislature. In fact, how many of you heard about this Stanislaus case? Way back in 1977 itself, the Supreme Court has upheld this. If you don't remember the case, that is well and that is not an issue, but you remember the principle, okay? So this is definitely true. So this is what you'll have to keep it in your mind. So that means you should have an understanding, can the state legislature regulate the religious conversion? Yes, because right to freedom of religion is also not an absolute right, they can regulate it. But you should also keep it in your mind that usually under what circumstances the religious conversion can be considered to be invalid if it is having these principles, okay? So which of the statements given above are incorrect? What is the incorrect one? It is A only. Come to the next question. Right to equality is covered under. So this is again a very important thing. There's one question on right to equality, but they can talk about right to freedom, or they can talk about right against exploitation, religious rights, cultural and educational rights of minorities. Any of these things can be asked. Especially for the fundamental rights, try to remember all the articles, and also you should know under which theme certain fundamental right comes. That's a very important thing. UPSC is asking the question. So what is the answer in this case? Option C. Come to the next question. Which of the following are the objectives of the fundamental rights? To give directions to the state to make welfare policies? No, this is the objective of the DPSP, not the fundamental right. So this is wrong. Statement 2, to limit the powers of the state. Is it to limit the powers of the state? In fact, that's the primary objective of the fundamental rights, to prevent the state from functioning arbitrarily in nature. So this is definitely there. To empower the citizens against arbitrary action of the state? Yes, it is not only restricting the state. Whenever the state functions arbitrarily, the citizens can also go to the court. So therefore, that can also be done. To empower the citizen against arbitrary action of the state. So this is also true. So how many of the statements given above are correct? It is 2 only. So UPSC does ask one question from this theme also. Generally, whether the student is having an idea as to what is the objective or the essence of the fundamental rights. Which of the following the feature of the fundamental rights. Again, from the features of the fundamental rights, UPSC can ask you question, is it justiciable in nature? What do you mean by justiciable? Can be enforced in a court of law. Under which article they can go to the court of law? Article 32, not article 30. So what is article 30 related to? It is about the minority rights, which I will subsequently discuss. This year I feel that there can be question from the minorities, because recently the Supreme Court has conferred the status of the minority education institution to the Aligarh Muslim University. So therefore I will discuss that also subsequently, but that area is an important area which I will discuss. Which of the following are the features of the fundamental rights? Is it justiciable? Yes. Available only to the citizens, because some of the, in fact most of the fundamental rights are available to both citizens as well as the aliens. Only certain fundamental rights are available only to the citizens. So what are the fundamental rights restricted only to the citizens? This you should remember: article 15, 16, 19, 29 and 30. So sometimes I may not ask you the articles, but they can directly put the fundamental rights, and they can ask you which of the following fundamental rights are available to the citizens. And under article 19, how many fundamental rights are there? 6 or 7? 6. Presently it is only 6. Before the 44th Constitutional Amendment Act 1978, there was 7, including the right to property, but today only 6. So therefore they can ask you that also. They can put in right to association, right to freedom of movement, right to profession. They can ask you which of these rights are available only to the citizens. Okay. So available only to citizen is wrong. Enforced only against the state. While most of the fundamental rights are available only to, most of the fundamental rights are enforced only against the state, but to say that all the fundamental rights are enforced only against the state is not the right answer, because some of the fundamental rights can also be enforced against the private entities or private individuals as well. So can you give me an example of right enforced against the private individuals? Article, very good, article 15 clause 2, it can be enforced against the private individual as well. Article 15 clause 2 talks about that nobody shall be prevented from having access to any public places, be it by the state or by the private individuals. Is it only article 15 clause 2? Do you have any of the other fundamental rights? Article untouchability is there, article 17, article 23, article 24, right against exploitation, both child labor and trafficking. So all these things are available even against a private individual as well. Okay, so you have to understand, to say that the fundamental rights are available only against the state is not the right answer. Okay, but if they say most of the fundamental rights, maybe it is right, but fundamental rights only against the state, all the fundamental rights, is not a right thing. Choose the correct answer. What is the answer here? 1 only is the answer. Okay, just 5 more questions. If you have any questions, I will take it after that. I will solve 5 questions. Which of the fundamental rights are available only to the citizens? Just now we discussed. What is the answer? 15, 16, 19, 29 and 30. Maybe not the articles, they can ask you in the form of the rights also. So you should know what these rights are also. Okay. What is the major objective? The major objective of fundamental right is what? Limit the action of the state against a citizen. Because this concept of fundamental right is also related to the concept of what is called as limited government. Does the fundamental right limits the powers of the state? So therefore it ensures what is limited government, which is also related to the concept of what is called as constitutionalism. Which anyways, I will take up the political themes, I will discuss that in detail, but these concepts are interrelated to one another. So what is the answer here? Come to next question. Consider the following statements again regarding the fundamental rights. They are absolute in nature. Are they absolute? They are qualified in nature. They come with reasonable restrictions. In fact, you should also try to remember the reasonable restrictions for the fundamental rights, especially related to the right to freedom of speech and expression, or related to the other rights under article 19, right, your restrictions related to right to freedom of religion. So try to remember some of these things. At any time UPSC can ask you these things, especially at least remember right to freedom of speech and expression, which has got the largest restriction.
They can't be suspended under any circumstances. They can be suspended. In fact, during national emergency they can be suspended. During martial law also they can be taken away. So therefore, to say that they cannot be suspended is not the right thing. So when I take up the emergency topic, I will deal in detail about Article 358 and Article 359, where it talks about the suspension of the fundamental rights. They can't be amended. They can be amended. So that is also wrong. Choose the correct answer from the codes given below. So what is the answer? The correct answer is none. The major objective of fundamental right is to what again? I think the same question is repeated. Anyways, what is the answer? Limit the action of the state against the citizen. Okay, no issues. So come to the next question. A legislation. This is an UPSC question. A legislation which confers executive or the administrative authority an unguided or an uncontrolled discretionary power in the matters of application of law violates which one of the following articles in the Constitution? Whenever you talk about unguided or uncontrolled power, then that is giving arbitrary power in the hands of the state. And whenever they are given an arbitrary power, they can use this power discretionary, at their discretion. And whenever they use their power at their discretion, then it is going to violate the principle of equality. That is equality before law. So therefore, what is our answer here? It is Article 14 of the Constitution. So if you try to just remember the answer, you will make mistakes, because UPSC can reframe this question very well. But once you try to understand the concepts, you will not make the mistakes. Alright. So we are done with 50 questions. So just go through it very quickly for a couple of minutes. So we are almost at 4:15. I am planning to cover at least 75 questions today. So I will try to do that. But you can take a couple of minutes. If you have any questions, you can ask me the questions. Then I will proceed further with the remaining questions. There is no break officially. But if you want to go for a break, do not disturb others. You can just go and you can come back. Okay, but I will start after a couple of minutes. Any questions from the online students? Sit there and ask. Later you can ask. From there you can ask. There's, Okay, so please listen. The writ of quo warranto is not applicable in case of ministerial post. Ministerial does not mean ministers. So you should have an understanding of what is ministerial post. Ministerial post is a word that was introduced as a part of the Britishers, and it is a colonial legacy even today that we use. Ministerial post means lower level post. Ministerial post means or clerical post. People who are engaged in part of what is called as a clerical post. So therefore, a writ of quo warranto cannot be entertained by the courts for the clerical post, but for important statutory post, important constitutional post, where the court may look into the qualification of an individual. Suppose if somebody is appointed as a clerk in an office, the Supreme Court cannot sit on this particular petition to see whether he is having the qualification to occupy this particular office or not. Somebody appointed as the president, somebody is appointed as a chief minister, prime minister, statutory positions, chief election commissioner, against them, because their actions have a lot of implications upon the general public. So therefore, ministerial is not equivalent to that of minister. Ministerial means clerical post. Okay. All right. So we'll move to the next question. Can I have a little bit of energy from your side? Can we move to the next question? Okay. Let's move to the next question. Which of the following fundamental rights are not available to an alien? That means basically which is again available only to the citizen. Right to life and liberty, is it available to an alien? Article 21, is it available? Yes. So therefore they are asking which is not available. So when you say which is not available, so first let us see what are all available. So right to life and liberty is available to an alien. So this may not be the answer. Freedom of movement. So this is not available to an alien. This is only to a citizen. So therefore, yes, this shall be, it should be part of our answer. Equal opportunity in matters of public employment. This is not available to an alien. So therefore, yes, this should be part of our answer. Right to freedom of speech and expression, not available to an alien under Article 19. No discrimination by the state on the grounds of religion, race, caste, sex, place of birth. Which article is this? Article 15 of the Constitution. Is it available to the alien? It is not available to the alien. So therefore, yes, this is also not available. So therefore, what is the answer in this case? It is 2, 3, 4 and 5. So whatever is Article 15, 16, 19, 29 and 30, remember these articles also, what those articles say. That is also very important. So what is the answer here? It is option D. Which of the following rights are implied under Article 21 of the Constitution? Today a lot of rights the Supreme Court has told implied under Article 21. Some of the questions I put at least couple of current affairs here, because recently the Supreme Court has said certain rights implied under Article 21. So whenever the Supreme Court confers a judgment, UPSC usually asks such question. Right to privacy was asked by UPSC after the Supreme Court judgment. Right to marry a person of one choice was asked by UPSC after the Supreme Court judgment. So similarly, this year also UPSC, this year I think last year 2024, the Supreme Court has given a judgment. Can anyone tell me what was conferred by the Supreme Court, which is implied under Article 21 of the Constitution? Right to not right to clean environment was said long back. So what is that? Right to protection against the effect of the climate change. But that was implied not only under Article 21 but also under another article. So what is that article? Both Article 21 and Article 14 of the Constitution. There is a separate question on that, I will discuss that, but first let me complete this particular area. So right to privacy, is it a fundamental right under Article 21? Yes, the Supreme Court has already declared that. In which case the Supreme Court declared that? In Puttaswamy case in 2017. Right to marry a person of one's choice. But that does not give you the right to marry a person of same sex. But whatever is allowed under the law, yes, you have a right to marry a person of your choice, which was held by the Supreme Court in 2018 in Hadia case. Case is not very important, but just try to remember the rights. Right to travel abroad and to come back. Is it a right? Yes, under Article 21 of the Constitution, the Supreme Court has held it to be a fundamental right in the Maneka Gandhi case. So this is also true. But what about right to move anywhere within the territory of India? That is Article 19. Right to move outside India, abroad, and to come back is under Article 21. So this is part of your right to personal liberty, whereas right to move freely within the territory of India is under Article 19. Right to strike, there is no such fundamental right, it is a legal right. Right to speedy trial, yes, way back in 1979 itself the Supreme Court has recognized this, and subsequently in other cases also. Choose the correct answer from the codes given below. What is the answer? It is 1, 2, 3 and 5 only. Which of the following constitutional amendment, UPSC these days is also asking questions like that. So let me see anyone is getting the right answer for this particular question and who is getting the right answer for this particular question. And it is not just the answer, an explanation also. Then only I will accept, otherwise I will not accept. Okay, so tell me what is the answer in this case. Which of the following amendments is related to the fundamental rights? Which of the following amendment is related to the fundamental rights? First constitutional amendment, is it related to fundamental right? Yes. If you say first constitutional amendment not related to the fundamental right, it is the most important thing related to the fundamental rights. Article 31A was inserted, Article 31B was inserted, Article 31A, Article 31B. I will discuss about all those things. I have given a question related to current affairs. because of late there is one important issue that is happening is with regard to the right to property. A lot of issues, and also the conflict between the fundamental rights and DPSP as to how to the courts have to look into these conflicts. These are all current affairs issues, but questions are coming. We will discuss about that in detail when I take up the questions. Is there any other article related to the first Constitutional Amendment Act? Article 15 clause 4. In fact, Article 15 clause 4, which is paving way for the reservation in the educational institutions for the backward classes, was inserted by the first Constitutional Amendment Act. Any other amendment? Article 19 clause 1, or in fact I would say clause 2, because Article 19 clause 1 subclause A talks about the right to freedom of speech and expression. But in the original constitution, how many restrictions are there to the right to freedom of speech and expression today? How many grounds on which the right to freedom of speech and expression can be restricted? How many grounds? Very good, 8 grounds. But in the original constitution, there are not 8 grounds. I think there are only 3 to 4 grounds. In fact, one important ground that was later added by the first Constitutional Amendment Act was public order. The right to freedom of speech and expression can be restricted on the grounds of public order. So, to that extent, Article 19 clause 2 was also inserted. You don't have to remember all these articles, but you should know the first Constitutional Amendment Act is related to fundamental right. So, definitely it is there. What about 24th Constitutional Amendment Act? What was inserted? Article 13 clause 4 was inserted. So, Article 13 was amended, and explicitly they said that under Article 13 of the Constitution, the law does not include a constitutional amendment. So, what is included under law is only an ordinary law and not a constitutional amendment. So, to that extent, Article 13 clause 4 was inserted. So, this is also true. What about 25th Constitutional Amendment Act? Very, very important this year for your examination, because a lot of current issues happening in relation to that particular article, which was inserted by the 25th Constitutional Amendment Act. Which article? No, President has to mandatorily give the assent by 24th Constitutional Amendment Act is true, but does it have a relation to fundamental right is the question here. So, the question is related to the fundamental rights. So, here the whatever you are talking about is 24th Constitutional Amendment Act. Here the 25th Constitutional Amendment Act is Article 31C was inserted. So, it has also a relation to the fundamental rights. So, what is Article 31C? I will discuss this also because it is also part of current affairs. Okay, I will discuss this. 44th Constitutional Amendment Act, does it have a relation? Yes. What is 44th Constitutional Amendment Act? Article 19 clause 1 subclause F has been completely repealed. It has been taken away, and what happened to Article 31, which was placed as Article 300A in the Constitution? Both the things have changed by the 44th Constitutional Amendment Act. 103rd Constitutional Amendment Act, which amended which article in the Constitution? It inserted Article 15 clause 6 and Article 16 clause 6, which paved way for the EWS reservation. So, therefore, what is the answer? All of the above. So, this is also a way UPSC is asking the question. Okay. So, sometimes they can ask you, but with related to the fundamental right, I have tried to cover all the things. With regard to the other amendments also, I will try to cover. And amendment is a separate topic also. There also I will give some questions. So, what is the answer here? Option D. Okay, come to the next question. What does it mean by protection against ex post facto legislations guaranteed under Article 20 of the Constitution? Article 20 of the Constitution does not allow for what is called as ex post facto legislation. So, what is true about that? Protection against giving retrospective effect to any criminal law only. Protection against giving retrospective effect to any civil law only. Both protection against giving retrospective effect to any criminal and civil laws, none of the above. What is the answer? Now, try to remember that under Article 20 of the Constitution, it categorically prevents ex post facto legislation only in criminal laws, not in case of the civil laws. Okay. So, but what does it mean by ex post facto legislation? What does it mean by ex post facto criminal legislation? Ex post facto criminal legislations or ex post facto law means making a law today and giving it a retrospective effect or giving it an effect from a back date. That is not possible when it comes to what is called as a criminal law. But can a civil law be given a retrospective effect? Yes, there is no such restriction. But for a criminal law, there is a restriction. But what in case if we make a law today, it is very clear that we cannot give a retrospective effect. But already there is a law. But that law is amended and they are increasing the punishment. Can the increased punishment be given retrospective effect? They are not making a new law, the law is already there and they are making an amendment to the punishment only. And can they give the amendment the retrospective effect? That is also not possible. But can they decrease the punishment and give retrospective effect? That is not prohibited under the constitution. So whenever it is going to affect the rights of the people, when you increase the punishment, it is affecting the rights. So therefore, you cannot give what is called as a retrospective effect. Is that clear? So what is the answer here? It is Article 20. The answer is option A. In addition to this, what are the other rights that is guaranteed under Article 20? One is no ex post facto criminal legislation. There shall be no double jeopardy. That means nobody can be punished twice for the commission of an offence in a single point of time. If he is punished for an offence, then he cannot be punished for the same offence. But if he commits an offence in a different point in time, then he can be punished, but not for the same punishment. And then he also have protection with regard to what is called as no self-incriminating evidence. That means an individual cannot be punished to give oral or documentary evidence against himself. That doesn't mean that he will not cooperate with the investigation. He has to cooperate, but he cannot be forced to admit the guilt. That is not possible. If he is forced to admit the guilt, what will happen then? That is not admissible as an evidence in a court of law, which is basically the violation of right under Article 20 of the Constitution. So therefore, that is not accepted as an evidence. So whatever he says, that has to be corroborated with sufficient material evidence. Otherwise, it is not admissible as an evidence. But is a confession made in front of a judge, is it accepted? That is admissible as in a court of law. Okay. Now in this regard, now let us try to understand this particular thing. Suppose let us assume a husband and wife is there. The husband or the wife, they are spying on the other, and without the knowledge of another person, they are collecting some evidence. Maybe they are trying to hack their WhatsApp or the email, whatever it is. And this evidence is produced in a court of law. And even if it is adverse against a party, will this be admissible as an evidence in a court of law? Yes or no? And can that be a ground for divorce, or can that be a ground for prosecution? Will it be admissible as an evidence in a court of law where an evidence is collected without the knowledge of another person? How many of you think yes? It will not be admissible as an evidence in a court of law. So therefore, because recently the judgment was passed by the Madras High Court that right to privacy includes what is called as right to spousal privacy. So the right to spousal privacy is part of the fundamental right of an individual. So therefore, if an evidence is given without the knowledge of another person, that is not accepted as an evidence in a court of law, though no remedy, even if you can prove something. So it is only an unnecessary burden. At least the individual will not be aware of what is happening. So therefore, the court said the very basis of the relationship depends upon the trust of the partners. So therefore, this is not the way that you will be able to prove, and therefore the right of the spousal privacy was considered to be part of the fundamental right, which anyways I will discuss at later stage because this is also part of your current affairs. So what is the answer here? Okay, come to the next question, that is Article 55. In essence, what is due process of law means? This is part of your UPSC question. What does due process of law means? It is part of natural justice. So for example, you will have to understand very quickly the difference between the procedure established by law and due process of law. Now what is procedure established by law? Procedure established by law, because for that you will have to just go to Article 21 of the Constitution. What is Article 21 of the Constitution is saying? Nobody shall be deprived of their right to life and liberty except in accordance with the procedure established by law. Even today it is reading as procedure established by law. but the Supreme Court in the Mana Gandhi case said that the procedure established by law will have the same meaning as that of what is called as due process of law. So what is the difference between procedure established by law and due process of law? In procedure established by law, the court was constrained in seeing whether a particular action of the state is it in violation of the right to life and liberty under Article 21, where it can only verify whether the procedure that is laid down in the law has been followed or not. It does not look into the subject matter of the law, but what the judiciary can see, whatever is the procedure that is laid down, whether it has been followed properly or not. Say for example, if the law says an individual can be arrested, and if the law says an individual can be arrested only in case of cognizable offence, not in case of non-cognizable offence. So the court will see whether it is a cognizable offence or not, where an individual has been arrested. So this is what is procedure established by law. But however, on the other hand, the due process of law gives the power to the judiciary in seeing whether the right to life and liberty of an individual has been deprived. What it can verify, it will not only verify whether the procedure has been followed, but whether the procedure that is laid down in the law, that is the subject matter of that particular law, itself is just, itself is fair in the first place. And when the court will come to a conclusion that the procedure in the law is just and fair, only when it follows the principle of natural justice. Say for example, if the law says an individual can be arrested in case of cognizable offence, but the law does not say that the individual should be informed of the grounds of arrest. If the law says, let us assume two laws is there, one law is saying that the individual can be arrested in case of cognizable offence, and at the time of arrest he should also be informed of the grounds of arrest, therefore he can make a representation. There is another law which is saying an individual can be arrested in case of cognizable offence without giving him the reason. Therefore, in the first case, if the procedure established by law is to be applied in both the cases, both the law would be considered to be valid law as long as the procedure is followed. But when you apply the due process of law, one law will not be considered to be valid. Which law will not be considered to be valid? Where a law is saying an individual can be arrested without giving the reasons, because the procedure is unjust. So therefore, when you have to apply the principle of due process of law, the law should bring in what is called as a principle of natural justice. So therefore, both the parties are having sound enough reasons and the law is fairly treating everybody. That is basically what is called as a principle of natural justice. And most importantly, when you talk of due process of law, while in procedure established by law, the procedure established by law gives a power to the judiciary only to judicially review the executive action, not the law, not the legislative action. But whereas the due process of law gives a power to the judiciary to judicially review both the executive action as well as the legislative action. Is that clear to all of you? So in crux, what is due process of law? That whether the principle of natural justice is followed or not, or in other words, whether the law provides for a just procedure, whether the law is fair in the first place. So this is the answer. Come to the next question. According to the Constitution of India, the central government has the duty to protect the states from internal disturbances. Is that true? Yes. Which article entrusts this responsibility upon the center? Which article? Very good. Article 355 of the Constitution. In fact, this is also part of the current affairs. This is also part of the current affairs. Why? Because the Tamil Nadu state legislature has passed a resolution that the center has to protect the state. From whom? From the governor of Tamil Nadu. The governor of Tamil Nadu is not approving any of the bills that is passed. So therefore, normally it is for the center to protect the states from any form of disturbance, but one of the state is asking the center, come and protect, because you have a responsibility to protect us from the governor of Tamil Nadu. So therefore, that was there in the news. So this is again relevant to the current affairs. Okay, so this is true. Statement 2. The Constitution of India exempts the state from providing legal counsel to any person being held for preventive detention. Is it true? The Constitution of India exempts the states from providing legal counsel to a person being held in preventive detention. This is very important. Does it exempt? Now, there are two things that you have to remember when it talks of preventive detention. I said in case of preventive detention, the general rule is the individual should be informed of the grounds of detention, but that doesn't mean that he should be given a legal counsel. because there is no need for any legal counsel because he has not made any offence in the first place. But he should be informed of the grounds of arrest. But there is no need for what is called as providing a legal counsel. So now is this statement true? Yes. So this is true in case of preventive detention. But whereas in case of punitive detention, he should be allowed to consult a legal counsel of his choice. According to the Prevention of Terrorism Act 2002, confession of the accused before a police can be used as an evidence. Is it true? In fact, under Article 20 of the Constitution, we have seen that there is no self-incriminating evidence, but this law was violative of that, and that is why subsequently this law was repealed. But at the time this was true, that according to the Prevention of Terrorism Act, confession of the accused before the police officer of certain rank, I think SP level officers, whatever confession that is made, it was admissible as an evidence. Okay, so it is factually true, but what it is saying, confession before the accused cannot be, so therefore it is wrong. Okay, so it was admissible as an evidence, but subsequently because of the criticism to this law, now it has been repealed. Okay, so what is the answer? How many of the statements given above are correct? Only 2. Right to privacy is protected as an intrinsic part of right to life and liberty. Which of the following in the Constitution of India correctly and appropriately imply the above statement? What is the answer here? It is Article 21 in Part 3 of the Constitution. Which of the following are envisaged by right against exploitation in the Constitution of India? Again, the same thing that I said. So, which of the following? Right against exploitation, 2 important articles. Article 23, which talks about provision of trafficking in human being and beggar and other similar forms of forced labor. Article 24 is about child labor. So, what is the answer? This and the child labor. What about abolition of untouchability? Which article? Article 17, which is part of equality. Article 17, sorry. And protection of interest of minorities. Protection of interest of minorities in general, Article 29 and Article 30, but the Article 30 specifically for minorities. I will discuss that at a little later stage. So, what is the answer here? What is 1 and 4 only. Which of the following categories of fundamental rights incorporates protection against untouchability as a form of discrimination? Which one? Which one? Right to equality. This is a very, very important thing. UPSC can ask this question. Okay. Which of the following rights is are part of right to freedom under Part 3 of the Constitution? That is, right to freedom in Part 3 of the Constitution is from which article? Article 19 to Article 22. So, just see that. Right to free speech and expression? Yes. Right against self-incrimination? Yes. Right to education? Article 21A. Yes, yes, it is there. Right against arbitrary detention? Right against arbitrary detention is there in Article 22 as well as part of Article 21. Okay, so definitely there. So, what is the answer here? All of the above. So, this is again a UPSC question, is trying to define the term state, general political science definition of state, not state under Article 3 under Article 12 of the Constitution. Unless and until they ask definition of state under Article 12, you should not have that understanding. Okay. So, what is the answer here? In fact, as per the political science, state should have 4 entities. It should satisfy 4 conditions, 4 criteria. It should have a people of its own, a community of people. It should have its own territory, political territory. It should have a government, any form of government, not necessarily a democratic government, any form of government of its own. And then the state should be sovereign in nature, so free from external control. So, you just try to see where it is all satisfying. What is the most appropriate of all these things? So, sometimes if more answers are seeing like correct, you should go for the most appropriate thing. Okay, there is one question: does the district judiciary come under the definition of state under Article 12? It is not about only the district judiciary. In general, do the judiciary fall within the definition of state under Article 12? It is not explicitly mentioned in the constitution. What is explicitly mentioned in the constitution as a state? It includes the government of India, government of the states, Parliament of India, state legislature. Then it includes the local authorities and other authorities within the territory of India, for which the Supreme Court has given a definition. What can be seen as the other authorities falling within the definition of state? But there is no explicit mention of whether the judiciary will fall within the definition of state. So therefore, this matter has gone to the court, and the court has categorically said the judiciary will not fall within the definition of state when they perform judicial functions. Any type of judiciary, be it Supreme Court, High Court or the subordinate court, when they perform judicial function, that means whenever they deliver a judgment in a particular case, that itself cannot be seen. The act of passing a judgment itself cannot be seen as a violation of the rights. But when they perform administrative functions like recruitment of the officers to the court, giving leaves to the judges, these are all administrative functions. When they perform the administrative function, any type of judiciary, any hierarchy of judiciary, they will fall within the definition of state. Okay. Okay, what is the difference between a cognizable and a non-cognizable offence? Cognizable offence is a type of offence where the police can arrest without a warrant. Just an individual go and makes a complaint to the police station, based on the complaint itself the police can arrest, because these are all in general considered to be very serious in nature. So the individual has to be the alleged person, or the accused has to be immediately constrained. So therefore, he will not do away with the evidences. But non-cognizable offences are offences which are not very serious in nature. So therefore, the police will take the complaint and they will produce a complaint in front of a magistrate. If the magistrate issues an arrest warrant, based on the warrant only the individual can be arrested. Okay, so this is what basically you have to understand. And what is a cognizable offence and non-cognizable offence is all given in the law. It is given in the procedural laws. So based on that, the police will take the action. Okay, so what is the answer here? The right answer is option A, as per UPSC also, because it satisfies all the things. A community of people is here, a group of people is there, permanently occupying a definite territory. So people, territory, independent of external control, which means sovereign in nature, and possessing an organized government. If you read the other statement, some of the things are not very clear if you go through the other things. So the most appropriate thing is option A. With reference to India, consider the following statements. 1. The judicial custody of an accused is the custody of the concerned. The judicial custody means an accused is in the custody of the concerned magistrate, and such accused is locked up in police station, not in jail. Again in UPSC question, for which you will have to understand the concept of punitive detention. Let me just quickly explain for the students who have not attended my class already. Please listen to that. So Article 22 of the Constitution allows for what is called as punitive detention. What is punitive detention? Punitive detention is a detention by way of a trial, but trial may go on for years. It is not that today an individual is arrested by the police, tomorrow the trial will be completed and then the third day he will be put in the jail. That is not possible. Sometimes the trial may go on for 10 years, 15 years, especially in criminal cases. Now till the time the trial is completed, the individual cannot be kept in jail. Why? Because what ultimately in the end of the trial he is found not guilty. Therefore, you cannot punish an individual unless and until he is proved guilty. That is a general rule in our country. But what happens is, normally, suppose let us assume A goes and makes a complaint against B to the police station. So A makes a complaint in the police station against whom? Against the B, and B has made a cognizable offence. Let us assume B has committed murder, which is a cognizable offence. So therefore, what happens is, immediately the police will arrest B. So police is going to arrest B. So at the time of arrest, B has certain rights as per Article 22 of the Constitution. What are the rights that B will have? He should be informed of the grounds of arrest, he should be allowed to consult a legal practitioner, and he should be produced before the nearest magistrate within 24 hours. So the immediate thing is, so for the first 24 hours, he is in what is called as lockup. When I say lockup, it is usually denoting he is in police custody. So first 24 hours where B is kept in police custody, but after within 24 hours he has to be produced before whom? The nearest magistrate. Now why he is produced before the nearest magistrate? Because the police will make a plea that we wanted to make further investigation, because this 24 hours is not sufficient for the police to make an investigation on this particular matter. So therefore they will produce B in front of the magistrate. Normally the magistrate will remand him. So normally he or she is remanded for 15 days, which may be extended further also. I think as per the new law they can be extended up to 90 days, but normally usually they are remanded initially for 15 days. Why do you think that they are kept in remand? So during this remand, the word remand or 15 days, whatever I talked about, this is usually called as judicial custody. He is still not a convict, he is still an accused person, but he is kept under judicial custody. What is the purpose of keeping him in judicial custody? So that this 15 days time is good enough for the police to complete the investigation on the charge or the kind of complaint that is made against B. So while this is police custody, this is judicial custody. Now what is the difference does it make between police custody and judicial custody? Judicial custody will prevent B from any police harassment. So while the police is allowed to investigate, but the police can investigate only with the permission of the judge. So therefore he is under the supervision of the judge. So therefore he is prevented from any form of harassment. After 15 days, probably if the police is not able to complete the investigation, the police might again seek an extension, and it is at the discretion of the judge. He may provide for an extension, he may not also. But suppose if the investigation is over, then the police will file a charge sheet, then normally the individual will be released on bail. Then he will be free on condition he will be released on bail, and he will come for the trial, and the trial will then go on. So whenever the trial will be completed, after the trial is completed, if he is found guilty, what will happen? He will be sent to jail and the punishment will be given, he will be sent to jail. But if he is proved not guilty or innocent, or if he is acquitted from the court, then he will be a free man. So this is how the trial happens. Okay, so based on this information, now come here. Judicial custody means the accused is in the custody of the concerned magistrate. Is it true? Yes. And such accused is locked up in the police station, not in jail. What about the second part of the statement? Is it true? So judicial custody means where he will be there. He will be in the judicial custody. He will be in jail under the judicial custody, under the supervision of the judge, not in police lockup. So therefore this particular statement is wrong. It's partially right, partially wrong. So therefore it is wrong. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Is it true? He is allowed to interrogate, but only with the permission of the court. Okay, so therefore this is true. So which of the statements given above are correct? What is the answer? 1 only. So what is correct? It is 2 only. Come to the next question. Consider the following statements with respect to the Bharat Ratna and Padma awards. Again an UPSC question, which is in Article 18 of the Constitution. What does Article 18 of the Constitution prohibits? Prohibits conferring of titles by the state. Suppose if two private individuals, if they confer title upon another person, that is no way violation of the fundamental right. The state shall not confer any title upon the citizens. So that is except for the exception of academic and military titles. So Bharat Ratna and the Padma awards are titles under Article 18 clause 1 of the Constitution. This the Supreme Court has clearly categorized that the awards like the Padma awards, which includes Bharat Ratna, Padma Bhushan, these are all considered to be awards and not considered to be what is called as titles, because they consider titles as something which is passed on, and titles is something which creates a social distinction, artificial social distinction, but not the awards. So therefore awards are allowed but not the titles. So to say these to be titles, it's a wrong thing. So this is not the right answer. Padma awards which were instituted in the year 1954 were suspended only once. As per the internet sources, it has been, as per the government sources also, it has been suspended twice in the history of India, not once. So this is also factually wrong. The number of Bharat Ratna awards is restricted to a maximum of 5 in a year. It is restricted again by the government sources to a maximum of 3 in a year. Okay, so therefore this is also wrong and not 5. And who decides as to who is to be given all these awards? Any idea? It is a Prime Minister, or which is basically done by the Prime Minister's office. Upon the approval of the cabinet, all these things are decided. So what is the answer here? Which of the following is wrong? Correct? Not correct? Okay, so all of them. Okay, so what is the position of right to property in India? So for which you will have to understand as to what is Article 300A of the Constitution talks about. Article 300A talks about no person shall be deprived of right to property except in accordance with law. That means although this right to property is guaranteed in the Constitution, what is the way by which it can get executed? It can be executed only by a way of a law that is made by the Parliament. So therefore, it also becomes what is called as a legal right. But now the question is whether this right is available only to the citizen or to the aliens also. And that question is also answered because Article 300A is saying no person shall be deprived of their right to property. They are not using the word no citizen shall be deprived of the right to property. So therefore, it is available to whom? It is available to both aliens as well as the citizens. And basically, it is what type of right? Legal right. So fundamental right is definitely not there. Legal right available only to citizen is not there. Legal right available to any person. Okay, so the answer is option B. With reference to the writs issued by the courts in India, consider the following statements. Mandamus. What is mandamus? We discussed this. We command. Whenever any public authority fail to perform their duty, the court is giving a direction to perform that particular duty. Mandamus will not lie against a private organization unless it is entrusted with a public duty. Is it true? Yes. I said mandamus will not lie against a private authority. But when the private authority is performing a public duty, they may fall within the definition of state. So what are the grounds on which the private authority may fall within the definition of state, or any authority which is not explicitly mentioned in Article 12 may fall within the definition of state? It depends upon number of characters, number of conditions, especially the nature of public duties and the share capital of the government control over those organizations. So these are all some of the factors. Okay. So this is definitely there. So this is true. Mandamus will not lie against a company even though it may be a government company. So mandamus will lie against a government company. In fact, most of the PSUs mandamus may lie. Okay. So because will not lie is a wrong thing. Any public minded person can be a petitioner to move to the court to obtain the writ of quo warranto. Is it true? Yes, the principle of locus standi does not apply in case of writ of quo warranto. So which of the statements given above are correct? It is option C, or okay, sorry, it is C. It is 1 and 3 only. Alright, so come to the next question very quickly. I'll try to cover till 75 very quickly, another 10 minutes. Which of the following fundamental right is the heart and soul of the Constitution? Article 32. Can anyone tell me why Dr. B.R. Ambedkar called this to be the heart and soul of the Constitution? Because unless and until this right is there, you cannot enforce any of the other fundamental rights. Other fundamental right would become merely a theoretical thing, because when it is violated, then there is no remedy. Which protects the other fundamental rights is only Article 32 of the Constitution. Consider the following. Religious rights are protected under the Constitution or not absolute. Is it true? Yes, because what is the grounds on which they can be restricted? Public order, health, morality, and also on the grounds of violation of other fundamental rights. State cannot intervene in the matters of religion in our country. So of course they can, because we follow positive secularism. Any person has a right to convert from one religion to another religion on his own conscience. Yes, this is true, but religious conversion cannot happen on the grounds of force, fraud, inducement, or allurement. Religion can be the basis of imposing tax in our country. Religion is not the basis on which a tax can be imposed, and not only the religion can be a basis of imposing tax, religion cannot be the basis, or the tax money can also not be used to promote any religion. But can they be used to any of the other secular activities associated with the religion? can the money be spent on the secular activities? Say for example, Kumbh Mela festival was there. Can the government spend the tax money collected for the better infrastructure, health facilities, transport of the people going for this Mela? Is it possible? Yes. The money can be spent for the secular activities. Secular activities means not associated with the religion, but for the other activities they can spend it, but not directly to promote any religion. Directly to promote any religion, say for example, they cannot directly fund money to construct a temple probably, but other secular activities or any religious institution, but other secular activities they can do. So this is also true, can be the basis, okay, can be the basis of imposing tax. So what is the answer here? What is the answer? Incorrect, it is, what are the options incorrect? 2 and 4 only. Okay, so come to the next thing. The minority rights guaranteed under Article 30 of the Constitution is based on what? Minorities is a topic which I will discuss tomorrow, but try to answer this particular question. What is the ground on which the minority rights are protected under Article 30? What are the grounds? Religion and linguistic minorities are only 2 categories of minorities. But is the word minority defined in the Constitution? The word minority is nowhere defined. It is only based on the interpretation of the Supreme Court. In the next class, when I go to the current affairs part question, separately I have given some 10 questions. Now there I will discuss this in detail, because this year it is very important. As I already said, that the Supreme Court has restored the minority status of Al-Azhar Muslim University. So therefore I will discuss that particular area a little detail. But right now, what is the ground on which it can be done? On the grounds of religion and language. Answer is 1 and 2 only. Consider the following. So what are the grounds on which the religious rights can be restricted in our country? All the above. Public order, health, morality. If there is an addition of fundamental rights also, that is also true. So here it is all of them. Which article of the Constitution of India says? Basically, which article prohibits child labor in our country? Article 24, both against the state as well as the private individuals. Okay. The Constitution of India recognizes what type of minorities under Article 30? Religious and linguistic minorities. Okay, this is a very good question. Have a look into this particular question. Consider the following statements. No one can be compelled to sing national anthem since. They are giving some reasons. Since. But do you think that is it true that nobody can be compelled to sing national anthem? Okay, since. Statement 1. It will be violative of the right to freedom of speech and expression. If somebody is compelled to sing national anthem, do you think it is violative of your right to freedom of speech and expression? The Supreme Court has already clarified that right to freedom of speech and expression includes right to remain silent. So therefore, no one can be compelled to do anything, including singing what is called as a national anthem. As long as somebody is not disrespecting the national anthem, that is sufficient enough. Because there is also a law which allows individual to be punished if they disrespect the national anthem. That is the Insults to the National Honours Act. So as per that, if somebody is disrespecting the national anthem, then they can be punished. But somebody respecting the national anthem, they are standing, they are not moving, respecting the national anthem, but not singing it is not a punishable offence. Okay. The Supreme Court has made it very clear in the Bijo Emmanuel case. So if you are not remembering the case, that is not important, but try to remember it. That it will be violative of the right to freedom of speech and expression, wherein in this particular case, the Supreme Court categorically said the right to freedom of speech and expression includes the right to remain silent. In fact, if you see the background of this particular case, some of the school students were expelled from the school. For what reason they were expelled from the school? Because they are not singing the national anthem. And why they are not singing the national anthem? Because that went against the religious belief. So therefore, not to violate the religious belief, these students belonging to certain religious community, they are not singing the national anthem. And then the school has expelled these students. And subsequently, they have gone to the court, wherein the Supreme Court said that right to remain silent is part of the right to freedom of speech and expression. And as long as the students were respectful to the national anthem, they are not violating any laws in our country, and hence the school was wrong in expelling these students, and the court reinstated these students. Okay. Anyways, it will be violative of the right to freedom of speech and expression. Is it true? Yes. It will be violative if somebody is compelled to sing the national anthem. It will be violative of the right to freedom of conscience on practice and propagation of religion. Yes, that is also true. The Supreme Court in this case, why the students are not singing national anthem? The 𝐔𝐬 community, to be very specific, because for them singing national anthem is going against their religious belief. So therefore, you cannot be forcing anyone to sing what is called as national anthem. So this will also true. There is no legal provisions obliging anyone to sing national anthem. This is also true. There is no legal provision making it compulsory to sing national anthem, but there is only a legal provision to respect the national anthem. Okay. So this is also true. So what is the answer here? It is C. C is the right answer. Okay, so come to the third last question. I'll just do till 75, question number 75. The word minority is not defined in the Constitution of India. Is it true? Yes, it is nowhere defined. Now, what the Constitution says, I'll deal with all those things elaborately in the next class. So, yes, factually this is right. The Minorities Commission is not a constitutional body. What about this particular statement? Yes, of course, a Minority Commission today is not a constitutional body, it is a statutory body established by the National Minorities Commission Act. But however, there is no any relation, logical relation between these two statements. Okay, so separately two statements has been given. So in this context of the above statement, which of the following is correct? What is the right answer? A and R are true, but R is not the correct explanation of A. Okay, so it's a random statement that has been given. The prohibition of discrimination on the grounds of religion, etc. under Article 15 of the Constitution is a fundamental right classifiable under which theme of the fundamental right? Right to equality. Okay, so come to the last question for the day. Come to the next question. The basic structure theory of the Constitution of India implies what? What does the basic structure theory implies? Certain features of the constitutions are so essential to it that they cannot be abrogated. There's some mistake, I think. So anyways, the meaning is certain provisions in the Constitution are so essential that it cannot be abrogated. B, fundamental rights that cannot be abridged or taken away. No, it has nothing to do with the fundamental rights. Basic structure is not only related to the fundamental rights. Basic structure can be anywhere in the Constitution. The Constitution of India cannot be amended except in accordance with the procedure prescribed under Article 368. That is true, but that is not related to the basic structure. The preamble of the Constitution cannot be amended, for it is not part of the Constitution and at the same time represents the real spirit. It is in fact an integral part of the Constitution. So what is the answer here? Certain features of the Constitution which cannot be abrogated. Okay, so with that we are almost coming to the end of the fundamental rights, but few more questions are there. Okay, so directly come to question number 76. This is where we, until 75 we are done yesterday. Okay, so come to the freedom of the press in India. So what about the freedom of the press in India? Do we have freedom of the press? Is it explicitly mentioned in the Constitution? There is no explicit mention in the Constitution. But however, the Supreme Court of India has said that it is implied under Article 19 class 1 subclause A. That is, it is implied under the right to freedom of speech and expression. Does anyone know in which case the Supreme Court held this? That is just an extra information. If you know, probably. It was held by the Supreme Court for the first time in 1915, the Romesh Thapar case. Subsequently, the Supreme Court also held this in the Bennett Coleman case in 1973. But anyways, you just remember that it is not directly mentioned. It is only an implied right under which article? Article 19 class 1 subclause A. Okay. How many reasonable restrictions are there when it comes to right to freedom of speech and expression? 8 reasonable restrictions. So just try to remember that also. Sometimes questions may come from that particular area also. Come to question number 77. The right to freedom of speech in India may be restricted if the freedom is used. Okay, so here it is about the reasonable restrictions. Under what grounds among the given options the right to freedom of speech and expression can be restricted? Incite to violence. Can you also tell me the other grounds? We have already read that there are 8 grounds.
One is on the grounds of sovereignty and integrity of India, security of the state, affecting the international relations, friendly relations with a foreign country, public order, decency or morality, defamation, contempt of the court, and then the last thing is incitement to an offence. Okay, so therefore, the right answer here is this one. In fact, this is an UPSC question, previous year UPSC question. So therefore, it is also a key that you should remember all the reasonable restrictions. They can ask anything at any point of time. At least the right to freedom of speech and expression, which is one of the right which is mostly reported in the newspaper. So just try to remember that. So come to question number 78, writ of mandamus. So what you have learned about the writ of mandamus? We command, where the court is giving a command when any public authority has failed to perform their duty, which resulted in the violation of the fundamental rights. Can a writ of mandamus be issued against a private authority? Normally no, but if a private authority is performing any of the public duties, then yes. What about the principle of locus standi? Does it apply in case of writ of mandamus? Does it apply? Does it apply means only the affected person can file a case. So the principle of locus standi does not apply. So these are all some of the information that you have to understand. What about the writ of mandamus? Can a writ of mandamus be directed against a Chief Justice of a High Court when the Chief Justice of a High Court is performing what is called as an administrative function? I am specifically putting a condition when he is performing an administrative function. When not just the Chief Justice of India, any judge for that particular matter, but the administrative functions of a particular court is mostly entrusted upon the Chief Justice of the concerned High Court and the Chief Justice of India. So they are the head of the administrative functions. So therefore, when they are performing these administrative functions, will they fall within the definition of state? Will they fall within the definition of state? And when they fall within the definition of state, against their actions, writs can be issued by the other judges also in the High Court. So try to remember this, but only when they are performing what is called as an administrative function. So what is the answer in this particular case? A writ issued by the superior court to command that a specified thing be done. Is that the right answer? Yes, the writ issued by a superior court to command a specific thing to be done towards a public authority. That's an implied understanding. Okay. So the right answer is option A. Any questions? Okay, so come to the next question. The greatest hallmark of personal liberty. What is the greatest hallmark of personal liberty? Which writ do you think? Well, all the writs are trying to protect the fundamental rights, but specifically against, because we already learned that the different types of writs are used for different purpose, for violation of different rights. So which is closely and most importantly associated with the writ of with personal liberty? It is a writ of habeas corpus. So there should be no doubt in this regard. Yesterday also I think I asked this particular question in the class. Okay, so come to the next question. Which famous judgment restricted the authority of the Parliament to amend the constitution so as to damage or destroy its basic or essential features or basic structure? 𝐂𝐭𝐿 Bharati case. You all know that 𝐂𝐭𝐿 Bharati case, but let me discuss about the other case also. What is the significance of the Golaknath case? Golaknath case was the first case to say that the fundamental rights cannot be amended, and if it is amended, then it can be declared to be invalid. But that was again reversed by the 𝐂𝐭𝐿 Bharati case in 1973. What is the speciality of the Shankari Prasad case? Shankari Prasad case in 1951. What was the speciality of this case? This was a case for the first time said that the law in the Article 13 of the Constitution does not include a constitutional amendment. It includes only the ordinary law. Okay. And then it also gave amending powers to the Parliament, that they can amend any provisions of the Constitution, including the fundamental rights. So this was the significance of the Shankari Prasad case, but gradually all these things culminated in the 𝐂𝐭𝐿 Bharati case, which was considered to be the, which declared that there exists what is called as a basic structure. But for this year examination, one case, if at all very important, I feel it is a Minerva Mills case, because there is a lot of controversy that is happening with regard to the directive principles of state policy and the fundamental rights, because in the way of implementing the directive principles of state policy, some of the fundamental rights get affected.
So in that context also it is very important. And to what extent do you think that the Minerva Mills case is related to the present controversy? Is there any relation between the Minerva Mills case, or in general is there any relation between the Minerva Mills case and the fundamental rights and directive principles of state policy? So what was held by the Minerva Mills case in relation to the fundamental rights and DPSP? Very good. It is a Minerva Mills case which brought in the idea of what is called as harmonious balance between the fundamental rights and directive principles of state policy. By harmonious balance, they meant that both have to complement one another. It is not that both are opposing one another, both has to complement one another. And to that extent, the Minerva Mills case gave primacy to two directive principles of state policy over certain fundamental rights. What are the directive principles of state policy which may have primacy over Article 14 and Article 19? It is Article 39B and Article 39C. So try to remember this. So they said that Article 39B and Article 39C may have primacy over Article 14 and Article 19. So this means that when any law is made by the Parliament or by the state legislature, and the objective of that particular law is to implement Article 39B and Article 39C. And what is Article 39B and Article 39C? Can anyone tell me? Very good. Distribution of material resources and prevention of concentration of material wealth. So in order to implement the objective under Article 39B and Article 39C, any law, if it is enacted by the Parliament or by the state legislature, and if that law is found to be violative of Article 14 and Article 19, still they cannot be challenged in a court of law. But on the grounds of what? Only on the grounds of violation of Article 14 and Article 19, not on the grounds of other articles. So therefore, this becomes very, very important. And in fact, this exemption to Article 39B and Article 39C over Article 14 and Article 19 was given by a specific constitutional amendment. Which constitutional amendment? 25th Constitutional Amendment Act. And which article was inserted by the 25th Constitutional Amendment Act? Article 31C. So all these things are important for your examination. Okay, so in addition to all those things, I also discussed one more thing. In fact, this 25th Constitutional Amendment Act came in 1971. 1971, 25th Constitutional Amendment Act was brought in, which gave primacy to Article 39B and Article 39C over Article 14 and Article 19. At that point of time, it was Article 31 also, but subsequently Article 31 was repealed. So presently the position is only over Article 14 and Article 19. Is that clear? But however, this position was changed subsequently by Prime Minister Indira Gandhi, because you know that she was very much into social justice and to bring in economic justice. So she gave primacy to all the directive principles of state policy over Article 14 and Article 19. And you know by which Constitutional Amendment Act the protection that was given only to Article 39B and Article 39C was extended to all the directive principles of state policy over Article 14 and Article 19. Which Constitutional Amendment Act? Very good. It was 42nd Constitutional Amendment Act 1976. But what is the position of this particular amendment presently? This was again struck down by the Supreme Court in the Minerva Mills case. So the Minerva Mills case restored the position of the 25th Constitutional Amendment Act. So today presently, which directive principles of state policy can have primacy over the fundamental right of 14 and 19? Only Article 39B and C, which is now presently pending in the court. We will have to see whether the court will take a different view than what has been already held, which is there in front of a constitutional bench, but the matter is still sub judice. So therefore, this matter was repeatedly coming in the newspaper, but unless until a judgment is there, UPSC may not focus on that, but you should be aware of whatever I talked about. You should be aware of 25th Constitutional Amendment Act, 44, Article 39B and C, harmonious balance, Minerva Mills case. So from these areas a question may come. So what is the answer in this case? It is the 𝐂𝐭𝐲 Bharati case. Clear? Please come to the next question. The 44th amendment of the Constitution speaks of what? Is related to what? Right to property was taken away as a fundamental right. So what is the position of right to property today? So right to property is still a constitutional right, but executed by a way of a law. So therefore it is also considered to be a legal right. Okay, so the right answer is option A in this particular case. Come to the next question. What is the objective of Article 31C inserted by the 25th Constitutional Amendment Act 1971? What is the objective of this? To provide judicial immunity to the laws made to give effect to Article 39B and C over the fundamental right of Article 14 and Article 19. Now, when I talk of the laws here, is it only the law made by the Parliament or law made by the state legislature only, or both? It is both, any ordinary law, either made by the Parliament or by the state legislature. So, the right answer is option C. How many of you have revised the yesterday's question? Have you all revised it? So, please try to revise on a daily basis, it will be very crystal clear in your mind, okay. Come to the next question, consider the following statements. The constitution, these are all I think from the last 2-3 questions mostly related to the current affairs, okay. So, now come to this particular question. The constitution enables a state to make reservation on the ground of religion. That is the first statement. Now, why this is in news? Because today there is lot of news that has been reported. Many states in our country, they are giving sub-quota for the Muslim community, especially the states like Andhra Pradesh, Telangana, Kerala, Karnataka, including Tamil Nadu. So, most of these states has given reservation within reservation, a sub-quota within the sub-quota to the Muslim community. So, therefore, this was widely reported in the newspaper. Now, just read this particular question, try to answer this question. I will then discuss about it. Just take a moment, read this particular question. Okay, so what about statement number 1? The constitution enables a state to make reservation on the grounds of religion. Is it possible to make reservation on the grounds of religion? No, it is not possible to make reservation directly on the grounds of religion. That is not authorized under the constitution. The constitution provides only for social and educational backwardness, which may be a ground for reservation. Now, after the economically weaker sections reservation, the economic backwardness is also a criteria based on which a reservation can be done. So, therefore, making reservation only on the grounds of religion is not authorized, it is not allowed under the constitution. So, then how is it possible that the Muslim community are given reservation? So, now come to the second statement. There are many state government in India which provide separate reservation, sub-quota to the people belonging to the Muslim community. Is that true? That is factually true. But is it not contradicting one another? So, do you think that the states were wrong in doing that? How many of you think that the states are wrong in doing that? Now, they have not given reservation on the grounds of religion. So, now try to understand, although the beneficiary are from the Muslim community where a sub-quota is given to them, it is only the backward people belonging to the Muslim community who are given the benefit of reservation. So, the reservation is only on the grounds of backwardness, and already the Supreme Court has approved this. Any community of people for that particular matter, if they are backward, they can be given the reservation. So, that is the reason a sub-quota has been given to them, okay. So, this is true while this is not true, okay. So, but the very basis of reservation is only what? It is the backwardness, that is social and educational backwardness. So, this particular statement is true. Which of the statements given above are incorrect? What is the answer? It is 1 only. So, please come to the next question. Which of the following is the right guaranteed under the constitution to the accused in case of arrest under Article 22 of the constitution? So, what are the rights that is available in case of arrest? I am specifically talking about the arrest, because arrest is a word that is only related to punitive detention, okay. So, come to this, right to be informed of the grounds of arrest, yes. Right to consult a legal practitioner of his or her choice, yes. Right to be produced before the nearest magistrate within 24 hours, yes. Right to be granted bail, no, it is not a fundamental right, sure, it is not a fundamental right, right to be granted bail. How many of you think no, it is not a fundamental right? Anybody who thinks it's a fundamental right? Okay, anybody who thinks it's a legal right? Of course, it is not a fundamental right, but right to be granted bail is a legal right. But however, try to understand, again it is not mandatory in all the cases. There are different types of offences. If it is a cognizable offence, then it is at the discretion of the judge. So, it is not mandatory in that particular case, okay. So, yes, in this case definitely it is wrong, it is not a fundamental right. Is it clear to all of you? So can anyone tell me what is the difference between a cognizable and a non-cognizable offence? Yesterday itself I discussed this. Cognizable offence are considered to be more serious in nature. So therefore the police can immediately arrest on a basis of a complaint. But whereas in case of a non-cognizable offence, they are not serious offences. So therefore the police can arrest only after taking a order from the magistrate. So what is the answer in this particular case? It is 1, 2 and 3 only. This is, I think, a very not this right to property. Next question, which is related to minorities. Now come to this particular question. Which of the following is true with regard to the right to property in India? This is also again very important, because recently I think in 2024 December or the end of 2024, the Supreme Court has given a series of guidelines as to how the private property can be acquired by the state. So it was also in the newspaper. Now first of all, tell me, can the private property be compulsorily acquired by the state? Is it possible under the constitution? Can the private property, can our property be compulsorily acquired by the state? Yes, it can be compulsorily acquired by the state, but only for public purpose. If the property is acquired for public purpose, it is not that somebody who is in position of authority, they wanted that property, it cannot be acquired compulsorily. For public purpose, it can be compulsorily acquired. But however, in this case also, the Supreme Court has given a detailed guideline as to how a public property can be acquired, how a private property can be acquired for a public purpose. In that case also, a series of guidelines has to be followed. So in fact, the first thing that the Supreme Court has said is, if the government, if the state is private property for public purpose, first the property owner should be given a notice. The state should give a notice that it is willing to acquire that particular property. And then the concerned individual should be allowed to make a representation, whether he is willing to give the property or not willing to give the property. He should be given a reasonable opportunity for that. And after that, the state can go for compulsory acquisition of the property, provided it is in what? It is in for public purpose, with a fair compensation that is given to the individual. And the entire process has to be completed within a reasonable time frame. It is not that undue time will take. You will acquire the property. Once you start acquiring the property, if it take 5-10 years, the individual cannot use that property for anything, and then you will subsequently later pay the compensation to him, and which is not worth for that particular individual. So therefore, all these guidelines has to be followed by the state if at all they have to acquire what is called as a private property. Now, is it possible for the state to acquire the private property of a minority educational institution? Is it possible? Can the state compulsorily acquire the property of a minority educational institution? Yes or no? Yes, the state can compulsorily acquire the property of the minority education institution as well. But the only difference is, in case of a private individual, a fair compensation has to be given. But whereas in they are acquiring the property of a minority education institution, a full compensation has to be given. So there is a difference between a fair compensation and a full compensation. Fair compensation means it may not be to market value, but full compensation is always to market value. Okay. So now come to this particular question. The right to property is guaranteed under Article 300A of the Constitution. Is it true? Yes. Right to property is guaranteed under Article 300A. The state can compulsorily acquire the private property for public purpose by providing fair compensation without giving a reasonable opportunity to the individual to be heard. Is it true? No, it is against the direction that has been given by the Supreme Court. The individual should be given a fair opportunity to be heard. Okay, so therefore, the procedure here is wrong. Otherwise, the subject is correct, but the procedure is wrong. Which of, choose the correct answer from the codes given below. What is the answer here? 1 only. Okay, so this is a very important topic. UPSC may ask, may not ask, but you should be aware of this. Possible that they can ask you, not from this current affairs, but maybe from the minority rights, or maybe from the current affairs also. You never know. Now, why this is important is, recently the Supreme Court has restored the minority status to the Aligarh Muslim University as a minority institution. Now, do you know what was the issue earlier with regard to Aligarh Muslim University, and what was held by the Supreme Court to restore the status of the minority status to the Aligarh Muslim University? Now, before I discuss all those things, we will have to understand basically about Article 29 and Article 30 very quickly. Now, both these articles, if you see, the title talks about the protection of the interest of minorities. But who is a minority is nowhere defined in Part 3 of the Constitution or anywhere in the Constitution. That is the first important thing that you should know. While Article 29 and Article 30 generally talks about the protection of interest of minorities, but if you specifically see, only Article 30 talks about the interest of the minorities. Article 29 is not only for the minorities, but it is for any section of citizens, but having what? Distinct language, script or culture. So, either they have a distinct language or have a script or a culture, then it can be protected. It can be for any section of citizens, be it a majority or a minority, it does not matter. But whereas Article 30 is only for the minorities. And another difference between Article 29 and Article 30 is, while under Article 29, they can protect their distinct language, script or culture by any section of citizens by any means. There is no specific means that is given in the Constitution as to how they can protect it. But whereas under Article 30 of the Constitution, the minorities can do only one thing, is that they can establish and they can administer an educational institution. So, what is the only right or only means that is provided for the minorities to protect the interest under Article 30? Is to establish and to administer an educational institution. So, this word establish and to administer an educational institution becomes very, very crucial. And as I already said, the Constitution also does not define as to who is minority, but the Constitution says under Article 30 on what grounds a minority shall be identified. What are the grounds on which a minority shall be identified? It is either on the grounds of religion or language. Only on two grounds the minority shall be identified, and they shall be conferred the privilege of establishing and administering the educational institution. Establishing means the founder of that educational institution should belong to a minority community, or it should be by a trust which belongs to a minority community. Once they establish, then they will have the right to administer. Now, with this information, if you come to the issues in the Aligarh Muslim University very quickly, although I am saying that the current affairs will not be very important as long as it is changing the provisions of the Constitution or something, but anyways, you should briefly know about this. If you see the status of this Aligarh Muslim University, when it was established, the name of this particular college was Mohammedan Anglo-Oriental College, which was established for the benefit of the Muslim community by the person belonging to the Muslim community. So, no problem. But in 1920, the university was established by, it was renamed as what is called as Aligarh Muslim University based on the law passed by the British Parliament. And then it was established by a particular act that is passed by the British Parliament, then controlled by the state. Then subsequently, this matter was brought in front of the Supreme Court in a case which is called as Ajiz Basha case. Now, these things are not very important, but what has happened in this particular case is, the Supreme Court said, look into Article 30 of the Constitution. Article 30 of the Constitution gives a right to minorities when it is established by whom? Established by a minority and administered by, then they will have the right to administer that. But however, in this case, the Supreme Court said that starting 1920, it was established, Aligarh Muslim University was established by way of what? By way of a statute, by way of the law that is passed by the British Parliament. So, therefore, it is not established by the minorities, and hence it cannot be given the status of a minority educational institution. After this judgment, some amendment has been made, but then again the matter has gone to the court. Now, recently the Supreme Court said, you cannot take away the minority status of a educational institution just because it is established by way of a statute. What is important in seeing whether an educational institution will be given the minority status or not depends upon the genesis of that particular educational institution and what is the larger objective based on which the educational institution was established. So, though in 1920 it was established by a way of a statute, but if you look into the genesis, it was established by the minorities, and the larger objective as to why they established this educational institution is to protect the educational interest of the minorities. So, therefore, they have to be given the minority status, and they have restored the minority status of the Aligarh Muslim University. So, this is something that you will have to keep in your mind, which is a change that has happened in the stand that is taken by the Supreme Court of India. Now, the second thing is it possible that in a minority educational institutions, there can be admissions to the students from the non-minority community? Yes. The Supreme Court has made it very clear, it is not there in the Constitution, but the Supreme Court has made it very clear, one of the privilege of any minority educational institution is that they can reserve the seats for the students belonging to the minority community up to 50%. Apart from that, they can give the seats to the non-minority community also. So, therefore, there is no restriction in that particular regard. One last information that I want to discuss is, what is the basis on which the minorities are identified under Article 30 of the Constitution? That is, the basis of course is on two grounds. One is religion and language, but when it comes to the territorial
entity, whether the entire country is to be taken into account, or a particular state where the educational institution is established should be taken into account. A state has to be taken into account to identify what is called as minority. So in any state, if a particular section of people belonging to any religion or belonging to any language, if they are less than 50%, then they would be considered to be minorities. Is that clear to all of you? So with that information, try to solve. I try to give you the holistic knowledge about Article 29 and Article 30. So consider the following statements. While Article 30 is only for the minorities, whereas Article 29 is for any section of citizens having distinct language, script or culture. Is it true? Yes, that is true. The term minority is well defined in the Constitution. It is nowhere defined in the Constitution. Any minority educational institution will lose its minority status if it is incorporated by way of a statute and administered by the state. No, because the Supreme Court has recently taken a stand. You will have to look into the genesis of that institution and the larger objective as to why it has been established. So this is also wrong. A minority educational institution cannot admit non-minority students into the educational institution. So they can admit. Okay. So what is the answer in this case? So 1 and 4 is the right thing. The question is asking for the correct one or the incorrect one. So what is the answer? Which of the statements given above are? Or let me just check. A minority education should. Okay, so this is wrong. So this is also wrong. This is also wrong. This is also wrong. So this is right. So what is the answer? Option C only. Come to the next question. Which of the following is or not part of right to privacy? So which of the following is implied under right to privacy? So based on the judgments and all those things, can you just tell which of the following is not part of right to privacy? Right to privacy to personal data, is it part of right to privacy? Yes, it has been recognized by the Supreme Court in the Puttaswamy case. What about bodily integrity? Is it part of right to privacy? Bodily integrity means one's autonomy over one's body. Say for example, somebody wanted to undergo medical treatment, somebody wanted to terminate their pregnancy. So these are all part of their bodily integrity, which the Supreme Court has recognized. It's part of the right to privacy. Right to spousal privacy, yes, recently although it was not held by the Supreme Court, it was held by the Madras High Court, but sometimes it can also come. So right to spousal privacy is also part of the fundamental right, which was recently held by the Supreme Court. I gave an example also yesterday as to what is this right to spousal privacy, which means within the partners, no spouse can spy upon another individual and get some evidence which is not admissible. If they even get them record something which is not admissible as an evidence in a court of law. Why? Because the process by which they have taken this particular material or record is violating the privacy of the spouse. So therefore, they declared that in infringement of fundamental right, you cannot produce any evidences in a court of law. So therefore, this is also part of the fundamental right. So what is the answer in this case? The answer is option D. D is the right answer. Okay, so come to the next question. So these are all based on the current affairs. The Supreme Court of India has recently declared which of the following to be the fundamental right? Recently, which of the following to be the fundamental right? Can anyone tell me? So first let us try to eliminate the things. First of all, let us try to eliminate. What about right to die? There is no right to die. There is only right to die with dignity. Okay, so right to die is not the right thing. Okay, so there is a lot of difference between right to die. In fact, there is no right to die. There is only what is called as right to die with dignity. So can anyone tell me what is the difference when you say right to die? Right to die means anybody at any point of time can give up their life. That would amount to suicide, which is a punishable offense. But what is right to die with dignity? Right to die with dignity means somebody's natural death has already commenced. So natural death has already begun, but the life is not completely gone. So therefore, the way that they are leading their life is below their dignity. Especially someone is in a permanent vegetative state, they are not able to take care of themselves and there is no possibility that they will come back to normalcy. Under such a situation, the court has allowed to carry out what is called as passive euthanasia. So therefore, this is definitely not there. So we will eliminate this. What about right to internet? Do we have right to internet? How many of you think we have right to internet? Please raise your hand.
So in which case do you think that the Supreme Court has given the right to internet? Which case? There is no right to internet in our country, please be very clear about it. In the Anuradha Basin case, the Supreme Court said that the state cannot prevent the use of internet for a prolonged period of time. Why? Because if you restrict the access to the internet, it is violative of their right to write under Article 19, that is right to freedom of speech and expression and right to profession. So therefore, internet can be restricted, but it is subject to the reasonable restrictions that is given under Article 19. So it did not say that right to internet is a fundamental right. They said that while you should not prevent the people from having access to the internet, it can be restricted, but it should not be restricted in an unreasonable manner, because preventing access to internet would be violative of Article 19, that is right to freedom of speech and expression and the right to freedom of profession. It has not directly said right to internet as a fundamental right. So therefore, it was also reported like that in the newspaper, but you please read the judgment, you will understand. You don't have to read the judgment. If you trust in me, you can take this particular statement. So right to internet is not a fundamental right. So it has not been declared to be what is fundamental right. So this also you can eliminate. So we are just left with two more options. So what are the other two options? Right to be forgotten, and the other thing is disabled person's right to access to environment, services and opportunities. So what is the answer between these two? Right to be, okay, so right to be forgotten, if you look into the judgment of the Puttaswamy case, somewhere, although we do not have a legal mechanism right now with regard to right to be forgotten, but however, if you look into the Puttaswamy case, somewhere there is a reference of this right to be forgotten. So what is this right to be forgotten? Can anyone tell me? Not only on the internet, anything on public records. Anything on public records, anything which is available to the public, if it is no longer relevant, then it should be erased. So as long as it is relevant, say for example, somebody is accused of some crime which is published in various newspapers, then later he was found to be innocent in a court of law. So therefore, the individual will have the right to erase all those things. So that is basically what is called as the right to be forgotten. So somewhere in the Puttaswamy case, they have talked about this right to be forgotten, but however, that is not the answer in this particular question, because the question is asking recently. So recently means today we are in 2025. So recently between these two things, in 2024 or in the 2025 beginning, the Supreme Court has declared, in fact the then Chief Justice of India has declared that the right of the persons, disabled persons right to access to the environment, services and opportunity should be a right implied under Article 21 of the Constitution. Yes. No right is an absolute right. No right is an absolute right. It can be reasonably restricted on rational grounds. Okay. Okay, because to perform some of the duties, it requires certain ability. So therefore, on those grounds, it can be restricted. So whenever I talk of right to equality, you should understand only the equal should be treated equally. So there is no point in comparing absolute equality. But this has been declared. The Supreme Court has declared, but it will take some time to frame a law and to implement this effectively. So what is the answer in this particular case? It is option A. Case, I am not sure. If you want, I will refer that and I will tell you, but it was declared to be a fundamental right. Okay, so come to the next question. The Supreme Court of India, as per the Supreme Court of India, the right against the adverse effect of climate change is a fundamental right implied under which article? Both Article 21 and Article 14 of the Constitution. Article 21 is clear, natural extension of right to clean environment, but how it is implied under Article 14 of the Constitution? Why it is implied under Article 14 of the Constitution? Article 14 of the Constitution also talks about what is called as equal protection of laws, which means try to understand the people in our country and their ability to cope up with the effects of climate change is not equal. Somebody who is rich, they can have an air condition in their home and then probably they can cope up with the effect of the climate change. But however, somebody who is not even having a house, for them to cope up with the effect of climate change is very difficult. So therefore, who has to pitch in and protect all these things? It is a responsibility of the state. Okay. So that is the reason that they said that it is implied under Article 14 and Article 21 of the Constitution. So what is the answer here? Both 1 and 2. Okay, so come to the last question in fundamental rights. Which of the following best explains the difference between writ of prohibition and certiorari? Now, one, while the writ of prohibition prevents a lower court from exceeding its jurisdiction, whereas the writ of certiorari rectifies an error in the judgment of the lower court. Is it true? That is why prohibition is preventive in nature, writ of certiorari is curative in nature. So yes, this statement is true. The writ of prohibition is majorly curative in nature and the writ of certiorari is preventive in nature. It is rather vice versa. So this is also wrong. What about in these two cases? Does the principle of locus standi applies? That means only the affected individual can approach the court. But in all the other three writs, the principle of locus standi does not apply. That is also very important. Sometimes UPSC can put one statement and it can ask you. So what is the answer here? Choose a correct answer from the codes given below. What is the answer? 1 only. Okay, so come to this area. This area also very easy area, but you can get 2 questions in your prelims examination. One from DPSP, one from fundamental duties. Very simple, but 2 questions. Okay, so don't underestimate this area. Very, very important. Come to the next part. The instrument of instruction contained in the Government of India Act 1935 has been incorporated into the Constitution in the year 1950 as what is objectives resolution related to? Preamble. Instrument of instruction, directive principles of state policy. Which of the following, and this is again another important thing. Before you appear to the examination, you should be in a position to differentiate between what is a fundamental right, what is a directive principles of state policy, what is a fundamental duty. This is one important thing UPSC year after year has been asking the questions. Usually you will get confused not between the fundamental rights and the other things. DPSP and fundamental duties, there can be some confusion. So try to be very clear about it. Okay. So now come prohibition of traffic in human being and forced labor. Is it a DPSP? No, it is a fundamental right. Under which article it is a fundamental right? Article 23. Very good. Prohibition of consumption except for medicinal purposes of intoxicating drinks and other drugs which are injurious to health. What about this? It is DPSP, not under Article 39, but it is part of DPSP. In fact, it is because of this only many states have passed legislations to prohibit the consumption ban on the sale of alcohol. Some of the states. Okay, so this is definitely there as a part of DPSP. So what is the correct answer? The correct answer is option 2 only. And one more important area with regard to the DPSP is you should all be aware of what is a socialistic principle, what is a Gandhian principle, and what is a liberal intellectual principle. That at any point of time can be asked by UPSC. And you should also be very clear that this distinction is not there in the Constitution. It's only philosophically, by principle they are little different. So therefore it is classified for the academic purpose, but there is no such distinction in the Constitution. Okay, come to the next question. The purpose of inclusion of directive principles of state policy in the Constitution is to establish social and economic democracy, that is the social and the economic well-being of the people. Which of the articles of the directive principles of state policy deals with promotion of international peace and security? Which article? The last directive principles of state policy, which is Article 51. Very simple questions may be asked from here, but yes, 2 questions you can expect. Okay, so this is again very important. Which article? Because this is the directives outside the part 4 of the Constitution. There are some directives outside part 4, so this is one such directive. Which article of the Constitution provides that it shall be the endeavour of every state to provide adequate facility for instructions in mother tongue at the primary stage? Okay, so before we go to the answer, what is Article 349? 349 allows an individual to make a representation with regard to their grievances to the government in any of the languages of the government. Whatever official language of the union, in any official language you can present it. Whatever the official languages of the state, in their official languages you can present your grievances. So that is what is Article 349 is saying. So Article 349 is related to how an individual can present their grievances to the state. What about Article 350? What is Article 350? Does anyone know? Article 350. Okay, Article 350A is related to the answer in this particular case. Does anyone know what is Article 351? So Article 350 allows for the appointment of a linguistic commissioner for the linguistic minorities. So that is what is Article 350. Article 350A is related to the question what has been asked, that the state shall take measures to promote what is called as instructions in mother tongue. What about Article 351? Duty of the state to promote Hindi language. Okay, so these are all different things. So try to remember all those things. Any of these things may be asked. Okay. So this is related to how the citizens can present their grievances. This is related to linguistic commissioner. This is related to promotion of mother tongue. This is related to promotion of Hindi language. So answer in this case, what is the answer? It is Article 350A. Which of the following is not included in the list of fundamental duties in the Constitution? Which of the following is not a fundamental duty? Please say the answer. To safeguard the property and to abjure violence. Is it there in the fundamental duty? Okay, fundamental duty is in which part of the Constitution? 4A. Which article? 51A. How many duties are there? Initially, how many duties? What was the last duty to be added? 8. What was the last duty? Not the amendment. It's responsibility of the parent or the guardian to educate the child, and that was last inserted by the 86th Constitutional Amendment Act. There is one significance about this 86th Constitutional Amendment Act. What is the significance of this 86th Constitutional Amendment Act? In fact, it is this 86th Constitutional Amendment Act that has amended all the three parts in the Constitution: fundamental rights, DPSP, as well as the fundamental duty. Okay, so try to remember this as well. What it has inserted into the fundamental rights? Article 21A. What change it has made into the DPSP? That the state shall take care from 0 to 6 years. Initially, it was not 0 to 6 years. But then 6 to 14 years, they have made it as a fundamental right, education. So they have made changes in the DPSS 0 to 6 years. And then correspondingly, they have inserted one more fundamental duty also in the fundamental duties. Okay, anyways. So this is definitely there. To uphold and to protect the sovereignty, unity and integrity of India, is it there? Yes, that is there. To abide by the constitution and to respect its ideals? Yes. Secularism is not there in the, it is only a feature in the preamble. Okay, so who is a good citizen? While your opinion might vary from individual to individual as to who is a citizen, but for the purpose of UPSC examination, so what shall be the answer? Who is a good citizen? Not bothered about anything. Okay, that is not the answer. You can eliminate this. These are all the things that you should definitely attempt, but you should get it right. That is very important. Not attempting is important. You should get it right. Educated? Not necessarily. Not necessarily. Rich in cultural heritage? Not necessarily. See, all these things may not help others. So a good citizen is someone that who should not create any problem to others. Not necessarily only create problem to others, he should help others also probably. That means he should be aware of the social obligations. So he is considered to be a good citizen. Okay. So the right answer is option A. The concept of welfare state is included in the Constitution of India. Where it is mentioned? It is in the directive principles of state policy. To uphold and protect the sovereignty, unity and integrity of India is a provision made in what? Fundamental duties. It is in the fundamental duties. Okay, so come to the next question. Consider the following statements regarding the directive principles of state policy. The principles shall spell out the socio-economic democracy in the country. Is it true? Yes. So mostly it is related to the socio-economic democracy. The provisions contained in these principles are not enforceable by any court. Is it true? One fundamental principle that you have to understand is the DPSP is non-justiciable in nature. What does it mean by non-justiciable in nature? That they cannot be enforced in a court of law just because it is mentioned in the constitution. That is, no citizen can go to a court and tell that the state have to come out with a policy or the state has to come out with a law to implement all those things. That is not possible. But what if some law is already made to implement any of the directives, and by way of that particular law they are conferring some legal rights, and if there is a violation of that right, can it be enforced in a court of law? Yes, that can be enforced in a court of law. So you should have a very clear understanding. So the provisions contained in these principles are not enforceable in a court of law. This is okay. So this is true, not enforceable. So what is the answer here? Both 1 and 2. Can you give an example of any law that has been made to implement the directive principles and thereby it is conferring legal right upon the people? Any example? Yes? Alcohol prohibition. So what is the legal right that it is conferring? Very good. NALSA is there. NALSA, which provides free legal aid. So certain categories of people are given the free legal aid. So therefore, when they are not given the free legal aid, they can approach the courts. Very good. Mahatma Gandhi National Rural Employment Guarantee Act is there. To certain sections of the people, it is providing 100 days of wage employment, which is with an objective of ensuring livelihood to all the people, so at least to the poor people. So there are certain laws. And why I am saying this, there is one more important category where UPSC asks a question is, they can give you a list of laws and some policies, and they can ask you which of these laws and policies are aimed at implementing the directive principles. So normally for such question, the answer would be all of the above. 99% it would be all of the above, okay, because most of the legislations in our country, one way or the other, will be related to any of the directives. But sometimes, yes, it cannot be related. So you should be very sure that yes, it is not at all related. So in that case only, it will not be all of the above. Otherwise, it is mostly all of the above, okay. So come to the question. In the context of India, which of the following is correct relationship between the rights and duties? What is the correct relationship between rights and duties? Rights are correlative with duties. We will just try to eliminate so that we are correct. Rights are personal and hence independent of society and duties. So rights are personal, that is true, but to say independent of societies and duties may not be a right thing, okay. So here come to rights, not duties, are important for the advancement of the personality of a citizen. Which of the following is a correct relationship? So here it is not talking about any relationship, it is only talking about what is rights. Duties, not rights, are important for the stability of the state. So that is definitely not true, because that is non-justiciable in character. So therefore you can rule out this, because you cannot say that only rights are very important. Of course rights are important, you cannot ignore the duties. Rights are personal and hence independent of society and duties, that is also completely not true, because the way the rights itself to be exercised is to take care into the society into consideration. That is why the reasonable restrictions are there. Rights are correlative with duties. What does it mean by rights are correlative with duties? The way the rights are exercised, in most of the way it is related to the duties also. Say for example, Article 21 of the Constitution, 21A of the Constitution is talking about what? Right to education of the child. But there is also a fundamental duty which is talking about the duty of the parent or the guardian to educate the child. So in a way there is a relationship between to the right and the duties, okay. So the answer is option A. Which of the following statement is true of the fundamental duties of an Indian citizen? A legislative process has been provided to enforce these duties. So what does it mean by legislative process has been provided? Does the Constitution provides for a specific procedure to enforce any of the duties? Can any of the duties be enforced in the first place? Yes, the state is free to enforce any of the duties. So please have an understanding of this. If tomorrow if the parliament wanted to make any law, and by that law they can enforce any of the duties, but the fundamental duties cannot be enforced just because it is mentioned in the constitution. So when I say that the fundamental duties are non-justiciable in character, it cannot be enforced just because it is mentioned in the constitution. But the state is free to bring any law, and by that law they can enforce any of these duties. But the question here is, the key word here is, there is a legislative process that is provided. Say for example, to bring in a money bill there is a separate process. To bring in a constitutional amendment there is a separate process. Is there a legislative process that is mentioned in the constitution to enforce any of the fundamental duties? There is no separate legislative process. So therefore, it is because of that this particular statement is wrong. They are correlative to legal duties. What does it mean by they are correlative to legal duties? Does it make the duties enforceable in nature? They are not correlative to what is called as legal duties unless and until a law is made. So just because it is there in the constitution, they cannot be enforced. So select the correct answer using the codes given below. What is the answer? Correct answer, right? So it is neither 1 nor 2. Is that clear to all of you? Correlative means, is it related? Or in other words, to put it very simply, can the fundamental duties be implemented legally? That is not possible unless until there is a law. So therefore, it has no relation to what is called as legal duties. Okay. So that is also wrong. So the answer is option D. Come to next question. Consider the following statements. With reference to the Constitution of India, the directive principles of state policy constitutes limitation upon what? Is there any limitation upon the legislative functions because of DPSP? There is no limitation because there is nothing upon the state to implement any of these duties. If they want, they can implement, otherwise they will not implement. Okay, so therefore there is no such limitations. But however, do you know what is the reason? So this is definitely there is no limitation. So there is no limitation upon the legislative function. Is there any limitation upon the executive function? There is no limitation upon the executive function also. So now try to understand the executives. There are two ways that they can bring in welfare to the people. One is by a way of a law, one is by a way of just a policy, by an executive action. So in both the cases there is no limitation. If they want to do, they can do, otherwise they will not do. So therefore there is no limitation upon the executive functions as well as the legislative functions. But why do you think that it has been made non-justiciable in character? What is the reason that was given by Dr. B.R. Ambedkar? So who said that it should be non-justiciable in nature? The first thing is, these are all very idealistic in nature. It is of very high level of thing that is to be achieved, which the state may not have the resource. So therefore there is no need to make it justiciable in nature. Second thing is, in a democracy no government can ignore these directives for a long time. If they ignore these directives for a long time, then the people will ultimately remove this government in a democracy. So therefore anyways there is a pressure for the government to implement these directives. So he said that let it continue to be a non-justiciable part, and the state whenever it has the resources, let it implement the various directives. So therefore it does not put any restriction on the legislative function or the executive function. Or in other words, to put it very simply, any legislation that is brought in by the state or any policy that is brought in by the state, let us assume any welfare scheme that is brought in by the state, which is an executive action, cannot be challenged in a court of law on the ground it is violative of the directive principles of state policy. But it can be challenged in a court of law on the grounds of violation of fundamental rights, but not on the grounds of directive principles of state policy. Therefore, there is no restriction on the legislative actions and the executive functions. Okay, so what is the answer here? It is both 1 and 2, right? Okay, so it is neither 1 nor 2 because they are asking correct. Okay. With reference to the provisions contained in part 4 of the constitution, which of the following statements are correct? They are enforceable by courts? No, they are non-justiciable in nature. They are not enforceable. They shall not be enforceable by a court. They shall not be enforceable by a court. So that is true. Now don't think that what if they make a law? That assumption you should not make unless and until it is explicitly given in the question. So sometimes students overthink and they make a mistake. Just read what is given in the question. The principles are laid down in the part or to influence the making of laws by the state. Is that the objective? Yes, that's the objective. So what is the answer here? It is 2 and 3 only. Okay, so which of the following are the socialistic principle? This is what I said. You should be aware of these differences also. Today when you go home, just try to see once as to what are the socialistic principle, Gandhian principle, liberal intellectual principles. State to secure an uniform civil code. It's a liberal intellectual principle. Very, very important. It is a first in the liberal intellectual principle. Free legal aid to the poor. Yes, it's a socialistic principle under Article 39A. Okay, socialistic principle. I thought Gandhian principle. Okay, so here it is true, socialistic principle. To promote cottage industries, that's a Gandhian principle. Okay, even if you remember Gandhian principle, you will be in a position to eliminate the other things. So what is the correct answer here? 2 only. Okay, so which of the following is or a fundamental duty under the Constitution of India? Paying taxes? No, it is not a fundamental duty. It's a legal obligation based on the laws in our country, only for those people who are making the income, not for everyone, because it is based on the principle of equal protection of laws. Okay, so this is not there. Respect national anthem and national flag? Yes. Is it mandatory to sing national anthem? Nobody can force it. Nobody can force it because right to remain silent is a fundamental right, as long as we don't disrespect the national anthem. So yes, it is a fundamental duty. To protect environment? Yes, specific fundamental duty is there. To avoid practices derogatory to the dignity of women? Yes, that is also there. So which of the statements given above are correct? It is 2, 3 and 4 only. This is an important area, uniform civil code. Probably you can expect a question in the prelims, because there is a particular state which has brought in a law with regard to the uniform civil code. Which state is that? Uttarakhand. Even before Uttarakhand, there was one more state, Goa, but that was from the very long back. So recently, one more state has brought in a legislation. Recently, I read an article where they have framed rules also to implement this uniform civil code in the state of Uttarakhand. And the other states are also, I think, considering bringing in a uniform civil code. States like Assam, Haryana, they are also considering this. So let us see when they are bringing this uniform civil code. Consider the following statements with regard to the idea of uniform civil code, which is recently reported in the newspaper. Under the Constitution, it is a legal obligation for a state to ensure uniform civil code in personal matters in the long run. Is it true? It is not a legal obligation because it is mentioned in the directive principles of state policy. So therefore, it is not a legal obligation. Only the Parliament is empowered to bring in a uniform civil code and not the state legislature. That is not true. In fact, it is a state legislature which is bringing in the uniform civil code. Okay, so this is also wrong. In fact, the religion is not specifically mentioned in any of the things. But as I already said, why the states are making law when it comes to religious conversion or the uniform civil code? Because all these things are closely related to law and order. So therefore, the states are making law in this particular regard. So which of the statements given above are incorrect? Both 1 and 2 are incorrect. Which of the following state in India has recently enacted a legislation bringing in uniform civil code in India? Which state? Uttarakhand. Okay. The 86th Constitutional Amendment Act has amended which of the following parts in the Constitution? All the above. Very important. Sometimes they do ask a question on the amendments also in all the 3 things. So the answer is all of the above. Okay, last question from the first part. Section 6A of the Citizenship Act, recently upheld by the Supreme Court, is related to granting citizenship to illegal migrants from Pakistan, Afghanistan and Bangladesh, granting citizenship to Rohingya refugees in India, granting citizenship to certain immigrants enter into India between 1st Jan 1966 and 25th March 1971. None of the above. How many of you think it is A? granting citizenship to illegal migrants. Section 6A of the Citizenship Act is not related to this. There is a separate amendment which is the Citizenship Amendment Act 2019, and that is still sub judice in a court of law. It is nowhere related to Section 6A. Now, Section 6A was related to the Assam Accord, and based on the Assam Accord, they have inserted this Section 6A, because Assam Accord is only an agreement between different parties. In fact, it was a tripartite agreement between Government of India, Government of Assam and the All Assam Students Union. Now, what is the objective of that particular agreement? Can anyone recollect what is the objective? If you know, what is the objective of that agreement? The objective of that agreement is to identify the illegal migrants who have entered into Assam and to deport them back to Bangladesh, because it was thought that a lot of illegal migrants are entering from Bangladesh into India. So, therefore, those migrants, illegal migrants have to be identified and they have to be deported back. So, an agreement was made, but an agreement will not have any legal validity. An agreement can be implemented only when it becomes a law. So, to implement this Assam Accord, an amendment was brought into the Citizenship Act where they inserted the Section 6A. And the Section 6A talks about a specific category of illegal migrants who entered from Bangladesh into India in a specific point in time. And what is that particular point? Between 1st January 1966 and 25th of March 1971. Now, what will happen to those people who have entered before 1st January 1966? If they have entered as an illegal migrant from Bangladesh to India, they will be given the citizenship, no problem. For those categories of people who entered from 1st January 1966 and before 25th March 1971, that is till 24th March 1971. Now, what is the significance of this 24th March 1971? The significance is that is when independent Bangladesh was created. So, till that point of time, anyone who has entered into India, what will happen to those categories of people? They will be given the citizenship, but not immediately. Whenever they will be identified as an illegal migrant, then from that point of day, for 10 years they have to stay in India, and then after that a citizenship will be given to them. In the meantime, they will have all the rights of a citizen except the right to vote. They will not be given the right to vote. Now, this provision is what is there in Section 6A of the Citizenship Act. And this was recently challenged. Long back it was challenged in the Supreme Court. Recently the Supreme Court has upheld this particular provision. Okay, so that is what is Section 6A. So, what is the answer in this particular case? Granting citizenship to certain immigrants, in fact, they are illegal migrants entered into India, into Assam between 1st Jan 1966 and 25th March 1971. Alright, so with that we are done with the first part. You can expect at least 3 to 4 questions minimum. I am saying it can be more than that also. So, even if you are listening to the class well, if you are lucky enough, you are doing only the class, but if you have attended my PMP or whether without PMP, if you have done your part on your own, then I am sure that you can get most of the questions right from this particular area. It is not necessary that you should be part of PMP or any of my classes, but if you have done your part of reading the basic books and knowing the things, along with it solving these questions, it will help you to get the 90% of the questions. Okay. Alright, so now we will move to the second part where we will get into the union and the state executives. So, this is also the area UPSC asks 2 to 3 questions every year. So, this is again a very important area. So, I will try to cover as much as possible. If time permits, we will try to complete all the things, but we will try to cover as much as possible. Alright. So, before going there, if you have any questions, you can ask me your questions very quickly for a couple of minutes, and then we will move to the next part. I will also just check the online students if they have any questions. If you are not having the handout, please collect the handout because that is very important for you to make the notes. Alright, shall I move forward to the next one? Can a state? No, not directly in the name of religion. They can identify certain categories of people from a particular religion, provided those categories of people are backward in nature, social and educationally backward, and then the reservation can be conferred upon them. So, just not directly in the name of religion, unless and until they do not belong to the backward community, the reservation cannot be given. Okay. Alright, shall I move forward? Can you be little louder? Okay, so we'll move to the next part. So come to the union and the state executives. So union and the state executives means I'll cover all the things. I'll cover president, vice president, prime minister and the council of ministers, attorney general. In the state, when you go, governor, chief minister, council of ministers, advocate general. So all those things will be covered through the questions. Okay, along with here and there some current affairs. Only governor is so controversial in all those things. So few questions from the governors. Okay, so other things are only a normal thing. Consider the following statements. Statement 1. The governor of Punjab is concurrently. So this is a very old question, but presently also you should know. Okay, so let us see. The governor of Punjab is concurrently the administrator of Chandigarh. Is that true? You just try to see presently. This is in fact a very old question, 20 years old question. But if you see presently, is it true? The governor of Punjab, anyone from the state of Punjab, anyone from Chandigarh in this class? So the governor of Punjab is also concurrently the administrator of Chandigarh, because whoever is appointed in the Chandigarh, he is only designated as an administrator, because for the union territories it is for the president to designate him. He may be designated as a lieutenant governor or as an administrator. It is for the president to do. So is it true the statement? Presently I am asking if you are aware of this. The governor of Punjab is concurrently the administrator of Chandigarh. So presently it is true. It is not only presently true, from 1984 the government of India is following this conventional practice. So that means almost for over 40 years the government is following this conventional practice, that whoever is appointed as the governor of Punjab is also concurrently appointed as the the administrator of Chandigarh. But it is not necessary, it will not be changed. It can be changed if the government wants to change it, but this is a convention that I have been following for a long time. So yes, statement 1 is right. The governor of Kerala is concurrently the administrator of Lakshadweep. What about this? Is it true presently? The governor of Kerala is also concurrently the administrator of Lakshadweep. So presently this is not true. There is a governor for the state of Kerala, there is a separate administrator for the union territory of Lakshadweep. So here the government is not following that convention. It may change in the future, but presently it is not the case. The governor of Kerala is concurrently the administrator of Lakshadweep is wrong. So which of the statements given above are correct? So what is the correct answer? 1 only. So therefore you cannot stop it here. So instead of Lakshadweep, they can ask what is called as Andaman and Nicobar Islands, or maybe they can ask Puducherry. So therefore it is also your responsibility to see who are the governors and administrators of certain union territories. So normally there is a convention that they follow, that a nearby state governor is also appointed as an administrator, but not necessarily it may be true in all the cases. Okay. So the answer for this particular question is option A. Okay, now tell me when the governor, so in this case the governor of Punjab is also concurrently the administrator of Chandigarh. Now when he is acting as an administrator of Chandigarh, does he have to act in accordance with the aid and advice of the Council of Ministers of Punjab? Yes or no? In that case he will be an independent authority. So he will directly report to the president. Okay, so he doesn't have to act on the aid and advice of the Council of Ministers. Okay, so come to the next question. Consider the following statements. The Advocate General of a state in India is appointed by the President of India upon the recommendation of the governor of the concerned state. Is that true? So the Advocate General of a particular state is always appointed by the governor of that particular state. It is not by the president but by the governor. So it is on the advice of the Council of Ministers of that particular state. The governor appoints the Advocate General. Is there any qualification that is given in the constitution as to who can be appointed as the Advocate General of a state? Is there any qualification there in the constitution? Yes or no? Very quickly. Rapid fire round, no time to think. Yes or no? Any answer? No? Yes? The constitution does give a qualification. The only qualification that is given is that he should be appointed as a judge of a high court. He should have all the qualification to be appointed as a judge of high court. So try to remember that. So anyone who is eligible to be appointed as a judge of high court, they can be appointed as an advocate general. Okay, so that is an extra information. And the governor appoints advocate general. Somebody is appointed as advocate general. Does he have a fixed tenure? There is no fixed tenure that is given in the constitution. His service conditions, his tenure, salary, everything will be determined by the governor. And normally it is a case whenever the government changes, the advocate general will also change. Okay, so this is how, so there is no fixed tenure to the advocate general, but there are certain privileges that is given to the advocate general. So what are the privileges that is given to the advocate general? That he can attend the meetings in the state legislature. He will have the right to participate in any of the committees or in the legislature, take part in any of the proceedings. He will have the right to speak there, but without the right to vote. So without the right to vote, whenever he is taking part in the proceedings in the state legislature, he will have all the privileges of the members of the state legislature as well. The only exception is he will not have the right to vote because he is not a member of the house. So he will not have the right to vote. Does the advocate general do have the right to private practice? Yes, he can have private practice. That is also not restricted under the constitution. But the only thing is he should not hold a brief against the government. So that means he should not bring any disrepute or he should not appear against the government. Okay, so that's the only thing that he has to keep in mind. Otherwise, no problem. Okay, come to the next statement. As provided in the Civil Procedure Code, high courts have original, appellate and advisory jurisdiction at the state level. Is it true? For which you will have to understand the various jurisdiction of the high courts. In fact, one principle that you will have to remember is, unlike the Supreme Court of India, where the Supreme Court of India derives most of its powers and jurisdiction directly from the constitution. But for the high courts, not every jurisdiction is provided in the constitution. Only very limited jurisdiction to the high courts is given directly by the constitution. Can you recollect what are the jurisdiction directly given by the high courts by the constitution? What are the powers does it get directly? Of course, it has got the writ powers under Article 226, supervisory powers under Article 227. So these are the few powers that they derive. In fact, these two they directly derive from the constitution. Remaining all the powers of the high courts and jurisdiction of the high courts, they derive it based on the law that is made by the parliament and the state legislature. So the laws made by the parliament and the laws made by the state legislature can empower the high courts. Now in this context, now this statement is partially true, but is it fully true? As provided in the Civil Procedure Code, the high courts have original jurisdiction. Can they have original jurisdiction? See, one thing that you will have to keep in your mind is that the high courts will not have original jurisdiction in criminal matters, but it is only talking about the Civil Procedure Code. That is means it deals with the civil cases. So can the high courts have original jurisdiction in civil matters? Yes, they can have. Of course, not in all the cases, but in certain cases they can have. Say for example, any property dispute which is above a 1 crore value, that dispute can go to the high court under original jurisdiction. So in criminal cases they may not have original jurisdiction, but in civil cases they may have original jurisdiction. So that is true. What about appellate jurisdiction? Yes, the high court will have appellate jurisdiction both in the civil as well as in the criminal cases. So therefore, yes, this is also true. What about advisory jurisdiction? There is no advisory jurisdiction to the high courts. The only court in our country which has its advisory jurisdiction is the Supreme Court of India. So under which article the Supreme Court has got the advisory jurisdiction? Article 143. Anyways, I will discuss in detail when I take up the judiciary, but to that extent you should know, as per the Civil Procedure Code, the high courts may have original jurisdiction in civil cases. They will have appellate jurisdiction, but definitely not advisory jurisdiction. So what is the answer, correct answer here? It is neither one nor two. Please come to the next question. With reference to the union government, consider the following statement. Statement 1. The Constitution of India provides that all cabinet ministers shall be compulsorily sitting members of Lok Sabha. Is it necessary that they should be sitting members of Lok Sabha? Can a member from a Rajya Sabha be appointed as a minister? Can a person who is not a member of parliament, can he be appointed as a minister? Yes. So he or she can also be appointed as a minister. The only condition is within 6 months they have to become a member of the parliament. So students ask me, they should be elected or they can be elected, nominated. In any way they should become a member of parliament. So therefore, to say that the constitution provides only that a sitting member from the Lok Sabha can become a cabinet minister. So what is this cabinet minister? Anyways, the statement is wrong, but what is cabinet minister? Is the word cabinet mentioned in the constitution? Yes or no? Yes, it is mentioned in only one place, in article 352 of the constitution, but however it does not define what is cabinet. It is only saying that the president to go for a national emergency, the president should get a written recommendation from all ministers of cabinet rank. But however it is not defined. So, but what is your understanding of a cabinet minister? It is not mentioned in the constitution, be very clear about it as to what is a cabinet minister. The word cabinet is mentioned but not cabinet minister. So it is only saying ministers of cabinet rank. And the constitution does not categorize different categories of ministers. It is only through the transaction of business rules that we have different categories of ministers. So normally the ministers today is presently in the category of cabinet minister and the minister of state. Today there is also not much use of deputy ministers. Earlier there used to be deputy ministers also. So what is the distinction between these ministers? Cabinet ministers, minister of state, deputy ministers. Who is a cabinet minister? Who are definitely having an independent portfolio. So can you give me examples of some of the cabinet ministers in the union? In fact, even the prime minister himself is a cabinet minister, but he is the head of the cabinet ministers. So therefore he is the prime minister. You have the finance minister today, you have the defense minister, you have the home minister, you have the agriculture minister. So these are all some of the cabinet ministers. So definitely they will have an independent portfolio. What about the minister of state? The minister of state are given to those people. Usually they are secondary in the importance after the cabinet ministers. The minister of state may or may not have a portfolio, not necessarily in all the cases they will have a portfolio. Some minister of state who are considered to be independent charge. If you see minister of state, independent charge, but in other categories it will be given only minister of state. So minister of state is someone who is below the cabinet minister in most of the cases, but some cases the minister of state may have an independent charge. In that case, while his status is minister of state, but he is having an independent charge of certain ministry or a portfolio. That means they will be on the verge of getting promoted, probably when the next time the government comes. So that is minister of state. What are deputy ministers? The deputy ministers definitely will not have any independent charge. They will either assist a union cabinet minister or they will assist a minister of state with independent charge. Okay, so that is what is deputy ministers. Anyways, come to the statement 2. The union cabinet secretariat operates under the directions of the Ministry of Parliamentary Affairs. Is that true? The Union Cabinet Secretariat has nothing to do with the Ministry of Parliamentary Affairs. The Ministry of Parliamentary Affairs is just one ministry which takes care of how or what are the proposals that the government has to introduce in the parliament. So the Union Cabinet Secretariat is headed by the Cabinet Secretary, and the Cabinet Secretary is the secretary to the entire Union Cabinet and not only to the Union Parliamentary Affairs. And there is one distinction, one convention that we follow with regard to the Cabinet Secretary. What is the convention that we follow with regard to the cabinet? Who is appointed as a cabinet secretary in our country? He or she is a senior most civil servant in our country, serving senior most civil servant. Okay, so that is okay. Is the cabinet secretary more powerful or the principal secretary to the prime minister who is more powerful? Practically, I am asking. On paper also, practically also. It is a principal secretary because a cabinet secretary has nothing to do with the decision making of the government. He just gives secretarial assistance to the union cabinet. The prime minister closely operates with the principal secretary to him, who is also there in the prime minister's office. Okay. What is the equivalent of cabinet secretary at the state level? Who is equivalent of the cabinet secretary at the state level? it is a chief secretary. In the state level, if you see, it is a chief secretary who is the most powerful person when it comes to administration. But whereas in the union level, there is nothing similar to that, because a cabinet secretary is not very powerful. It is a principal secretary. Okay. Which of the following constitutional amendment states that the total number of ministers, including the Prime Minister, in the Council of Ministers shall not exceed 15% of the total number of members in the House of People? Which constitutional amendment act? 91st Constitutional Amendment Act. That's a factual question. But is it in all the cases? Is it in all the cases, or are there any exception? No, leave about the union territories. I am not even talking about the union territories. I will discuss about the union territories later. I am talking about the states. It is only for the states. Is there any exception in this case? If any state will have less than 12 ministers, so for example, if the 15% is less than 12 ministers, then in that case, for a state, minimum 12 ministers has to be there. So for example, suppose let us assume a state is having only 60 MLA. What would be 15% of 60 MLAs? What is 15% of 60 MLAs? 9. So there the 15% maximum is only 9 ministers. In that case, that particular state can have how many ministers? Minimum 12, maximum is 15% of the total membership of the Legislative Assembly, whichever is higher. That is the answer you should have. Okay. So there are exceptions to this. With reference to the union government, consider the following statements. The ministries and departments of the government of India are created by the Prime Minister on the advice of the Cabinet Secretary. So who creates all those things? Who creates the number of ministries and departments? Tomorrow, if the government is to create a new ministry, Ministry of Cooperation was created recently by the NDA government. So who is having the authority to create a new ministry? Who is authority under the Constitution? President, Prime Minister, Union Cabinet. Now all these things are authority of the President of India, because Article 77 of the Constitution talks about who is supposed to take care of the transaction of the business rules. It is a President. But we know that the President does that on the aid and advice of the Council of Ministers. But as per the Constitution, who can do that? It is only the President. At the state level, who can do this? The Governor on the aid and advice of the State Council of Ministers. So therefore, it has got nothing to do with the Prime Minister, but who does all these things? President. But we know that the President is only a nominal executive. So therefore, this is wrong. The ministers is assigned to a ministry. So the ministries is assigned to a minister by the President of India on the advice of the Prime Minister. Is it true? Is it true? This is true. Who appoints the ministers? Who appoints the Prime Minister? It is the President who appoints the Prime Minister, and it is the President who will appoint the other ministers also on the advice of the Prime Minister. Okay. So which of the statements given above are correct? 2 only. The resolution for this is very important, because I think in the entire history of India, never ever a notice was brought in the House to remove the Vice President of India. For the first time, the opposition were contemplating to remove the present Vice President. It may happen, it may not happen, mostly it may not happen. But in the history of India, this is the first time. So therefore, you should be aware of not who was the Vice President and all those things, but what is the process that is given in the Constitution with regard to their removal. Okay, so this may be related to the current affairs also. The resolution for removing the Vice President of India can be moved. Where it can be moved? It can be moved only in the Rajya Sabha. I am quite sure you are clear about all those things. Okay, so whenever such a notice is to be moved, so as per the Constitution, a 14 days prior notice is to be given to the presiding officer there. and to the, sorry, not to the presiding officer, to the vice president. A 14 days notice is to be given. After giving a 14 days notice, then the proposal can be brought in, if it is brought in. Okay, if the proposal is brought in, then what is the majority with which it has to be passed in the Rajya Sabha? How many of you think it is special majority? Please raise your hand. Plus special majority. How many of you think it is simple majority? Effective majority. So it has to be passed with what is called as effective majority. So not with special majority, effective majority. So what is this effective majority? It can be introduced only in the Rajya Sabha, and in the Rajya Sabha it has to be passed with effective majority. Now can anyone tell me what is this effective majority? Majority of then members of the house, or to put it in a very simple way, it is a majority of the effective membership of the house. And what is effective membership is what you said. Effective membership is total membership minus vacancies. It is not about absence, it is about vacancy. Do not confuse about absence. If somebody is present or not present on a given day is immaterial. But how many seats are vacant has to be taken into consideration, and a majority of that would be effective majority. Okay, after it is passed with effective majority in the Rajya Sabha, then the proposal goes to the Lok Sabha. What is the majority with which it has to be passed in the Lok Sabha? It has to be passed with simple majority. Very, very important. So therefore, there is a distinction when it comes to the removal process of the president and the vice president. For the president, it can be introduced in either houses, but for the vice president, where it can be introduced? Only in the Rajya Sabha. For the president, it can be introduced in either houses, and it has to be passed with special majority in both the houses. Whereas in case of vice president, effective majority in the Rajya Sabha and simple majority in the Lok Sabha. Is it clear? So what is the answer for this question? Okay, what is a special majority for the president? Not less than 2/3 of the total membership of the house. So the answer for this question is Rajya Sabha. Under which article in the constitution did the president give his assent to the ordinance on electoral reforms which it was sent back to him by the union cabinet without making any changes? So here you don't have to worry about anything. Here you should know which is related to the ordinance making power. Which article? 123. But however, remember, under article 123 of the constitution, when the president issues any ordinance, that is not a discretionary power of the president. He is supposed to do that based on what? On the aid and advice of the Council of Ministers. So whenever any proposal is brought in front of the president doesn't have to immediately agree to it, because the president can send it once for reconsideration. So which article gives this power to the president to send it once for reconsideration? And it was brought in by which Constitutional Amendment Act? Now, two questions I have asked. Which article gives the president to send it for reconsideration any proposal? Don't think it like a bill that is presented in front of him, because whenever a bill is presented in front of the president, what are the options that can be exercised by the president is governed under article 111 of the constitution, where he can send it for reconsideration. That is a different thing. But here this is not a bill, it is like a proposal that is placed in front of the president. Apart from the bills, many advice can be given to the president, but not every advice is related to a bill which is presented in front of the president. So in case of the bills, he can send it for reconsideration under article 111 of the constitution. That we will also see, you also know it. But apart from the bills, when any proposal is brought in front of the president and when the cabinet is giving him the advice, he can send it once for reconsideration. And which article is giving this power? Very good, it is article 74 of the constitution. But which Constitutional Amendment Act made it mandatory for him to give the assent approval once it is again sent back to the president? 44th Constitutional Amendment Act. So therefore, the answer to this particular question is what? Article 123 of the Constitution. What is a similar power which is given to the governor under which article? Article 213 of the Constitution. So try to remember that also. For the governor, it is under article 213. So also remember what is there in the 44th Constitutional Amendment Act 1978. You should also remember this Article 74, which gives a power to the President to send it for reconsideration any advice which is presented in front of him. Consider the following statements. In the electoral college for the election of in the presidential election in India. So first of all, who constitutes the electoral college? I will discuss that. We will come to that particular point. Okay, first I will discuss that. Who are all part of the electoral college of the president? Elected MLAs, member of the legislative assemblies of all the states, and then you have elected MPs, members of parliament in both the houses, only the elected MPs, not the nominated MPs. And then apart from that, do you have any of the other people who are part of the electoral college? Elected MLAs in union territories. And what are the union territories? Puducherry and Delhi. What about the union territory? Because today the Jammu and Kashmir, which is a union territory, is also having a legislature and they have elected MLAs there also. Will they be part of the electoral college? Just think about it once and tell me. The elected MLAs in case of Jammu and Kashmir, will they be part of the electoral college? They are not part of the electoral college. Do not have any confusion. Because if you look into the constitution, the original constitution does not provide for the representation of the union territories. The representation to the union territories in the electoral college was brought in only by the 70th Constitutional Amendment Act. And by that amendment, specifically they have mentioned the elected MLAs in case of union territory of Delhi and Puducherry. But at that point of time, there was no issue for Jammu and Kashmir because Jammu and Kashmir was a state at that point of time. And only these two union territories were having the legislative body. So therefore, these two union territories were included. But recently in 2019, Jammu and Kashmir has become a union territory. So the moment they have become a union territory, they will not fall within the definition, they are not part of the state. So therefore, the MLAs there are not part of the electoral college. Presently, they are not part of the electoral college. I am repeating it. Can they become part of the electoral college in the future? Yes. There are two ways by which they can become part of the electoral college. One is if tomorrow Jammu and Kashmir is again converted back into a state, automatically the MLAs will become part of the electoral college. Or specifically you amend the constitution and you include the MLAs in case of union territory of Jammu and Kashmir also. So either of these two things has to happen if they have to become part of the electoral college. So otherwise they are not presently part of the electoral college. Is that clear? Okay, so with that come to the answer. Come to the question, statement 1. The value of vote of an elected member of a legislative assembly are equal. Is the value of vote of an MLA from the state of Tamil Nadu equal to that of the value of vote of an MLA from Kerala? It will never be the same. There may be a possibility if all the things are same, but by the theoretically it can never be the same. Okay, so definitely this is wrong. Why it is wrong? Because the value of vote of an MLA is calculated based on what? Population of that particular state in the denominator by, in the numerator by the number of elected MLAs in that particular state. So no two states will have the same population and the number of elected MLAs. So therefore the values cannot be the same. Okay. Now come to the second question. The value of vote of an elected member of parliament are equal. Is it true? Yes. For all the MPs, the value is the same. And if I have to put one more thing, between the MLAs of different state and the MPs, whose value is higher? The value of MP is far higher than value of MLA of any state. Which state MLA is having the highest value? Uttar Pradesh. You don't have to remember these values, but at least remember the principles. Okay, so with that, what is the answer in this particular case? So this is not going to be equal. Value of vote of an elected member of parliament are equal. And sometimes they can ask you the formulas also. So try to remember the formulas also. So what is the value to formula to calculate the value of vote of an MLA? Population divided by elected MLAs multiplied by 1 by 1000. How do you calculate the value of vote of an MP? total value of votes of all the MLAs, total value of valid votes of all the MLAs divided by elected MPs, both houses, that is Lok Sabha and Rajya Sabha. So then you will get the value of the MP. Okay, so try to remember any of those things can be asked. Which of the statements given above are correct? What is correct? 2 only is correct. Okay, I talked about the population. So which population is used for the purpose of calculating the value of vote of MLAs? For the election of the president, which census is used? 1971 census. And this 1971 census is likely to continue till what point of time? Anyone? Till what point of time? Yes? Till what point of time? Till the first census is published after the year 2026. So whenever the first census will be published after the year 2026, till that point of time, which census will be taken into account? 1971 census. So the answer is 2 only here. Come to the next question. Which one of the following amendments amendment to the Constitution of India empowers the President to send back any matter for the reconsideration of the Council of Ministers? 44th Constitutional Amendment Act 1978. And the 44th Constitutional Amendment Act 1978 also made it mandatory that it is obligatory on the part of the President to give the assent when it is sent back. Consider the following statements about the Attorney General. Advocate General or Attorney General? Definitely one question you can expect. Okay, so focus on these areas. Consider the following statements about the Attorney General of India. He or she is appointed by the President of India. True? Yes. It is only the President who can appoint on the aid and advice of the Union Council of Ministers. The only qualification for someone to be appointed as Attorney General of India is he or she should be qualified to be appointed as a judge of a Supreme Court. So can anyone tell me what is the qualification for someone to be appointed as a judge of a Supreme Court? They should have practiced as an advocate in a High Court for minimum 10 years, or they should have served as a judge of High Court for minimum 5 years, or a distinguished jurist in the opinion of the President. Along with that, in all the category, they should be a citizen of India. So then they are eligible to be appointed as a judge of a Supreme Court. So any of those people can be appointed as the Attorney General by the President. The service condition, salary, everything will be decided by the President. And they hold office during the pleasure of the President. When I say they hold office during the pleasure of the President, they can be removed by the President at any point of time. Okay. So here also same thing. The Attorney General will have the same privileges that of members of the Parliament, except what is called as the right to vote. So therefore, he can take part in the parliamentary proceedings, in any of the parliamentary committees. All those things are allowed. And will he have the right to have private clients? Yes. In this case also, he is only should not appear against the government. Otherwise, he can have private clients. And he has certain other privileges, is that he can be an audience in any court within the territory of India. So these are all the privileges that he has got. Okay. So come to the statement. So he must have the same qualifications as required to be appointed as a judge of a Supreme Court. Yes. So this is true. He must be a member of either House of Parliament. No, there is no such requirement. Okay. So even if he is a member of either House of Parliament, after appointment he cannot hold it. Okay. So that is the possibility. So it is definitely not a requirement. He can be removed by impeachment by the Parliament. He can be removed by the President at any point of time. That is, he holds office during the pleasure of the President. So which of the statements given above are correct? 1 and 2 only. Okay, so what is the answer to this question? 1971 census. There should not be any doubt. Okay, what is the census that is used? Because this year there is a lot of current issues that is coming with regard to delimitation also, which I will discuss when I take up the Parliament chapter in detail. But anyways, I just wanted to ask, when it comes to election to the Lok Sabha and the legislative assemblies today, the seats are decided based on which census? seats are decided based on which census? It is 1971 census. You should not have any doubt in this regard. I am talking about the number of seats. I am not talking about how the boundaries are drawn or how the boundaries are redrawn. The number of seats is strictly based on which census? 1971 census. No issues. Further in next class I will talk about the delimitation when I take up the parliament part. But the answer here is which census? 1971 census. Which of the following is part of the electoral college for the election of the president but does not form part of the forum for his impeachment? Who does not form? Assemblies. Think about it properly and tell me the question. Which one of the following is not part of the electoral college for the election of the president of India but does not form part forum for his impeachment? Assembly or the council? Assembly or council? There is again. Assembly, please raise your hand. Assembly. It is the assembly. Anyways, council is not part of the his selection process also. So assembly is part of it, but not part of the removal. Because for the removal of the president, who is part of the impeachment of the president? Only the members of the parliament, and both elected as well as the nominated members. And what is the majority with which he has to be impeached? Not less than 2/3 of the total membership of the house. Okay, just try to go through it. Give me the answer for this particular question. 123. There is a question from, okay, just listen to this question. Anyways, certain questions I am not taking it up because I will take it up in the order. Because if you ask me the question which is related to judiciary now, then the entire discussion may not be organized. But anyways, let me see how many of you know the answer. What is the difference, basic fundamental difference between what is a bail and a parole? That is related to judiciary topic, which I will subsequently discuss, because one student has asked me this particular question. I just wanted to put it. What is the basic difference between a bail and a parole? Bail is given to an individual who is not yet convicted in a court of law. He is not yet convicted, he is merely an accused. But parole is given to an individual who is already convicted in a court of law. He is convicted in a court of law, gone to jail, and a temporary relief is given in the form of a parole. There are other differences, but this is a basic difference. But anyways, when you ask me your question, one request from my side, try to ask a question from the relevant topic. Otherwise, the entire discussion will be so disorganized for your own benefit. Okay, so whatever is the doubt, I will take it up, but in the appropriate area, I will take up those discussions. Okay. Okay, so please read this question. Which one of the following statement is correct? The Prime Minister of India is free to choose his ministers only from among those who are members of either houses of the parliament. We have already seen that even someone who is not a member of parliament can be appointed as a minister. So therefore, this is not true. Can choose his cabinet colleagues after due counselling with the President of India in this regard. He doesn't have to consult the President. That is also not true. Has full discretion in the choice of persons who serve as the ministers in his cabinet. Is it true? Yes. He will just make the recommendation or he will just give the advice based on which the president will appoint. So this is definitely true. Has only limited powers in the choice of his cabinet colleagues because at the discretionary power vested in the President of India. No, it is the Prime Minister who will decide all those things. That is why he is called as a Prime Minister. He is the prime of all the ministers. If any minister is having a disagreement with the Prime Minister, then what is likely to happen? Either the minister has to give up the differences of opinion, or otherwise he has to resign. There is no other way, because it is ultimately the will of the Prime Minister as to how the other ministers will survive. Which one of the following is not explicitly stated in the Constitution of India but followed as a convention? So please try to answer this question. Go through it once. Which one of the following is not explicitly stated in the Constitution but followed as a convention? The finance minister to be a member of lower house. This is not explicitly mentioned in the Constitution, and there is no convention also. The finance minister can be from any house. We are not following any convention in this regard. A finance minister may not be from any of the house also. When Mr. Arun Jaitley was appointed as a finance minister, he was not even a member of parliament. Subsequently, he became a member of Rajya Sabha. So therefore, that is not a convention. The Prime Minister has to resign if he loses majority in the lower house. That is followed as a convention. That is not anywhere mentioned. But if the Prime Minister failed to do that, then the President will have a discretion to dismiss. So in order to avoid that embarrassment, the conventional practice is the Prime Ministers will resign. Okay. So this is definitely a conventional practice. All the parts of India are to be represented in the Council of Ministers. There is no such constitutional provision also, no such conventional practice also. But today, many of the governments are trying to do this. Why they are trying to do that? In order to provide representation to different parts of the country in the ministry. But it is not still a very healthy convention. In the event of both the President and the Vice President demitting the office simultaneously before the end of their tenure, the Speaker of the lower house of the Parliament will officiate as the President. There is no such convention, no such constitutional practice. What the Constitution says in this regard? When both the President and the Vice President demit the office simultaneously, who will officiate the office of the President? Does the Constitution say that? Yes, sir. Yes or no? Yes, no? How many of you think yes? The Constitution does not say that. The Constitution only gives the power to the Parliament to decide the President in case of contingencies. Under Article 70 of the Constitution, it is nowhere directly mentioned in the Constitution. So accordingly, the Parliament has enacted a law, and by that law, who will become the President of India when both the President and the Vice President is not there? It is the Chief Justice of India. And even if the Chief Justice of India is not there, then who will act as the President? The senior most judge of the Supreme Court. If that person is not there, the next person. So this is what is given in the law that is made by the Parliament, not directly in the Constitution. The Constitution only says when there is no President, then the Vice President. Then if both are not there, then it is a contingency. So in case of contingency, the law can be made by the Parliament. Accordingly, the law has been made. But anyways, it is not part of the convention also. So what is the answer? Answer is option B. The Chief Minister of a state is not eligible to vote in the presidential election if he is not part of the electoral college. So when he is not part of, when he will not be part of the electoral college of the President? When he himself is a candidate. If he himself is a candidate, what is the case? Is it possible, can he himself be a candidate? Can a Chief Minister contest election of the President without resigning from his office? Is it possible? Because one of the qualification to contest election is he or she should not hold on to office of profit. But there are exceptions. Very good. But there are exceptions. So what are all the things, what are all exempted under the Constitution? The post of President, the post of Vice President, the post of governors of the state, and the post of ministers, be at the union level or at the state level. So therefore, a sitting Chief Minister can contest election, no problem, and therefore he will also have the right to vote if he is part of the electoral college. So this is not the case. So but in which case he will not have the right to vote? If he is a member of upper house of the state legislature, that is if he is part of the legislative council. What about if he is a caretaker chief minister? He can. Who is a caretaker chief minister? So normally the position of the caretaker chief minister is when the election is pending. So at that point of time, he is considered to be a caretaker chief minister. Okay, so which of the following statements regarding the election of the President of India is correct? Okay, so come to statement A. A candidate securing more number of votes than the other candidate is automatically elected. Is it true? Leave that word automatically, nothing. So that is not the concern. But the key word here is a candidate securing more number of votes than the other candidates. If you say a candidate securing more number of votes than the other candidates, then it is based on the first past the post system. So the key here is not automatically. We are not concerned about how he gets appointed and what is the process. So that is not the concern. But constitutionally, the concern here is you should be aware of whether he is elected based on first past the post system or on a basis of electoral quota. The president is elected based on an electoral quota. So therefore, if he gets more number of votes than all the other candidates, he is not considered to be elected, although he may have more number of votes, unless and until somebody gets what is called as the electoral quota. So therefore, this particular statement may not be right. So what is the electoral quota? Can anyone tell me in the election of the president? What is the electoral quota? To put it in a very simple way, it should be more than 50% of the valid votes, more than 50% of the value of the valid votes. So total value of the valid votes divided by 2 plus 1. So if you put that, then it becomes the electoral quota. So it is not just because he gets more number of votes. So therefore that statement is wrong. The Supreme Court has no jurisdiction in any doubt or dispute arising in connection with the election of the president. That is false. In fact, the only court which can have the jurisdiction with regard to these disputes is the Supreme Court of India. So this is also wrong. The president election cannot take place when one or more state assemblies stand dissolved, because all the state assemblies form part of the electoral college. So while it is partially true, but it is very clearly said in the constitution, just because there is some vacancies in the electoral college, you cannot postpone the election of the president, because the president election has to happen every 5 years, because the country cannot function without the president. So whether some of the state, there is a state legislative assembly dissolved or not, still the election has to happen, even if there is a vacancy. So this is also wrong. The total value of votes allotted to both the houses of parliament is much more than the total value of votes of all the states taken together. So which one of the statements regarding the election of the president is correct? A candidate securing more number of votes than the other candidate. Okay, it's not automatically elected. Sorry. I thought that it is automatically elected. It's not automatically elected. So from here it was not visible. Okay. Okay, so it is not automatically elected. So that means I thought it is automatically elected. So this is wrong. This is wrong. Why this is wrong? The total value of votes allotted to both the houses of the parliament is much more than the total value of votes to the state legislature. If you say almost they are equal, the value of votes of all the MLAs on one side and the value of votes of all the MLAs of all the states, they are almost same. How they have calculated this formula in order to ensure that there is equal representation to all the states on the one hand and the union on the other side. So in electing the president of India, so therefore the values are almost the same. So okay, so this is also wrong. So what is the answer here? It is A. So the candidates are not automatically elected because it is not based on the first past the post system, but on the basis of now automatically is important. Okay, so in this case, because of that not, it becomes important because it is based on the electoral quota, not based on the first past the post system. So what is the answer here? Option A. Okay, so come to the next question. So what is Article 78 talks about primarily? Very good. It is the duty of the Prime Minister towards the President. So there are some of the duties that the Prime Minister has to apprise the President of various developments. If any legislations are to be introduced, that has to be informed. If these things are not informed, then the President can call upon the Prime Minister to do all those things. And sometimes if any decision has been individually taken by a particular minister or by the Prime Minister where the approval of other ministers are not there, the President can direct the Prime Minister to consult with the other ministers also. So these are all possible under Article 78 of the Constitution. Theoretically, but practically, most of the President has not exercised these powers. Why the President would not exercise his power? Because in the first place, the President is chosen like that. Because who is supposed to elect the President? It is the ruling party. So therefore, they will take a President who will not create any problem. Because in the history, there are presidents who have created problem to various governments. Because once a president is elected, then you cannot remove the president. Also, theoretically, you can remove the president, but impeach a president, what is the majority that is required? 2/3 of the total membership of the House. So, if the president is creating problem to the government, the opposition will enjoy that. So, why will the opposition support in removing the president? So, therefore, it becomes really impossible to remove the president of India. Okay, but that is the reason why the parties, the government is also very careful in choosing the president. Anyways, one of the following which does not, with which does Article 78 of the Constitution deals with? Okay, so what are all the things that is there under Article 78? So please give me the answer for this. Emergency powers of the President, it is nowhere related to the emergency powers. The Prime Minister's duty regarding keeping the President informed about the government decisions and policies, yes. The President power to send advisory messages to the Parliament, no. This is not there under Article 78. So try to understand Article 78 only deals with the relation between the President and the other executives, nothing related to the legislature. But can the President send advices to the Parliament? Yes, he can send messages to the Parliament, but under Article 86 of the Constitution, not here under Article 78. The President power to get information from the Council of Ministers, is that true? Yes, so that is true. So what is the answer here? 214 only. In case of dispute in the presidential, in the presidential election is referred to where? It is referred to the Supreme Court, not to the Election Commission of India. The Election Commission of India has no role in this regard. The only authority who can entertain any petition with regard to the dispute of the election of president is the Supreme Court of India. But who can take it to the notice of the Supreme Court? Who can challenge the election of the president? Anyone? Anyone in the sense like you and me can challenge it? Very good. Any member of electoral college or a person who has contested in the election of the president. So only they can file a petition as per the law that has been made in this regard. Because they are the one, they will have the locus standi in that particular case. So what is the answer here? Supreme Court. Okay, come to the next question. A bill passed by both the houses of the Parliament is sent to the President for assent. The President send it back to the legislature for reconsideration. If the legislature again send it back to the President without making any changes, the President, but before going to the answer, tell me which article is related to this particular question. Article 111. See, Article 111 is specifically related to the bills. Article 74 in general, but Article 111 is the one which is related to the bills. So whenever a bill is presented to the President, what are the options that the President can exercise? He can give the assent, he can withhold the assent, he can send it for reconsideration. Giving the assent means the bill becomes an act. If he is withholding the assent means, that means he is not giving the assent. He is communicating he is not going to give the assent, but he cannot do it under all the circumstances because the President is bound to act on the aid and advice of the Council of Ministers. So therefore, when he can withhold the assent to the bill? Only in certain circumstances. Suppose if the bill is passed to the president and before the president act, there is a no confidence motion against the government is dismissed, then he can use his withholding power. And then at any time he can send it for reconsideration. Once he can send it for reconsideration. But if the bill is again sent back with or without any changes, then the president is bound to give the assent. That's the only option that he has got. Students keep asking me that what even after that he is sitting on top of that particular bill because there is no time limit as to when he has to give the assent. That he can do, but the constitution does not allow for it. The constitution does not explicitly say for that. The constitution only explicitly says what? That he has to give the assent whenever it is sent back. But if the president is again sitting on that particular bill, the only option that is left with the government is to impeach the president. But the government cannot do that because they do not have the majority. That is the reason they will be very careful in choosing the president in the first place to avoid such a situation to arise in the first place. Okay, so what is the answer? Can send the bill for reconsideration again, can take the help of the Supreme Court, can arrange for a referendum, not at all possible, all the three things. The only thing that he has to do is, of the options given is that he must give the assent to it. Yes, anybody has a question? Somebody asked me a question. Is it clear? So he has to give the assent to that particular bill. Okay, so there are some differences when I take up Article 111. Okay, so here in certain cases he will not be able to send it for reconsideration. In certain type of bill, the only option that he has got is he has to give the assent. In case of which bill he has to give the assent? The only option. In case of a constitutional amendment bill. In case of a constitutional amendment bill, the only option he has got is what? He has to give the assent. There is no other option, which has been made mandatory by the 24th Constitutional Amendment Act. In case of a money bill, he can give the assent and he can withhold the assent also, but he cannot send it for reconsideration. So therefore, giving the assent to the bill is only in case of the constitutional amendment bill. In case of a money bill, he can withhold the assent to the bill under certain conditions, but he will not be able to send it for reconsideration. Is that clear? The dispute regarding the election of Prime Minister and the President can be decided by whom? The dispute regarding the election of the Prime Minister and the President can be decided by? There is nothing common to both the things. For the President, it is the Supreme Court. For the Prime Minister, if there is any dispute with regard to his election, it will be first decided by the Election Commission of India, because he is just a member of Parliament, nothing more than that. After the Election Commission of India decides that, the matter will go to the High Court concerned, and then subsequently it will go to the Supreme Court of India. So there is nothing which is common to both the cases. Okay, so what is the answer here? So in both the cases, the dispute regarding the election of Prime Minister and the President, nothing is common. So it is none of the above. The answer is option D. Okay, do you know that in the history of India, once the election of Prime Minister was held to be invalid? It was the election of Prime Minister Indira Gandhi. So therefore, when this matter was pending in the Supreme Court, an amendment was brought to the Constitution, and that amendment made that the Supreme Court will not have the jurisdiction to hear this particular matter. When the matter was pending in the Supreme Court, after one hearing, before the next hearing, the amendment was passed. And when the next hearing came, the Council of Prime Minister Indira Gandhi said the Supreme Court does not have the jurisdiction to look into this particular matter, because as per the Constitution, the Parliament has a power to make a law, and by that law they will decide the authority who can hear this particular matter. And then subsequently the Supreme Court strike down that particular amendment, held that this amendment is violative of the basic structure. But anyways, that election was held to be valid by the Supreme Court in the Rajnarayan case, but that amendment was held to be invalid. The question is, which amendment brought in this particular change? Is a question. Which amendment has brought in this particular change in the Constitution? Not the 42nd, 44th, no. Which amendment? 39th Constitutional Amendment Act. Okay, so once was asked in UPSC, you should be aware of this because it is asked in UPSC. 39th Constitutional Amendment Act. Okay, please come to the next question. Consider the following statements with regard to the presidential election in our country. The value of vote of MLAs in the electoral college is not the same for different states. Is it true? Yes, it is not the same because we know how it is calculated. See, this is one theme repeatedly asked in UPSC. Be very clear about these areas. Anyone who is elected as the president need to secure an electoral quota which is more than 50% of the total valid votes polled. Yes, in fact, the most appropriate thing is, it is true in essence, it is more than 50% of the value of total valid votes polled. Okay, so anyways, this particular statement is true, but it is about the value that is very important. A legislator voting in the election contrary to the party direction is liable to be disqualified on the grounds of defection. Is it true that now, if suppose a member of parliament, suppose a person who is part of the electoral college, if he votes contrary to the party direction in the presidential election, why he will not be liable to be disqualified under the anti-defection law? Because anti-defection law clearly says if you are not acting as per the party direction or voting contrary to the party direction, you can be disqualified. But how is it not possible here? Because it is based on secret ballot, because nobody will be able to know to whom he has exercised this vote. Okay, so that is the reason that the anti-defection law does not apply in this particular case. So this is wrong. So which of the statements given above are incorrect? What is the answer? 3 only. Come to the next question. Which of the following is the discretionary power granted to the governors under the Constitution of India? So under the Constitution, who is having more discretionary power? Is it the president or the governors? The governor has a lot of discretionary power. So let us try to see some of the discretionary powers. Giving assent to the bill, is it a discretionary power? Giving assent to the bill is not a discretionary power of the governor, but unfortunately today many governors are thinking that it is their discretionary powers. That is why the states have to pass a resolution to the center to protect the states. So, but that is not their discretionary power. So, which article is dealing with the power of the governor with regard to giving assent to the bills? Which article? For the president it is article 111, and for the governor it is 201 or 200? 200 or 201? 10? It is article 200. It is article 200 that deals with the power of the governor. So therefore, what is article 201? See, the options that the governor can exercise is there only in article 200. But one of the options under article 200 is he can also reserve the bill for the consideration of the president. So if the governor reserves a bill for the consideration of the president, then what the president can do is there in article 201. But the governor's power is only in article 200 of the Constitution. Is it clear? So what are the things? So this is again a very important area because a lot of controversies have happened here. Now what are the options that the governor can exercise under article 200? This one. Left side. No, that is okay. Okay, leave it. Okay, so article 200, what are the options that is available? One is give assent. Withhold the assent. Send it for reconsideration. and then the last thing is reserve for the president. Okay, so among all the 4 options, the Supreme Court has made it very clear. Okay, before I come to the Supreme Court, if the governor exercises the option of reserving the bill for the consideration of the president, then the fate of the bill will be decided henceforth only by the president. The governor has no role in this regard. But if exercise any of these 3 options, then it will be still decided by the governor. Okay, now if he gives the assent, no problem. Withhold the assent means that he is not giving the assent to the bill. But what has happened in the recent past is most of the governors, especially the governors from the states which is ruled by the opposition parties or not in coalition with the central government, they have been withholding a lot of bills. So some of the states have gone to the Supreme Court. They filed a petition, including states like Tamil Nadu, Kerala, Punjab, Bengal. So some of the states have gone to the Supreme Court. The Supreme Court categorically said, okay, the governor can give the assent. The governor can send it for reconsideration. That is one of the option. When they send it for reconsideration, if the bill is again sent back with or without changes, then the governor must give the assent. But if the governor is withholding the assent, and the Supreme Court categorically made it very clear, withholding the assent to the bill is not a discretionary power of the governor. If the governor chooses to withhold the assent to the bill, then as soon as possible he has to send it for reconsideration. So withholding the assent to the bill should be followed by what? Reconsideration. Either you can use this or you can use it directly. If you are choosing to do this, this has to be followed with what? Sending it for reconsideration. So when it is again sent back, then he has to give the assent to the bill. So this is what you'll have to understand. Now why? Because you can withhold the assent to the bill under certain conditions. Say for example that the bill has been sent to the governor, but the legislative assembly is dissolved. So therefore you can withhold. But when the legislative assembly is there, when the council of ministers is there, can you withhold the bill for a long period of time? And that means you are preventing a democratically elected government from making any legislations. So therefore, whenever withholding the assent to the bill, you will have to send it for reconsideration as soon as possible. And when they send it back, again you will have to give the assent within a reasonable time frame. But the biggest concern even in this particular judgment is they have said it has to be done within a reasonable time frame. But what is this reasonable time frame is again not given in the judgment. Okay, so that's one of the biggest concern. Okay, so with that you please come to the question. Which of the following are the discretionary powers granted to the governors under the Constitution of India? Giving assent to the bill, is it a discretionary power? Reserving bills for the consideration of the president, that is his discretionary power. That means if the governor chooses to reserve any bill for the consideration of the president, can he do it? Yes. But in one case it is mandatory. In all the other cases it is discretionary, but in one case there is no discretion even to the governor. He has to definitely reserve the bill for the consideration of the president. If any bill that is passed by the legislature is trying to take away the powers of the High Court concern, which is given to the courts by the constitution or by any of the other laws, in that case it is mandatory for the governor to reserve the bill for the consideration of the president. In all other cases, it is his discretionary power. Reading selectively the text during the special address to the houses of the state legislature. Is it a discretionary power to the governor? That means when I say reading selectively the text during the special address which is made by the governor, which means I have already thought or you might have come across something which is called as the motion of thanks. Have you heard of the motion of thanks? So motion of thanks is usually a motion which is introduced after a special address is made by the president and a special address is made by the governor also. And when does a special address happens? When normally the special address happens? The special address normally happens in couple of occasions. It is during the first session every year, that is budget session, and the first session after the general elections in case of the union, and the first session after the election to the state legislature. In both the cases, address will be prepared by the government and that address will be delivered by the governor in the state legislature, president in the parliament. Now, after the president or the governor delivers a speech, to thank the president or the governor, a motion is introduced. That is basically what is called as motion of thanks. And this motion of thanks is also very important. It will be debated, it will be put to vote, and if the motion of thanks is not passed, then it is automatically amounting to the no confidence motion. So therefore, this motion of thanks has to be passed in the Lok Sabha and the motion of thanks has to be passed in the Legislative Assembly. If they are not passed in the other house, no issue, but in these houses it has to be passed. Now, with regard to the address that is made by the governor, does he have any discretion to change the words that is given by the government? That is the question. The constitution does not give any discretion to the governor. Why this is? Because this is also again part of the current affairs. So, the governor of Tamil Nadu, when he was making an address prepared by the Tamil Nadu government, he skipped some of the portions. And then later he gave an explanation, he was skipping all those things because he felt morally it was wrong for him to read all those things. So, the constitution does not give any discretion explicitly with regard to the governor, but unfortunately under the constitution, if any governor is doing whatever he wants to do, the state government cannot do anything against the governor. Why? Because the governor can be removed by whom? Only by the President of India. So, the only remedy that they have got is they can go to the court. So, that is the only thing that can happen. So, here also there is no such discretion that is given to them. Sending report to the president to impose president rule in a state. What about this? Yes, they have a discretion in this regard. Under which article they have this discretion? Article 356. You will have to add 100 to that. 4 is a 256, just add 100. So, it is article 356 of the constitution. So, what is the answer in this case? So, it is asking about what? Which of the statements are correct or incorrect? So, correct is what? 214 only. Okay, let's come to the next question. Consider the following statements regarding the governor of a state under the Constitution of India. A person who is appointed as a governor should be a person normally outside that particular state. Does the Constitution say anything in this regard? The Constitution does not say anything in this particular regard. What is the qualification that is given for the governor? He should be a citizen and should have completed 35 years of age. Nothing more than that is given in the Constitution. So, this is a recommendation that is given by the Sarkariya Commission, that normally he should be outside the state, but the recommendation till this point of time is remaining only as a recommendation. So, it is not part of the Constitution. Okay. So, therefore, this is not the correct thing. The governor holds office during the pleasure of the president and can be removed by him even before the completion of his term. Is it true? If you look into the Constitution says that the normal tenure of the governor is 5 years, but subject to the doctrine of pleasure. That means, though the tenure is there 5 years, but he may be removed even before that if the president is not happy. So, this is definitely true. The state legislature is empowered under the Constitution to pass a resolution for the removal of the governor, which is binding upon the president. There is no such provision in the Constitution. So, this is definitely not true. So, the only authority who can remove the governor is, it is the president. And what is the ground on which he can be removed? What is the ground on which he is removed? There is no ground that is mentioned. The only thing that is mentioned is pleasure of the president. That means, if the president is not happy, then they can remove the governor. Okay. So, consider the following statements regarding the governor of the state. What is the answer here? It is 2 only. Okay, so which of the following statement is true? Attorney General and Advocate General, again I am repeating it, small topic, but you can expect a question. Which of the following statement is true with regard to the Attorney General of India? Statement 1. The Attorney General of India is appointed by the President of India based on the recommendation of a select committee headed by the Prime Minister along with the leader of opposition in the Lok Sabha and the Chief Justice of India. This is all just to confuse you. There is no such provision. Who appoints Attorney General? The President on the advice of the Council of Ministers, maybe even only the Prime Minister. Okay. The Attorney General is a first law officer of the country and is also the member of the cabinet in the government. Partially it is true, he is a first law officer of the government, that is okay, but he is not member of the cabinet. The Attorney General has a right to take part in the proceedings in the Parliament and its committees, and is also entitled to vote in the Houses of the Parliament. This is again partially true and partially wrong. So, he is not entitled to vote. So, that is not his privilege. So, what is the answer here? None of the above. Which of the following statements are true regarding the ordinance making power of the President and the governors? So, what are the articles that is related to this? So, for the President it is article 123 and for the governor it is article 213. So, with that you please come statement 1. Promulgation of ordinance is the discretionary power of the President and the governors. No. Promulgation of ordinance is strictly based on the aid and advice of the respective Council of Ministers. Second thing is, repeated repromulgation of ordinance is recognized in the Constitution and by the courts. In fact, it is not mentioned in the Constitution, the word repromulgation, but the courts have said that repromulgation of ordinance is a fraud on the constitutional power. Now, what does it mean by repromulgation of ordinances? If the same ordinance is promulgated again and again. So, when the Supreme Court said that if the same ordinance is promulgated again and again, the government tried to change few words here and there, and they said that it is not the same ordinance. Then the court said it is in essence that the same ordinance should not be promulgated again and again, then that would amount to repromulgation of an ordinance. So, therefore, that is fraud on the constitutional power, because ordinance is only a temporary law making power. Ordinance is only a temporary legislation and it must be approved by the legislature within a period of 6 months after it is promulgated. Is it true? True or false? It is not true. It is not 6 months. It has to be within 6 weeks after the both houses of the Parliament comes into session, or both houses of the state legislature comes into session. So, the time is only 6 weeks and not 6 months. UPSC exactly know where you will make mistakes. You will be little carried away. You might know the answer, but there is a possibility we all get carried away in the examination process. So, this is one such area, not 6 months, it is 6 weeks. So, all the 3 statements are wrong. Fourth is also there, okay. Ordinance making power of the President and the Governor is coextensive with that of the power of the respective legislature. Is it true? Coextensive. What does it mean by coextensive? That means on whatever areas the Parliament can make law, is it possible for the state, is it possible for the President to issue an ordinance? On whatever area the state legislature can make law, is it possible for the Governor to issue an ordinance? Yes, they are coextensive. So, in all the areas where the Parliament can make a law, the President can promulgate the ordinance. I am talking about the ordinary laws, whatever be the case, the ordinary laws or money bills, whatever it is. Can a money bill be, instead of making a money bill getting passed in the legislature, can it be issued as an ordinance? That is also possible, because their power is coextensive. The only exception is that while a constitutional amendment can be done by the Parliament, where the President cannot bring it in the form of an ordinance, otherwise it is coextensive. So, in general, this statement is true. So, this is true. So, what is the answer here? Which of the options given above are correct? So, option 4 is the only correct answer. So, there are few things that you will have to keep in your mind with regard to ordinances. One is you should be clear that it is not the discretionary power. Second, you should be clear that under what circumstances the ordinance can be issued. So, the ordinance can be issued only when either of the houses are not in session, or at least one of the houses is not in session. And then whenever an ordinance is issued, it has to be approved by the respective legislature within a period of 6 weeks. When both houses of the Parliament comes to session, they have to be approved within a period of 6 weeks. And if they do not approve it, automatically the ordinance will lapse. And even before the 6 weeks, the President or the Governor can revoke the ordinance at any point of time. So, try to remember all those things, okay. Come to the next question. Which of the following is true regarding the Advocate General of a state? The Advocate General of a state holds office during the pleasure of the President. No, it is not the pleasure of the President, but it is a pleasure of whom? pleasure of the governor. He or she has a right to audience in any court within the territory of the concerned state and also take part in the proceedings of the state legislature without the right to vote. Is it true? Yes, this privilege he has got. So choose a correct answer from the codes given below. Is only option 2. 2 only is the answer. Come to the next question. Which of the following? Okay, so next question. Recently means couple of years back this happened. Recently, the governor of Kerala threatened to sack the ministers who lowered the dignity of his office. In this context, which of the following reflects the correct constitutional position of governor in our constitutional system? 1. The chief minister and the other ministers are appointed by the governor and holds office during his pleasure, which also means they can be removed by the governor at his or her discretion. Is it true? Okay, instead of the second part of the statement, if the statement is the chief minister and the other ministers occupy the office during the pleasure of the governor, is that true? That is true. That is definitely mentioned in the constitution, but you'll have to understand as to what is this doctrine of pleasure. That is what is very important. So again I am repeating it, if the statement is saying that the chief minister and the other ministers hold office during the pleasure of the governor, that is definitely true. But what is the meaning of this doctrine of pleasure? That means it is not that the governor can exercise his power at any point of time. When the governor can exercise his discretion, the governor can exercise the discretion only when the council of ministers lose majority in the legislative assembly. As long as they have the majority in the legislative assembly, the governor cannot exercise his power. Is that clear? So now with that you come to this statement. The chief minister and the other ministers are appointed by the governor and holds office during the pleasure, which also means they can be removed by the governor at his or her discretion. No, it is not definitely their discretionary power. The members of the state civil service holds office during the pleasure of the governor and can be removed at any point of time by him. Is it true? The members of the state civil service holds office during the pleasure of the governor. Is that true? Not the entire statement. The members of the state civil service holds office during the pleasure of the governor. Is it true? The member of the state civil service holds office during the pleasure of the governor, and the member of the union service holds office during the pleasure of the president. So this is true. But the next part, and they can be removed at any point of time, that is definitely not true. Okay, so this is also wrong. So in this context, you should also be aware of all these provisions. Article 309, Article 310 and Article 311. Is there anyone in the class who can tell me what all these articles means? All the 3 articles, Article 309, 310 and 311. So what this article is about? Yes, at least one article of the 3 who can give me as to what this article provides for. No, you will have to say it to me, not to yourself. So many people are giving the answer, but it is only to you that you know what you are saying. Okay, anyone who can tell me? Okay, Article 309 of the Constitution is talking about who can determine the service conditions of the members of the state service and the union service. So for the members of the state service, the state legislature can make a law and determine the service conditions. And for the members of the union, the parliament can make a law and they can determine their service conditions. So suppose if you enter into the all India service, or for that matter any union service, who will determine your service condition? The parliament has the power to make the law. Accordingly, the parliament has enacted the All India Services Act, Central Civil Services Act. So if you get into the state services, the respective state legislature can make a law, and that power is given under Article 309. What is Article 310 of the Constitution? It is talking about doctrine of pleasure. It is saying that all the members of the state service hold office during the pleasure of the governor. and all the members of the central service holds office during the pleasure of the president. But however, why this particular statement is wrong when I say that the governor can remove at his pleasure at any point of time, can be removed at any point of time by him is the issue here. Why? Because this doctrine of pleasure has to be read along with a condition which is given under Article 311, that no person, be it in a central service or in the state service, they can be removed from the service without giving them a reasonable opportunity to be heard. So here they are following the principle of natural justice. They should be given an opportunity. An inquiry has to be conducted, an opportunity should be given for them to explain. So at the discretion, removing them is not possible. So the protection is given under Article 311 of the Constitution. So in this regard, what is the answer in this particular case? It is neither 1 nor 2. Shall I move forward to the next question? Louder? Okay. So come, we will go to the next question. Consider the following statements regarding the pardoning powers of the President and the Governors under the Constitution of India. The President and the Governors must exercise their pardoning powers only based on the aid and advice of the Council of Ministers. So the first thing is, what is the relevant article here? So for the President it is Article 72 and for the Governor it is Article 161. In both the cases, try to understand the exercise their power based on the aid and advice of the respective Council of Ministers. Okay, so this is definitely true. It is not their discretionary powers. So this is true. In case of mercy petition regarding the death sentence, the President is supposed to dispose them in a reasonable time frame. Otherwise, it is a violation of their right to life and personal liberty. Is it true? Yes. Though it is not directly given in the Constitution, the Supreme Court of India has categorically said that it should be disposed of within a reasonable time frame, and if they fail to do that, then that would amount to violation of the right to life and liberty of an individual, and therefore the Supreme Court can give a remedy also if there is a violation of fundamental right. What is the remedy that the Supreme Court of India can do? So many times what the Supreme Court of India has done is, they have commuted the death sentence and they have converted that into what is called as life imprisonment. Okay, so that is very much possible. Under the Constitution of India means not necessarily it is mentioned in the Constitution. Whatever the interpretation that the Supreme Court gives with regard to the Constitution is also under the Constitution of India. So for example, if you talk about the Constitution of India provides for the due process of law, that is true, it is not directly mentioned, but it is an interpretation that is given by the courts. You will have to only see that whether it is there in an ordinary law or it is not there in the Constitution. So if the interpretation is given by the courts, it is under the Constitution. Under special circumstances, the petitioner has the right to oral hearing in front of the President while filling the mercy petition. What about it? So one of the things that you have to remember is, whenever the mercy petitions are filed to the President or for that matter to the Governor, there is no right to oral hearing. So whatever they want to present, it is only in the form of written submissions. Okay, it is not a court to go and argue or to present your case. So this is definitely not the answer. So what is the answer here? They are asking incorrect. Okay, so the right answer is option 3 only. Come to the next question. Consider the following statements regarding the removal of governor under the Constitution of India. So presently, how the governor can be removed? The governor can be removed by the President at any time based on the pleasure doctrine of the President. So the governor, according to the Constitution, holds office during the pleasure of the President. Yes, he holds office during the pleasure of the President. The Punchi Commission, what is this Punchi Commission? It is related to what subject matter? It is related to center-state relationship. Very good. So the Punchi Commission was the latest commission. Before that, we had one thing which is called a Sarkaria Commission. So UPSC sometimes pick some of the statements and some of the recommendations and put it as a part of a question also. Both the commissions have extensively talked about the position of governor. One thing that both the commissions have in common is both the commissions wanted to make the office of the governor more independent, and by making the office of the governor more independent, they wanted to provide the states to function effectively, so that the center does not use the power of center does not prevent the states from doing anything through the office of the governor. So to that extent they have given recommendation. Now look into this recommendation. The Punchi Commission recommended for that the governor to be removed through the process of impeachment by the state legislature. This is one of the recommendation that is given by the Punchi Commission. Now Sarkaria Commission has also given recommendation, not the same recommendation, but the Sarkaria Commission in general said that the office of the governor should be more independent. But it is a Punchi Commission which explicitly said that the doctrine of pressure of the president or the pressure of the president word should be removed, and to bring in a different process for the removal of the governor, similar to that of the president, how he is removed. In the same way, the governor shall be removed by the state legislature. So therefore, this particular statement is true. So what is the answer in this case? Which of the following or the statements given above are incorrect? What is the answer? It is neither one nor two. Okay, so which commission recommended that the governor shall be an outsider, and which commission recommended that the governor should be someone who is retired from active politics before he is appointed? Someone who should have retired from active politics if at all a politician is appointed. That is also Sarkaria Commission. Okay, but those are all not mentioned in the constitution. It is only the recommendation. Okay, so please come to the next question. Consider the following statements with regard to the Constitution of India. Statement 1. The normal function of Vice President of India is to act as the ex officio chairman of Rajya Sabha. Is it true? Yes, that is the normal function. Apart from that, does the Vice President do any of the other function? Yes, he may discharge the duties of the President when there is an absence or vacancy to the office of the President. But when he is discharging the duties of the President, will you also officiate the Rajya Sabha? So at the time, who will be officiating the chairman of Rajya Sabha? The deputy chairman. Okay, so normally this is the power. So this is definitely true. The Vice President is elected indirectly by an electoral college comprising of members of both houses of the Parliament. Is that true? Does it consist of members of both houses of the Parliament? Yes, if you see the electoral college of the Vice President, it comprises of members of both the houses of the Parliament. There is no distinction between elected member and nominated member. So it includes the members of both houses of Parliament. He is also elected indirectly, yes. Only limited people are part of electoral college. The value of vote of members of the electoral college of the Vice President may vary from state to state depending upon the population of that state. Is it true? There is no such provision that is there in the constitution. In fact, the MLAs are not part of the electoral college. It is only the MPs who are part of the electoral college, and no such provision is given in the constitution. Okay. So which of the statements given above are incorrect? What is the answer? It is 3 only. The Prime Minister of India at any time, the Prime Minister of India at any time, at the time of his or her appointment. So what is the answer? Please read this question. Need not necessarily be a member of the House of Parliament, but must become a member of the House within 6 months. Is that true? Okay. Need not necessarily be a member of the House of the Parliament, but must become a member of Lok Sabha within 6 months. Not necessarily. Now, why this is important is, though we have following the parliamentary system similar to that of the British parliamentary system, we are not almost identical. We are maybe similar but not identical. In Britain, is it the case? In United Kingdom? In United Kingdom, the Prime Minister can be only from their lower house, that is only from their House of Commons, but that is not the case in India. So sometimes a question can come from the distinction also. Must be a member of one of the houses of the Parliament at the time of appointment, not necessarily. Can you give me examples of Prime Ministers who are not member of Parliament? No, Mr. Manmohan Singh was a member of Parliament. Rajiv Gandhi was not a member of Parliament. I think Prime Minister Indira Gandhi was also not a member of parliament when she was initially appointed. So must be a member of Lok Sabha, not necessarily. So this is all wrong. Need not necessarily be a member of one of the houses of the parliament, but must become a member of the house within a period of 6 months. Can be elected or nominated, but they should become a member of parliament. Consider the following statements. The Council of Ministers in the centre shall be collectively responsible to the parliament. Is it true? Very, very important. The constitution specifically says that they should be collectively responsible to the Lok Sabha and not to the parliament in general. Why it is specifically to the Lok Sabha? Because it is only to the Lok Sabha they should always have a majority. So therefore, the right answer is only Lok Sabha, not the parliament. The union ministers shall hold office during the pleasure of the president. Is it true? Yes, to that extent it is true. They hold office during the pleasure of the president. But if there is a question on what is this pleasure of the president, when it can be exercised, can it be exercised at the discretion of the president? No. Only when they lose a majority in the Lok Sabha, then they can exercise this pleasure. The Prime Minister shall communicate to the President about the proposals for legislation. Is it true? Under which article? Article? No doubt, we have just discussed this, Article 78 of the Constitution. So what is the answer? 2 and 3 only. Come to the next question. According to the Constitution of India, it is a duty of the President of India to cause to be laid before the Parliament which of the following. So as per the Constitution, the President has to submit some of the reports. Normally there are certain commissions which are all appointed by the President of India. So therefore those commissions will submit the report back to the President. But in a parliamentary democracy, to make the government accountable, executives accountable, these reports will be placed in front of the parliament so that the parliament can scrutinize and they can ask questions. So considering this, based on whatever I said, what could be the answer? The recommendations of the Union Finance Commission. Who appoints the members of the Finance Commission? President. So will it be a correct thing? Yes, constitutionally also he has to submit the report to the parliament. So this is true. The report of the Public Accounts Committee, yes or no? Why no? The report of Public Accounts Committee, the President does not appoint the Public Accounts Committee. The President has nothing to do with the Public Accounts Committee because Public Accounts Committee is part of the legislature and the members of the Public Accounts Committee are elected. And how they are elected? What is the principle on which they are elected? Can anyone recollect? Okay, at least tell me what is the composition of this Public Accounts Committee? Very good, 15 plus 7, 15 in case of Lok Sabha, 7 in case of Rajya Sabha. So this is one of the financial committees in the parliament. But however, there is nothing that the President has got any relation with these committees. This committee is a parliamentary committee and the members of this committee are elected from among the members of the parliament. Very, very important. They are elected based on the principle of proportional representation by means of single transfer vote. Anyways, I will discuss this when I take up the parliament chapter in detail, but try to understand this is a financial committee which has got representation from both Lok Sabha as well as Rajya Sabha. And from among the members, one person is appointed as a chairperson. So who appoints the chairperson of the Public Accounts Committee? The Speaker of the Lok Sabha appoints a chairperson of the Public Accounts Committee. So therefore, the chairperson of the Public Accounts Committee is from the ruling party or from the opposition party? Opposition or ruling? What is given in the Constitution? You tell me what is given in the Constitution. Nothing is given in the Constitution. In fact, there is no mention of this Public Accounts Committee in the Constitution. This is all only based on the rules of the house. As a parliamentary convention, the chairperson of the Public Accounts Committee is from the opposition party. Okay, so presently, do you know who is the chairperson of the Public Accounts Committee? Very good. Mr. 𝐂𝐨𝐬𝐭𝐡 from the Congress party is the chairperson of the Public Accounts Committee. Anyways, so the president has nothing to do with what is called as the Public Accounts Committee. So this is wrong. The report of the Comptroller and Auditor General, is it true? Yes. Who appoints the Comptroller and Auditor General? President. So therefore, he will submit the report to the president. Okay. The report of the National Commission for Scheduled Caste. Yes. Yes. The report of the National Commission for Scheduled Caste. Under which article? 3 something. Okay. So Finance Commission, which article? Very good. Article 280. Comptroller and Auditor General. Very good. Article 148. National Commission for Scheduled Caste. 3. Very good. Article 338. National Commission for Scheduled Tribes. 338A. National Commission for Backward Classes. 338B. When was this constitutional status was given to the National Commission for Backward Classes, which means under which constitutional amendment? 103 is related to EWS reservation. 102nd Constitutional Amendment Act. Okay, so what is the answer in this case? Except for 2, everything 1, 3 and 4 only. Okay, so which of the following are the functions of the Cabinet Secretariat? Who heads the Cabinet Secretariat? The Cabinet Secretary. So the Cabinet Secretary is the senior most civil servant, serving civil servant, but he is not heading any department or ministry. Who will head a department or a ministry? A secretary to the Government of India. There is a secretary to the Ministry of Finance, there is a secretary to the Ministry of Railways, there is a secretary for each and every department. So the Cabinet Secretary does not head any specific department or a ministry, but he is the secretary to the entire Cabinet Ministers. So therefore, what is the role of the Cabinet Secretary? He will provide secretarial assistance to the Cabinet Ministers. That means he will arrange the meetings, but he won't go and stand and do all those things. He will have a team of members whom he will direct. He will make notes of the Cabinet meetings, circulate those notes. If there is any difference of opinion between different ministries, the Cabinet Secretary will coordinate those differences. So this is what is the function of the Cabinet Secretary. So with that, you just come to the question here. Preparation of agenda for Cabinet meeting, is it true? Yes, of course he has to prepare the agenda for the Cabinet meeting. Secretarial assistance to the Cabinet committees, yes. For all the Cabinet committees, there are different Cabinet committees in our parliamentary system. What are the Cabinet committees that you can recall? Cabinet Committee on Political Affairs, Cabinet Committee on Economic Affairs, Cabinet Committee on Parliamentary Affairs, Cabinet Committee on Security. So therefore, number of Cabinet committees are there. Appointments Committee. So for all those Cabinet committees, the secretarial assistance is given by the Cabinet Secretary. Allocation of financial resource to the ministries. Is it true? Allocation of financial resource to the ministries is a function of the Finance Secretary. The Cabinet Secretary has nothing to do with this. That is why I said that the Cabinet Secretary, though the senior most civil servant, is the least powerful person. The secretaries are more powerful when it comes to the respective departments or ministries. Okay, so this is not the right answer. So select the correct answer using the codes given below. What is answer? 1 and 2 only. Consider the following statements. 1. The President shall make rules for more convenient transaction of business of the Government of India and for the allocation among the ministries of the said business. Is it true? Yes. But he does that based on the aid and advice of the Council of Ministers. Under which article the President exercises this particular power? Article 77 of the Constitution. So what does it mean by transaction of business rules? What does it mean by transaction of business rules? Transaction of business rules basically means how the entire administration of the central government is to be carried forward. So to carry out a large administration, you will have to create various ministries, departments, you will have to hold accountable for various actions of the government. So you will have to appoint various authorities. So who is authority to authenticate various files? So who will determine all those things for the union government? The president under the advice of the council of ministers. All executive actions of the government of India shall be expressed to be taken in the name of the prime minister. Is it true? It is all to be taken in the name of the president of India and not in the name of the prime minister. So which of the statements given above are correct? One only. Okay, come to the next question. The executive power of the Union of India is vested in the prime minister. On whom it is vested? It is vested in the president, because the president is the head of the union executive. The prime minister is the ex officio chairman of the civil service board. The answer is no. Who said yes? It is not the prime minister, it is the cabinet secretary is the chairman of the civil service board. Okay, one power that the cabinet secretary exercises this. So that is the reason while all the civil servants may be wanted to be in the good books of the cabinet secretary, but not related to the general public. So what is the civil service board? The civil service board will decide and clear the names for appointment of various secretaries to the government of India. Additional secretaries, joint secretaries, public sector undertaking directors, board members. So all these names will be cleared by the civil service board. And who will head that civil service board? It's a cabinet secretary. Okay. So this is definitely wrong. So what is the answer here? Which of the statements given above are correct? It is neither one nor two. Consider the following statement. Statement 1. No criminal proceeding shall be instituted against the governor of a state in any court during his term of office. It is true. It is true. This is also very important for the coming year, because there is a criminal case that was filed against the governor of West Bengal. So there was a sexual harassment case, I think, against the governor of West Bengal, but it has not moved forward. But that matter is now inquired by the Supreme Court. The Supreme Court is looking into this particular matter. Will there be a new interpretation that is given by the Supreme Court? We do not know. But as of now, what is the position? The constitutional authorities does exercise privilege under which article? Article 361 of the Constitution for the president as well as the governor. But for the president and the governors, it is only in case of criminal matters, in criminal cases, not in civil cases. So is there any exemption which is given in civil cases under Article 361? There they can be prosecuted, they can be summoned, but after giving a 2 months of prior notice. But in criminal cases, complete immunity. Complete immunity does not mean that they can never be prosecuted. They cannot be prosecuted during their term of, during their tenure. After that, they can be prosecuted. So therefore, even after that, you will have to meet it. So therefore, when you are in service, you should not do anything wrong, especially in constitutional positions. The emoluments and allowances of the governor of a state shall not be diminished during his term of office. Is that true? Yes, it cannot be. This is guaranteed in the Constitution itself. It cannot be diminished and vary to their disadvantage. So this is true. Which of the statements given above are correct? So both 1 and 2. Who determines the salaries and allowances of the governor? Parliament or the president? Salary and allowances of the governor? It is of course a parliament, no doubt should be there. But if the same person is appointed as a governor for 2 or more states, then in that case, the president might specify those extra allowances and all those things. Okay. With reference to the election of the President of India, consider the following statements. The value of vote of MLA varies from state to state. Is it true? Yes, we have seen that, because it is depending upon the population. The value of vote of MPs of the Lok Sabha is more than the value of vote of MPs in Rajya Sabha. Is it true? No, their value is almost the same. Not almost, it is the same. Which of the statements given above are correct? One only. Come to the next question. Which of the following suggested that the governor should be an eminent person from outside the state and should be a detached figure without intense political links or should not have taken part in the politics in the recent past? Sarkaria Commission. So sometimes they can ask you questions like this, but very rare questions. What is the Rajamannar committee is related to? It is not related to abolition of all India service. Of course, one of the recommendation that they have given is abolition of all India service. It is a center-state relationship committee, but appointed by a state government. The Tamil Nadu government has appointed a committee to study the center-state relationship. And one of the recommendation that was given by Rajamannar committee is to abolish the all India service. Now, why do you think that they would recommend to abolish an all India service? Because they are of the opinion that it goes against the federal provisions in the constitution. So how it goes against the federal provision, I will discuss when I take up the center-state relationship. Most of you might have an idea, but still I will discuss at the time. What is this National Commission to Review the Working of the Constitution is about? In general, bringing changes in the constitution, as the name suggests. What is this Administrative Reforms Commission is related to? Bringing in reforms in the areas of administration. Now, after the commencement of the constitution, how many Administrative Reforms Commission has been established? 2 Administrative Reforms Commission till this point of time. One in 1966, other I think in 2005. Okay, now there is a happy news. Last question for the day. Okay, so after that we will take a break and we will continue it tomorrow. Okay, so happy news. Happy news for both you and me also. I am also tired after discussing these many questions. Okay, come to the next question. Consider the following statements. According to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months even if he or she is not a member of the legislature of that state. Is it true? How many of you think it is true? Because we know that someone who is not a member of parliament can be appointed as a minister. The only thing is he or she should become a member of parliament within 6 months. But still, why it is not true? Because it is given that according to the Constitution of India, a person who is eligible to vote, is just 18 years, who is not less than 18 years of age. But for someone to become a member of parliament, to the Lok Sabha it is minimum 25 years and for the Rajya Sabha it is minimum 30 years. So therefore, someone who is eligible to vote cannot be appointed as a minister. They should also have the eligibility to contest election. So that is what is very important. Only such members can be appointed as a minister. Okay. So this the courts have clarified. So this is wrong. According to the Representation of People Act 1951, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting election even after the release from the prison. No, there is no permanent disqualification in any case, only that whatever is their punishment, after they come from the jail, another 6 years they are disqualified from contesting the election. So therefore, this is also wrong. So which of the statements given above are correct? Neither 1 nor 2. So with that, please listen to me just a moment. Class is not yet over. So with that, we are almost done with the executives, but I think we have another 25 questions. Alright, so please settle down. We will just move on to the next question. Shall I proceed further? Yes? Yes? Okay, so we will move to the question number 151. Okay, so please settle down, all of you. Okay, so look into the question number 151, which is part of the executives. With reference to the union government, consider the following statements. Statement 1. With reference to the union government, consider the following statements. 1.
N. Gopalaswamy Iyengar committee suggested that a minister and a secretary be designated solely for pursuing the subject of administrative reforms and promoting it. This is a question that you cannot expect. It has been asked randomly, but factually this particular statement is wrong. So, N. Gopalaswamy Iyengar, who was a member of the Constituent Assembly also, and he was also very influential number of committees that was appointed by the Government of India. So, this committee was appointed in 1949, where he has primarily discussed about the reorganization of the Central Secretariat and also to bring in administrative efficiency into the government. So, although he has given number of recommendations with regard to improving the administrative efficiency, but he has not specifically recommended anything about what is called as creating a designated ministry and a secretary for pursuing administrative reforms. So, this is something that he has not suggested. So, majorly his recommendations were related to improving or reorganizing the Central Secretariat. Okay, so therefore, this particular statement is wrong. So, these are all questions you cannot predict. In case in the examination also, if it comes, if you are lucky enough, it is okay, because it is only purely based on luck. We are not going to the examination. So, when you are preparing well, luck will also favor us, but purely based on luck, we should not go to the examination. That is not the right approach. Okay, so therefore, even if the luck is not favoring also, we should be in a position to clear it. That is how your preparation has to be. Okay. Okay, so this particular statement is wrong. In 1970, the Department of Personnel was constituted on the recommendation of Administrative Reforms Commission 1966, and this was in place under the Prime Minister charge. Is it true? Yes. In 1970, the Department of Personnel was constituted on the recommendation of the first Administrative Reforms Commission, and the Department of Personnel and Training today is directly under the charge of whom? It is under the charge of the Prime Minister. Below the Prime Minister, there is a Minister of State who might look after this, but however, it is directly under the charge of the Prime Minister. The Minister of State only assists the Prime Minister. Okay, so therefore, this particular statement is true. So, which of the statements given above are correct? So, what is the answer here? It is 2 only. Okay, so please come to the question number 152. Consider the following statements. The Constitution of India classifies the ministries into 4 ranks: Cabinet Ministers, Minister of State with independent charge, Minister of State and Deputy Minister. The Constitution has no such classification. In fact, of all the things, only one thing that is mentioned in the Constitution is the Cabinet, not the other type of ministers. Always what is mentioned in the Constitution is only the Council of Ministers. This is only based on the allocation of business rules. It has no mention in what is called as the Constitution of India. So, therefore, this particular statement is wrong. The total number of ministers in the Union government, including the Prime Minister, shall not exceed 15% of the total members in the Lok Sabha. Is it true? Yes, this is true. But however, this was brought in by which amendment? Very good, 91st Constitutional Amendment Act 2003. So, in case of centre, this is true. But however, in case of states, what is the answer? In case of states, it is also the case that it shall be not more than 15% of the members of the Legislative Assembly of that particular state. But however, if the minimum number of ministers will not be 12, then in that particular case, at least it has to be 12. Okay, so that is what is the general thing for the states. So, this is true. Along with that, you also remember please the 91st Constitutional Amendment Act 2003. So, what is the answer in this particular case? 2 only. If it is asking, yes, it is asking for the correct one. Please come to the next question. Consider the following statements. Statement 1. The Attorney General of India and the Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament. Now, before that, please tell me whether the word Solicitor General is it mentioned in the Constitution. The only word with regard to the law officer of the Union is the Attorney General, and with regard to the law officer of the state, it is the Advocate General. Now, below that, to assist the Attorney General and the Advocate General, number of other law officers of the government is also there, but all those things are created only by the business rules, which can be created by the President and the Governor respectively. So, therefore, there is no mention of Solicitor General in the Constitution, and also this privilege is only given to the Attorney General in the Union level and to the Advocate General in the states. So, therefore, this particular statement is wrong. According to the Constitution of India, the Attorney General of India submits his resignation when the government which appoints him resigns. Is it true? There is no such requirement under the Constitution. The Constitution says
that the Attorney General holds office and he holds office during the pleasure of the President. So therefore, the Attorney General normally will submit the resignation if the government changes, because the other government might make him to resign. But however, he does not, under the constitution, doesn't have to resign. Okay, so therefore this particular statement is wrong. So it is not there in the constitution. That is the idea you should have. So what is the answer in this particular case? The answer is, they are asking for correct one or the incorrect one? Incorrect? Correct. So it is, so therefore it is neither one nor two. Okay, so come to the next question. Consider the following in respect of the election of the President of India. The members nominated to either houses of the Parliament or the state legislative assemblies of the state are also eligible to be included in the electoral college. The members nominated to the either houses. So therefore the nominated members are not there. Anyway, so this is wrong, because it consists of only the elected members and not the nominated members of the Parliament or the legislative assemblies of the state. So nowhere the nominated members are there. So is there a provision for nominated members in the Lok Sabha today? Is it possible to have nominated members? What about the original constitution? Was there a provision for nomination? Yes, in the original constitution it was there, but today it is not there. By which constitutional amendment it was done away with? 104th Constitutional Amendment Act. So 104th Constitutional Amendment Act has done away with the nomination. So today this nomination is not there. But in the original constitution, 2 members can be nominated from the Anglo-Indian community in the Lok Sabha, and 1 member can be nominated in the Legislative Assembly from the Anglo-Indian community. So the President can nominate there, here the Governor can nominate. But anyways, this particular statement is wrong. The higher the number of elective assembly seats, the higher the value of vote of each of the MLAs in that particular state. Is it true? The higher the value of the MLAs, the higher the value of MLAs, will it be higher the value of votes? Because if you look into the formula for calculating the value of vote of an MLA, population of the state divided by the elected MLAs. So therefore, if in the denominator more number is there, the value is going to decrease. So therefore, this particular statement is wrong. So this is also wrong. So higher means it will be lower value. The value of vote of MLA of Madhya Pradesh is greater than that of Kerala. So this is again based on your luck. So this is something which is not most of you can remember, and there is no need to remember also. So that's why I said that 100% approach is not possible even in certain areas UPSC. But the good thing about this particular question is 99% of the questions students will not be able to do it. If they get it by luck, that is a different thing, but they may not know it at the time of examination. So these are all the questions that you should not worry. So these are all, this should not be the approach based on which you will prepare. Your approach has to be on the areas where you can do it. But anyways, because it has been asked, now we know the answer, but otherwise it is difficult for us to know the answer at the time of going to the examination. So the value of vote of MLA in Madhya Pradesh is not greater than that of Kerala. In fact, Kerala has greater value. Okay, so this particular statement is also wrong. Now come to the last thing. The value of vote of each MLA of Puducherry is higher than the value than that of Arunachal Pradesh, because the ratio of total population to the total number of elective seats in Puducherry is greater as compared to that of Arunachal Pradesh. See, the population of Arunachal Pradesh is very less, but they got 60 MLAs, more number of MLAs. But whereas in Puducherry, the MLAs are less and they have a substantial population also. So therefore, whose value will be higher? The value of MLAs in case of Puducherry. So therefore, this particular statement is correct. This is again a very difficult thing. It is not a very easy thing, but yes, UPSC can ask such questions also, but that doesn't mean that you should look into all the states and remember the MLA value of all the states. That is not the approach. Okay. So how many of the statements given above are correct? One only. A is the answer. Okay, so come to the next question. Consider the following statements. If the election of the President of India is declared to be void by the Supreme Court of India, all acts done by him or her in the performance of duties of his or her office of the President before the date of decision will become invalid. Will it become invalid? No. Even if the election is declared to be invalid, all the prior actions that is done by the President of India would continue to be valid. I also gave a reason for this. Why this is considered to be valid? Two reasons in fact. One is it will create a lot of administrative inconvenience. The second thing is, anyways the president is acting on the aid and advice of the council of ministers. So therefore, he is not taking any decision on his own. So therefore, these actions will be continued to be valid. All acts become invalid. So therefore, this particular statement is wrong. Election for the post of President of India can be postponed on the ground that some legislative assemblies have been dissolved and the elections are yet to take place. What about the statement? Whether the electoral college is full or if there are some vacancies, still the election has to happen on time. Okay. So because the constitution says there needs to be a president and every 5 years election has to happen. Okay. So therefore, this particular statement is wrong. And in fact, can you tell me what is the ground on which the election of the president can be challenged in the Supreme Court? Can anyone tell me what is the ground on which it can be challenged? What does the constitution say? The constitution does not say anything in this regard. Okay, so the constitution does not say what is the ground on which it can be challenged. The constitution only says what is the ground in which it cannot be challenged. So the ground on which it cannot be challenged is that there is a vacancy to the electoral college. Otherwise, the petitioners are free to challenge it on any ground. Then it is for the court to decide whether it is a valid thing or not. So very, very important. And in the last class, I also discussed about what is the ground on which, who can challenge the election of the president. Anyone who is part of the electoral college or anyone who is contested in the presidential election. Okay, so and there is also time limit. So UPSC may not go to this extent. So based on the President Vice President Election Act, so any election of the president can be challenged within 30 days after the declaration of result by the Election Commission of India. So anyways, UPSC may not ask, just an extra information. Now come to the statement number 3. When a bill is presented to the President of India, the constitution prescribes a time limit within which he or she has to declare the assent to the bill. This is not there. That is the reason why the president exercises what is called as pocket veto, because there is no time limit that is explicitly mentioned. So therefore, this particular statement is also wrong. How many of the statements given above are correct? These are correct, none of them is correct. So the idea of this class, it should be a revision to all of you, and wherever you have a gaps, it has to fill in those gaps. So this class should not be seen as where you are trying to learn a lot of things. It should be more of a revision, and of course, yes, certain new information you will also get definitely. Who among the following is or eligible to be appointed as an Advocate General of a state? Who is eligible to be appointed as an Advocate General? One who is qualified to be appointed as a Judge of High Court. That's the only qualification that is given apart from being a citizen of India. So one should be eligible to be appointed as a Judge of High Court. District judges. Can the district judges be appointed? Not all the district judges. It is not possible. So anyone who has held a district judicial office for 10 years can be appointed as a Judge of High Court, but not every district judge is occupying the office for 10 years. We do not know that. So therefore, this cannot be right. Advocates of High Court having 5 years of practice. Yes. To be appointed as a Judge of a High Court, how many years of practice has to be there? 10 years of practice. So it is not 5 years of practice. So they will also not be eligible. So choose the correct answer from the quotes given below. What is the answer? It is 1 only. Consider the following statements. Fixing population on the basis of 1971 census in presidential election, making cabinet advice binding on the president, allowing the president to send the cabinet advice once for reconsideration. Which of the above are part of the 42nd Constitutional Amendment Act 1976? Which of the following are part of the 42nd Constitutional Amendment Act? Census was fixed to be 1971 census. Till what year in 42nd Constitutional Amendment Act? Till the year 2000. And only in the year 2001 again it was amended by the 84th Constitutional Amendment Act, and they increased it till 2026. But by the 42nd Constitutional Amendment Act, they extended till the year 2000. But anyways, this is right. Making cabinet advice binding on the president. Yes, it is a 42nd Constitutional Amendment Act said that the president shall act in accordance with the aid and advice of the Council of Ministers. So this is also true. Allowing the president to send the cabinet advice once for reconsideration. That was by 44th Constitutional Amendment Act and not by the 42nd Constitutional Amendment Act 1978. So therefore, this would be wrong. Which of the statements? Which of the above are part of the 42nd? It is 1 and 2 only. Come to the next question. Consider the following statements. The governor of a state has a constitutional discretion in appointing the ministers of the state cabinet. Is it true? In fact, the governor shall appoint the ministers only on the advice of the chief minister. And who is appointed as a chief minister? Does the governor has any discretion in appointing the chief minister? So generally he does not have any discretion. So don't talk about the exception. Generally he does not have any discretion. So who shall be appointed as a chief minister is only the leader of the single largest party, or the leader of the largest party, or the leader of the largest coalition. But if there is no party, no coalition which is having a majority, or not a single party is having a majority, then it is considered to be a hung assembly. In case of hung assembly, then the governor will have a discretion in appointing the chief minister. But otherwise, generally he should not appoint anyone as a chief minister. But however, it is not given in the constitution. It is only a conventional practice that is followed in our country. Okay, so you should be very clear about all those things. So therefore, once a chief minister is appointed, then the other ministers are appointed only on the aid and advice of the chief minister. Okay, so this is definitely wrong. The governor of a state is appointed by the president by a warrant under his hand and seal. Is it true? Yes. The governor is appointed by a warrant under his hand and seal. Can you tell me some of the other authorities who are appointed by a warrant under their hand and seal? The judges of the Supreme Court, High Courts, and then the attorney, so not the attorney general, the comptroller and auditor general. So these are all some of the authorities where there is use of what is called as warrant under the hand and seal. Which of the statements given above are incorrect? One only. Consider the following statement. Statement 1. The governor as per the constitution should be an outsider and should not be a resident of that particular state where he or she is appointed as a governor. Is it true? So the key word here is as per the constitution. There is no such provision in the constitution. It is merely what? It is merely a recommendation that is given by which commission? Sarkaria Commission. What is the major recommendation that is given by the Punchi Commission in this regard? With regard to bringing in independence to the office of the governor. In fact, the Punchi Commission suggested that the word pleasure of the president shall be removed, that the governor occupies office during the pleasure of the president. Instead of that, what they said, how the governor shall be removed? A same manner as that of the president. That means the impeachment process which can be done by the state legislature. Okay. So this is not there in the constitution. The governor's salary can be diminished during his term of office by an act of parliament. The governor's salary cannot be diminished during his term of office. It cannot be varied to his disadvantage. Governor enjoys a fixed term under the constitution. Is it true? So if you read the constitution says that normally the tenure of governor is 5 years, but that is subject to the doctrine of pleasure of the president. So therefore, to say, if you read combinedly these things, the constitution does not provide him what is called as a fixed tenure. Okay, so that's the understanding you should have. So the governor enjoys a fixed term under the constitution is wrong. So how many of the statements given above are correct? None of them is correct. Okay, so come to the next question. A member of parliament or state legislature cannot be appointed as a governor. Is it true? A member of parliament or a member of state legislature can be appointed as a governor. That is not an issue. Because what is the qualification for someone to be appointed as a governor? Should be a citizen of India and he should have completed 35 years of age. There is no other thing. A member of parliament or a member of state legislature can be appointed as a governor. But once a member of parliament or a member of state legislature is appointed as a governor, can they continue to be a governor and also member of parliament or state legislature? That is not possible. Because one of the conditions of the office of the governor is that they should not hold on to any office of profit. And not only office of profit, this is not even office of profit, but it will create a conflict of interest between an executive post and a legislature post. So therefore, he should not hold on, he should not be a member of parliament or a state legislature once he is appointed. But at the time of appointing, he can be a member of parliament or a member of state legislature. To say cannot be appointed, it is wrong. The salary and other allowances of the governor is determined by the President of India. So who determines the salary and allowances? It is a parliament that determines the salary and allowances. But when the president comes into play with regard to the governor, when the same person is appointed as a governor for 2 or more states. In that case also, the president does not determine the salary. It is only how the extra allowances shall be payable by different states. That order will be issued by the President of India. So, what is the answer here? Which of the following are incorrect? So, the answer is option C. So, both are incorrect. Come to question number 161. Consider the following statements regarding the removal of the Vice President of India. He or she is removed by a resolution passed by special majority in both the houses of the parliament. Is it true? What is the majority with which the Vice President has to be removed? By effective majority in Rajya Sabha and simple majority in Lok Sabha. But however, in which house the resolution shall be introduced? It can be introduced only in the Rajya Sabha, and before introducing that, what is the time duration the notice has to be given? 14 days of notice has to be given. So, it has to be passed with what? Special majority. So, special majority is wrong. So, can anyone tell me what does it mean by effective majority? Majority of effective membership of the house. And what is effective membership? Total membership minus vacancies. Okay. The resolution for his or her removal can be introduced in either houses of the parliament. Can it be introduced? This year, this is a very, very important topic because as I already said, never ever in the history of India that they try to introduce a notice to remove the Vice President of India. So, either houses is wrong. The resolution for his removal can be introduced only after giving 14 days of prior notice. Is that true? Yes, that is true. So, how many of the statements given above are incorrect? It is 2 only. Okay. Consider the following statements. Repeated, huh? Okay, so this is repeated. Okay, come to question number 163. Who of the following is a part of the Electoral College of the Vice President of India? Who is part of the Electoral College of the Vice President of India? Members of the Parliament. There is no distinction between elected and a nominated member. The members of the Parliament, because Electoral College itself was very restricted, they did not make any distinction in this regard. And moreover, the Vice President was not to perform any executive function. Normally, he is to act as the ex officio chairman of Rajya Sabha. But what about the Electoral College of the President of India? Elected members of both houses of parliament, elected members of legislative assemblies of the state, and the elected members of legislative assembly of Delhi and Puducherry. What about the elected members of legislative assembly of Jammu and Kashmir? Are they part of the Electoral College? Presently, they are not part of the Electoral College. What is the way by which they can become part of the Electoral College? Either there should be an amendment to the constitution and they have to specifically insert the word Jammu and Kashmir as a part of the union territory, or the union territory of Jammu and Kashmir is converted into a state. That is the way that which they can become part of the Electoral College. So, what is the answer in this case? Elected members of parliament, yes. Vice President, elected members of the state legislature, no, it is not there. Nominated members of the parliament, yes. So, the answer is 1 and 3 only. The President of India can be removed by a resolution passed by a special majority in both houses of the parliament. Which of the following correctly represents the special majority? Which special majority is required? Majority of not less than 2/3 of the total membership of the house. This is very, very important. So, please do not make a mistake. Don't think that it is not less than 2/3 of the members present and voting. It is the total membership of the house. So, therefore, how many are present in a given day is not important. So, what is important is it should be passed by 2/3 of the total membership of the house. So, in this case, where the notice can be introduced, it can be introduced in either of the houses. Here also 14 days prior notice to the president, and the president will have the right to defend in which house? Second house or in the first house? Why not in the first house? There is no need to defend it in the first house, because unless and until it is passed in the first house, the president does not have to do anything, because it has to go to the second house, then he will have the right to defend it. So, the answer here is option C. How many times notice has been introduced to remove the President of India? We have no president in our constitutional history. Okay. So consider the following: proportional representation, single transfer voting system, open ballot. Which of the above mechanisms are associated with the system of presidential election in our country? So do we follow a system of proportional representation? Do you follow a system of single transfer voting system? And do you also follow a system of secret ballot? Yes, all the three things are part of the presidential, sorry, here it is open ballot is not there, but we follow what is called as secret ballot. So therefore, this is not there, this and this is there. So what is the answer here? 1 and 2 only. So the right answer here is secret ballot. And because we follow what is called as a secret ballot, now the question is, will the anti-defection law applies in case of president election? The anti-defection law cannot apply because it is based on what is called as secret ballot system. Okay, so that's very, very important. Consider the following statements regarding the President of India. Statement 1: in case of vacancy to the office of the President, a new President must be elected within a period of 6 months in all cases. Okay, first of all, tell me, can anyone tell me what are the grounds on which the vacancy can arise to the office of the President? What are the possible grounds? One is vacancy because of the expiry of the term of the incumbent President, expiry of the term, then death, resignation, removal, or otherwise. Otherwise is what is given in the Constitution. What does it mean by otherwise? Anything apart from these 4 things, which may be that the Supreme Court of India declares the election of the President to be unconstitutional or invalid. So in all these 5 grounds, there can be vacancy. I am just repeating it again: expiry of the term of the incumbent President, because of the death of the incumbent President, resignation of the incumbent President, we can resign it to the Vice President of India, submit the resignation, or it can be because of what? Removal or otherwise. In all these cases, there will be a vacancy. Now the question is, in case of vacancy to the office of the President, the new President must be elected within a period of 6 months in all the cases. Is it true? In case of vacancy, suppose if it is going to arise because of the expiry of the term, then the new President has to be elected even before the expiry of the incumbent President, even before the term is expiring. So therefore, to say it in all the cases, it is wrong. But if the vacancy is arising because of what? Death, resignation, removal, or otherwise, then within 6 months, the new President has to be elected. So in the meantime, who will act as the President of India? It is the Vice President. Suppose if the new President is elected before the expiry of the term of the incumbent President, but the new President is not able to assume the office. So for example, the new President, before assuming the office, he met with an accident, a minor accident, so therefore he is hospitalized. So when on the day that the term is getting expiring for the incumbent President, the new President is not able to assume the office, then who will act as the President of India? Vice President or the outgoing President? The outgoing President would continue to be the President of India, and there is no time limit for this. Till the time the new President assumes the office, the outgoing President will continue to be in office. Okay, when the new President assumes the office, what will be his term? His term will be less than 5 years, or it will be a full 5-year term? Because already let us assume that the outgoing President is acting as a President for another 3 years, sorry 3 months, let us assume. So then the new President is assuming the office. So this new President will have a full 5-year term, okay, whenever he assumes the office. So therefore, to say in all the cases, it is wrong. Any election dispute regarding the election of the President can be challenged only in the Supreme Court of India. Is it true? Yes, only in the Supreme Court. This word only, exclusively, these are all very, very important, because 90% of the cases they are wrong. But in polity, you cannot say it is always wrong, because there are certain areas where it can be right also. Okay, so you have to be very careful. So which of the statements given above are incorrect? It is one only. Consider the following statement: as per the conventional practice, the returning officer for the presidential election is usually the Secretary General, Lok Sabha or Rajya Sabha. Now this is not directly given in the Constitution. This is as per the President, Vice President. It is as per the President, Vice President. Is it audible to the online students? Is it clear? So please give me confirmation. I guess it is audible to the online students. Okay. As per the convention, okay, so this is not directly given in the Constitution, it is only mentioned in the President Vice President Election Act 1952. So if you see that the returning officer is someone who will preside over the entire election. So who is supposed to carry out the election of the president and the vice president? Who is authority under the constitution to carry out the election for the president and vice president? It is the Election Commission of India. And what is the responsibility of the Election Commission of India as per the constitution? What are all the areas they have to carry out the elections? To the president, to the vice president, elections to the parliament and elections to the state legislature. When I say election to the parliament, both to the Lok Sabha as well as Rajya Sabha. Election to the legislature means legislative assembly, and in case if a state is having legislative council also. These are the only 4 areas where they have to carry out the elections. And the only responsibility of the State Election Commission is to carry out election only to the local bodies. Now, based on my experience, even after the students reading for 1 or 2 years, they are confused whether the State Election Commission will carry out the election to the state legislature or is it the Election Commission of India. So, please make it very clear, it is the State Election Commission which will carry out elections only to the local bodies. Okay. Okay, now come here. So, the constitution does not say that. So, to some extent, okay, so did I say that it is mentioned in the President Vice President Election Act? Okay, it is not mentioned in the President Vice President Election Act, it is only a conventional practice. It is only a conventional practice that this has been followed, because there has to be someone who will preside over the election of the President and the Vice President. Okay. So, as per the conventional practice, the returning officer of the President election is usually the Secretary General Lok Sabha, Rajya Sabha. This is true. Now, who is the returning officer? Can anyone tell me? What is the role of this returning officer? Why it is called as returning officer? In the Lok Sabha elections also, they are called as returning officer. In the Legislative Assembly election also, they are called as returning officer. So, of all the members who contest the election, only one person is declared certified as a returned candidate. That means he is a winner, the returned candidate. So, therefore, who is supposed to certify that? The returning officer. So, similarly, in the election to the President of India, there has to be someone who has to certify this. So, normally who is appointed as the returning officer by the Election Commission of India? It is either usually the Secretary General Lok Sabha or the Secretary General Rajya Sabha. Okay, so this is true. And the practice that is followed is it happens alternatively. So, in the first year election, it is the Secretary General Lok Sabha, then it is Secretary General Rajya Sabha. Last election, I think it was the Secretary General Rajya Sabha. Okay, so anyways, you can verify that. So, this is true. Anti-defection law applies in case of voting in presidential election. Is it true? No, anti-defection law does not apply. As per the presidential election rules, it is mandatory for an elector to give his all preferences at the time of voting. So, you know that how the electors who are taking part in the election of the president, you can understand that there can be multiple candidates who will contest in the election. So, therefore, unlike the elections, how we vote in the Lok Sabha elections and the Legislative Assembly elections, where we can vote to only one candidate, that is not the case in the presidential election. They can give multiple preferences. But is it mandatory for the elector to give preferences to all the candidates? That is not mandatory. But what is mandatory is that they have to give the first preference. If they do not give the first preference, then it becomes what is called as an invalid vote. Okay. And also, do you know how the Election Commission of India distinguishes between the electors when it comes to the presidential election? Do you know how they distinguish? Because there are MPs also, there are MLAs also, and different values has to be assigned to these votes. So, different color voting card is given to different people. Okay. So, I think to the members of the parliament, they give what is called as a green color, and to the members of the state legislature, a green color is given. Anyways, you just remember there are different colors that is given. Okay. So, as per the presidential election rule, it is mandatory for an elector to give all the preferences. No, that is also not true. So, what is the answer here? It is, how many of the statements are incorrect? It is 2 only. Consider the following statements regarding the President of India. So, please come to the next question. The electoral college of the President includes members of both the houses of parliament, both elected and nominated. It includes only what? The elected members. So, this is quite easy. A sitting member of parliament or a state legislature cannot contest to the office of the President. Can they contest? Please tell me. Can a sitting member of parliament and a state legislature, without resigning from being a member of parliament or a state legislature, can they contest? But you already read that one of the qualification to contest election to the office of the president is that they should not hold on to any office of profit. It is an exception. The exception is only to the, let me just read the question again, okay. The exception is only to what? The exception to contest election of the office of the president is only for president, vice president, governors and the ministers. So the members of the parliament or the members of the state legislature, you cannot say them to be ministers. Of course, not everyone cannot be a minister. If it is a minister, it would be mentioned as a minister. So therefore, just rethink on this. I am giving you one more time to think, and if at all you want, you can change your option, but you cannot do that in UPSC. So therefore, you have to be very clear when you do the answer in UPSC. So my question is, can a sitting member of parliament or a sitting member of state legislature, can they contest to the office of the president without resigning from being a member of parliament or member of state legislature? Yes or no? Yes, because a sitting member of parliament or a sitting member of state legislature is not an office of profit. I have already made it clear to my students, but if somebody who is new to the class, you should be very clear that a sitting member of parliament or a sitting member of state legislature would not be considered to be an office of profit. Why it is not an office of profit? Because office of profit is majorly an executive post. That is, either it is an office under the central government, state government or the local authorities, by a way of which a profit is receivable. But whereas a sitting member of parliament or a sitting member of state legislature, are they part of executives? They do draw a salary. I am not saying they are not drawing a salary, but they are part of the legislature. So therefore, they will not qualify as what is called as an office of profit. But if a sitting member of parliament or a sitting member of state legislature, if they contest election to the office of the president, for which they don't have to resign, but once they get elected as the president, then they automatically cease to be a member of parliament or a member of state legislature. Okay, is that clear? So that's a condition under the office of the president. So therefore, a sitting member of parliament or a state legislature cannot contest election is a wrong thing. They can contest election. The emoluments and allowances of the president are determined by an act of parliament. Is it true? Yes, for the president, the emoluments and allowances are determined only by the parliament, not by any of the other authority. So what is the answer here? Which of the statements given above are incorrect? So what is the answer? 2 only. Okay, so come to the next thing. Consider the following statement as per the Constitution of India. The notification to the election of new president must be issued by the Election Commission of India anytime 60 days prior to the expiry of the outgoing president. Is it true? This statement is true, but not as per the Constitution of India. Okay, so the question is, consider the following statement as per the Constitution of India. The Constitution does not say this. It is only as per the President Vice President Election Act. Okay, so therefore, while it is factually true, but it is not as per the Constitution. It is only as per the President Vice President Election Act. So therefore, this particular statement is wrong. The nomination paper of a candidate for the election to the office of the president to be accepted by the returning officer requires it to be subscribed by 50 electors as proposers and 50 electors as seconders. Is it true? The nomination for the candidate, so this is again true, but not as per the Constitution. This is again, it is a rule under the President Vice President Election Act. Okay, so this is also, the statement per se is true, but not in the Constitution of India. The Constitution of India provides only certain qualifications, that he should be a citizen of India, completed 35 years of age, should not hold on to any office of profit, subscribe to an oath in front of the authority as appointed by the Election Commission of India. So some qualification is there in the Constitution, but these are all additional qualifications by way of the President Vice President Election Act. Which of the statements given above are correct? It is neither one nor two. Suppose instead of the Constitution, then that would be a right thing. With reference to the election of the President of India, consider the following statements. The value of vote of each MLA varies from state to state. Does it vary? Yes, of course it will vary. There is no doubt. It varies from state to state. The value of vote of MPs in the Lok Sabha is more than the value of vote of MPs in the Rajya Sabha. Is it true? It is false. Their value is the same because there is only one formula for the value of vote of MPs. Can anyone tell me what is the formula to calculate the value of vote of MPs? Total value of all valid votes divided by 2 plus 1. Okay, so this is a this is electoral quota. Okay, let me just correct it. Total value of all the by not the MLAs. So this is total value of valid votes of all the MLAs from all the states and union territories divided by elected MPs. And what is that elected MPs? It is 543 plus 233. Okay, so that's the number of elected MPs. So that means it is 776. So this is the value of the MPs. It is not 238 because right now in Rajya Sabha how many MPs are there? Only 245. Although the total authorized strength is 250, but presently there are only 245, of which 12 are nominated members. So therefore it is only 233. So what is the answer here? Which of the statements are correct? So therefore the answer is 1 only. Okay, so come to the next question. As per the Constitution of India, the governor or the ex officio, this is part of your current affairs. Okay, so I put this question because it is very much related to the current affairs. So what is the issue right now is many of the states have passed a bill where they wanted to replace the governor as the chancellor of the state universities, but none of the governor have given assent to this bill. So because they are giving assent to a bill where somebody else will replace him as the chancellor. So many of the governors are sitting on this particular bill. So there is a lot of news that is coming. Should the governor continue to be the chancellor of the state universities? So to that extent, tell me, as per the Constitution of India, the governor or the ex officio chancellor of state universities, is it true? Is it true or false? This is not a constitutional position that is given to the governor. It is only a statutory position. Many laws enacted even before India became independent by the British Parliament, which has made the governors of the state to be the chancellors. So at that point of time, you had governors for the provinces. So they were made as the chancellors of the state universities. So that is even continuing today. So many states wanted to replace this position. So they enacted already a bill and they have sent it to the governor where the governor is not giving the assent. But anyways, that is not in the Constitution. It is only based on a statute. So this is wrong. The Punchi Commission on Center-State Relationship recommended appointment of an eminent academician as Chancellor of State Universities. What about this? Does anyone know? Punchi Commission was a commission which is related to center-state relationship. They also understood that the position of governor should become independent, and they also thought that the governor is unnecessarily occupying certain powers and position. So Punchi Commission made this recommendation. They wanted an eminent academician to become the chancellor. That makes sense also because not all the governors may be an eminent academician. So therefore, that is a recommendation that was given by the Punchi Commission. So this is true factually. So what is the answer? Which of the statements given above are correct? It is 2 only. Which of the following article deals with the power of the governor in relation to the bills presented for his or her assent? 200 or 201? 200, sure. So what is there in article 201? When the bill is reserved for the consideration of the president, then what are the options that can be exercised by the president of India under article 201? Okay, I yesterday discussed what are the options in the hands of the governor. What are the options in the hands of the governor? Very quickly, he can give the assent, or he can, what he can do, he can withhold the assent or send it for reconsideration, or he can reserve it for the consideration of the president. Okay, so these are the options that he can exercise. But recently the Supreme Court has made it very clear, he can give the assent, he can withhold the assent, he can send it for reconsideration, and he can also reserve it for the consideration of the President. But if he is directly withholding the assent, then as soon as possible he has to send it for reconsideration. And if the state legislature is again passing it, then the governor has to give the assent. So this is what the Supreme Court has said. But however, what is that as soon as possible? What is the reasonable time limit within which he has to send? That is not given in the judgment. Okay, now when he is reserving it for the consideration of the President, now then the fate of the bill will be decided only by the President of India. Now then Article 201 will come into existence. So as per Article 201 of the Constitution, what are the various options that the President can exercise? So what he can do is that he can give the assent. What he can do? He can withhold the assent, or he can send it back for reconsideration. Okay, so when he sends it for reconsideration, what will happen? When he sends it for reconsideration to the state legislature, then the state has to again send the bill back to the President within a period of 6 months. And in this case, it is not binding upon the President to give the assent. Okay, so this is what you will have to understand. But whatever the decision that he takes under Article 201, the President is going to act as per the aid and advice of the Union Council of Ministers. Okay, so that is also very important. What is Article 111 of the Constitution is related to? Power of the President to give assent to the bills passed by the Parliament. Okay, so please come to the next question. Consider the following statements. As per the Constitution, shall I proceed? Shall I proceed? Okay. So consider the following statement. As per the Constitution, a person who has held the office of the President is not eligible for re-election. So there is no restriction as to how many terms one can be a President of India. But however, we do not have a President except for Dr. Rajendra Prasad, who has been President twice. We do not have any other President apart from that, but constitutionally there is no such restriction. As per the Constitution, a person who has held the President office is not eligible to re-election is a wrong thing. One of the conditions to the office of the President as per the Constitution is he or she should not hold any office of profit. Is it true? Office of profit is also one of the qualification to contest election, and office of profit is also one of the condition for the President office. So how many of you are clear as to what is the difference between qualification and condition? Is that clear? So qualification means these are all the qualification one has to possess to contest election. Condition of President office means once somebody gets elected, then also they have to fulfill certain constitutional conditions to continue in that particular office. So in both the cases, be it to contest election or after winning the election, in both the cases the President should not hold on to any office of profit. So where is this office of profit defined in the Constitution? Is it defined in the Constitution? It is nowhere defined in the Constitution. It is only an interpretation that is given by the Supreme Court of India. So what is considered to be an office of profit? Any office either under the center, state or any of the other local authorities by way of which a profit is receivable. It is not mandatory whether the profit is received or not, but what should be seen is whether the profit is receivable in the first place. Or to put it in a very simple way, suppose let us assume a government post is there and somebody occupying that government post and not taking the salary. So therefore, can he say that he is not holding on to any office of profit? Whether the individual takes a salary or not, that is immaterial. But if the office provides for the salary in the first place, that itself is sufficient enough to consider that particular office to be office of profit. Okay. So therefore, one of the condition of the office of the President as per the Constitution is he or she should not hold on to office of profit. So this is definitely true. So which of the statements given above are correct? Two only. Who among the following shall administer the oath to the governor before assuming the office? This is as per the Constitution. Who is supposed to administer the oath? Okay, let us see. The Chief Justice of the concerned High Court. Is he supposed to administer the oath? Okay. So come to the second statement. In the absence of the Chief Justice of the concerned High Court, then the senior most judge of the court available. Is that true? Is it mentioned in the constitution? Of course, it is mentioned in the constitution. Okay, the constitution says that the administration of that oath has to be administered by whom? The Chief Justice of the concerned High Court, and in the absence of the Chief Justice, then who will administer the oath? The senior most judge in the particular High Court. So this is also true. The President of India, no, the President will not administer the oath. The Speaker of the Legislative Assembly. So which of the statements given above are correct? So the answer is 2 only. So both the statement 1 and 2 are correct. So this is the answer for this particular question. Okay, so come to the last question as a part of the executives. Consider the following statements. The number of ministers in the state shall not exceed 15% of the total members of the Legislative Assembly in all cases. Is it true? Here the key word is in all cases. So it's an extreme statement. So whenever an extreme statement is given, you have to be very careful about that. So is it true? It is not in all the cases, because what is the exception that you already learned? If the 15% of the total members of the Legislative Assembly is less than 12, then minimum there has to be 12 ministers. So therefore, it is not possible in all the cases. So whenever they are trying to put a statement like this in all cases, then in that particular case, you will have to think about the exceptions. Otherwise, there is no need to think about the exceptions. So therefore, this particular statement is wrong. As per the constitution, the Council of Ministers shall be collectively responsible to the state legislature. Is it true? As per the constitution, the Council of Ministers shall be collectively responsible to the Legislative Assembly, not to the state legislature. So in case of Parliament, the word Parliament would be wrong. They are collectively responsible only to the Lok Sabha. So here similarly, they are collectively responsible only to the state legislative assembly and not the state legislature. Because the word state legislature will also include what? The legislative council also. Okay. So therefore, this is not the right thing. So which of the statements given above are correct? Which of the statements are correct? Sorry, it is neither 1 nor 2. Option D is the right answer. Can anyone tell me what is question number 168? What is the answer that you are given for 168? Is there any confusion in that question? What is that question? Some student is asking it out in the online. Okay, I am just repeating that question. The electoral college of the president includes members of both the houses of the parliament, both elected and nominated. So statement 1 is wrong because it includes only the elected members. A sitting member of parliament or a state legislature cannot contest election to the office of the president. Can a sitting member of parliament or state legislature contest election? Yes, they can contest election because the statement is saying cannot contest election. So therefore, it is wrong. Statement 2 is also wrong. The emoluments and allowances of the president is determined by an act of parliament. So that is true. So how many of the statements are incorrect? So incorrect would be 2 only. So 1 and 2 are incorrect. Okay, so when I say MPs, so there was one question, the total value of MPs, that apostrophe is, that is not the cumulative value of all the MPs, it is only for one MP. So don't get confused. If at all UPSC wanted to check that the value of the cumulative value of MPs in Lok Sabha is more than the value of MPs in the Rajya Sabha, then that is right. So if they put apostrophe S, it is only a single value. Okay, so don't get confused in that regard. Alright, shall we move to the next part, that is the legislature part? Can I have a better response? Yes. Okay, so we'll move to the next part, very important part. Okay, so minimum 4 to 5 questions is what is in the UPSC trend, and there are few areas where UPSC repeatedly asking question. So taking note of that, I have put a lot of questions, especially the constitutional amendment bills, the money bills, financial bills. So certain areas are there, so we'll try to see all those areas. Okay. Okay, so come to the first question in the parliament. Look into the question, which of the following is responsible for the preparation and presentation of union budget to the parliament? So whose responsibility is this? Although it is not there in the constitution, it is based on the transaction of business rules. Okay, tell me, as per the constitution, who is supposed to lay down the budget? President or the finance minister or the prime minister? It is a president who is supposed to lay down the annual financial statement. So if they ask as per the constitution, it is only the president of India. But we know that the prime minister or any of the other union council of minister is a subordinate of the president. So if you look into the constitution also says the president is head of the union executive and he can perform the functions of union executive on his own or through his subordinates. So therefore, it is based on the transaction of business rules, it has been given to the union finance minister to present the budget. But as per the constitution, who is supposed to do that is the president of India. So who will help out the union finance minister in presenting the budget is the Department of Economic Affairs, and within the Department of Economic Affairs, it's a budget division. So if you organize a ministry, the lowest level is the division. After the division, it is a department, and then you have a ministry. Okay, so it is budget division, Department of Economic Affairs, Ministry of Finance. So what is the answer here? It is the Department of Economic Affairs. So the Department of Economic Affairs itself is headed by a secretary level officer. Okay. Okay, consider the following statements. The Constitution of India provides the Legislative Assembly of each state shall consist of not more than 450 members chosen by a direct election from territorial constituency in that particular state. Is it true or false? As per the constitution, what is the range when it comes to the state legislative assembly? It shall not be less than 60 and more than 500. So the range is between 60 to 500 and it is not 450. So with regard to the number it is wrong, but with regard to the principle it is right. So all the members shall be elected by a territorial constituency election. But however, this statement is factually wrong. It is 60 to 500. But is there any exception to this number of 60 to 500? There are certain exceptions that is given in the constitution. Say for example, Sikkim is an exception, and certain other northeastern states also there are some exceptions. Subject to the exceptions, so generally it is what? It is 60 to 500. Suppose if the question comes as per the constitution in all the states it should be 60 to 500, then it is wrong. But if it is not saying all the cases, then that should be a right statement. So therefore this particular statement is wrong. A person shall not be qualified to be chosen to fill the seat in the legislative assembly of a state if he or she is less than 25 years of age. Is it true? Yes, one of the qualification for someone to contest election to the Lok Sabha or to the legislative assembly is he or she should not be less than 25 years of age. In addition to that, they should be a citizen of India. They have to subscribe to an oath in front of an authorized authority. And apart from that, they should be an elector from any constituency in India in case of Lok Sabha elections. What about in case of the legislative assembly elections? They should be an elector from any constituency in that particular state. Okay, that is very important. Now tell me this, there should be an elector from any constituency in that particular state or anywhere in India in case of Lok Sabha. Is this a qualification that is mentioned in the constitution? Is it a qualification which is prescribed in the constitution or not? This is not a qualification prescribed in the constitution, it is based on the Representation of People Act. Okay, so just try to keep this in your mind. So if a person is not qualified to be chosen to fill the seat in the legislative assembly of a state, if he or she is less than 25 years of age, so this is true. But it is asking the Constitution of India, okay, this is provided in the constitution. So this particular statement is true. Which of the statements given above are correct? Two only. This is again a factual question. Sometimes it was asked in previous year questions also in UPSC. Who was a speaker of the first Lok Sabha? When was the first Lok Sabha came into existence? 1952. Before that it was only the Constituent Assembly that considered to be a provisional parliament. So but the first Lok Sabha came into existence only in 1952, and who was the first speaker? It was G.V. Mavlankar. And what is the majority with which speaker has to be elected? Simple majority or special majority? The only qualification that is given in the constitution for someone to be elected as a speaker, what is the qualification? That's the only qualification. He should be a member of that particular house. Only a member of that particular house can contest election to become the speaker, and the speaker is elected by simple majority. Not necessarily the elections may happen, not necessarily every time the elections may happen. Most of the times the elections will not happen because somebody will have a clear majority. So therefore, if the ruling party nominates someone as a speaker, as a candidate, and if there is no opposition, then he will be unopposed, elected. So, but if the election happens, then he has to be elected by what is called as simple majority. This is very, very important. And who conducts the election of the speaker? Who will conduct the election of the speaker? It will be conducted by the speaker pro tem. So who will appoint the speaker pro tem? It is a president who will appoint the speaker pro tem. And who shall be appointed as a speaker pro tem as per the constitution? Let me complete the question. So that is why you should always read the question fully in UPSC. You should always listen to the question in the interview, most importantly. So don't jump into conclusions. So that's a very bad thing because you tend to make a lot of mistakes. So listen carefully. So as per the constitution, who is supposed to be appointed as a speaker pro tem? Nothing is given in the constitution. It is only a conventional practice that the senior most member in the Lok Sabha is appointed as a speaker pro tem by the President of India. Okay. Okay, once a speaker pro tem conducts election, once a speaker is elected, then the office of the speaker pro tem ceases to exist. Who will decide the date of election of the speaker? It is a president who will decide the date of election of the speaker. Is that clear to all of you? So the answer is option B in this case. Okay, come to the next question. With reference to the Indian public finance, consider the following statement. Statement 1. The disbursement from the public accounts of India are subject to the vote of Parliament. Is it true? In fact, what are the funds that is mentioned in the constitution? What are the different funds that is mentioned in the constitution? One is the consolidated fund of India, the most important fund. You have public accounts of India and then the contingency fund. Okay, now all these funds are mentioned in the constitution, but is all the three funds established by the constitution directly? So how many of you think that yes, all the three funds are established by the constitution directly? That is, in case of the union, that is the consolidated fund of India, the public accounts of India and the contingency fund of India. Are they directly established by the constitution? How many of you think yes? Okay. So not all the three funds are directly established by the constitution. Though it is mentioned in the constitution, there are only two funds which is directly established by the constitution. What are the funds? It is only the consolidated fund of India and the public accounts of India. When it comes to the contingency fund of India under Article 267 of the constitution is only empowering the Parliament to make a law, and by that law they can establish. So not necessarily it will come into existence unless and until the Parliament enacts a law. So therefore today do we have a contingency fund of India? Yes, because the Parliament has enacted the Contingency Fund of India Act 1951, and by which the Contingency Fund of India Act is established. So therefore if a question comes, how many of the funds are established by the Constitution of India? What is the answer? Now why I am discussing this is there is a previous year question where they have asked this. So only two funds are established directly. What are the two funds? Consolidated fund and the public accounts of India, and not the contingency fund. But if the question is, if it is mentioned in the constitution, yes, it is mentioned, but it is not directly established by the Constitution of India. So anyways, with that you just come to this particular question. The disbursement of the public accounts of India from the public accounts of India are subject to the vote of Parliament. Is it subject to vote of Parliament? Only in one case it is subject to vote of Parliament. If they are going to appropriate money from where? If they are going to take out money from the consolidated fund of India. Because the constitution very clearly says that not even a single rupee can be taken out of the consolidated fund of India except for an appropriation bill passed by the Parliament. What about taking out money from the public accounts of India? It does not require the approval of the Parliament. It is at the disposal of the executives. So the executives can pass the order. and through which the money can be taken out. And what about the contingency fund of India? It is at the disposal of the President of India, and the President has delegated this power to the Secretary Ministry of Finance. He can delegate it to some other authority also. So therefore, to take out money from which fund, it requires approval of the Parliament, only the consolidated fund. And what are the money that belong to these funds, I will subsequently discuss. There are questions coming, I will discuss at that particular time. Okay. So therefore, with that, come to this particular question. The disbursement from public accounts are subject to vote of Parliament, definitely not true. The Indian Constitution provides for the establishment of consolidated fund, public accounts and the contingency fund for India and for each state as well, if you see that. So the Indian Constitution provides for establishment of a consolidated fund for the state, public accounts for the state, but not for the contingency fund for each state. Even for the state also, the contingency fund can be established based on the law that is passed by the concerned state legislature. So it is not directly established by the Constitution. So therefore, this particular statement is wrong. So which of the statements given above are correct? It is neither one nor two. Okay, which article in the Constitution provides for the consolidated fund of India and the consolidated fund of states? Article 2. Article 266 provides for 4 funds. What are the 4 funds? Article 266 provides for 4 funds, not 2 funds. Consolidated fund of India and the consolidated fund of states, public accounts of India and the public accounts of the states. Now these are all directly established by the Constitution. And the Article 267 provides for 2 funds, but not directly established by the Constitution. It provides for contingency fund of India, which can be established by an act of Parliament in case of union. It also provides for contingency fund for every state, provided the law made by the concerned state legislature establishes them. Okay, please come to the next question. Consider the following statements. The Speaker of Lok Sabha has a power to adjourn the House sine die, but on prorogation, it is only the President who can summon the House. The Speaker of the Lok Sabha has a power to adjourn the House sine die, but on prorogation, it is only the President who can summon the House. Is it true? So first of all, tell me what is adjourn sine die and what is prorogation? What is adjourn sine die? Can anyone tell me? Adjourn sine die means basically the House is still in session, but the House does not actively perform any function because the presiding officer has adjourn sine die, which means that he has given an indefinite break. It is not a definite break. What is a definite break in the House? Adjournment is a definite break. Adjournment means whenever the House is adjourned, the session is still intact, but when the session is adjourned, when the House is adjourned, that means the presiding officer is saying when the House will meet again. Adjournment can be for hours, it can be for days, it can be for weeks, but it is something which is very definite. But when the presiding officer is saying that I am adjourning the House without saying when the House will meet again, then he is adjourned sine die, that is adjournment sine die. So who can adjourn and adjourn sine die the House? The presiding officers. So once the House is adjourned sine die, then the President will prorogue the House, because then the President knows that all the function in the House is over for the session, and then the President will prorogue the House. What is prorogation? Prorogue means terminating the House, terminating the session. Now once a session is terminated, then again who can summon the House? Only the President can summon the House. So therefore this particular statement is correct. Unless sooner dissolved or there is an extension of the term, there is an automatic dissolution of the Lok Sabha by the efflux of time. Efflux of time means the time is over at the end of the period of 5 years, even if no formal order or dissolution is issued by the President of India. So now before I answer this particular question, unless sooner dissolved, is it possible to dissolve the Lok Sabha sooner? Yes. What is the ground on which it can be dissolved? When there is a no confidence motion, or even when the Council of Ministers themselves advise to dissolve the House earlier. Okay, unless sooner dissolved. or there is an extension to the term of Lok Sabha. Can there be an extension to the term of Lok Sabha? What is the ground on which it can be extended? Only when there is a national emergency. And who is authority to extend the term of Lok Sabha? Parliament or the president? It is a parliament who is authority. The parliament by a law, they can extend the term of Lok Sabha indefinitely, but however 1 year at a time. So every year they can pass a law and they can extend the term of Lok Sabha. So unless until it is sooner dissolved or extended by the parliament because of the national emergency, there is an automatic dissolution. So this is very much true. The Lok Sabha automatically gets dissolved. So not necessarily every time the president has to pass a formal order, because who is supposed to dissolve? It is the President of India, but it is not necessary for him to do. Once the time is over, automatically the president will, automatically the house will dissolve. When the president will pass a formal order is only when the ministers fail to submit the resignation. If they fail to submit the resignation, then the president will pass an order and he will dissolve the Lok Sabha. Otherwise, it will happen automatically. And by parliamentary convention, whenever the time is over, the government automatically submits the resignation and there is an automatic dissolution. And at that point of time, the government, once the Lok Sabha is dissolved and the minister submits the resignation, will there be a prime minister and the council of ministers for our country? Yes or no? Yes. They already submitted the resignation, then how they can continue to be a prime minister or a council of ministers? They would still be the prime minister and the council of ministers, but in caretaker capacity. Because what the constitution says, that the president shall always act in accordance with the aid and advice of the council of ministers. So therefore, the prime minister and the council of ministers would continue to exist, but in what is called as a caretaker capacity. So what does it mean by caretaker capacity? So when they are acting as a caretaker government, they cannot give any new policy advice. Whatever is already in place, with regard to that, the advice can be given. No new bills, no new policies, nothing can be done by a caretaker government. Okay. So this is true. The Speaker of Lok Sabha continues in office even after the dissolution of the Lok Sabha until immediately before the first meeting of the House. Is it true? This is also true, because it is also very important. The term of the Speaker is not coterminous with the term of the House. That means even after the Lok Sabha is dissolved, the Speaker would continue to exist, because once the Lok Sabha first sitting or the first session come into existence, you don't have a Speaker, because who is appointed as a Speaker at that point of time? It is only the Speaker pro tem by the President, and then the elections has to happen, then the new Speaker will be elected. So the Speaker would continue to exist even after the dissolution of Lok Sabha till the time in the new Lok Sabha somebody is appointed as a Speaker pro tem. Once a Speaker pro tem is appointed, then the Speaker ceases to exist. Okay. So what is the answer here for this particular question? It is 1, 2 and 3. All the 3 things are the right answer. Which of the following statement is correct? Statement 1. In Lok Sabha, the no confidence motion has to set out the grounds on which it is based. First of all, tell me, where is this no confidence motion mentioned? Where is it mentioned? It is mentioned in the rules of the House. Very good. It is not mentioned in the Constitution. So if you see, the Constitution only says that the Council of Ministers shall be collectively responsible to the Lok Sabha. So therefore, there should be a way to check the responsibility of the ministers to the Lok Sabha, and therefore accordingly the Lok Sabha has made a rule. It is in rule number 198 of the Lok Sabha. So as per rule number 198 of the Lok Sabha, any member of parliament can introduce a notice to check whether the government is having the majority or not. But however, as per this particular rule, there is no need to specify the reason as to why they wanted to introduce a no confidence motion. And this is one motion, they can discuss anything. But in the other motions, if you see, specifically they have to state the reasons as to why they wanted to introduce this, but there is no such reason that is required when it comes to what is called as no confidence motion. So in Lok Sabha, the no confidence motion has to be set out on the grounds on which it is based, so definitely it is not true. There are also other things that I have to discuss about the no confidence motion, but there is a specific question that is coming. I will discuss about that. So right now you remember that there is no need for any ground or reason to introduce the no confidence motion. In the case of a no confidence motion in the Lok Sabha, no conditions of admissibility have been laid down in the rules. What about this? Is there any conditions for admissibility of this particular notice? Of course, there are conditions. Of course, There is no need to specify the reason, but there are conditions. Say for example, before this notice can be admitted by the speaker in case of Lok Sabha, it has to be minimum supported by 150 members in the Lok Sabha. So therefore, there are conditions for its admissibility into the House. So therefore, this is wrong. The Rajya Sabha is not empowered to entertain the motion of no confidence. Is it true? Yes. The Rajya Sabha cannot entertain, because as per the rules of the House, in which House a no confidence motion can be introduced? Only in the Lok Sabha, not in the Rajya Sabha. And that is in line with the constitutional principle, because the Council of Ministers shall be accountable or collectively responsible only to the Lok Sabha and not to the Rajya Sabha. So what is the answer here? So anyway, C is a correct answer. Come to the next question. Which of the, consider the following statements. While the members of the Rajya Sabha are associated with the committees on public accounts, public undertakings, public accounts committee and the committee on public undertakings, the members of committee on estimates are drawn entirely from the Lok Sabha. Is it true? Okay, before we see whether these things are true, most of the year there is one question from the parliamentary committees. So therefore, this area is a very, very important area. We will try to revise everything through the questions. Okay, I will discuss this question and I will see some online doubts are there. Okay, so come to this particular question of these three committees. There is one similarity between all the three committees. What is the similarity? All the three committees are considered to be the financial committees of the parliament. Okay, so if at all the question comes, which of the following are the financial committees? There are only three financial committees. And all these three committees are also permanent committees in the parliament. So there are two similarities. One is they are all financial committees and they are all permanent committees. Okay, but there are differences. Coming to the differences, when you come to the Public Accounts Committee and the Committee on Public Sector Undertaking, in both these committees there is representation from both Lok Sabha as well as Rajya Sabha. And what is the membership of the Public Accounts Committee and the Committee on Public Sector Undertaking? Both have got 22 members, and out of which in both the cases 15 members from Lok Sabha and 7 members from Rajya Sabha. And in both the cases, whether the members are elected or nominated. Think about it one more time, whether elected or nominated. They are elected, and they are elected by a principle of proportional representation. So that means the representation in these committees will be proportional to the members from different party in the House. So therefore, who is likely to have more members in these committees? Of course, the party that is there in power. So, or the coalition which is there in power, because it is all based on proportional representation. So 15 members from Lok Sabha, 7 members from Rajya Sabha. In both the cases, they are all elected, and usually their term is for a period of 1 year. Can they again get re-elected? Is it possible? Mostly the same member is again will get re-elected to the particular thing. And one thing that you have to remember is, when it comes to the Public Accounts Committee, the chairperson of this Public Accounts Committee as well as the chairperson of the Committee on Public Sector Undertaking, they are nominated among the members elected from the houses. So usually the chairperson of the Public Accounts Committee is from the Lok Sabha, and who appoints someone as a chairperson? The Speaker Lok Sabha will appoint the chairperson, and as per the conventional practice, not in the constitution, as per the conventional practice, usually an opposition member is appointed as the chairperson of the Public Accounts Committee. In the last class also I asked this question, I think. Who is the chairperson of the Public Accounts Committee? Mr. 𝐂𝐨𝐬𝐵 of the Congress Party. So he is the chairperson presently. But however, there is no such conventional practice in case of the Committee on Public Sector Undertaking. So there usually the chairperson is again appointed by the Speaker, but from the ruling party. So this is with regard to these two committees. But however, in case of Estimates Committee, there are only members from the Lok Sabha. And how many members are there in this particular committee? 30 members. All the 30 members are only from the Lok Sabha. And all the members are again elected by proportional representation. and the speaker will nominate one person as the chairperson of this particular committee as well. So this is what you should know. So whether the statement is true or false? While the members of Rajya Sabha are associated with the committees on public accounts and public undertakings, the members of committee on estimates are drawn entirely from the Lok Sabha. Yes, this is true. The Ministry of Parliamentary Affairs work under the overall direction of Cabinet Committee on Parliamentary Affairs. So you have seen different cabinet committees. So we have different cabinet committees. So what are these cabinet committees? Who comprises cabinet committees? The cabinet ministers. So normally if you see, do you know what is the main role of the Ministry of Parliamentary Affairs? The Ministry of Parliamentary Affairs is to see the government agenda in the parliament. What type of bills they wanted to introduce, what kind of discussions they wanted to have. So everything will be decided by for the government by the Ministry of Parliamentary Affairs. So it is looking into one of an important agenda of the government in the parliament. So therefore, who will guide the Ministry of Parliamentary Affairs in this particular regard? The decision will be taken by what is called as a Union Cabinet on Parliamentary Affairs, because we follow what is called as a cabinet system. It is not that the major decisions of the government is taken by an individual minister, but who will take the major decisions of the government? A cabinet committee related to a particular matter. So therefore, this particular statement is true. The Ministry of Parliamentary Affairs works under the overall directions of the Cabinet Committee on Parliamentary Affairs. So this Cabinet Committee on Parliamentary Affairs means it's an executive body. It will comprise of the Union Cabinet Ministers. It will definitely consist. It is headed by the Prime Minister, or the Prime Minister can allow somebody else to head it also, maybe by the Home Minister also, and it will contain other cabinet ministers also as a part of it. So they will decide with regard to what they have to do in the parliament. Come to statement number 3. The Minister of Parliamentary Affairs nominates members of the parliament on committees, councils, boards and commissions etc. set up by the Government of India in the various ministries. Just think about this particular statement for a moment. See, what happens is, sometimes the government, for better analysis, even it is a government decision to take, they may nominate some of the members of the parliament to give some suggestions on that particular matter. So in that particular case, if at all the government wanted to nominate some of the members of the parliament to various government boards, government councils, so in that particular case, who will decide as which member of parliament shall be appointed to all those things? Is it the Minister of Parliamentary Affairs? That's the question. So this is nowhere given in the constitution, but as per the transaction of business rules, it is the responsibility of the Ministry of Parliamentary Affairs to do that. Okay, it is the Minister of Parliamentary Affairs who will do that. So this is also true. So which of the statements given above are correct? The correct answer is 1, 2, 1, 3 only. Is that clear to all of you? What is question number 177? Can anyone tell me what is question number 177? What is the doubt there? Can anyone give me the copy? Okay, question number 177. The Legislative Assembly of each state shall consist of not more than 450 members and chosen by direct election from the territorial constituencies of each state. What about this particular statement? It is clearly wrong, because the Legislative Assembly of each state shall not consist more than 500 members and not 450. So therefore, that is clearly wrong. Second statement, a person shall not be qualified to be chosen to fill the seat in the Legislative Assembly of a state if he or she is less than 25 years of age. This is also clearly given in the constitution. So this particular statement is true. So which of the statement given above are true? It is option B only. Okay, so there is no doubt. So option B is a right answer. Guruprit Kaur, you have asked a question, but I do not know what is your question. You can just post your question once again. So just you also revise, just give me a couple of minutes. I'll just attend to some of the doubts of the online students. Okay, all right. I think we are good to go. There is no other questions. Guruprit Kaur, you can just put your question because I could not see your question. No, the age criteria is directly there in the constitution. So please look into that particular question. The age criteria not less than 25 years of age and not less than 30 years of age for the Rajya Sabha is directly given in the constitution itself. Alright, shall we move forward? Shall we move forward? Okay. Okay, so come to the next question. Which one of the following bills must be passed by each house of Indian Parliament separately by a special majority? What is the answer? Ordinary bill, what is the majority that is required? Has it to be separately passed in all the cases? When the question stresses upon passed separately by special majority, that means there is no other way, only separately it has to be passed. What about the ordinary bill? Is it mandatory it has to be passed separately? There are exceptions to that. What is the exception? It can be passed by a joint sitting. So in the entire political history of India, how many times a joint sitting has happened? 3 times it has happened in the entire history of India. Okay, so therefore not necessarily in all the cases it has to be passed with separately, and anyways in this case it is only a simple majority. Money bill, what is the majority that it is required? Simple majority. Has it to be separately passed? It has to be separately passed, but unfortunately for the Rajya Sabha they cannot do anything about it. They can delay it only by a maximum of 14 days. There is no possibility of joint sitting here also. What about the finance bill? It has to be passed with simple majority. So here also it is almost similar to that of the ordinary bill, but anyways it is passed with simple majority. So what is the answer? Constitutional amendment bill. That means you should have an understanding. In case of a constitutional amendment bill, there is no provision for joint sitting. It has to be separately passed by both the houses of the parliament. So therefore my students were asking me, what if the Rajya Sabha is not accepting? Because if the government is not having the majority, what if the Rajya Sabha is not accepting for a constitutional amendment bill? So does there any alternative? No way. Only when the Rajya Sabha passes it, then only they can get it done. That is why recently Mr. Shashi Tharoor, when he was giving one of the speech, the government was so adamant on introducing a constitutional amendment bill with regard to bringing in what is called as simultaneous elections. So therefore Mr. Shashi Tharoor said that anyways you don't have the majority in the Rajya Sabha, so you don't even have the simple majority, but you need a special majority in the Rajya Sabha to get this simultaneous elections bill passed, because for the simultaneous election you need to make amendment to the constitution also. So therefore in this regard it is also related to the current affairs. So which is the only case which requires a special majority in both the cases? Separately it is a constitutional amendment bill. Okay, so this is the answer. Which one of the following statement is correct? Statement 1. Okay, here there is a small correction. I will just make a small correction here. With that you read it. Both in the Rajya Sabha and the Lok Sabha, both in the Lok Sabha and Rajya Sabha, both not the Lok Sabha can have nominated members. 1 minute. Both Rajya Sabha and the Lok Sabha. Okay, so both Lok Sabha and the Rajya Sabha, both Rajya Sabha and the Lok Sabha, and not the Lok Sabha alone. So just make it small correction here. So both Rajya Sabha and the Lok Sabha, and not the Lok Sabha alone can have nominated members. Is this statement true? Is the statement true or false? Anyways, the Lok Sabha cannot have nominated members. So in the original constitution, both Lok Sabha and Rajya Sabha were having the nominated members, but presently who is having the nominated members? Only the Rajya Sabha. So anyways, this particular statement is wrong. Okay, so this is wrong. There was some small typo in this particular question. Okay, anyways, come to the second question. There is a constitutional provision for nominating 2 members belonging to the Anglo-Indian community to the Rajya Sabha. Is it true? So this was there for the Lok Sabha initially, but however it has been done away with right now. So what is the amendment by which it was done away with? 104th Constitutional Amendment Act, it was done away with. There is no constitutional bar for a nominated member to be appointed as a union minister. Is it true? Is there a constitutional restriction to appoint a nominated member as a minister? There is no such restriction. So therefore this particular statement is true. A nominated member can vote in the presidential election. Can a nominated member vote in the presidential election? No. Be it Lok Sabha or Rajya Sabha, that's not possible. So what is the answer in this case? It is only option C. Okay, come to the next question. Consider the following statements. The joint sitting of the two houses of the parliament in India can be sanctioned under Article 108 of the Constitution. Is that true? Can it be sanctioned under Article 108 of the Constitution? Now tell me, who is supposed to convene a joint sitting? Can anyone tell me who is supposed to convene a joint sitting? It is a president who can convene a joint sitting, and that is not a discretionary power of the president. It is based on what is called as the aid and advice of the Council of Ministers. Okay, whenever a joint sitting is convened, after it is brought into the joint sitting, who is supposed to preside over the joint sitting? The speaker. In the absence of the speaker, deputy speaker. In the absence of both speaker and the deputy speaker, it is a deputy chairman of Rajya Sabha, not the chairman of Rajya Sabha. Is this explicitly mentioned in the Constitution? Yes? How many of you think this is explicitly mentioned in the Constitution? How many of you think it is not mentioned in the Constitution? It is not explicitly mentioned in the Constitution. If you read Article 108 of the Constitution, Article 108 of the Constitution gives this power to the President. But however, Article 108 of the Constitution is only allowing the President to make an order in this regard. The President can make rules in this particular regard as to who can preside over the House. So accordingly, the President has made the rules, but it is not explicitly mentioned in the Constitution. Anyways, UPSC may not go in depth into all those things, but probably in case if they ask you, the benefit that you may get because sitting in the class, spending the time, these are all some of the benefits that you should get, okay, which the other students may not get, okay. So this is not specifically mentioned in the Constitution, but the President has made a rule. So it's the Speaker. In the absence of the Speaker, the Deputy Speaker. If in the absence of both, then it is the Deputy Chairman of the Rajya Sabha, okay. The first joint sitting of Lok Sabha and Rajya Sabha was held in the year 1961. Is it true? Yes, factually it is true. 1961 for the dowry prohibition bill. So it was for the first time that they met, and the second time that they met in the year 1977. 1977 in case of what is called as the Banking Service Repeal Bill, Banking Services Commission Repeal Bill, okay. So that was in the second time. And when was the third time? Third time it was in the year 2002 for the Prevention of Terrorism Bill, okay. So Pusa Bill, that is the third time that they met. So that is not very important, but just remember 3 times they have met till this point of time. First in 1961. So this is true. This is also true. The second sitting of the two houses of the Indian Parliament was held to pass the Banking Services Commission Repeal Bill. This was also true, 1977. So this is also true. So which of the statements given above are correct? It is 1, 2 and 3. The last time they have sat in 2002 for the repeal of what is called as the Pusa Bill, for the Pusa Bill, okay. So Prevention of Terrorism Act. Okay, so come to the next question. Which one of the following authorities recommend the principle governing the granting aids to the revenue of the granting aid of the revenues to the state out of the consolidated fund of India? We know under the Constitution that the center can give some granting aid to the states. So who will recommend the center to give some granting aid to the states? That's a question. It is a Finance Commission of India. Does anyone know under which article this happens? Under Article 280 is where the Finance Commission can give the recommendation. But which article in the constitution allows a center to give this granting aid to the states? Does anyone know? See, they can, the Finance Commission makes a recommendation, that is all okay, but there is a specific article in the constitution that allows the center to give the granting aid to the states. It is article 275 of the constitution. Anyways, I will discuss that when I take up the center state relationship in a little detail. So the answer here is the Finance Commission, and while the Finance Commission gives a recommendation under article 280, but which article allows a center to give the granting aid to the states is article 275 of the constitution. The speaker can ask a member of a house to stop speaking and let another member speak. This phenomena is what is the phenomena? Yielding the floor. That means he is giving somebody else to talk. So it is the speaker's permission with whom anybody can talk in the house, not without the permission of the speaker. So therefore the speaker can allow somebody else to talk during the discussion. So that is basically what is called as yielding the floor. What is interpellations? In the parliamentary language, interpellation means questions, asking questions in the house, that is basically interpellations. What is crossing the floor? Crossing the floor means a member is defecting. A member is defecting from one party to another party, that is basically what is called as crossing the floor. And then what is decorum as per the parliamentary language? Maintaining the discipline in the house. So that is basically what is called as decorum. What happened? What is the answer? Okay, so the answer is yielding the floor in this case. Okay, so come to a very important area. Every year the question is coming from the money bill. Every year, every single year UPSC is asking. Okay, tell me, where is this money bill or the subject matter of the money bill is defined in the constitution? Which article? 110 or 109? I am talking about the subject matter of the money bill, no confusion, article 110. But the procedure for a money bill is given under article 109. So do not get confused. So UPSC rarely asks articles, but last year I think they have asked the article. So the subject matter of the money bill is article 110, procedure for a money bill is article 109. Okay, so when a money bill is presented to the president, I will discuss about the money bill. When a money bill is presented to the president, what are the options that the president can exercise? He can give the assent. Can he withhold the assent? Yes, he can withhold the assent, but he cannot send it for reconsideration. That is not possible, because the matter is so urgent and so important, you cannot waste the time. Withholding the assent to the bill on certain conditions, he can do that. Of course, it is not his discretionary power. Yes, under certain circumstances, certain situations he can do it, but not returning it for reconsideration. Okay, when a bill is considered to be a money bill, in fact, have it in your mind very clearly that all money bills are financial bills. Is it true to say all money bills are financial bills? Because in general, what is a financial bill? Any bill which deals with the financial matters of the government. It can be revenue, it can be expenditure, it can be any other financial matters. If a bill deals with financial matters, then that's a financial bill. And in fact, all money bills are financial bills. But can we say that all financial bills are money bills? That is not possible, because there are different types of financial bills. You have a money bill, and then apart from that, the financial bills are classified into type 1 and type 2 financial bills. Usually they are classified depending upon the subject matter of that particular bill, what they deal with. So therefore, to say all financial bills are money bills is wrong, but all money bills are financial bills. Is that clear to all of you? First thing that you will have to keep in your mind. Okay, then what type of financial bills can be considered to be money bill? That's the question. So I said in general, if they deal with the finances, they are financial bills. But if they deal with specific type of finance matters or financial matters, then they are considered to be what is called as money bill, for which you should have an understanding of what is mentioned in article 110 of the Constitution. So article 110 of the Constitution categorically says it deals with certain subject matters. In fact, to be very specific, it deals with 6 subject matters. So if any financial bill which contains only these subject matters is very important. only the subject matters which is mentioned in Article 110 of the Constitution. Only the subject matters mentioned in Article 110. It can be one matter, it can be two matter, or it can be all the matters, it does not matter. But it shall not contain any of the other matter apart from what is mentioned in Article 110. So, if any financial bill is containing only those subject matters which is mentioned in Article 110, then they would be considered to be what? It would be certified as a money bill by the Speaker. So, therefore, tell me, at the time of introduction of a bill, is it a money bill? It is not a money bill, it is only a financial bill which is containing only those matters which is mentioned in Article 110. Then subsequently, who will certify this particular bill as a money bill? Then the Speaker will certify this particular bill as a money bill before it is sent to the Rajya Sabha. So, once the Speaker certifies this bill as a money bill before it is sent to the Rajya Sabha, then the Rajya Sabha will know what are their powers with regard to this particular bill and what is the maximum power of the Rajya Sabha with regard to this particular bill, that they can delay the passage of the bill by 14 days. Can they reject a money bill, Rajya Sabha? Can they amend the money bill? Yes, they can amend a money bill. They can suggest some amendments and they can send it back, but they can do it within 14 days. But however, it is not binding upon what? It is not binding upon the Lok Sabha. And if they do not take any action for 14 days, then the bill is deemed to be passed. If they suggest amendments and send it back to the Lok Sabha may accept or may not accept. But all these things has to happen within 14 days. So, therefore, their maximum power is that they can delay it by 14 days. Okay, again I am repeating it. Can all the money bills be considered to be financial bills? Can all the financial bill be considered to be money bills? No, because there are other types of financial bills which are basically financial bill type 1 and type 2. So, therefore, any financial bill which contains only those subject matters mentioned in Article 110, then they can be certified as a money bill. So, what is a financial bill type 1? It is also a financial bill. It is also dealing with finances, but this does not exclusively contain only those matters mentioned in Article 110. That means financial bill type 1 will partly have some items or at least one of the item which is mentioned in Article 110, but it does not exclusively contain only those matters. So, that means a financial bill type 1 is a classic example of combination of a money bill and an ordinary bill. So, it will have subject matter related to the finance bill and it will money bill, it will also have subject matter related to an ordinary bill. That is basically what is called as a financial bill type 1. So, in case of a financial bill type 1, when the bill goes to the President, what are the options in the hands of the President? Can he give the assent? Can he withhold the assent? Can he send it for reconsideration? Yes. Remember, he can do everything similar to that of an ordinary bill because it is partly an ordinary bill. Now, what is a financial bill type 2? A financial bill type 2 is also related to matters of finances, but it does not contain any of the matter mentioned in Article 110. So, not even a single subject matter which is there in Article 110 is there in this financial bill type 2, but it also has a financial implications to the government. That is a financial bill type 2. So, in case of a financial bill type 2, what are the options in the hands of the President? He can do everything as that of an ordinary bill. He can give the assent, withhold the assent, send it for reconsideration. All these things can be done. Okay, now coming back to the first point. If any bill which has only those matters which is mentioned in Article 110, then such financial bill can be certified as a money bill. So, whenever a bill is introduced in the Parliament, and if this bill is having only those subject matters, what is the subject matter of the bill? Only those subject matter which is mentioned in Article 110 of the Constitution. In this particular case, as per the procedure, it is saying that this bill can be introduced where? Only in the Lok Sabha, and it can be introduced only with a prior recommendation of the President. That is why we are saying that the money bill can be introduced only in the Lok Sabha with a prior recommendation of the President. But initially itself it is not certified as a money bill, but it is containing only those subject matters for the money bill. So, it can be introduced where? Only in the Lok Sabha with a prior recommendation of the President. And then it goes through all the steps passed by Lok Sabha, and what is the maximum power in the hands of Rajya Sabha? Delayed by 14 days. Then it goes to the President. The President can either give the assent or withhold the assent. Is it clear? Okay, now the procedure in the Constitution is also saying that if any bill which is containing any of those matters which is mentioned in Article 110, and in addition to that it has certain other provisions also, that is basically a financial bill type 1. This can also be introduced only in the Lok Sabha and with a prior recommendation of the President. So, this is the only similarity between a financial bill type 1 and the money bill. In all other cases, financial bill type 1 is similar to that of an ordinary bill. So therefore, once it is passed from the Lok Sabha to the Rajya Sabha, what are all the options in the hands of Rajya Sabha? The Rajya Sabha can accept the bill, so they can accept it, or they can reject it, or they can make amendments and send it back to the Lok Sabha, or they do not take any action for a period of 6 months. And we know that in certain cases there arise what is called as a deadlock. If they accept in the same version, then it will go to the president. In certain other cases, there will be a deadlock. What are the conditions that there will be a deadlock? If they don't accept it, that is, if they make an amendment, if they reject it, there is a deadlock. Or if they make an amendment and send it back to the Lok Sabha, which is not acceptable to the Lok Sabha, then also there is a deadlock. Or if they do not take any action for a period of 6 months, then also there is a deadlock. In case of a deadlock, then what will happen? If the government is serious on this bill, in case of a deadlock, then the government can request the president to convene a joint sitting, and then we have already seen what will happen in the joint sitting. Now the third type of bill is what is called as a financial bill type 2. A financial bill type 2 is similar to that of an ordinary bill. It is entirely similar to that of an ordinary bill, which means it can be introduced where? It can be introduced in either houses of the parliament, and there is no need for prior recommendation. The only difference between a financial bill type 2 and that of an ordinary bill is that in case of a financial bill type 2, procedurally it is little different. How? It requires a recommendation of the president after the bill is introduced in the houses. It is not the prior recommendation, so don't confuse. That means in case of a financial bill type 2, the bill can be introduced in the parliament. But after the introduction stage, what is the next stage for any bill? It will be either referred to the DRSEs or it goes for the second reading in the house, whatever may be the next stage. After the introduction of the bill cannot go to the next stage unless and until the president recommends for it. And this recommendation of the president is required separately in both the houses. So once introduced in the Lok Sabha also, the president recommends, then it goes to the next stage. Then it goes to the Rajya Sabha. The Rajya Sabha also, after introduction, the president recommends, then the bill goes to the next stage. In all other respects, it is similar to that of an ordinary bill. That means what are the options in the hands of the president in case of an financial bill type 2? He can give the assent, withhold the assent, or send it for reconsideration. And because there is no time limit, they may exercise the packet veto also. Okay, so these are all the things that you should understand. So with that, please come to this particular question. So we almost discussed most of the things. If there is any specific thing input I have to give, I will give it when I discuss the question. Now please come to the question. A money bill can be tabled in either houses of the parliament. Is it possible? No, because this is a financial bill which contains only those matters which is mentioned in Article 110. So therefore, where it can be tabled? Only in the Lok Sabha. So this is wrong. The Speaker of Lok Sabha is the final authority to decide whether a bill is a money bill or not. Is it true? Yes, within the house he is the final authority. Now don't confuse whether it can be subject to judicial review or not. That's not the question. Who is the final authority within the house to decide whether it is a money bill or not? It is the Speaker. The Speaker is the final authority to decide whether it is a money bill or not. So this is true. They are asking which is not correct. Okay, anyways, we will see the other options. The Rajya Sabha must return the money bill passed by the Lok Sabha and send it for the consideration within 14 days. Is it true? Yes, the maximum time that they have got is 14 days. The president cannot return a money bill to the Lok Sabha for reconsideration. In fact, not only to the Lok Sabha, in general. Okay, he cannot send it because why they are using Lok Sabha is, in fact, in case of a money bill, who is the final authority? It is the Lok Sabha. Okay, so therefore, this is also true. So therefore, what is the right answer in this case? It is A, because it is asking for which of the following is not correct. Who among the following have the right to vote in the elections of both Lok Sabha and Rajya Sabha? So who among the following, or who is the electoral college both in case of Lok Sabha and Rajya Sabha? That's the question. So elected members of lower house of the parliament, can they vote in the Rajya Sabha elections? That's the question. Can they vote in the Rajya Sabha elections? So who among the given can vote in both elections to the Lok Sabha and Rajya Sabha? That's the question. Can we vote to the Lok Sabha elections? Can we vote to the Rajya Sabha elections? So therefore, you will have to understand who is eligible to vote in the Rajya Sabha elections. Who is eligible to vote in the Rajya Sabha elections? MLAs in case of the state, the elected members of the legislative assemblies. So they are eligible. So therefore, try to give an answer. So, the elected members of lower house of the parliament is not the answer. The elected members of upper house of the parliament is also not the answer. So, then who else is the answer? The elected members of upper house of the state legislature, no. The elected members of the lower house of the state legislature. That means the MLAs will have the right to vote in the Lok Sabha elections and they also have the right to vote in the Rajya Sabha elections. Is that clear? So, as a citizen of India, they have the right to vote in the Lok Sabha elections. As an elected member of the Legislative Assembly, they are part of the electoral college when it comes to the Rajya Sabha elections. Is that clear to all of you? Any doubt here? Lok Sabha? General elections. Yes. As a common citizen, he will have a right to vote. So, there is no problem with regard to that. Okay. So, the elected members of lower house of the state legislature. That means an MLA will have the right to vote in the Lok Sabha elections. The MLA will, of course, he will have the right to vote in the Lok Sabha elections. That is the answer. What is the answer here? It is option D. Is it clear to all of you? Don't hesitate to ask question. If you have questions, please ask it at least after the class is over. Okay. Otherwise, your doubt will always remain a doubt. Okay. And exactly that will appear in the examination. So, you might think that I should have asked this particular question. Okay. If an election to a state legislative assembly, if in an election to the state legislative assembly, the candidate who is declared elected loses his deposit. See, as per the Representation of People Act and the rules of the elections, if any candidate has not got 1/6 of the total valid votes, then you lose their deposit. So, every person who is contesting election to either Lok Sabha or to the Legislative Assembly, they have to pay a deposit amount, 10,000, 15,000, some amount is there. So, that deposit amount will be given back by the Election Commission of India if they minimum secure how much votes? 1/6 of the votes that has been polled. If they fail to secure this 1/6 of the vote that has been polled, then they lose their deposit. But still the candidate can be a winner of the election. That is not possible. That is possible. Why it is possible? Because the election is based on what? The election is based on the first past the post system. All that he has to make sure is that he should get more number of votes than the other candidates. Not necessarily 1/6 of the votes. Even less than that can make him a winner. But in that case, what is the possibility? That is this particular question. If in an election to the state legislative assembly, the candidate who is declared elected loses his deposit, it means what? Can he still be a winner? Is it possible that he has lost deposit but still a winner? Okay, that is possible. Then which of the following can be the situation? The polling was poor. Not necessarily, we do not know. The polling can be 100% polling also. 100% of the people have voted, but none of them got 1/6 of the vote because there was a very tough competition. But ultimately, one got more number of votes than all other candidates. So, therefore, it is not necessarily. The election was for a multi-member constituency. Multi-member constituency is wrong. Multi-member constituency means from a constituency, multiple winners can be there. But our election is based on single-member constituency. So, therefore, that is not definitely right. This is not necessarily the case. The elected candidate's victory over his nearest rival was very marginal. That also we are not sure. Now, let us assume that a particular candidate has not got 1/6 of the vote, but he has got more number of votes than all other candidates where the margin between the winner and the other candidates are very big. That is also possible. But the only possibility definitely we can say that is possible in this case is that a very large number of candidates have contested in the election. Suppose let us assume 1000 voters, but 100 people have contested in the election. So, therefore, the vote share has been divided by number of candidates. So, therefore, nobody has got the deposit, but still there is a winner because of the first past the post system. So, what would be the most appropriate answer here? A very large number of candidates have contested in the election. Is that clear to all of you? One-sixth of the vote polled, I think. Not the total number of votes, because you never know how many people will participate. So, as far as my knowledge is concerned, it is the total number of votes polled. Okay. Okay, so come to the next question. Which one of the following statement is correct? Statement A. All the members of Rajya Sabha are elected by the state legislative assemblies. Is it true? All the members of Rajya Sabha, whoever is elected, they get elected, but they are also nominated members. So therefore, to say all the members of Rajya Sabha are elected from the state legislative assembly is wrong. As the Vice President is ex officio chairman of the Rajya Sabha, only a member of Rajya Sabha can contest for the office of the Vice President. There is no relation between these two things. There is a separate qualification that is given to who can contest the office of the Vice President. Anyone who is a citizen and who has completed 35 years of age. Okay, so therefore here not necessarily only a person who is part of the Rajya Sabha. The Constitution of India explicitly prohibits the appointment of a nominated member of Rajya Sabha to the post of a minister. Is that true? Even someone who is not a member can also become the minister. So therefore, that does not explicitly prohibit. So what is the answer here? None of the above is the answer. Come to the next question. Which one of the following statements regarding the office of the speaker is correct? Very, very important. Two areas I will say every year question is coming. One is from the post of the presiding officers, most likely from the speaker, and the second thing is definitely from the bills. These are all areas definitely they will ask questions. Which one of the following statements regarding the office of the speaker is correct? Statement 1. He holds office during the pleasure of the president. The president has nothing to do with the speaker because the speaker is elected from among the members of the house. The only way that he can be removed is by a motion that is passed in the which house? Lok Sabha or both Lok Sabha and Rajya Sabha? Only in the Lok Sabha. With regard to all the presiding officer, it is only with regard to the respective house. And what is the majority with which it has to be passed? To remove the speaker. Now, please understand, for his election it is simple majority, for the removal for all the speakers it is effective majority. Okay. So, it is for all the presiding officers, sorry, it is effective majority. So, he holds office during the pleasure of the president is wrong. He need not be a member of the house at the time of his election, but has to become a member of the house within 6 months from the date of his election. Is it true? In fact, the only condition that is given is he should be a member of that particular house at the time of election. So, this is also wrong. He loses his office if the house is dissolved before the end of the normal tenure. Is it true? The speaker's term is not coterminous with the term of the house. They are not one and the same. Okay, so that is should be very, very clear in your mind. If he intends to resign, the letter of his resignation to be submitted to the deputy speaker. Is it true? Yes. But what if there is no deputy speaker? One of the student was asking, in the last two Lok Sabha there was no deputy speaker. So what if the deputy speaker is not there and if the speaker has to submit the resignation? Then nothing is given in the constitution, but as per the rules of the Lok Sabha, then the resignation is submitted to the Secretary General of Lok Sabha. Is that clear? So to whom it will be submitted? It is submitted to the Secretary General of Lok Sabha, but as per the rules of the house. So this is true. The answer is option D. Which one of the following are the financial committees of the Parliament in India? Which of the following are the financial committees? Public Accounts Committee, Estimates Committee, and the Committee on Public Sector Undertaking. Among all the three committees, which is the largest financial committee? It is the Estimates Committee. And in the Estimates Committee, the members are elected or nominated? All the members are elected based on the principle of proportional representation. And all the members are only from the Lok Sabha. Who appoints a chairperson of the Estimates Committee? The Speaker of Lok Sabha, and the person is usually from the ruling party. And among all the committees, which committee will have the chairman from the opposition party? Public Accounts Committee, and that is by a parliamentary conventional practice. Is that clear? Very, very important. So every year they do ask a question from this particular area also. So come to the next question. Which one of the following correctly reflects the position of the upper house of the upper house of the state legislature as compared to the position of upper house of the parliament. So, they are making a comparison between the legislative council and the Rajya Sabha in this particular question. So, look into the question. Statement A, while 1/3 of the members of the Rajya Sabha retire every second year, 1/4 of the members of the legislative council retire every 18 months. Is it clear? In both the cases, 1/3 of the members retire every second year. So, this is wrong. So, who is authority to create or to abolish a legislative council? Who is authority? Parliament or the concerned state legislative assembly? It is a parliament which is the authority, you should not have any doubt, but the parliament cannot do it suo moto on its own. Only on the basis of resolution passed by the concerned state legislative assembly, then they can either create or they can abolish. And I said that the legislative assembly has to pass a resolution, and what is the majority with which they have to pass this resolution? By special majority they have to pass it, not less than 2/3 of the members present and voting plus absolute majority. So, if they pass it. And is the resolution passed by the state legislative assembly, is it binding upon the parliament? Is it necessary for the parliament to immediately enact a law? It is not binding upon the parliament. Okay. There is no provision for a joint sitting of the legislative assembly and the legislative council in the states for resolving the deadlocks. Well, there is such a provision in case of the houses of the parliament. Is it true? Yes, there is no provision for deadlock in case of the state legislature. Now, why? Because the legislative council do not have equal powers as that of the assembly when it comes to the ordinary bills. Leave about the money bills, but in case of even the ordinary bills, they do not have equal powers. I will discuss that in detail. There are few questions that is coming, but just try to answer this question. What is the maximum power in the hands of the legislative council to delay a bill, or how long they can delay a bill? What is the maximum time? 4 months is the maximum time. 3 months in the first instance and 1 month in the second instance. So, their maximum power is only to delay by 4 months. And what all the power they can exercise, I will discuss. I think subsequently the questions are there, I will discuss. Well, no bill other than the money bill can originate in the state legislative council. No bill can originate in the Rajya Sabha. Is it true? This is definitely wrong. Okay, so this is a complete wrong statement. Well, Rajya Sabha has 12 nominated members. The state legislative council has none. While the Rajya Sabha has 12 nominated members, the legislative council has 1/6 of the members to be nominated by the governor. So, therefore, this is also wrong. Okay, whenever a legislative council is created or abolished, is there a need to make change in the constitution? Will there be changes in the constitution when a legislative council is abolished or created? Yes or no? Yes, no? No, there is a need to make change in article 168 of the constitution. So, article 168 of the constitution will mention the names of the state which has got the legislative councils. So, therefore, yes, there will be definitely change in the constitution, but the question is, to make this change, is it necessary to make a constitutional amendment under article 368, or can it be done by a simple act of parliament? It can be done by a simple act of parliament. Such an exception is given in the constitution. Okay. So, you do not have to make a constitutional amendment under article 368. By a simple act of parliament, you can amend article 168 of the constitution. Okay. Come to question number 195. Which of the following are the circumstances under which an elected member of parliament may be disqualified on the grounds of defection? Now, where is the ground for defection mentioned in the constitution? What is the ground on which they can be disqualified? It is mentioned in the 10th schedule of the constitution. Just knowing the schedule itself is very important. Many times questions have come from this particular area. Anyways, I will discuss about the schedules in the later classes. So, it is mentioned in the schedule 10 of the constitution. 4 grounds are given in schedule 10. So, what are the 4 grounds? If somebody gives up the party membership voluntarily, somebody abstains or act contrary to the party direction, these are all for people who are belonging to a party. And then one is for a nominated member. If any nominated member joins any party after 6 months, within 6 months is okay, but after 6 months he is liable to be disqualified. Any independent candidate joins any party at any time during the term of the house. If he joins, then also he is liable to be disqualified. These are all the only 4 things that is given under in the schedule 10 of the constitution. So, now please come here. If he voluntarily gives up the membership of political party, is it true? Yes, so this is definitely true. But the Supreme Court of India has said voluntarily giving up the party membership not necessarily only mean that he has joined another party. He can be in the same party and he can do something against a party. That also from his conduct, the presiding officer can come to a conclusion that he has voluntarily given up the party membership. So anyways, this is definitely true. If he votes or abstains from voting contrary to any direction that is issued by his political party without prior permission of the political party, is it true? That means, can someone take a prior permission from the party? Yes, they can take prior permission from the party. If the party accepts, then it is okay. But even without prior permission, they can do it, but then they have to ask the party to condone them within 15 days. So these are all some exceptions given in the constitution, but anyways, in general, this particular statement is true. If he speaks against a political party, what about this? Where he is speaking, what he is speaking, these things are not very clear here. So just because speaking against a party doesn't mean at some point of the other, someone will speak against the leadership. So therefore, not everybody is liable to be disqualified. So this is not a ground that is mentioned in the constitution. So we'll have to understand what he is speaking. What if the leader itself is wrong? It is not necessarily always a party is right. The individual can be right. In which forum he is doing it? What is the damage to the party? So nothing of that sort is very clear. So statement is very vague, and it is also not directly given in the constitution. So therefore, we cannot assume that it may fall under all those things. See whether it is there in the constitution or not. So therefore, this particular statement is wrong. If he joins a political party other than the party on whose ticket he has contested the election, so this is he is voluntarily giving up the party membership. Okay, so this is true. So which of the above is are correct? What is the answer here? 1, 2, 1, 4 only. So come to the next question. Who is authorized to decide over a dispute regarding disqualification of a member of a parliament? Who is authority? Who is authority? Is it the Election Commission of India, the Chief Election Commissioner, the President, the Speaker? Who is authority? Now please try to understand that in case of all the disqualification except the anti-defection law, who is authority to disqualify the members of the parliament? It is the President of India. The Election Commission of India has no authority to disqualify. The Election Commission of India will only make the recommendation after making an inquiry. Who is authority to disqualify the members of the parliament? It is the President. And who is authority to disqualify the members of the state legislature? It is the governor of that particular state. Except in case of anti-defection law. Only in case of anti-defection law, the speaker or the presiding officer will have the power to disqualify. In all other cases, it is the president and the governors. After the Supreme Court ruling, in certain cases, they have said there is an automatic disqualification when there is a conviction in a court of law. But otherwise, this is the thing that you have to understand. So what is the answer here? It is the President of India. Okay, now the students ask me that with regard to the disqualification of the members of the parliament also, do the President act on the aid and advice of the Council of Ministers? No, in this case, definitely not. Then the government Council of Ministers can advise to disqualify all the members of the opposition party. So here it does not happen that way, but on the recommendation of what? The Election Commission of India, and the recommendation of the Election Commission of India is binding upon the President. Okay, once the President disqualifies a member of parliament, is it subject to further appeal anywhere? Can that decision of the President be appealed? Yes, that is not a final decision. It can be challenged in the High Court concerned. From wherever a member has contested the election from that particular state, they can go to the High Court and challenge this order. And a further appeal can also be made to the Supreme Court of India. Okay. That is what I have said just now. Okay, so it is based on the recommendation that is given by the Election Commission of India, not on the aid and advice of the Council of Ministers. Okay, so please come to question number 197. in the estimation of expenditure charged upon the consolidated fund of India, okay, when the budget is presented, that is annual financial statement is presented, the budget has to be presented in the form of estimated revenue and estimated expenditure. And the estimated expenditure has to be further separated into two columns. One is the made expenditure, another is the charge expenditure. So, can anyone tell me what is the difference between the made expenditure and the charge expenditure? This is how the budget has to be presented. What is the difference between these two things? Which expenditure is discussed and also put to vote? At which stage it is discussed and put to vote? Which stage of the budgetary process? The second reading stage? Not in the second reading stage. Which stage it is discussed and put to vote? I mean, the expenditure is put to vote, discussed and put to vote. It is on the vote on demand for grant stage. So, when you go to the vote on demand for grant stage, if you look into the expenditure, those expenditures which are made expenditures, it is discussed as well as put to vote. But whereas the charge expenditures can be discussed, but it is not put to vote. Without voting, it has to be passed. That is why these expenditures are considered to be very important expenditures. So, therefore, the person who is preparing the budget, that is the Department of Economic Affairs, whoever is concerned with consolidating the entire budget, before giving it to the finance minister, they should be aware of what should be part of charge expenditure and what should be part of the made expenditure. So, from where do we get this information as to what is when it comes to the union budget, and where do we know as to what are the charge expenditure? Article 112 of the Constitution. Is Article 112 of the Constitution is the only source for charge expenditure? Is it the only area where the charge expenditure is mentioned? So, what are the source of charge expenditure? Because the person, as long as he knows what is charge expenditure, he cannot fill this particular column, and these two things are mutually exclusive. Whatever is not a charge expenditure, that's a made expenditure. But so at least you should know what is a charge expenditure, so that the other expenditures can be put in the made column. So, how do we know what is a charge expenditure? It is mentioned in Article 112 of the Constitution. It is mentioned in certain other provisions of the Constitution. So, for example, Article 146 is there. What is Article 146 related to? Does anyone know? Salary allowances of whom? Judges. The judges of the Supreme Court are all mentioned in Article 112 itself. What is Article 146? Where it is mentioning the staffs and the other clerks, the officers and the other servants of the Supreme Court, their salaries and allowances shall be charged upon the consolidated fund of India. So, therefore, whatever is there in Article 112, and apart from Article 112, any of the other provisions of the Constitution where they declare an expenditure to be a charge expenditure, and apart from that, the law made by the Parliament. The Parliament can make a law, and by that law, if it declares an expenditure to be a charge expenditure, that shall also be a charge expenditure. So, all these things will be part of what is called as a charge expenditure. So, remaining expenditures will be what? Made expenditure. So, once you know this, when it is a charge expenditure, when the budgetary process, when it comes to the vote on demand for grant stage, while the made expenditure is discussed and then put to vote, whereas the charge expenditure can be only discussed, but it is not put to vote. That means practically you cannot make any changes to what is called as a charge expenditure. Even to the made expenditure, there may not be any change per se, because in the made expenditure also they are discussed and put to vote, and while putting it to vote, there can be some cut motions that can be introduced if at all they are intending to make some changes. And what are the cut motions that can be introduced? It can be a policy cut motion, it can be a token cut motion, it can be an economy cut motion. When I say policy cut motion, let the demand be reduced to ₹1. When I say it is a economy cut motion, let the demand be reduced by a specified amount. And when I say it is a token cut motion, when the demand be reduced by ₹100, it does not make any change. But although those motions can be introduced, none of these motions will be passed. If any of these motions are passed, then what can be assumed? That means it is a no confidence motion against the government. So, therefore, in this case also changes are unlikely. But however, the cut motions can be introduced. But whereas in case of charge expenditure, because it is not put to vote, the cut motions cannot be introduced there. These are all considered to be very important expenditures. Alright. So, this is something basically you have to understand. But what are all charge expenditure? There is a separate question that I will further discuss, but it is very, very important for you to know the difference between the made expenditure and the charge expenditure. Is that clear to all of you? Yes, please come to the question. In the estimation of expenditure, if the estimation of expenditure is charged on the consolidated fund of India, the Parliament has no power to discuss. They have the power to discuss. Yes, so this is wrong. Full power to discuss. Yes, they have full power to discuss. Full power to discuss during financial emergency, not necessarily in financial emergency. Every regular budget they can discuss. This is all to distract and confuse you. Don't get confused. None of the above. So what is the answer? It is option B. Okay. What is the maximum gap between two sessions of the Parliament? Who is supposed to summon the session and prorogue the session? Is it to be done on the aid and advice of the Council of Ministers? And which article in the Constitution talks about this? Article 85. Okay, if you are not remembering, it's okay, but it is Article 85. So what can be the maximum recess in the Parliament? 6 months. So if it say, so recess is the word that technically that is used. Okay, don't get confused if they put the word recess. So maximum it shall be 6 months. Is there any minimum requirement as to how many days the Parliament has to be in session? Is there any minimum number of requirement in the Constitution as to how many sessions has to be in a given year? Is there any minimum requirement? No, nothing is given. Only one information is given, is that the gap between two sessions should not be more than 6 months. Is that clear to all of you? Can the Parliament session be convened in a different place apart from the Parliament? Is that possible? Yes, because the Constitution does not say it has to be convened only in the Parliament. It can be convened in other places also. So today we have 3 sessions in the Parliament, and the 3 sessions in the Parliament is based on what is called as a conventional practice, and nothing is there in the Constitution. So what is the answer for this particular question? The maximum gap between 2 sessions of the Parliament is 6 months. So what is the answer? Option A. The Deputy Chairman of Rajya Sabha, question number 199. The Deputy Chairman of Rajya Sabha can be removed by a resolution passed by, what is the majority with which he can be removed? By effective majority. In all the cases, when it comes to removal, it is effective majority. The only exception is the President of India. Anyways, he is not a presiding officer. But the one thing that you have to remember is, when it is the Chairman Rajya Sabha, it has to happen in both the houses. Because he is not removed as a Chairman Rajya Sabha, he is removed as a Vice President of India. Okay. So what is the answer here? It has to be passed by, here it is 2/3 majority no, simple majority no, moved in Rajya Sabha but passed by Lok Sabha no, none of the above, because nothing is given, so it is none of the above is the answer. Okay, but there are certain important things that you have to remember. If a resolution is, if a notice is introduced with regard to removal of the Deputy Speaker in case of the Rajya Sabha, can the Deputy Speaker preside over the House? If the Speaker is, if the Deputy Chairman, if a notice is introduced to remove the Deputy Chairman of Rajya Sabha, and let us assume the Chairman is absent on a given day, can the Deputy Chairman still preside over the House? No, the Deputy Chairman cannot preside over the House once a notice is admitted. So who shall preside over the House? Panel of chairpersons. So vice chairpersons, I think. So they, anyone among them will preside over the House. Can the Deputy Chairman be present in the House and take part in the proceedings? Yes, he can do that. Can he vote in the first instance? Can he vote in the first instance? Then he becomes a normal member of the Parliament in that House. So therefore, he can vote in the first instance. So remember that the casting vote is exercised by the presiding officer only when they are acting as a presiding, or when they are presiding over the House. Otherwise, they will vote in the first instance. Is that clear? So when a notice is there, he will have the right to present, he will have the right to participate in the proceedings, and he will also have the right to vote in the first instance, but not in case of casting of vote. That will be done only by someone who is presiding over the House. This is also true for both the Speaker as well as the Deputy Speaker. But when the notice is introduced with regard to removal of the Chairman of Rajya Sabha, who is also the Vice President of India, So in that particular case, can he preside over the house? He cannot preside over the house. Can he present in the house? Can he participate in the proceedings in the house? He can participate in the proceedings. He can participate in the proceedings. Will he have the right to vote in the first instance? He will not have the right to vote in the first instance, because the difference between the chairman Rajya Sabha and all the other presiding officer, the chairman Rajya Sabha is not a member of parliament, but whereas all the three members are members of parliament, so therefore they will have the right to vote in the first instance. Is that clear to all of you? Very, very important area, don't get confused. Okay, is that clear? Does anyone want me to repeat this? Clear? Okay. So please come to the next question. What is the minimum percentage of strength of opposition is required to the state legislature for the appointment of opposition leader in case of states? What is the minimum requirement? Not less than 1/10 of the membership of that particular house. But is it mentioned in the constitution? It is only a conventional practice that we follow. Okay, it is not mentioned in the constitution. So the answer here is none of the above. Okay. No, the ruling party will not recognize them as there is no need for them to recognize. Anyways, there is no legal position in this regard, except in the parliament there is a legal position, but in case of the state legislature there is no such legal position. So the opposition will not recognize. Why would the government recognize that? Because opposition leader means they have to give them a status. So normally they will not allow that to happen. Majority means not the 1/10 minimum strength, huh? So they can talk and they can consider, but will it happen or not, that is for the government, but the government will not accept it, because that is a way that they can corner the opposition. Okay, that is how they can take a political advantage of that. Okay, so now we are done with 200 questions. We'll try to see how many more questions we can do in the parliament. Any questions? I'll just take a moment to see the online students' question. Okay, so there's a question from one of the online student. The question is, sir, if the Lok Sabha speaker decides it is a money bill or a finance bill, if he says that the bill as a, so the question I think is, if it is not a money bill but he says it to be a money bill, he certifies it to be a money bill, is his decision final? Nothing can be done in the parliament. That is final and binding, and then the Rajya Sabha will have a power only to delay it by 14 days. But if if it is done arbitrarily, then subsequently it is subject to a judicial review in a court of law. That is a different thing, but within the parliament nothing can be done, because that authority is only to the speaker. Which is the important committee? Is it the Public Accounts Committee or the Estimates Committee? So that is not the way to ask the question. UPSC will not ask, because every committee has their responsibility to do. So maybe they can ask based on the membership. So who are we to assess which is the most important committee? That is a very subjective nature. So such type of questions UPSC may not ask. Don't worry about that. But yes, they can ask you from the composition, from the election and all those things. And both have a very important role to play. The Estimates Committee play a very important role in terms of presenting the estimates in the first place, whereas a Public Accounts Committee has a very important role in scrutinizing the report that is submitted by the CAG. So therefore, both have an important role. Okay. Please come to the next question. When a money bill is passed by the parliament, the president has the power to what? Okay, just let me know what is your answer and the reason for that. So please try to give your reason and also the answer for this question. Okay, when a money bill is passed by the parliament, the president has a power to amend it. The president has no power to amend it. How the president can amend it? The president has no power to amend it. In fact, the president has no power to even send it for reconsideration. In the reconsideration also, he can suggest certain changes. He doesn't have the power to amend it. Okay, so anyways, this is definitely wrong. Okay, he can return it for reconsideration. He can also not do it. Maybe the confusion is between reject it or keep it with him. So you tell me what is the answer. Keep it with him. How many of you think keep it with him? How many of you think reject it? Okay, now see, you'll have to see what is there in the constitution. So whenever a money bill is presented to the president, what the president can do? He can give his assent, he can withhold his assent. These are the only two things that is given. So therefore, he cannot amend it, he cannot return it for reconsideration. He can withhold it, subject to certain conditions. The understanding is in certain conditions he can withhold it. Withholding means he is rejecting the bill. But there is no explicit mention of keeping it with him. That is because there is no time limit that is given in the constitution. He is exercising that pocket veto. But that should not be understood as a power that is given to the president under the constitution. So therefore, what is the right answer in this case? He can reject it. Is it clear? So the right answer is he can reject it, but he cannot keep it with him. So therefore, this is the right answer. The answer is what? It is option B. He is sitting on the bill because there is no time limit, but the constitution does not say the president to do that. So what is the power that is given to the president under the constitution? He can withhold it. So therefore, he can reject it, but not withhold it. But then the bill will not become an act. If he rejects it, then the bill does not become an act. No, you can ask me under what situation he can do it. So normally when the president is likely to do that, when a money bill is sent to him, just a moment, when a money bill is sent to him, and when he has received this particular money bill, and then let us assume that the government is, the legislature, the Lok Sabha is dissolved. So therefore, he will withhold the assent to the bill, and if he withhold the assent to the bill does not become an act. It is as simple as that. So therefore, when the government is a legitimate government, the president cannot exercise his power. When the government is having a full majority in the Lok Sabha, then the president should not do that. And if the president is doing that, then what is the remedy? Then the president can be impeached, which is also not possible. So that is why the government is very careful in choosing the president, which we do not have a precedent for this. No president have done like that, because money bill has a very important implications for the government and of course to the people also. So therefore, the president will not do this. But if in case the money bill is sent to the president, but then the Lok Sabha is dissolved, so therefore he can reject it. That is very much possible. He can withhold the assent to the bill. Yes, what is your doubt? Okay. No, that can go for a change. The way that the bill has been introduced, not necessarily it is the same way it will be sent to the president. When it is made a prior recommendation, it can go in the parliament, the Lok Sabha can make changes, the Rajya Sabha can suggest some amendments which may be acceptable to the Lok Sabha. So therefore, when it comes to the president, is not in the same case. So that is the reason he can still use it. Okay. Alright, so please, is it clear to all of you? Okay, come to the next question. In which case a joint session of the Lok Sabha and the Rajya Sabha is convened by the president. So in which case a joint session can be convened? Statement A, when the finance bill is to be passed by the Lok Sabha and the Rajya Sabha with 2/3 majority. There is nothing in the constitution like this, some random thing to confuse the students, it has been given. Okay, so this is all distractors. To impeach a president, no, it has to be separately passed. So there is no joint sitting. If after a bill has been passed by one house and transmitted to the other house and the bill is rejected by the other house, is it true? Yes. So here the implied understanding is mostly it is an ordinary bill or any of the bill where there is a possibility of having a joint sitting. So this is definitely true. So definitely not all of the above. Okay. So the answer is option C. Come to the next question. Consider the following statements. Conviction on defamation is a ground for disqualification of a member of parliament. Is it true? Conviction on defamation, is it a ground for disqualification of a member of parliament? What are the grounds for disqualification of a member of parliament? What is there in the constitution? If he gives up the citizenship, if he becomes an undischarged insolvent, if he is of unsound mind declared by a competent court, if he holds any office of profit, and apart from that any of the grounds as per the law made by the parliament. And accordingly the Representation of People Act was enacted, and the Representation of People Act says that if somebody is convicted of any offence for 2 or more years, then they are liable to be disqualified, and they are liable to be disqualified, and there is a ban for another 6 years after they complete their conviction term. So with that knowledge, come here. Conviction on defamation is a ground for disqualification of a member of parliament. Mere conviction on the grounds of disqualification, is it a ground for disqualification? Yes or no? How many of you think no? How many of you think yes? Conviction on disqualification. Okay, conviction on conviction on defamation. But conviction on defamation, let us assume the punishment is only 6 months. Here the quantum of punishment is not given. So it is only saying conviction on defamation. In fact, the defamation, the maximum punishment for criminal defamation in our country is 2 years. So not necessarily in every case the judiciary will give 2 years of punishment. But what if the punishment is less than 2 years? So therefore my question is a mere conviction on the grounds of defamation, is it itself a ground for disqualification? No, unless and until the minimum punishment is how much? 2 years. Mr. Rahul Gandhi was unfortunate, he was given 2 years of punishment for criminal defamation. That's a maximum punishment under the law. So therefore, if that punishment was likely to continue, he has to be disqualified as a member of parliament, and another 6 years he would not be able to contest the election. But fortunately for him, the Supreme Court came for his rescue. They suspended the punishment itself till the time the matter will be finally decided by the Supreme Court. So therefore, the statement you will have to see, the conviction on defamation is a ground for disqualification is not true. But if the minimum punishment is 2 years, then it is true. So therefore, this statement cannot be completely seen as a right thing, because we are not sure as to what is the quantum of punishment in this particular case. Is that clear to all of you? But there are certain offences where a mere conviction is itself enough to disqualify them. But defamation is not one such crime. But there are certain other offences where mere conviction itself is sufficient to disqualify them for another 6 years. Whatever may be the quantum of punishment, even if they are convicted with fine, still they can be disqualified immediately. But defamation is not one such offence. Can you just recall some of the offences? If they are convicted under hate speech, if they are convicted under the Prevention of Corruption Act, if they are convicted under the Civil Rights Act, if they are convicted under any of the terrorism related acts in our country, under those cases mere conviction itself is sufficient. But defamation is not a grave offence. So therefore mere conviction is not sufficient, but minimum punishment has to be how much? Minimum 2 years. Okay, so come to the next question. Defamation is a criminal offence under the Constitution. In fact, the Constitution does not deal with any of the criminal offences. So not only defamation, there are separate laws in our country which deals with the criminal laws. Okay, so therefore that is definitely not right. Any member of parliament convicted on the grounds of defection. So the question, this ground of defection, will not be able to contest election for another 6 years after the completion of his term. This is not true. There is no restriction. Okay, so let us assume that a person who is convicted on the grounds of defection is not convicted, disqualified on the grounds of defection. Will they able to contest in the next election? Will they be able to contest in the by-election? Is it possible? Because once a member is disqualified on the grounds of defection, there is a vacancy in some constituency, and then the by-election is likely to come. Will they be able to contest in the by-election? Yes. Of course, they will be able to contest in the by-election. There is no such restriction. But one of the students was asking, will they be able to contest from the same party? That is for the party to decide. Will they be able to contest from the same party? That is for him and for the party to decide. I cannot say that, but it is very unlikely to happen. Just now he has defected that particular party. So therefore, that I cannot answer, but by common logic it is unlikely to happen. Okay, so what is the answer here? Any member of parliament convicted on the grounds of defection will not be able to contest election for another 6 years is wrong. Okay, so what is the answer here? Which of the above are incorrect? So all of the above. Consider the following statements with regard to the anti-defection law in India. So where is this anti-defection law mentioned? Okay, so 10th schedule. So when was this anti-defection law brought in? 52nd Constitutional Amendment Act 1985. Is there any other amendment related to the anti-defection law? Which amendment? 91st, very good. 91st Constitutional Amendment Act. So what change was brought in by the 91st Constitutional Amendment Act? They have brought in an exception with regard to the anti-defection law. So which was initially 1/3 split, and that 1/3 split was replaced by what is called as 2/3 merger. So these are all the factual things that you have to remember. And we already seen with regard to, when it comes to the defection, the grounds for defection, which is mentioned in the 10th schedule. And who is authority to disqualify? The members of the parliament, not the speaker, the presiding officers. Not necessarily the speaker, the presiding officer is the authority. The Lok Sabha speaker as well as the Rajya Sabha chairman. Is there any time limit for the speaker to decide the disqualification petitions? There is no time limit that is mentioned in the constitution, but some of the Supreme Court has mentioned reasonable time frame, where they also said it to be 3 months, but that is not a binding aspect of the judgment, so therefore there is no time limit as of now. Can the presiding officer take an anti-defection petition suo motu? Can they raise it on their own? That is not at all possible. It is only based on a petition that is brought in front of the presiding officer. Okay, so these are all some information, probably you can keep it in your mind from the prelims point of view. Okay, come to the first statement. The President of India and the governors of the state are the disqualifying authority in case of defection under the constitution. So who is the disqualifying authority? It is a presiding officer, not the president. In all other cases, it is a president and the governors. In this case, it is a presiding officer. Once disqualified under the law, the legislature cannot contest election from the constituency where he or she got elected. There is no such restriction. They can contest the election. But there is one restriction for a person who is disqualified on the grounds of defection. Now we know, let us assume, we have already seen that a person who is not even a member of parliament, he or she can be appointed as a minister. How long he or she can be appointed as a minister? Within a period of 6 months. But that is not applicable for a person who is disqualified under defection. Suppose if somebody is disqualified under defection, then he is not a member of parliament or a member of state legislature. Can he or she be appointed as a minister for 6 months? Not possible. They will not be eligible to be appointed as a minister unless and until they get elected back to the house. So they can contest in the by-election, they can get elected, that's a different thing, but they cannot be appointed as a minister. But once they get elected, can they be appointed as a minister? Of course, yes, that they can be appointed. So once disqualified, they cannot contest election from the constituency. This is wrong, they can contest. The 10th schedule of the constitution deals with the anti-defection law. Is it true? Yes, the 10th schedule of the constitution deals with that. Is it 9? Okay, so therefore it is wrong. So it is the 10th schedule. So what is the answer here? Huh? Okay, we'll make a small change. Instead of either we'll do that or we'll have to make none of the above. So we'll do this. Okay, we'll make it 10th schedule. The 10th schedule of the constitution deals with the anti-defection law. Choose the correct answer. What is the answer? 3 only. Okay, so this is a typo. I think instead of my intention was to put 10th schedule, but somehow it came as 9th schedule. So what is the answer here? It is option B. Consider the following statements with regard to motion of thanks. So yesterday itself I have discussed about the motion of thanks. What are the 2 occasions where this motion of thanks happens? Every year during the first session and also first session after the general election. Now in both the cases, the government will prepare a speech for the president to deliver the speech. And does the president has a discretion in changing or altering this particular speech? In fact, the constitution does not explicitly say anything, but we know that the president has to act in accordance with the aid and advice of the Council of Ministers. So therefore, there is no discretion that is there explicitly. The president will come and deliver the speech on behalf of the government. And once the speech is delivered, then to thank the president for this particular speech, a motion is introduced. That is basically what is called as motion of thanks. And this speech is usually introduced by the Prime Minister himself in the Lok Sabha. and by a very important minister in the Rajya Sabha. So after that motion is introduced, the opposition may not agree with everything in the speech, because of course they are likely to oppose the government. So then there will be a discussion on this, and then finally it will be put to vote. And when it is put to vote, if this motion is passed with, if it is not passed with simple majority, then that amounts to no confidence motion against the government. Okay, it is automatically deemed. And if it is not passed in the Rajya Sabha, there is no effect to the government. Okay, so only in case of Lok Sabha it has to be passed. Similarly, the same thing will happen in what is called as the state legislature as well. So please come here. The motion is passed during the first session of the parliament every year after the presidential address. Is it true? Yes. The defeat of the motion in the Lok Sabha shall be considered to be a vote of no confidence. Is it true? Yes. So which of the statements given above are incorrect? It is neither 1 nor 2. Okay, come to the next question. Consider the following statements with regard to the private member bill. So what is a private member bill? Any bill which is introduced by a person who is a member of parliament but not a minister. So sometimes students have a misunderstanding that a private member bill is from an opposition party. Not, it can be from the ruling party or the opposition party, but someone who is not a minister. A bill which is introduced by a member of parliament from the opposition party, no. It can be from the ruling party or it can be from the ruling party, but who is not a minister. A constitutional amendment bill can be introduced by a private member. Is it true? Can a constitutional amendment bill be introduced by a private member? There is no such restriction as to who can introduce a constitutional amendment bill. It can be introduced by a minister or by a private member. But if a private member is introducing it, it cannot move forward apart from that. So he can introduce, that is not a problem. But unless and until they are having the support of the government, how they can get it passed? So therefore, it is very unlikely it will get passed, but they can introduce that. There is no restriction to that. So this is definitely true. Which of the statements given above are incorrect? 1 only. So come to the next question. The Speaker of Lok Sabha can be removed by a resolution passed by what? By effective majority. And effective majority in which house? In the Lok Sabha. It is only in the Lok Sabha, not in the other house. Elected by what majority? Speaker. Which of the following statements are true with regard to the parliamentary standing committees in the parliament? Very important. So how many standing committees are there in the parliament? 24 standing committees in the parliament. Of these 24 standing committees in the parliament, how many committees are housed in the Lok Sabha? So 24 DRSCs. So this is what you will have to understand. So overall, of which there are 16 in the Lok Sabha and 8 in the Rajya Sabha. But every committee will have 31 members, and all the committees, it is a combination of 21 plus 10. That means all the committees in the Lok Sabha will also have members of Lok Sabha as well as Rajya Sabha. So here also 21 plus 10, 21 from Lok Sabha, 10 from Rajya Sabha. But the most important thing that you have to remember is, in case of DRSCs, all the members are nominated. There is no election. In case of the financial committees, we have seen that there is an election. That there is an election, and it is based on the principle of proportional representation. But here everything is what? Nomination. The Speaker will nominate all the 21 members, the Chairman Rajya Sabha will nominate all the 10 members. So there it is same in both the cases. In all these 16 committees, anyone from the Lok Sabha will be made as nominated as a chairperson. For all these 8 committees, anyone from the Rajya Sabha will be nominated as a chairperson. And what are the functions of these DRSCs? Normally they scrutinize the relevant bills, they scrutinize the budget relevant to them, they scrutinize the implementation of various government schemes which is relevant to them. So these are all some of the functions that is performed by the DRSCs. Okay, now come here. The members of these committees are usually elected for a term of 1 year. Are they elected? No, they are nominated. 1 year term, but they get again repeatedly nominated. The committees have representation from members of both the houses. Is it true? Yes, they do have representation. The committee help in discharging various functions of the parliament, including scrutinizing bills, implementing various schemes of the government, etc., thereby help in ensuring the accountability of the executives. Is it true? That's a general essence and functions of these committees. So choose a correct option from the codes given below. What is the answer? Option C only. Parliamentary committees, again I am repeating, very, very important. Come to the next question. Okay, so come to question number 209. Consider the following statements with regard to the procedure to amend the Constitution of India. A constitutional amendment bill can be introduced only in the Lok Sabha with a prior recommendation of the President. Now, one of the procedure that you should know is a constitutional amendment bill can be introduced in either houses of the Parliament, and there is no need for any prior recommendation. It can be introduced either by a minister or by a private member. A constitutional amendment bill seeking to amend the federal provisions of the Constitution also requires ratification by more than half of the state legislature, approved by both the houses of the Parliament by special majority. Is it true? Is it true or false? Why it is? What is the mistake here? A constitutional amendment bill seeking to amend the federal provisions of the Constitution requires ratification. It is not more than half of the state legislature. It is not less than half of the state legislature. There is a difference between these two things. Okay, so more than half is different from not less than half. Why it is there's a difference? More than half, 28 states, more than half means 15 states, but not less than half means only 14 states. So therefore there's a difference between these two words. So exact word that is given is very, very important. Not less than half of the state legislature after approved by both houses of the Parliament by special majority. So in fact this is true, special majority is true, but it is because of not less than half of the state legislature. So this is wrong. The President can exercise his veto powers under certain circumstances when the bill is presented for his assent. This is regarding to a constitutional amendment bill. Can he use his veto powers? In fact, the 24th Constitutional Amendment Act 1971 makes it very clear the only option that the President has is to give the assent. Okay, so therefore this is not true. So which of the statements given above are correct? None of the above. Okay, so I'll try to complete another 15 questions before I wind up the day. Huh? At what time? 5 o'clock, exact 5. Which class? Okay, they will come and inform me. Let me see. If they inform, I will leave it. Otherwise, I will extend it. Okay. So whenever there is a class, they will come and inform me. Okay. So come to the next one. So Santosh, our class will go for another 3-4 hours. Huh? Sure. Okay. So which subject is dealing today? Economics. Related to the prelims only. Okay. Consider the following statements regarding the parliamentary privileges under the Indian Constitution. Statement 1. The parliamentary privileges are kind of special rights and immunities given to the members of the Parliament and of the state legislature presently regulated by an Act of Parliament. What is the article related to parliamentary privileges? It is Article 105 in case of the members of Parliament, Article 194 in case of the members of the state legislature. There are two explicit privileges which is given in the Constitution. What are the privileges? Right to freedom of speech and the right to publish under the authority of the Parliament, and the right to publish the proceedings in the Parliament under the authority of the Parliament, which also includes the right to expunge. So these are the two explicit privileges that is given in the parliamentary privileges. I am repeating it again, right to speech, but again this right to speech is not absolute. This right to speech is subject to the other provisions of the Constitution and the rules of the House. That means just because the members of the Parliament have the right to freedom of speech, they cannot use unparliamentary languages and start abusing one another. And just because they have the right to freedom of speech, they cannot engage in what is called as a contempt of the court or contempt of the judges. So therefore, it is subject to the rules of the House and the other provisions in the Constitution. The only advantage is that because they have the right to freedom of speech, they are not liable to be prosecuted in a court of law for whatever they have said in the houses of the Parliament. So that is their privilege. And then the second thing is they also have the right to publication, which means whatever is a proceeding that is happening in the parliament, under the authority of the parliament, they can publish it. But which also includes the right to expunge, which means if certain proceedings in the parliament are expunged, then they should not publish. If they publish that, then that amount to contempt of the parliament. So there they can be punished, or it can be seen as the breach of the privileges of the parliament. So, but who is authority to expunge? It is a presiding officer of that particular house. So today a number of controversial debates in the parliament, they are all expunged. So who is authority to do that? It is a presiding officer on behalf of the house, he will do that. Now these two things are explicitly given in the constitution. But apart from that, if any of the other privileges are to be exercised by the members of the parliament or the state legislature, the constitution says that the parliament can make a law and they can confer more privileges. And for the members of the members of the state legislature, the state legislature can make a law and they can confer the privileges. But till this point of time, no such law has been made. So therefore, what is a privilege that is exercised by the members of the parliament and the members of state legislature? Whatever is there in the constitution. But apart from that, the constitution says till the time such a law is made by the parliament or the state legislature, the members of the parliament and the state legislature can continue to exercise such privileges as it existed before the commencement of the constitution. Before the commencement of the constitution, they exercise a privilege in the form of conventional practices. So therefore, today what are the sources of parliamentary privileges? Whatever is there in the constitution and the conventional practices. And this is likely to continue till the time the parliament makes a law. And today we do not have a law. So with that, you try to answer this particular question. The parliamentary privileges are the kind of special rights and immunities given to the members of the parliament and the state legislature, which are presently regulated by an act of parliament. Is it regulated by an act of parliament? No, it is not regulated by an act of parliament. But can the parliament regulate it? Yes, there is such a provision. The parliamentary privileges are subject to certain provisions of the constitution and rules of the house. Is it true? Yes. So this is definitely true. So what is the answer? Which of the following given above are incorrect? What is the answer? One only. Come to the next question. Which of the statements given above are correct? I have another 5 minutes to 5 also. Huh? My class is still 5. How can I leave it early? My class is still 5 o'clock. Okay, so anyways, the next teacher will give you time. Don't worry. 5 minutes you can get it from the next teacher. So which of the statements given below are true? So what is the answer? The speaker and the deputy speaker of the legislative assemblies should be elected in a time bound manner. Is it true? There is no time limit to elect the speaker and the deputy speaker. Okay, so the date of the speaker is decided by whom? President, and the date of the election of the deputy speaker is decided by the speaker. Okay, so there is, but it is not done in a time bound manner. The speaker submits the resignation to the Secretary General Lok Sabha if the post of the speaker is vacant. Is it true? Yes. And so is the case with the deputy speaker also, if the post of the speaker is vacant. The speaker and the deputy speaker can be removed by resolution passed by an absolute majority in the house. No, it is by effective majority in the house. Any person, even without being a member of the house, can be elected to the post of the speaker or deputy speaker, but they have to get elected to the house within a period of 6 months. Is it true? No. The only condition is they should be a member of that particular house. So what is the answer here? It is 2 only. Come to the, I will do it till 2:15, just 4 more questions. There are 3 more minutes, I will complete it, okay. In the year 2021 marked a centennial year for the Public Accounts Committee of the Parliament. So 1921 this convention was established. Now it has become the part of the rules. In this context, consider the following statements. The Public Accounts Committee has members from both Lok Sabha and Rajya Sabha elected for a term of 5 years. It has members from both the houses but elected for a term of how much? 1 year. So this is wrong. As a parliamentary convention, the chairman of the committee is appointed from the opposition party starting there 1967. Yes. So this convention we are following since 1967, this is true. They play a central role in ensuring the financial accountability of the governance to the parliament, because the Public Accounts Committee is going to scrutinize the report of the CAG, and the CAG report is very, very important in ensuring the financial accountability. So this is true. So which of the statements given above are correct? 2, 1, 3 only. Come to the next question. Which of the following is the possible reasons for having the second chamber or the Rajya Sabha under our parliamentary system? What is the reason for having the Rajya Sabha or the second chamber? The Rajya Sabha helps in institutionalizing the power sharing between the center and the states in a federal political system. Is it true? Yes, Rajya Sabha represents the classic interest of the states. So therefore, this particular statement is definitely true. At least that is objective as to why the Rajya Sabha was established. The Rajya Sabha offers checks and balances for greater executive accountability and can also be a platform for great talent and expertise. Is it true? Because the very idea of having nominated members in the Rajya Sabha is to bring in wide experience and people from diverse background and intellectual people. Therefore, this is true. Rajya Sabha offers checks and balances for greater executive accountability. Is it true? Say for example, if a government is having a brutal majority in the Lok Sabha, they can amend the constitution to any extent, but the Rajya Sabha may not accept to that. So therefore, it is having certain element of checks and balances as well. So this is also true. What is the answer? Both 1 and 2. Okay, so this is part of your current affairs. Consider the following statements regarding Rule 267 of the Rajya Sabha. So many times today the opposition party wanted to have a discussion under Rule 267 of the Rajya Sabha, which means under Rule 267 of the Rajya Sabha, any business that has been listed on a given day can be suspended to take up a particular notice or to take up a particular matter that is to be discussed of urgent public importance. When this was highlighted in the Rajya Sabha again and again is when they wanted to discuss about the Manipur issue, when the Manipur violence was happening. So the purpose of having this Rule 267, this is only in Rajya Sabha, not in the Lok Sabha, is that whatever may be the business that is listed on a given day, all those business can be suspended, and what can be taken up for discussion? A matter of urgent public importance in case of what is called as Rajya Sabha. So with that, just come to this question. The rule allows a chairman to suspend the business of the house on account of a motion moved by a member to discuss a matter of issue of urgent public importance. Is it true? Yes. So this is definitely true. The rule has been invoked only once in the past to discuss the issue of demonetization in 2016. So whenever I said whenever only is there, 90% of the time it is what? 90% of the time it is wrong. But in this case, it is wrong. Okay, because as per the government sources, at least 7 times they have invoked since the commencement of the parliamentary system. Okay, so only once is wrong. Okay, so this is wrong. So which is the correct? Incorrect here. It is 2 only. So come here. Consider the following statements regarding the delimitation of constituencies to the election to the Lok Sabha and the Legislative Assembly elections. The delimitation of seats is carried out by a specific body called the Delimitation Commission for election to the Lok Sabha and the Legislative Assembly election. Is it true? Yes, this is true. Statement 1. The Delimitation Commission is a statutory body established by an Act of Parliament, usually headed by a chairman who would be a retired judge of Supreme Court. That is also true. You see the composition of the Delimitation Commission. It is 3 members, usually headed by a retired judge of a Supreme Court, and then they have someone who is the Chief Election Commissioner or any other election commissioner nominated by the Chief Election Commissioner as an ex officio member. And you know that the Delimitation Commission will carry out the delimitation every state wise. So the concerned state election commissioner will also be part of it. So this is what is the composition. So this is also true. Presently, the Delimitation Commission redraws the boundaries of the constituencies using 2001 census. Is it true? It is talking about redrawing the boundaries, not the total number of seats. So is it true? Yes. So this is also true. What is the answer here? All of the above. Okay, incorrect they are asking, sorry. So this is again very important. You should not make this mistake, okay. So which of the following statements are incorrect? So I'll just make it none of the above. Okay, so none. So the answer is option D. Okay, so please make that small correction. Okay. Okay, so come here, which of the following bills would not lapse on dissolution of Lok Sabha? What is a general rule that should come to your mind? That if any bill has got any relation to Lok Sabha, on dissolution of Lok Sabha, the bill will lapse. But what is the exception? If the president is involved, then the bill will not lapse. Or if the bill has no relation to Lok Sabha yet, then also the bill will not lapse. Is that clear? So with that, let us try to see. All bills pending in Lok Sabha not passed by Rajya Sabha, will it lapse? Yes, it will lapse. So here it is asking not lapse. So we'll just come back to that area, which will not lapse. But yes, all bills pending in Lok Sabha, this will lapse. So therefore, this cannot be an answer. Bills pending in Lok Sabha passed by Rajya Sabha, will it lapse? Yes, this will also lapse. Bills pending for the assent of the president, no, this will not lapse. Bill sent for reconsideration by the president, no, this will not lapse. Bills notified for joint sitting of the parliament, this will not lapse, because who can notify for a joint sitting? The president. So this will not lapse. Bills pending in Rajya Sabha not passed by Lok Sabha, that means this is introduced in the Rajya Sabha and pending in the Rajya Sabha, so this will also not lapse. So what is the answer here? It is 3, 4, 5 and 6. Is that clear? So very simple understanding, any bill which has got any relation to Lok Sabha is going to lapse on dissolution of Lok Sabha. What is the exception? If the president is involved, it will not lapse even on dissolution of Lok Sabha. Okay. So this is the general understanding you should have. Alright. So please quickly come to the next question. Which of the following is correct distinction between a money bill and a financial bill? So for the detailed explanation I have given in the previous class, we will directly go to the question. Well, all money bills are financial bills, but not all finance bills are money bills. Is that true? All the money bills are financial bills. Okay, so that is definitely true. While all money bills can be introduced only in the Lok Sabha with the prior recommendation of the president, the same is not true in case of finance bill. Is it true? While all money bills can be introduced only in the Lok Sabha, is it true? With the prior recommendation of the president, the same is not true for the finance bill. The same is not true for the finance bill, which means when you say that will all the finance bill also be introduced only in the Lok Sabha? No, because the financial bill type 1 should be introduced in the Lok Sabha, but not all the financial bills. So sir, completely you cannot say this particular statement to be true. So which of the options given below are correct? One only. Okay, so come to the next question. Consider the following statements regarding vote of no confidence motion. So is the no confidence motion mentioned in the constitution? It is nowhere mentioned in the constitution. It is only as per the rules of the Lok Sabha, which is rule number 198. And remember, no confidence motion is a tool that can be used only in the Lok Sabha, not in the Rajya Sabha, because the collective responsibility is only to the Lok Sabha. The motion can be introduced by any member of parliament by giving a valid reason for its introduction. Does it require a valid reason? There is no need for any reason to be given, but the condition is it should be supported by minimum how many members? It should be supported by minimum 50 members. So that is definitely there. The vote of no confidence is regulated under rule 198 of the Lok Sabha. Is it true? Yes. The passage of motion by simple majority would amount to defeat of the government. Yes. If it is passed with simple majority, it would amount to defeat. So what is the answer? So which of the statements given above are incorrect? So it should be 2 and 3 only. Okay. So 1 only, 2 only. I'll just make a correction. Which of the following statement is incorrect? Okay. Anyways, the way that it has been given is not right. So 1 only is the answer. 2 only. Let me put 2 and 3 only. None. So what is the answer? It is 1 only. Consider the following statements. Under the Constitution of India, it is the responsibility of the Union Finance Minister to lay down the budget in the houses of the Parliament every financial year. Whose responsibility is it? It is the responsibility of the President. It is not the responsibility of the Finance Minister, because the key word here is as per the Constitution. We come to the next thing. It is a responsibility of the Department of Revenue, Ministry of Finance to prepare and consolidate the budget as per the transaction of business rules. Whose responsibility? Department of Economic Affairs, Ministry of Finance. So this is also wrong. The Prime Minister has the power to determine the transaction of business rules of the government as per the Constitution. Who has the power? It is a president, not the prime minister. Very good. It is the president who will determine the transaction of business rules on the advice of the council of ministers, but not the prime minister himself. So what is the answer here? Which of the following is incorrect? See, all of the above is incorrect. Come to next question. Consider the following statements. The supplementary grants under the constitution raise a new demand which is not part of the budget. So for those who forget what are these grants, let me just recollect you the grants. Now there is something which is called a supplementary grant. So what is a supplementary grant? Supplementary grant is a grant which is introduced in the houses of the parliament, that is in the Lok Sabha, provided that any amount that has been allocated on a specific service is over. That means it is not a new service. For this service already in the budget money has been allocated, but the amount has been completed, or the whatever money that is allocated is already spent. So therefore, suppose for the entire year they have allocated let us assume 10,000 crores, but this 10,000 crore is completed in 10 months. For the next 2 months for that particular service there was no money. So therefore, to allocate the money they will introduce what is called as a supplementary grant. So supplementary grant is not for a new service, but for a service which is already part of the budget. Okay, so therefore what is this particular statement? The supplementary grant under the constitution gives rise to a new demand which is not part of the budget. Is it true? Which is already part of the budget. So that is basically what is called a supplementary grant. As the name suggests, it is supplementing the already existing service for which you are introducing this. An additional grant under the constitution increases the amount of the existing demand which is already part of the budget. Is it true? It is rather vice versa. Additional grant is for some new service which is not part of the budget. Supplementary grant is already for an existing service. And apart from that, there is also something which is called as an exceptional grant. What is an exceptional grant? See, exceptional grant is similar to that of the additional grant, but the difference between additional grant and exceptional grant is additional grant is for a new service for that particular year, but exceptional grant is never ever in the entire history, never ever such a grant has been made. So that is an exceptional grant. And apart from that, there is also something which is called as an excess grant. What is excess grant? Excess grant is they are trying to take the permission of the house when they have already spent money in excess to what has been allocated. But however, how they are able to make money excess, spend money excess in what has been allocated? That they transfer it from one head to another head within the ministry. Suppose within the defense ministry, I gave an example, if there are 4 or 5 areas where the expenditure is to be done, in one area less expenditure is happening, other area more expenditure is happening. So wherever money is there, from there they will transfer the money to another head. But this also requires approval of the parliament. So that is done by what is called as excess grant. Is that clear? So anyways, in this question, these are vice versa. So what is the answer here? Which of the following are incorrect? Both 1 and 2. Consider the following statements regarding the Legislative Council under the Constitution of India. Statement 1. The Legislative Council can be created and abolished by an act of Parliament by special majority. Is it true? It requires just a simple majority, but however, please understand it can be done only on the basis of a resolution that is passed by the concerned Legislative Assembly. And what is the majority with which the Legislative Assembly has to pass? It has to pass with what is called as special majority. Okay. So this is definitely wrong. The Parliament can create or abolish. The Parliament can create or abolish only based on the resolution passed by the concerned state legislature. Is it true? That is, the Parliament can create or abolish the Legislative Council only on the basis of resolution passed by state legislature, concerned state legislature. But to be very specific, it is state legislature or Legislative Assembly. It has to be very specific assembly. So therefore, it is wrong. Okay, it is not the state legislature. When I say state legislature, then it has to be passed by the council also, because it is about abolishing also. Suppose let us assume already existing council is there. To abolish that, you need not need the approval of the council. Okay, so please be very careful about whether what kind of word is used. Which of the statements given above are incorrect? Both 1 and 2. Is that clear to all of you? Why this is wrong? Both 1 and 2. Which of the following is the expenditure charged on the consolidated fund of India? What does it mean by the charged expenditure? It is not put to vote during the vote on demand for grant stage. But can it be discussed? Yes, it can be discussed. So where it is mentioned for the union expenditure, when it comes to charge expenditure, it is mentioned mostly in Article 112 and maybe in other provisions of the Constitution and also by a law made by the Parliament. Okay, so what are the expenditures here to be charged expenditure? The emoluments and allowances of the president and other expenditure relating to his office. Yes, it's a very important expenditure. The salary allowances of chairman, deputy chairman of the Council of State, speaker, deputy speaker of House of People. Yes, this is also charged. Salary allowances and pensions payable to the judges of the Supreme Court and High Court. No or yes? How many of you think no? Salary allowances and pensions payable to judges of Supreme Court and High Courts. When it comes to the High Court, the pensions are payable from the Consolidated Fund of India, but not their salaries. Salaries are payable from where? Salaries are payable from the Consolidated Fund of the respective states. Okay, so therefore this particular statement is wrong. Why this is mistake is coming, I don't know. Salary allowances and pensions payable or in respect of the Comptroller and Auditor General in India. What about this? So this is true. For the Comptroller and Auditor General, it is charged on the Consolidated Fund of India. So what is the answer? 1, 2 and 4 is right. Okay, so I'll just make a small correction here. 1 and 2 only. 1, 2 and 3 only. 1, 2 and 4 only. All the above. So please make a correction, so therefore in the future when you revise it, you should not have any problem. So what is the answer here? It is option C, that is 1, 2 and 4 only. All revenues received by the union government by way of taxes and receipts for the conduct of government business are credited where? Consolidated Fund of India. So what is credited into the Contingency Fund of India? Nothing will be credited into the Contingency Fund of India. Whatever is the money from the Consolidated Fund of India, during the budgetary process, they can allocate some money to the Contingency Fund of India. Otherwise, nothing specifically gets credited into the Contingency Fund. What is there in the public accounts of India? All the money that belongs to the public. Say for example, the public pension funds, the savings that they make from post office savings, other schemes that the government may bring in. So these all get into the public accounts of India. So to withdraw the money, to appropriate money or to take money from the Consolidated Fund of India, please have an understanding, does it require an approval of the Parliament? Even to take a single penny from the Consolidated Fund of India, it requires approval of the Parliament in the form of what is called as an appropriation bill. So what about taking out money from the Contingency Fund of India? So that is at the disposal of the executives. But however, once the money is over, once the money comes into the Contingency Fund, it is at the disposal of the executives. But if all the money is existed, then again you will get money from the Consolidated Fund to the Contingency Fund, which requires an appropriation bill to transfer money from the Consolidated Fund to the Contingency Fund. What about the public accounts of India? In case of public accounts of India, it is at the executive disposal. That does not require the approval of the Parliament. So what is the answer here? All revenues shall be crediting into what is called as the Consolidated Fund of India. And among the three funds, which is a constitutional fund, Consolidated Fund and the Public Accounts of India, whereas the Contingency Fund of India is created only by an act of Parliament. Okay. What is? Judicial deposit. The judicial deposit is normally during a case and all those things, they ask the petitioners or the respondent to deposit something. For the security, I am not sure where does it come, the judicial deposit. Okay. When the annual union budget, have we discussed the previous question? Okay, so come to the next question. When the annual union budget is not passed by the Lok Sabha, so what does it imply when it is not passed by the Lok Sabha? That means it will amount to what is called as a no confidence motion. It will amount to defeat of the government. So therefore, what is the answer here? the Prime Minister submits the resignation of the Council of Ministers. So, it is very, very important they get the budget passed, otherwise it is assumed that the government is not having the majority. Come to the next question. Regarding the office of Speaker of the Lok Sabha Speaker, consider the following statements. He or she holds office during the pleasure of the President. They have nothing to do with the pleasure of the President. They can be removed only by the Lok Sabha. And what is the majority with which they can be removed? By effective majority. So, this is wrong. He or she need not be a member of the House at the time of his or her election, but has to become a member of the House within 6 months from the date of his or her election. Is that true? That is not required. He or she should be a member of that particular House. So, that is a mandatory condition. If he or she intends to resign, the letter of his resignation is to be addressed to the Deputy Speaker. Yes. If the Deputy Speaker is not there, it is the Secretary General Lok Sabha, but that is as per the rules of the House. By the Constitution, it is only to the Deputy Speaker. Yes. This is mentioned in the Constitution that he will submit the resignation to the Deputy Speaker. But in case if the Deputy Speaker is not there, to whom the resignation will be submitted, it is to the Secretary General Lok Sabha, but that is not there in the Constitution. That is as per the rules of the House. So, this is true. So, which of the statements given above are correct? 3 only. Please come to the next question. In the Parliament of India, the purpose of an adjournment motion. What is the purpose of an adjournment motion? To discuss a matter of an urgent public importance. Now, yesterday I discussed about Rule 267 also, where it is about discussing a matter of urgent public importance. While Rule 267 is only for the Rajya Sabha, an adjournment motion, as the name suggests, it can be introduced only in the Lok Sabha as per the rules of the House. Although in the Rajya Sabha also it will suspend all the business under Rule 267, but it cannot be considered to be what is called as an adjournment motion. The name adjournment motion is specifically used only for what? Only for the Lok Sabha. Why? Because it has a serious element of ratification for the government to answer all the questions when an adjournment motion is introduced. And the government is specifically accountable to which house in the Parliament? To the Lok Sabha. So, therefore, the name adjournment motion is only used in case of Lok Sabha and not in case of what is called as Rajya Sabha. So, what is the answer here? To allow a matter of urgent public importance. And similarly, no confidence motion can be introduced in which house? Only in the Lok Sabha. What about privilege motion? This year the privilege motion I feel is very important. Can the privilege motion be introduced in both houses of the Parliament? Because the Congress was trying to introduce a privilege motion against Mr. Amit Shah, and it was there in the newspaper for some time. So, can the privilege motion be introduced in both houses of the Parliament? Yes. Is it possible? Think about it for a moment. Of course, it is possible in both houses. It can be introduced against any member of Parliament who is breaching the privilege. Not only against a member, against the non-members also. Okay, when it comes to the privilege motion, when this motion is introduced, normally this matter is referred to a privilege committee. Is there a privilege committee in both houses of the Parliament? Yes? Yes, there is a separate privilege committee in both houses of the Parliament. Anyways, there is a separate question on that. In the later part, I will discuss about it. Consider the following statements. The Parliamentary Committee on Public Accounts consists of not more than 25 members of the Lok Sabha. Is it true? It consists of only 22 members, not 25 members. This is wrong. The Public Accounts Committee, which committee is that? Okay, Public Accounts Committee scrutinizes the appropriation and the finance accounts of the government. Is it true? The Public Accounts Committee, do they scrutinize? What does the CAG do? The CAG in fact audits these accounts only, the appropriation and the finance accounts. So, that is only scrutinized by the Public Accounts Committee. Is it true? Of course, it is true. Examines the report of the Comptroller and Auditor General. Yes, in general the auditor report, specific they scrutinize these accounts. So, all the things are true. Which of the statements given above are correct? Okay, only 2 and 3. Okay, so option B, 2 and 3 is correct. Come to the next question. Consider the following statements. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only. So, it can be introduced in either houses of the Parliament. We have seen this yesterday. If such an amendment seeks to make changes to the federal character of the Constitution, the amendment also requires to be ratified by legislature of all the states in India. Is it not less than half of the states or more than half of the states? not less than half of the states. Is it clear? So this is also wrong. Which of the statements given above are correct? Neither one nor two. So most of the things it is getting repeated because of the previous year questions. So therefore, wherever a broader explanation is required, I will give it. Consider the following statements regarding a no confidence motion in India. There is no mention of no confidence motion in the constitution. Is it true? Yes. A motion of no confidence can be introduced only in the Lok Sabha. As per the rules of the Lok Sabha, it can be introduced only in the Lok Sabha. What is the rule number? 98. It can be introduced only in the Lok Sabha only. So this is true. So what is the answer? Both 1 and 2. Which one of the following is the largest committee of the parliament among the given things? So which of the largest committee in the parliament? It is a estimates committee. So quickly tell me, the committee on public accounts, how many members? Committee on estimates, 20, 30. Committee on public sector undertaking, 22. Committee on petitions, so for generally if you see these type of committees, usually they are both in the Lok Sabha as well as in the Rajya Sabha. Whatever committee that is there in the Rajya Sabha, it has got 10 members. Whatever committee that is there in the Lok Sabha, it will have 15 members in general. But they can vary it as per the rules, but it is generally how the case. So what is the answer in this particular case? It is the estimates committee. With reference to the union government, consider the following statements. The Department of Revenue is responsible for the preparation of the budget. So it is Department of Economic Affairs, not Revenue. See, the same area is repeated in UPSC. So that is why there are only very few areas that if you have conceptual clarity, you can easily do it. Okay. No amount can be withdrawn from the Consolidated Fund of India without authorization from the Parliament of India. Yes. So this is very, very important. All disbursement made from the public accounts also needs the authorization of the Parliament. No, it is at the executive disposal. So this is wrong. Which of the statements given above are correct? 2 only. So how many of you feel that I am not remembering anything, but I am able to solve the questions? So that means I am not able to recollect and recall most of the things, but when it comes to the question, I am comfortable. So that is absolutely no need to worry about this. So this is a situation that most of the students will have. Okay, there is no need for you to remember each and everything. Because of course, for a human capacity, you cannot remember each and everything. So, but you should know the proper understanding. So therefore, when it is in the form of a question, you should be in a position to solve it. Okay. Of course, there are few information you will remember. It is not necessary you should be able to reproduce each and everything. Certain areas, even for the mains also, when it comes to the mains examination also, you don't have to remember each and everything. Means like you would prepare for your school or college examination, you cannot remember the entire paragraph. You will only remember a keyword. So then you should write it in your own way. So that is how you will fetch the marks. So always to crack this examination, to make the process very simple, you should have a very brief consolidated notes, which is made by yourself. You can refer to number of materials. That doesn't mean you will read 10 books for a particular subject. You should restrict it to one major book. Here and there you can refer to some topics, and then you consolidate all the things, and then you keep revising the same thing again and again. Your preparation is going to become much easier. Anyways, so that doesn't mean that now I am telling you to prepare the notes. Now this is not the time to do that. If you have already done it, it is okay. If you have not done it, whatever source that you are referring to, you revise it from there itself. Okay. When a bill is referred to the joint sitting of both the houses of the parliament, it has to be passed by what majority? It has to be passed with simple majority. This is very important. Do not have any confusion in this regard, because the bill is normally referred only in case of an ordinary bill, and for an ordinary bill anyways it has to be passed with simple majority. Consider the following statements. The Rajya Sabha has no power to reject or to amend a money bill. They cannot amend it, they can suggest amendments. So appropriate word is they can suggest amendments and they can send it back. Okay. So the Rajya Sabha has no power either to reject or to amend it. So therefore this can be seen as right. They can suggest amendments, but they cannot make themselves the amendment. The Rajya Sabha cannot vote on the demand for grants. Voting on demand for grants is a prerogative of only the Lok Sabha. Okay, so this is also true. The Rajya Sabha cannot discuss the annual financial statement. Can they discuss? In fact, please understand, the budget is introduced in both the houses of the parliament and then it is discussed in both the houses of the parliament. Okay. So therefore, to say that the Rajya Sabha cannot discuss the annual financial statement is wrong. Okay. So the Rajya Sabha cannot discuss the annual financial statement, that is wrong. So what is the answer here? 1 and 2 only. But the budget speech is made by the finance minister only in the Lok Sabha. Is the budget speech made in both the houses? No, it is introduced in both the houses, but where the speech will be made? Only in the Lok Sabha. But the general discussion happens in both the houses. Which of the following statement is correct? All bills pending in Lok Sabha lapse on its prorogation. It has no effect on the bills when it comes to prorogation. When it will have effect on the bills? Only in case of dissolution. So prorogation is merely terminating of a session. So therefore it does not have any effect. All bills pending in the Lok Sabha lapses on its prorogation. So this is wrong. All bills pending in the Rajya Sabha which has not yet been passed by Lok Sabha shall not lapse on dissolution of Lok Sabha. Is it true? This is true because it has no relation to the Lok Sabha. So which of the statements given above are correct? What is the answer? 2 only. Come to the next question. The Parliament of India exercises control over the function of Council of Ministers through what? So basically, what are all the mechanisms that is available in a parliamentary democracy to make the government accountable? Can they be made accountable through adjournment motion? Adjournment motion means very serious discussion. So that means it is possible to make them accountable. Question hour, of course they can do it through the question hour. Means question means they have to give answers. It's a very difficult thing for them to give the answers. Now please tell me that in the question hours 3 type of questions can be raised. What are the types of questions? State question, unstate question, and then there is a short notice question. Now, how is a short notice question different from the other 2 types of question? The notice time is less. In the other cases, both in state and unstate question, minimum 15 days of notice has to be given, but whereas here less than 10 days of notice. So because of the urgency, they can use this tool of what is called as short notice question. And what is the difference between a state and an unstate question? A state question is where that they have to give an oral answer, whereas in an unstate question, it is given as a written answer for a written question. So these are all the broader things I have to remember. Supplementary questions. Supplementary question is possible in case of which type of questions? In case of stat question, where there is a oral question. So therefore, they can have a supplementary question to the answers. So what is the answer here? 1, 2 and 3 only. Consider the following statements. In the election for the Lok Sabha or the State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected. Is it true? In the election for the Lok Sabha or the State Assembly, the winning candidate must get at least 50% of the vote. No, it is based on first past the post system. So in the first past the post system, there is no need to get any minimum number of votes. All that they need is they have to get more number of votes than the other candidates. According to the provisions laid down in the Constitution of India, the Lok Sabha Speaker's post goes to the majority party and the Deputy Speaker to the opposition party. Is it true? There is nothing mentioned in the Constitution. So please be very clear about this. The Constitution does not say that. The Constitution only says 2 things. One is who can contest the election is someone who is a member of parliament from Lok Sabha, and who can get elected or who will get elected, someone who secures a simple majority. But it is an implied understanding that the government has this majority, and if the government wants, they can get elected the Deputy Speaker also. But as a parliamentary convention, the post of Deputy Speaker is given to the opposition party, provided they have a status of an opposition party. And to have the status of the opposition party, what is the majority they should have? Not less than 1/10 of the total membership of Lok Sabha. Again, this is nowhere mentioned in the Constitution. It's only a parliamentary conventional principle. Is that clear to all of you? So according to the provisions laid down in the Constitution, so always make clear whether it is saying mentioned in the Constitution or not. Okay. So nothing is given in the Constitution in this regard. So therefore, this is wrong. So which of the statements given above are correct? It is neither 1 nor 2. With reference to the Parliament of India, Which of the following parliamentary committees scrutinizes and report to the House whether the powers to make regulations, rules, sub-rules, bylaws conferred by the Constitution or delegated by the Parliament are being properly exercised by the executive within the scope of such delegation? What is the answer here? Committee on Subordinate Legislation. So can anyone tell me what does it mean by subordinate legislation? The rules that is made to execute the laws. Say for example, recently Citizenship Amendment Act was passed. When the Citizenship Amendment Act was passed? 2019. But only in 2024 they started implementing it. Now why it took 5 years for them to implement this? Because the rules has not been formulated. Because the law says people belonging to 3 countries, belonging to 6 minority communities, though an illegal migrant can become an Indian citizen. But how do we identify they have entered only from these 3 countries? They belong to these 6 religious communities. There should be a way to mechanism to verify. Now these things are not mentioned in the law, but the rules can specify as to how these things can be verified. So only in 2024 the Citizenship Amendment rules came in. Okay, so therefore rules, and who makes these rules? Normally it is done by the executives. So that is why it is called as subordinate legislation or delegated legislation or executive legislation also. So consider the following statements. The Parliament Prevention of Disqualification Act 1959 exempts several posts from the disqualification on the grounds of office of profit. Is it true? That we'll see that, because these are all the areas it is not very clear, but see how UPSC is asking the question. So come to statement number 2. The above mentioned act was amended 5 times. That's also quite factual. We will not be able to see. But come to the third statement. The term office of profit is well defined in the Constitution. Is it well defined in the Constitution? No, it is not defined in the Constitution. Leave about well defined. It is not defined in the Constitution. So therefore, anyway, statement 3 is wrong. So what is the answer? 1 and 2 only. Okay. So sometimes don't panic when you read the first statement. Try to always read all the statements and see the options as well. Okay. So that is how it becomes easier. So therefore, the Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on the grounds of office of profit. Anyways, you can consider this right based on general logic also, because what is the purpose of this particular act? Is to exempt certain officers from being office of profit. So this is true. So above mentioned act was amended 5 times. So factually it was also true, it seems. The Rajya Sabha has equal powers with Lok Sabha. In what are the matters they have equal powers? The matter creating new All India service. Do they have equal powers? Do they have equal powers? So who has the authority to create a new All India service? Very good. It is not the Rajya Sabha, it is a Parliament. So I have told it number of times, who has authority to create a new All India service? It is a Parliament of India. The Parliament has to enact a law by which they can create a new All India service. But the Parliament cannot enact a legislation unless and until a resolution is passed by the Rajya Sabha. So therefore, if they say who has to pass a resolution to create a All India service, it is Rajya Sabha. But who can create a new All India service? It is only the Parliament, based on the resolution that is passed by Rajya Sabha. Under which article the Parliament has the power to create a new All India service? Article 312 of the Constitution. What is the majority with which the Rajya Sabha has to pass a resolution? It has to pass a resolution by special majority, that is not less than 2/3 of the members present and voting. Clear? Okay, so with that the Rajya Sabha has got equal powers, definitely not with regard to creating an All India service. Amendment to the Constitution, do they have equal powers? Yes, because it has to be separately passed in both the houses. Removal of the government, no conference motion can be introduced only in the Lok Sabha. No. Making cut motions are during the vote on demand for grant, which is a prerogative of the Lok Sabha. So therefore all these things are wrong. Come to the next question. Consider the following statements. The President of India can summon a session of the Parliament at such places as he or she thinks fit. Is it true? not necessarily only in the parliament. He can summon the sessions outside the parliament as well if required. Say, think of a situation of emergency, war. So therefore, you cannot risk summoning all the members of the parliament in the parliament. Okay. So therefore, yes, it is possible for him to summon, but he can do that only on the basis of aid and advice of whom? On the aid and advice of the Council of Ministers. Under no circumstances this can be a discretionary power of the President. The Constitution of India provides for 3 sessions of the Parliament. Is it true? The Constitution does not provide for any fixed number of sessions. The only thing that is mentioned in the Constitution is that there shall not be a lapse of more than 6 months between 2 consecutive sessions, or there should not be recess of more than 6 months. That is the only thing that is mentioned in the Constitution. Is the number of days that they have to meet, is it mentioned in the Constitution? That is also not mentioned. Nothing is there. So which article gives the President the power to summon the sessions in the Parliament? Article 85 of the Constitution. Very good. So therefore, this particular statement is wrong. There is no minimum number of days that the Parliament is required to meet in a year. So this is also true. So what is the answer here? It is 1 and 3 only. I am sure that you are also quite clear about what is adjournment sine, what is adjournment, all those things. According to consider the following statements. According to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months, even if he or she is not a member of the legislature of that particular state. Is it true? According to the Constitution, a person who is eligible to vote. Rather, what is should be eligible? Eligible to contest, apart from eligible to vote. So he should be eligible to contest. And in fact, eligible to contest will come only when he is eligible to vote, because one of the requirement to contest the election is what? He or she should have a eligible voter ID card, or he or she should be eligible to vote. So therefore, it is not necessarily, not only the eligible to vote, but eligible to contest. So it is because of this particular statement is wrong. According to the Representation of People Act 1951, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting election even after his release. Is it true? There is no permanent disqualification. What is the maximum disqualification? Whatever is the term of imprisonment, once he is released, then 6 years. Okay, now tell me, what if the conviction is less than 2 years? On some criminal offence, let us assume there is a criminal offence of defamation. If the conviction is less than 2 years, then in that particular case, will he be disqualified? Who said defamation is also a criminal offence? There are 2 types of defamation. The defamation can be a civil offence also, criminal offence also. It depends upon what kind of petition that you file in a court. So defamation is both a civil as well as a criminal offence. So in a civil offence, if it is filed as a civil suit, they may look for some compensation for damaging the reputation. But if they file a criminal offence, then they can ask for the imprisonment of the individual also. So therefore, let us assume if somebody is convicted in a criminal defamation case, if the punishment given is 1 year for a member of parliament or a member of state legislature, is he liable to be disqualified? He is not liable to be disqualified. Okay, so although he may go to prison, but he is not liable to be disqualified, because what is the minimum number of years? Minimum 2 years. Okay, so then only he is liable to be disqualified. And then if minimum 2 years, then he is also not eligible to contest for another 6 years. But there are certain type of offence where they will be immediately disqualified even if they are convicted, irrespective of the quantum of punishment. That is specifically mentioned in the Representation of People Act. Some examples we have seen. Can you give me some examples? Hate speech, Prevention of Corruption Act, Civil Rights Act, terrorist related acts. So these are all something which is specifically mentioned. So with that, this particular statement is also wrong. So what is the answer here? What is the answer? Neither 1 nor 2. Come to the next question. With reference to the Deputy Speaker of Lok Sabha, consider the following statements. As per the rules of the procedure and the conduct of business in Lok Sabha, the election of the Deputy Speaker shall be held on such a date as the Speaker may fix. Who will determine the date of election of the Deputy Speaker? The Speaker. So that is true. This is as per the rules of the House. there is a mandatory provision that the election of the candidate as a deputy speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. There is no mandatory provision in this. It's only a parliamentary convention that the post of opposition, that post of the deputy speaker is given to the opposition party. Okay, so there is no such mandate. The deputy speaker has a power as of the speaker when presiding over the sitting of the house, and no appeal lies against his ruling. Is it true? When I say no appeal lies against his ruling within the house, suppose today let us assume the deputy speaker is presiding over the house on day number 1 because the speaker is absent. Now day number 2 the speaker comes and he presides over the house. Can the speaker overrule what has been done by the deputy speaker? That is not possible, because at the time when the deputy speaker is presiding as a speaker, his decision becomes final. That is what this means. Okay. So the deputies, that is why you will understand why the government is not giving the post of deputy speaker to the opposition party. So even now the Congress government has got more than 1/10 of the members, but still the deputy speaker is not elected, because for some reason if the speaker is not there, who will preside over the house? Automatically the deputy speaker, but otherwise it will be from a panel of chairperson. So therefore those members will be from the ruling party mostly. That is the reason why the government is also not willing to elect the deputy speaker. Okay, so what is the next thing? The deputy speaker has the same power as the speaker. Okay, this we have decided. So this is true. The well established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the deputy speaker and duly seconded by the prime minister. Is it true? There is no such conventional practice. There is no such practice in the first place. So this is wrong. So what is the answer here? 1 and 3 only. So these are all distractors. Usually the students get confused with the distractors, because the initial human tendency is that we have not read it probably. So it was there, but probably we have not read it. So that is a feeling you will have. So but don't have that particular feeling, because UPSC also put a lot of distractors. If you have the confidence, okay, I have never come across this, I have prepared for 2-3 years, I have never come across this, probably it is a distractor. Okay. Especially in the areas like this, if it is coming from a not so important area which you have not studied, it's okay. But there are certain areas you have studied well, then you see that it is nowhere that I have read it. So that means it is probably a distractor. Okay. With reference to the anti-defection law in India, consider the following statements. Statement 1, the law specifies that a nominated legislature cannot join any political party within 6 months after being appointed to the house. Is it true? A nominated legislature can join within 6 months. So if you want to join, so to say cannot join is wrong. So he can join it. The law does not provide any time frame within which the presiding officer has to decide the defection case. Is it true? Yes, there is no time limit. In fact, this is one of a major criticism when it comes to the anti-defection law. All right. So give me some more time. If there is any questions, I will take it up. Online students, I will take it up. So which of the statements given above are correct? What is the answer? It is 2 only. Which of the following are the exclusive powers of the Lok Sabha? Statement 1, to ratify the declaration of emergency. Is it the exclusive power of the Lok Sabha? To ratify any type of emergency, for that matter, national emergency, be it state emergency or the financial emergency, in all the cases it has to be ratified by both the houses of the parliament. Okay, so you should not have any confusion in this regard. Although ratification has to be done by both the houses, but revoking a national emergency can be done by one house. Which house? Lok Sabha alone can do it. But that provision was brought in only by the 44th Constitutional Amendment Act in 1978. Before that, the only way it can be revoked is the president can revoke it anytime on the aid and advice of the Council of Ministers. But after the 44th Constitutional Amendment Act, alternatively, the national emergency can also be revoked by the president based on the resolution that is passed by the Lok Sabha. Only the Lok Sabha. Rajya Sabha has no power in this regard. What is the majority with which the Lok Sabha has to pass a resolution? Which majority? By simple majority. So anyways, to ratify the declaration of emergency, exclusive power of Lok Sabha, no. To pass a motion of no confidence motion against the Council of Ministers? Yes. To impeach a President of India? No, it has to be passed by both the houses by special majority. What is a special majority in this case? Not less than 2/3 of the members, not less than 2/3 of the total membership of the house. So, which of the following is the correct answer? 2 only. Consider the following statements. Statement 1. A bill amending the constitution requires a prior recommendation of the President of India. Is it true? A bill requiring to amend the constitution does not require the prior recommendation of the President. So, therefore, you should always have full concentration even in the examination. Even a minor lapse in your concentration for the 2 years, for the 2 hours that you do there, some element of mistakes is likely to happen. So, therefore, try to have a full concentration when you do it there. A bill amending the constitution does not require the prior recommendation of the President. That is not required. When a constitutional amendment bill is presented to the President, it is obligatory for the President of India to give his or her assent. Is it true? Which Constitutional Amendment Act has made it mandatory? 24th Constitutional Amendment Act 1971. So, therefore, this is true. So, statement 1 is wrong, statement 2 is correct. What is the next statement? A constitutional amendment bill must be passed by both Lok Sabha and the Rajya Sabha by a special majority, and there is no provision for a joint sitting. Is it true? Yes, they have to be separately passed. So, therefore, what is the answer? Statement 2 and 3 are correct. Option B is the answer. Okay. With reference to the Parliament of India, consider the following statement. Statement 1. Prorogation of a house by the President of India does not require the advice of the Council of Ministers. Now, try to understand, be it summoning of a session, be it proroguing of a session, it always is based on the aid and advice of the Council of Ministers. What about dissolution? Dissolution may happen automatically by efflux of time that you have already seen, or the dissolution might happen at an earlier time based on the aid and advice of the Council of Ministers. So, otherwise it may happen automatically when the time is over. Okay, so please have an understanding. So, the prorogation of the house of the prorogation of a house by the President of India does not require the aid and advice of the Council of Ministers. Does the aid and advice of the Council of Ministers is mandatory to dissolve the Rajya Sabha also? Rajya Sabha is a permanent house. There is no dissolution for the Rajya Sabha. Okay, so please be clear about it. So, this is wrong, does not require the aid and advice. Prorogation of a house is generally done after the adjournment signed by, but there is no bar for the President of India proroguing the house which is in session. Is it true? It is not mandatory that the President should wait for the adjournment signed by, because the prorogation can be done by the President anytime based on the aid and advice of the Council of Ministers. But generally after adjournment signed by, he does it normally, but that is not mandatory. So, this is true. The dissolution of the Lok Sabha is done by the President of India, who save in exceptional circumstances does so on the aid and advice of the Council of Ministers. Is it true? Yes. So, normally he may do it on the aid and advice of the Council of Ministers, but sometimes the efflux of time also it may happen. Sometimes if there is a no confidence motion against the government, then there is no need for any aid and advice of the Council of Ministers. So, these are all the exceptional cases. So, this is also true. So, which of the statements given above are correct? 2 and 3 only. With reference to the Parliament of Indian Parliament, consider the following statements. A bill pending in Lok Sabha lapses on its dissolution. Is it true? Yes, this is true. A bill passed by Lok Sabha and pending in Rajya Sabha lapses on the dissolution of Lok Sabha. Yes, it has got a relation to Lok Sabha. A bill in regard to which the President of India has notified his or her intention to summon the House to a joint sitting lapses on its dissolution. So, though it has got a relation to the Lok Sabha, but because the President is already involved in the process, so therefore this bill is unlikely to lapse. Okay, so this is wrong. Joint sitting lapses on dissolution of Lok Sabha, it will not lapse. So, what is the answer here? 1 and 2 only. Which of the following statement is correct in respect of the money bill in the parliament? See, money bill, constitutional amendment bill, the presiding officers, budget, these are all areas very likely the questions are to come. Article 109 mentions a special procedure with respect to the money bill. Is it true? Then what about Article 110? Subject matter of the money bill. So this is true. A money bill shall not be introduced in the Council of States. Is it true? What is a money bill? A money bill is a financial bill which contains only those subject matter mentioned in Article 110. Therefore, such a bill can be introduced where? Only in the Lok Sabha, only with a prior recommendation of the President. So therefore, this is true. Shall not be introduced in the Council of States. The Rajya Sabha can either approve the bill or suggest changes but cannot reject it. Is it true? They can suggest changes, so but they cannot reject it. The amendment to the money bill suggested by the Rajya Sabha have to be accepted by the Lok Sabha. Not necessarily. They may accept or they may not accept. Most likely they will not accept it once they have decided it. Okay. So what is the answer here? 1, 2 and 3 is the answer. So what is option 1, 2 and 3? Option C is the answer. Which of the following statement is true about the ethics committee? See, last year there was lot of news about the ethics committee. So this year there is lot of news about the privilege committee. So probably they may come also. Be prepared for it. Which of the following statements about the ethics committee in the Lok Sabha is correct? Initially it was an ad hoc committee. Yes, initially when it was established it was an ad hoc committee. In 2000 I think it has become a permanent committee. So but before that it was an ad hoc committee in the Lok Sabha. So yes, initially it was an ad hoc committee, that is true. What is an ad hoc committee? Temporary committee. It is not a standing or a permanent committee. That means whenever there is a issue that is brought against a member, to study that a committee will be appointed. Once that issue is over, the committee is dissolved. Only a member of Lok Sabha can make a complaint relating to the unethical conduct of a member of Lok Sabha. So in a democracy, the members of the parliament has to be accountable to the people. So therefore, to say only the member of parliament can initiate that, it is not the right thing. Even the ordinary citizens can file a complaint to the respective houses. So therefore, only a member of Lok Sabha is wrong. This committee cannot take up any matter which is sub judice. Is it true? This is a general principle of separation of powers. So once a matter is there in the judiciary, that matter shall not be taken up by the legislature. So because to respect the principle of separation of powers. So for such questions, even if you are not aware, try to apply your common sense. Okay, so try to put it, don't just leave that particular question. So try to apply your overall knowledge. So with that you can especially get these two things right. So what is the answer here? 1 and 3 only. So even if you can eliminate 2 also, still you will arrive at the answer. That is option C. Which one? The committee cannot take up matter which is sub judice. That is true. The committee cannot take up any matter for discussion if already the court has entertained and the court is looking into this particular matter. Sub judice means already the court has taken up this particular matter. That is what is sub judice. Come to the next question. How many delimitations commissions have been constituted by the government? It is 4. Okay. What is the status of the delimitation commission? Statutory body. And what are the functions that is performed by the delimitation commission? First is, the most important thing is to determine the total number of seats, then to redraw the boundaries. In fact, they have to redraw the boundaries before every general election as per the population. And which population is used? 2001 population. And they shall also reserve the seats for the scheduled caste and scheduled tribe, depending again on the basis of population. Which population? 2001 census. In fact, they have to keep rotating these reserved constituencies. It is not that the same constituency will always be reserved. So therefore, all the people are given equal opportunities. So consider the following statement. Statement 1. The departmentally related standing committee has representation from both Lok Sabha and the Rajya Sabha. Is it true? Yes. The DRSEs have got representation from both Lok Sabha and Rajya Sabha. Are the members of DRSEs elected or nominated? Are they nominated? Sure. All the members of the DRSEs are only nominated. The election is only for the financial committees that you have seen. So for these committees it is nominated, and 21 members from Lok Sabha, 10 members from Rajya Sabha. How many committees are there in Lok Sabha? 16. And how many committees in Rajya Sabha? 8 committees. And who will appoint the chairperson of the respective committees? For the presiding officers of the respective houses. Okay, so that is something. The estimates committee has representation only from the Lok Sabha. Is it true? Yes, they have representation only from the Lok Sabha. How many members from Lok Sabha? So they have got 30 members. So this is true. So in this case only is right. The general purpose committee has a specific function to perform as per the rules of the house. Is it true? If it has a specific function to perform, then it is not called as a general purpose committee. The general purpose committee has no specific function to perform. Suppose if there is no specific committee for a particular purpose, and then all those functions are taken up by the general purpose committee. So that is basically the role of the general purpose committee. So it does not have any specific function to perform. It will take up all the functions which is not belonging to a specific committee in the parliament. Okay. So that is why this committee is very important, and this committee is headed by the speaker himself in the Lok Sabha. So how many of the statements given above are incorrect? No, it is asking for incorrect. Which is incorrect? Only one statement, yes. Any doubt? Clear? Okay, come to the next question. Consider the following statements. Statement 1. The Joint Parliamentary Committee is a standing committee of the Parliament. JPC is again very important. There is lot of small news articles that I have come across with regard to the Joint Parliamentary Committee. So there may be a question on the Joint Parliamentary Committee also. The Joint Parliamentary Committee is a standing committee of the Parliament comprising of members of both the houses, constituted under the direction of Supreme Court of India. Is it true? Why the Supreme Court will come? It is the role of the Parliament. There is no role of the Supreme Court in establishing a committee in the Parliament. So Joint Parliamentary Committee is usually established by the Speaker and the Chairman of Rajya Sabha. So they will consult, and according to their opinion, they will constitute a Joint Parliamentary Committee. That means one thing that is sure of Joint Parliamentary Committee is it will have members from both the houses. And different Joint Parliamentary Committee established at different point of time will have different members. So there is no fixed members. So then and there, when they decide, they will decide as to what is the number of members to be part of the Joint Parliamentary Committee. So therefore, an important understanding you should have is a Joint Parliamentary Committee is not a standing committee, it is an ad hoc committee. So as and when the need arises, they will establish what is called as a Joint Parliamentary Committee. Now, for what purpose do you think a Joint Parliamentary Committee is established? Usually to scrutinize some controversial bills. So presently I think the Waqf bill, which is pending in front of the Joint Parliamentary Committee, and not necessarily only to scrutinize the bills. Sometimes if the opposition say that there is a major corruption allegation against the government, to probe that also they can establish what is called as a Joint Parliamentary Committee. But however, not necessarily whenever the opposition asks for a Joint Parliamentary Committee, the government may go for a Joint Parliamentary Committee. It is a prerogative of the government, because both the presiding officers have to decide about it, and from which party the presiding officer is there? From the ruling party, the Speaker, and anyways the Vice President is also elected by the government, so majorly. So they have control over both the houses. So therefore, if the government accepts, then they can go and establish what is called as a Joint Parliamentary Committee. Do you have any instance of Joint Parliamentary Committee established to probe the corruption against the government? Yes, in 1980s, to probe the Bogus scandal, a Joint Parliamentary Committee was established. And at that point of time, the BJP was a major opposition party, the Congress was the ruling party, and the BJP demanded, the Congress accepted. So in 2016-17, the Congress said that we wanted to probe against what is the Rafale deal, and earlier we accepted for a Joint Parliamentary Committee on Bofus, but the BJP government did not accept for it. So there was no JPC, but yes, this is how the JPC may get established. The Joint Parliamentary Committee is a standing committee of the Parliament comprising of members of both the houses, constituted under the direction of the Supreme Court. No, but constituted as per the consultation between the presiding officers of both the houses. So therefore that particular statement would be wrong. So statement 1 is wrong. So remember that. Come to statement 2. The Public Accounts Committee has representation only from the Lok Sabha, ensures financial accountability of the executives to the legislature. Well, the objective is correct, but not the membership, because it has got representation from both the houses. So this is also wrong. So what is the answer? Which of the statements given above is incorrect? Both 1 and 2. Consider the following statements regarding the ordinance making power of the President. So what is with regard to the ordinance making power of the President? 1. The ordinance can be made at the discretion of the President. Is it true? The ordinance cannot be made, but it is based strictly on the aid and advice of the Council of Ministers. Ordinance requires approval of the Parliament within 6 weeks of the reassembly. Is it true? Yes, both the houses of the Parliament has to approve within 6 weeks after its reassembly. Okay. So this is true. Ordinance can be withdrawn by the President anytime. Yes, at any time the President can withdraw it, but based on the aid and advice of the Council of Ministers. So this is true. So how many of the statements are incorrect? 1 only. Okay, so try to give me an answer for this question. What is the answer? Because I have already discussed a similar question. The President of India has a power to exercise which of the following veto powers in case of a constitutional amendment bill? What type of veto he can exercise? As per the Constitution, after the 24th Constitutional Amendment Act, the President is bound to give the assent whenever a bill is passed. But can he sit on top of a constitutional amendment bill? If he is sitting on top of it without giving the assent, the government cannot do anything except for impeaching the President. But however, that is not explicitly given in the Constitution. What is explicitly given in the Constitution? The thing that is explicitly given in the Constitution is that he has to give the assent. So therefore, he cannot exercise what? Therefore, as per the Constitution, he shall not exercise absolute veto. He shall not exercise suspensive veto. This is also not given explicitly in the Constitution. What is explicitly said in the Constitution is only to give the assent. Okay, so therefore, the answer is what? It is none. What will follow if a money bill is substantially amended by the Rajya Sabha? What will follow? It's a very simple question. The Lok Sabha may still proceed with the bill accepting or not accepting the recommendation of the Rajya Sabha. So therefore, who is the final authority when it comes to the money bill? It is only the Lok Sabha. That is why it is very important that the speaker should not abuse or misuse his particular power. Once a speaker certifies a bill as a money bill, then the Rajya Sabha is deprived of its powers. So sometimes the government may not need to have a majority in the Rajya Sabha. All that they have to do is they have to certify a bill as a money bill. And once they certify a bill as a money bill, they can silence what is called as the Rajya Sabha. But this may not happen in case of a constitutional amendment bill. But in all other bills, they can do this. Because in a constitutional amendment bill, it has to be separately passed in both houses of the Parliament by special majority. Is the decision of the speaker subject to judicial review? With regard to certifying a bill as a money bill, yes, already we have a precedent. I think the 2017 finance bill, which was certified as a money bill, is still with regard to the judiciary. A judgment was given, but I think now it has been taken by a larger bench, which is still there in the judiciary. So therefore, is it subject to judicial review? The answer is yes. Okay. Again, on the grounds of malified intention, because if there was a malified intention behind certifying a bill as a money bill, it can be judicially reviewed. With reference to the union government, consider the following statements. Statement 1, the Department of Revenue is responsible for the preparation of budget. Is it Department of Revenue? No, Department of Economic Affairs. No amount of money can be withdrawn from the consolidated fund except the authorization of the Parliament. So this is true. All the disbursement made, so this is, I think, repeated this question. Okay, so previous year question has got repeated. All the disbursement made from the public accounts also require the authorization of the Parliament. No. So what is the answer? Okay, come to the next question. Consider the following: salary of President of India, pension of judges of Supreme Court and High Court, debt charges of Government of India. Of all the things that is given, which are all charged upon the Consolidated Fund of India? What about the salary of the President? Yes. What about the pensions of judges of Supreme Court? What about the pensions of judges of High Court? Is it charged on the Consolidated Fund of India? What about the salaries of the judges of the High Court? It is charged on the Consolidated Fund of the respective state. Be very clear. What about the debt charges of the Government of India? Yes, that is also charged on the Consolidated Fund of India. So, can you give me an example of what is the debt charges of the government? Debt charges include the interest that the government has to pay, whatever borrowings that they have made, or sometimes whatever loans that they raise. So, all these things will be part of the debt charges. So, they are all charged upon the Consolidated Fund of India. So, what is the answer? 3 only. Consider the following statements. The parliamentary privileges exercised and enjoyed by the members of the parliament are codified by an act of parliament presently. Is it codified? They are not yet codified. So, presently what are the sources of parliamentary privileges? The constitution and the conventional practices. And for the state legislature, what are the sources of parliamentary privileges? Same, constitutional provisions and the conventional practices. But in the future, is it possible for the parliament to make a law and codify it? The moment the parliament will make a law and codify the privileges, then the conventional practices cannot continue to be the privileges. So, similarly in the future, can the state legislature make a law and codify the parliamentary privileges for the members of the state legislature? Is it possible? See, as per the Constitution of India, the parliament can make a law and codify the parliamentary privileges for the members of the parliament. Now, similarly for each and every state, the state legislature can make a law and they can codify the privileges for the members of the state legislature. So, the moment they will codify the parliamentary privileges, then the conventional practices cannot continue to be a privilege. So, therefore, till this point of time, though there is a provision, either the parliament or none of the state legislature in our country has made a law in this particular regard. So, this is definitely a wrong statement. The quorum in case of parliament constitutes not less than 1/10 of the total members of the house. Is it true? Yes. This is again a conventional practice. Nothing is there in the constitution in this regard. Okay. Okay, it is about the quorum. Sorry. So, quorum is there in the constitution. So, quorum is mentioned in the constitution, but the leader of the opposition, that is not mentioned with regard to what is the majority that they should have. That is not there in the constitution. So, quorum is 1/10, that is explicitly given in the constitution, but can it be changed in the future without amending the constitution? Is it possible? See, it is mentioned in the constitution, so therefore is it possible to change the quorum without amending the constitution? Yes or no? How many of you think it is yes? So, how it can be changed? By an act of parliament. The parliament is free to make a simple act of parliament and they can change it if they want. But however, it has not been done till this point of time. Okay. So, it does not require a constitutional amendment to change this. The salaries and allowances of the members of the parliament are determined by an act of parliament. Is it true? Yes, their salaries and allowances are determined by an act of parliament. So, what is the answer in this case? Okay, sorry, what is the answer? This is not true, this is true, this is true. So, how many of the statements are incorrect? That is one only. Consider the following statements. Statement 1. A bill amending the constitution requires a prior recommendation of the President of India for its introduction in the House. Is it true? No. See, there are certain areas, even in PYQs, it is getting repeated. When a constitutional amendment bill is presented to the President of India, it is obligatory for the President to give her his or her assent. Yes. Which constitutional amendment? 24th. So, the idea is the moment you attend this particular class, most of the things should be there in your mind. But the problem is that still there are 50 days to go for the examination. So, if it is 1 week, probably you can retain most of the information, but still 50 days is a long time to go. In 50 days, you can make wonders. In 50 days, you can change whatever is already there. If you can use it, if you are confident, if you work towards it. So therefore, 50 days is still a long time for you to work, plan and to achieve what you want to achieve. Okay. So why I am saying this, after attending the class, you should again revise at a regular interval. Now it might appear that yes, you know most of the things, but after 10 days, if you don't revise, most of the information might, there are few information you can retain. Maybe you will be able to do 50% of your efficiency if you don't revise, but if you revise, you can do it up to 80 to 90%. Okay. A constitutional amendment bill must be passed by both the Lok Sabha and the Rajya Sabha by a special majority, and there is no provision of joint sitting. Is it true? Yes, there is no provision for the joint sitting. So therefore, this is also true. So what is the answer here? It is 2, 1, 3 only. What are the options available in front of the Legislative Council when an ordinary bill is passed by the Assembly? What are the options available in front of the Council when the Assembly passes it? Can they reject the bill? Think about it. Can they reject the bill? Of course, they can reject the bill. Do not have a misunderstanding. Now, the basic misunderstanding that the students have is, we say that the Council does not have equal powers. Of course, the Council does not have equal powers, but it does not mean that they cannot reject it. So, constitutionally, they have the power to reject it. But even if they reject it, there is a way that the bill can still become an act. But can the Council reject it? Yes, the Council can reject it. So, what are the options that they can exercise? They can accept it, that is, they can approve it. Sorry. They can approve it, that they can accept it. They can pass it with amendments. Can they make amendments, send it back to the Assembly? Yes. But if they send it to the Assembly, if the Assembly does not accept it, then the bill is deemed to be passed. Okay, so that is the thing that you have to understand. So yes, they can make amendments and they can send it back. That is not an issue. So they can make amendments and they can send it. They can even reject the bill. They can reject the bill, they can approve it, or they can keep it pending for 3 months. But the thing that you have to understand is, so whenever, let me just take a moment here. So some students may not have a clarity here. Suppose if the bill is passed by the Legislative Assembly, sent to the Legislative Council. So what the Council can do is, the Council can accept it. If they accept it, no issues. Or what they can do is, they can reject it. Can they reject it? Yes, this option is given there in the Constitution. But the bill does not come to an end just because they are rejecting it. Or what they can do is, they can make amendments. But if they make the amendments, in this particular case, it cannot go to the governor for the assent. If they make an amendments, again they have to send it back to the Assembly. Okay, so when they send it back to the Assembly, if the Assembly accepts it, it's okay. If the Assembly does not accept it, then the Assembly will again send the bill back to the Council. Second time, it will send the bill back to the Council. When the Assembly is sending the bill back to the Council for the second time, what is the time limit that the Assembly has got? Within 1 month, they have to either accept it, or they can reject it also, or they can again suggest the amendments. They can still persist with their amendments. But whatever may be the case, after 1 month, it is deemed to be passed in the same manner as it is passed by the Assembly. Or the last thing that they can do is, they don't take any action for 3 months. That means the bill is introduced in the Council, but the bill has not moved forward. So in this case also, in any of these cases, whether they reject it or whether they make an amendment, or it has 3 months have lapsed, in all these cases, the Assembly will again send the bill back to the Council. And what is the maximum time that is there for the Council to act? If they accept it within 1 month, it is okay. But except for accepting, if they do any of the other 3 things, after 1 month, it is deemed to be passed in the same manner as it is passed by the Assembly. So therefore, what is the maximum time for which the Council can delay the passage of a bill once it is passed from Assembly to Council? 3 months in the first instance and 1 month in the second instance. So therefore, maximum 4 months. Okay, just try to keep this in your mind and just quickly come here. So can they reject the bill? Yes, they can reject the bill. Rejecting the bill means, it doesn't mean that the bill will come to an end, but they can reject the bill. If they reject the bill, Assembly will again send the bill back to the Council. So keep it pending for 3 months. Is it possible? Yes. Can they approve the bill? Yes. Can they pass it with amendments? Yes, this is also possible. So what is the answer here? All of the above. So many students, I have seen that they have an understanding that the Council cannot reject the bill. No, it is explicitly given in the Constitution that the Council can reject the bill. but that doesn't mean that the bill comes to an end. If they reject the bill, again the assembly will send the bill back to the council. So what is the answer? Option D. Which of the following statement is true regarding the sessions in the parliament? The presiding officer has the power to prorogue the session of the parliament. Is it true? No. Who has the power to prorogue? It is only the president and not the presiding officer. What the presiding officer can do? So he can adjourn and he can adjourn sine die. Okay. The constitution prescribes the minimum number of sessions in a year. No. The only information that is given in the constitution is that there shall not be a lapse of more than 6 months between 2 consecutive sessions. The adjournment of a session can be done only by the President of India. The President of India will not do the adjournment. Who will do the adjournment? It is done by the, not the speaker, by the presiding officer. Don't assume it is only in the Lok Sabha. Okay. So it is a presiding officer. So it is not the president. So which of the statements given above are correct? What is correct? None of the above. So please give me the answer for this question. Which of the following majority is required for the election and the removal of the speaker and the deputy speaker? For election, what majority? For the removal? Sure. The only qualification for someone to get elected as a speaker or the deputy speaker, what is the qualification? There should be a member of that particular house, that's the Lok Sabha. So what is the answer here? It is option D. Okay, come to the next question. Consider the following statements regarding the disqualification of a member of a parliament. The member of a parliament is disqualified. So it's not or, is disqualified by the President of India in all cases. Is it true? Is it true in all cases? Yes, in most of the cases it is done by the President, but there are some exceptions also. What are the exceptions? That anti-defection law is an exception. So therefore, to say it in all the cases, it is an extreme statement. So please keep it in your mind. Always watch out for extreme statements. And 90% of the cases, extreme statements are wrong, but not in all the cases. So that is again very important. So you will have to take a call whether it is right or wrong. But if you are not sure, you can go for wrong. But in most of the cases, how UPSC do it? Whenever they use a word only, exclusively, in all the cases, these are all extreme statements. So please watch out for the extreme statements. If you even, why I am saying that you to practice lot of PYQs, from my experience, because I have done a lot of PYQs over a period of time, not only for polity, as a student I used to do for all the subjects, and even with the language I will be able to get 2-3 questions extra, because I am not knowing the answer, but I know the language of UPSC. So I make an educated guess in those areas, which helped me to sometimes get 2 to 3 questions. And thereby you will understand at the later stages, every single question is going to be very important. You will have nightmares if you make a mistake on a simple question. So please try to avoid that. So based on experience, suddenly in the middle of the night, you will wake up and start checking the key, and you look for whether any institute has given this answer as right. So whether it may be right or wrong, but you will try to make sure that yes, you have not done the mistake. So these things should not happen. So be very careful at the time of examination. Okay. And also, anybody has got an issue of marking in the OMR? So that is again very important. Okay. So how you do it in the OMR? Do not do it in one single go, because that can turn out to be disaster. So if you haven't that practice of going in one single go, wherever you have made a mistake, then you cannot undo itself. So therefore, do not go. Either you do it question by question, or you do it 3 questions. For example, in UPSC, in every page there will be 3 to 4 questions. Whenever you solve that 4 questions, mark those 4 questions. That's the best way, because you will keep a tab whether you are making mistakes or not. It will remember see the questions also. But you will feel that okay, I'll solve all the questions and then I'll do. That is not a right approach. You can do it if you like it, but I won't suggest that. The best way to go for your OMR is, in every page I think UPSC will have 3 to 4 questions. Solve those 3 to 4 questions, mark those 3 to 4 questions. Then again solve the 3 to 4 questions, mark those 3 to 4 questions, because your errors will be localized. Even if you are making an error, still there is something that you can do about it. but in one go if you do, there is a possibility that you can commit mistakes, so that is not a right approach. Or you can do it question by question also, it is up to you. Okay. Okay, so the members of the parliament is disqualified by the President of India in all the cases, so that is wrong. No. In case of anti-defection law, the presiding officers must decide the disqualification petition within 3 months. Is it true? No. There is no time limit. A member of parliament can be disqualified for holding office of profit. Is it true? Can a member of parliament be disqualified for having office of profit? Is the office of profit defined in the constitution? So yes, of course, the member of parliament should not hold on to any office of profit. But has anyone thought of what is the reason as to why a member of parliament should not hold on to office of profit? Because that creates a conflict of interest. A legislator, a person who is part of a legislative body to occupy an executive post creates a conflict of interest, because as per the constitution, what is the primary function of a legislator? To hold the executives accountable. So if he himself turns out to be an executive, then who will make the executives accountable? So it creates a classic conflict of interest. So therefore, that is not allowed under the constitution, but there are exceptions, because India is a parliamentary democracy, because the executives ultimately has to come from the legislator, from the legislative body. So therefore, some exceptions are given to the ministers and other thing, but not every legislator can be part of what is called as an executive. So how many of the statements given above are correct? One is correct. A member of parliament can be disqualified for, okay, sorry, the member of parliament can be, so this is not the wrong one. So yes, they can be disqualified for holding office of profit. So a member of parliament can be disqualified. So what is the answer here? One only. Consider the following statement. Statement 1. The duration of both the houses of the parliament is fixed under the constitution of India. Is it fixed? It is not fixed under the constitution. The duration of both the houses of the parliament is fixed under the constitution. The duration of both the houses is not fixed under the constitution. So what they are trying to assess, the duration of both houses of parliament is fixed under the constitution. Of course it is not, because anyways Rajya Sabha is a permanent house. So therefore there is no fixed duration, because the key word here is both the houses. If they say Lok Sabha, yes, there is a duration for that, 5 years, but again it is not fixed, because it can be dissolved earlier also. But definitely you can make this wrong, because the Rajya Sabha is a permanent house. Any person contesting the election to the Lok Sabha should be an elector from any constituency in that state where he or she is contesting the election. Is it true? It is not necessary that he or she should be an elector from that particular state. He or she can be an elector in any constituency in India. So how many constituencies are there in India presently? 540? 543, very good. Don't assume it to be 545. It is only 543 constituencies. Earlier 2 seats were for nomination from the Anglo-Indian community. It is only 543 constituencies. But however, the maximum number of constituencies given in the constitution is what? 550 constituencies. But however, presently only 543. 550 is maximum, but only 543 is presently allocated. Any person contesting election to the Lok Sabha need not be an elector from the state, but anywhere in India. So which of the statements given above are incorrect? Both 1 and 2. Come to the next question. Consider the following statements regarding the seats allocated to the Lok Sabha. The total number of seats allocated to the Lok Sabha from every state is presently based on 2001 census. Is it true? It is based on which census? 1971 census. Very good. It is based on 1971 census. I think only 10 more questions are there for the legislature. I'll complete it and I'll take any doubts if you have. Okay. For the online students also. The Delimitation Commission, which entrusted with the above function, is a constitutional body. What type of body? It's a statutory body, not a constitutional body. There is no representation of union territories in case of Lok Sabha. Is it true? There is no representation. It's an extreme statement. There is no representation in case of the Lok Sabha in case, representation in case of union territories in case of Lok Sabha. In fact, all the union territories are represented in the Lok Sabha. At least one seat is given for every union territory in the Lok Sabha, but you can say that not all the union territories are represented in the Rajya Sabha. Only very few union territories are represented in the Rajya Sabha. What are the union territories that is represented in the Rajya Sabha? Delhi, Puducherry and Jammu and Kashmir. These are the only 3 union territories. Okay. So to say no union territories are represented is wrong. So what is the answer here? Which of the following are incorrect? So it is 3 only. Which of the following Constitutional Amendment Act has done away with the nomination of the Anglo-Indians to the House of People? Which Constitutional Amendment Act? So let us try to see the last 7-8 amendments quickly. So let us see. What about the 99th Constitutional Amendment Act? Where the Supreme Court has struck down the NJSC. On what grounds it has struck down the NJSC? On the grounds that it is violating the basic structure, that is the independence of the judiciary. What about the 100th Constitutional Amendment Act? Exchange of enclaves between India and Bangladesh, because whenever India cedes a territory to a foreign country, it can be done only under Article 368 of the Constitution. 100th Constitutional Amendment Act. 101st Constitutional Amendment Act, GST reforms. They have inserted number of new articles, especially the article like 246A, 279A. So these articles has been inserted. What about 102nd Constitutional Amendment Act? They have given the constitutional status to the National Commission for Backward Classes. Inserted Article 338B and also 342A. So these articles has been inserted. Articles are not important, at least try to remember the constitutional amendment. 103rd Constitutional Amendment Act, they have given EWS reservation. Inserted Article 15 Clause 6 and Article 16 Clause 6. What about Article 104 of the 104th Constitutional Amendment Act? So they have done away with the Anglo-Indian nomination. While they have given extension to the representation to the scheduled caste and scheduled tribe, but the nomination to the Anglo-Indians has been done away with. 104th Constitutional Amendment Act. What about 105th Constitutional Amendment Act? They have restored by after the 102nd Constitutional Amendment Act, there was a confusion whether the states can have their own backward classes, whether they can determine the list of their backward classes in the respective state. So that was restored by the 105th Constitutional Amendment Act. Again, it is related to the states getting their power back to have their own backward classes when it comes to the other backward classes reservation. What about 106th Constitutional Amendment Act? The reservation of seats to women in the legislature, that is both in the Lok Sabha as well as in the not in the Rajya Sabha. In Rajya Sabha there is no reservation. In the Lok Sabha and the state legislature. Now today the women's have reservation in all the 3 categories of elections: local bodies, legislative assembly and also in the Lok Sabha. But yes, it will take some time to get implemented, but yes, that provision is already there in the constitution. Okay. So the latest amendments you should be aware of. So in this case, what is the answer? What? No, there is no reservation in the Legislative Council. There is no reservation in what is called as the Rajya Sabha, because the reservations are only given to the areas where they represent the people. The Legislative Council does not represent the people. The Rajya Sabha does not represent the people of our country. So therefore, there is no reservation in that particular case. So what is the answer here? 104th Constitutional Amendment. Consider the following: Statement 1, open ballot system, disqualification on the defection for cross voting, proportional representation. Which of the above are the feature of Rajya Sabha elections? Does the Rajya Sabha election is based on the system of proportional representation? Yes, it is based on the system of proportional representation. Who constitute the electors for the Rajya Sabha elections? The elected members of the legislative assemblies of the concerned state. Be very clear about it. So therefore, yes, proportional representation is definitely true. What about the system of election? Is it open ballot or secret ballot? It is partial open ballot. So therefore, you can call it as open ballot. Now, what is this partial open ballot system? Normally, open ballot means that everybody will know. But here there is a system of partial open ballot, which means every MLA who is voting in the elections, they have to disclose their vote to a particular to a particular person who is nominated by the party. The party will nominate a person, and to that person they have to show their vote, that they are voting to the right person. So therefore, yes, if they don't disclose their vote, then what will happen to their vote? That vote will be considered to be an invalid vote. It will not be counted. So therefore, open ballot is also right. But the important question is, does it would amount to disqualification on the grounds of defection if they are doing cross voting? Will it amount to disqualification on the grounds of defection? Because if the party is giving some directions, if they act contrary to the party directions, they are liable to be disqualified as per the anti-defection law. So here, if the party is giving a direction to vote to a particular candidate, but if an MLA is voting to a different candidate, although he is disclosing, so therefore they are knowing it also, is he liable to be disqualified under the anti-defection law? Yes or no? How many of you think no? Please raise your hand. How many of you think yes? They are liable to be disqualified. They are not liable to be disqualified under the anti-defection law. Now, why? The Supreme Court has clearly said why they are not liable to be disqualified, because anti-defection law will apply only in case of a legislative proceedings. That means, as a part of a legislative body, if you are performing any of your duties and responsibilities, and then if there is a cross voting, they are liable to be disqualified. But the question is whether voting in the election to Rajya Sabha is a part of a legislative proceeding. The Supreme Court said no, it is not a legislative proceedings. So therefore, you should have an understanding of what is a legislative proceeding. A legislative proceeding means introduction of bills, having some debates, some motions, voting in those motions. These are all legislative proceedings. These are all job of the legislature. But this is just an election where you will have the right to vote. This is not part of a legislative proceeding. So therefore, here the anti-defection law will not apply. Although the party is free to take a disciplinary action, the party can expel them from the party, but that doesn't mean that it will be disqualified as a member of parliament or a member of state legislature. That is not possible. Is that clear to all of you? So here the anti-defection law does not apply. So disqualification on the grounds of defection for cross voting is not the case. So which of the above are the feature of Rajya Sabha elections in India? What is the answer? It is 1 and 3 only. Very, very important. So these are all the areas you should have remember this, okay? Because if you don't remember, generally what will come to your mind is the anti-defection law, okay? So because it is not considered to be what is called as a legislative proceeding. Come to the next question. With reference to the parliament, under the constitution, consider the following statements. Statement 1, the parliament comprises of both elected and nominated members. Is it true? Yes, it consists of, especially in the Rajya Sabha, there is a nominated member. But in general, what the parliament comprises of? The members, it consists of Lok Sabha, Rajya Sabha and the President of India. So the President of India is also an integral part of the parliament. All the members of the Council of States are elected indirectly, and they can be elected only in the form of, only from the state where they are a resident. So when you say that all the members are elected indirectly, itself is wrong, because there are nominated members also. And can they be elected only from a state where they are a resident? Before 1996 this was the case, but subsequently the Representation of People Act has been amended. Today they can be resident in anywhere in India to get elected in the Rajya Sabha, not necessarily from the same state. So this is anyways wrong. Which of the statements given above are correct? One only. Consider the following statements regarding the privilege motion of the parliament. So privilege motion is again very important. Now when this privilege motion is introduced, the privilege motion is introduced usually when any member of parliament breaches the parliamentary privilege, or when he try to bring disrepute to the other members of the parliament. So then they can introduce what is called as this privilege motion. So recently the Congress was trying to introduce this privilege motion against Mr. Amit Shah, but the speaker did not allow for it, but they are trying to introduce this privilege motion. So whenever a privilege motion is introduced, they should bring in a notice that they wanted to introduce a privilege motion against a particular member. And then if the speaker or the presiding officer, because it can be introduced in both the houses, if the presiding officer gives a permission, then the notice will be admitted. And then once a notice is admitted, then the matter will be taken up by the privilege committee, because the committee has to study this particular matter. So therefore, to study this particular matter, both the Lok Sabha and Rajya Sabha has got their respective privilege committees. In the Lok Sabha, it has got 15 members. In the Rajya Sabha, it has got 10 members. Now, all these members are nominated. There is no election to this privilege committee. They are nominated, and the presiding officer is usually, the chairperson is usually nominated by the presiding officer. Okay, and then they will submit the report back to the House. And based on the report that is submitted to the House may collectively take some action against the member if they found that the member has breached the parliamentary privilege. Okay, so with that, please come to the question. It can be moved only in the Rajya Sabha with the permission of the presiding officer. This is part of your current affairs. So, can it be moved only in the Rajya Sabha? It can be moved both in the Lok Sabha as well as in the Rajya Sabha. Usually, if the person is from Lok Sabha, it will be moved in Lok Sabha. If he is from Rajya Sabha, it will be moved in Rajya Sabha. So, this is wrong. The privilege committee in the Rajya Sabha consists of 10 members. Is it true? Yes. In Lok Sabha, how many members? 15 members. So, this is true. Which of the statements given above are incorrect? What is incorrect? One only. Please come to the next question. Which one of the following is true regarding the Joint Parliamentary Committee? It is an ad hoc committee. Is it an ad hoc committee? Of course, it is an ad hoc committee. It comprises of members of both houses of the parliament. Is it true? Yes. The recommendations of the committee are binding upon the parliament. Is it true? Not only that of the joint parliamentary committee, the recommendation of any of the parliamentary committees is not binding upon the government. They are merely a recommendatory body. So, what is the answer? 1 and 2 only. Who is authority to disqualify the members of the State Legislative Assembly on the grounds of defection? On the grounds of defection, who is authority? So, among the given thing, who is the right? What is the right answer? So, you will have to always see based on the option. So, the option is, it is a speaker. Consider the following statements regarding the removal of chairman Rajya Sabha. Again, very important, because there is a notice that the opposition was trying to introduce with regard to the removal of the Rajya Sabha chairman, that is none other than the vice president. While a motion to remove the chairman of Rajya Sabha is pending in the House, he or she cannot preside over the House. Is it true? Once a notice is admitted, then the chairman cannot preside over the House. So, the deputy chairman will preside. So, therefore, this particular statement is correct. What is the notice time that has to be given? 14 days of notice. The removal motion has to be passed with effective majority in both the houses of the parliament. Is it true? So, it has to be passed. Does it require to be passed in both the houses? Yes, but in the Rajya Sabha, what is the majority? And in the Lok Sabha, simple majority. In which house it can be introduced? Only in the Rajya Sabha. So, therefore, to say that it requires effective majority in both the houses is wrong. So, which of the statements given above are incorrect? What is incorrect? The question is asking for incorrect. So, what is the answer? 2 only. Come to the next thing. The Delimitation Commission of India is what? Is a statutory body. So, we already discussed this. Who shall determine the service conditions of the secretarial staff of both houses of the parliament? In fact, try to understand that as per the Constitution of India, both the houses can have their own secretariat staff. So, they can make recruitment and all those things. And who is heading the secretarial staff? The Secretary General Lok Sabha for the Lok Sabha and the Secretary General Rajya Sabha for the Rajya Sabha. But as per the Constitution, who shall determine their service conditions? What is the answer? The presiding officers, the President of India. It is the Parliament of India which has got the power. The Parliament may by a law determine their service conditions. Okay. So, very important. How many of you thought it would be the Parliament? How many of you would have actually gone for the Parliament if it is an UPSC exam? How many of you would have gone for the President? How many of you would have gone for the presiding officer? So, these are all areas which looks very simple, but there is a possibility of making mistakes, and these are all the areas you cannot apply logic also, because everything looks like right. So therefore, unless and until you read it, you will not be able to do it. Okay. If luck is in your favor, yes, sometimes you can get it right. But as I always say, you cannot go to the examination only on the basis of luck. That is a very bad strategy. If you will think that the luck will favor you. Of course, luck will favor you if you have worked hard for it. If not in 1 year it will be in your favor. But the thing is, will you be able to persist till that point of time? That's another question. So therefore, your strategy should not be on the basis of luck. Your strategy should be on the basis of your own hard work and your own planning, and of course, to some element your smart work also. Only a little bit, not much in UPSC examination. Okay. Who shall determine the salaries and allowances of members of the Parliament? The Parliament itself. These are the only categories of people who can determine their own salary and allowances. Okay, so this is in case of Parliament. Okay, all right. Very quickly, any questions? I wanted to cover another at least 25, 30 or whatever is possible. The next part that you are going is Judiciary. But see, as of now, whatever we have completed, 8 to 10 questions, I am sure that you will be able to solve it. But provided you also revise it again, at least 1 or 2 times, if not more times, at least a couple of times you can revise these questions along with whatever material that you have had for revision also. I am sure that here you can get 90% of the questions right. Okay, there is one question the student is asking. Question number 217. Can anyone give me the copy? Just I will see what is 217. Okay, so please listen. While all the money bills are financial bills, but not all financial bills are money bills. That is quite clear. So that particular statement is true. While the money bills can be introduced in the Lok Sabha, that is true, part of the statement. While the money bills can be introduced in the Lok Sabha with a prior recommendation of the President, the same is not true in case of the financial bills. The same is not true in case of the financial bills. The same is not true in case of the financial bill means that it is saying that not all the financial bills requires a prior recommendation of the President. So therefore, that statement should be true. So did I make it wrong? Okay, so I think there's some element of lapse in the concentration. So please make a change in question number 217. I think that is the reason I think the student have asked. So it is saying that the same is not true in case of the financial bill means it is not true because the financial bill type 2 does not require this. So if all the financial bill requires this, then it is wrong. So anybody who has a doubt, please ask me. Again, I am repeating it again. So please, anyone give me the copy. Okay, look into the statement number 2 very carefully. While all the money bills can be introduced only in the Lok Sabha, is it clear? It can be introduced only in the Lok Sabha with a prior recommendation of the President. The same condition is not required for the finance bills. That means the same condition is not required for all the finance bills. So if it is for both the finance bill type 1 and type 2, if the same conditions are required, then this particular statement is wrong. But here it is saying it is not true in case of finance bill, because in case of financial bill type 1 it is true, but for not for the financial bill type 2. So partially it is right, but partially it is wrong. So therefore it is considered to be a correct statement in this case, because the question is not true. Okay. So please make a correction there. If you have any questions, you can ask me after the class also, but the second statement is right because it is given not true. So therefore, what would be the answer for that question? Both 1 and 2. Option C is the answer. Okay, shall I move to the next part? Any other questions? Okay, so can anyone tell me what is quorum? Quorum means is the minimum number of members who should be present in the house to carry out the proceedings. So without the minimum number of members, the presiding officer cannot carry out the proceedings, and that as per the constitution is not less than 1/10 of the members present in the house of the total membership of the house. Alright, so I think there is no other question from the online students. Any question? Yes, very quickly. Decisions are cabinet binding or not binding on whom? On the government. The government itself is a cabinet committee only. So therefore, to say that their decision is not binding is not an appropriate thing. Who heads all the cabinet committees? The Prime Minister himself heads all the cabinet committees. So therefore, their decision the government is likely to implement. Alright, any other questions? Yes. Not the previous Lok Sabha. The previous Lok Sabha is over. It may be joined by the new Lok Sabha, but it is very unlikely to happen. Once a joint sitting is convened and if the Lok Sabha dissolved, you never know, because again whatever will happen based on the aid and advice of the Council of Ministers. So therefore, the same Council of Ministers will come or not, the same government will come or not. So normally that bill will automatically will not become an act. It is very unlikely, but the bill may not lapse as such. If the government wanted to continue, they can continue, but it is very unlikely it will become an act. Okay, but definitely not the previous Lok Sabha. It is the new Lok Sabha. Alright, shall I move to the next part? Okay, so please come to the next part, which is about the judiciary. So from now on, whatever topic that I am taking up, possibility is one question. One question for all the small topics. Okay, so judiciary also one, maybe two questions. So randomly UPSC can ask. So whatever we are going to see from here on is for 5 to 7 questions. 8 to 10 questions you already covered. Okay, so come quickly to the judiciary part. Consider the following statements. Consider the following statements. The Supreme Court of India tenders advice to the President of India on matters of law or fact, the conditions on its own initiative. Is it true? First of all, tell me under which article the Supreme Court will tender the advice? Article 143 of the Constitution. And who can seek this advice? The President of India can seek this advice. Very good. So under Article 143 of the Constitution, the Supreme Court will not give the advice on its own, but only when the President asks for the advice on a question of law or a question of fact or the interpretation of the Constitution. So the President has to initiate this. But however, the President can ask two types of advice: an advice which is related to post-constitutional matters and an advice related to what is called as pre-constitutional matters. So, but however, in both the cases, the opinion that is given by the Supreme Court is not binding upon the government. But however, if it is a pre-constitutional matter, the Supreme Court is bound to give the opinion. But the Supreme Court is not bound to give the opinion when it is a post-constitutional matter. But however, in both the cases, try to understand, in both the cases, it is not binding upon the President or the government. But in one case, when they are bound to give the opinion, in case of what is called as a pre-constitutional matter, that is any dispute that has arisen before the constitution, before the constitution came into force, or any agreement that is entered upon before the constitution itself, which is still in force. So now come to this particular question. On its own, is it true? No. If he seeks such an advice, yes. Only if the matters related to the fundamental rights of the citizens, not necessarily, no. So which of the statements given above are correct? It should be 2 only. That is option B, which is correct. Is it mandatory for the Supreme Court to give the opinion? When it becomes mandatory for the Supreme Court to give the opinion? If it is related to a pre-constitutional issue. But if it is a post-constitutional issue, it is not mandatory. But in both the cases, whatever is opinion is not binding upon the President, because in both the cases, it is not considered to be a judgment of the court. It is not considered to be a decree or a judgment of the court. Because any judgment of the Supreme Court is binding. But this is not a judgment, this is merely an advice or an opinion which is given by the Supreme Court. So therefore, it is not also precedent to the other courts in our country. There is one provision in the Constitution which talks about any judgment or an award which is passed by the Supreme Court is binding upon all other courts. Under which article it is binding upon all other courts? Article 141 of the Constitution. Very good. But however, whatever opinion which is given by the Supreme Court under Article 143 is not considered to be a judgment or a decree. It is not setting any precedent for the other courts. It is strictly related to only to that particular matter. Okay, and that too is not binding upon the President. Okay, consider the following statements. The Central Administrative Tribunal (CAT) was set up during the Prime Ministership of Lal Bahadur Shastri. Is it true? When was the Central Administrative Tribunal was established? in 1985. In 1985, it was Mr. Rajiv Gandhi was the Prime Minister of India, because the Central Administrative Tribunal was established based on the Administrative Tribunal Act 1985, and the Administrative Tribunal Act 1985, which led for the establishment of Central Administrative Tribunal by the center and the State Administrative Tribunal by the states, and based on which article in the Constitution they are established? Article 323A of the Constitution. So therefore, the Central Administrative Tribunal, is it a constitutional body? Is it a constitutional body? Constitutional, a statutory, which type of body is it? If you look into Article 323A of the Constitution, Article 323A of the Constitution is saying that the Parliament shall have the power to make a law, and by that law they can allow for establishment of what is called as administrative tribunal. So therefore, the administrative tribunal in our country is only a statutory body. So under Article 323A, only one type of tribunal can be established by the law that is made by the Parliament, and under Article 323A, only the Parliament can make law, and by that law they can establish only one type of tribunal. And what is a tribunal? Administrative tribunal. But the administrative tribunal is a statutory body. And there is also another article, that is Article 323B. Under Article 323B, both the Parliament and the state legislature can make laws, and they can allow for establishment of any other tribunal apart from administrative tribunal. So for example, we have taxation tribunals, we have green tribunals, we have electricity tribunals, we have rent tribunals. All these tribunals are established under which article? Not directly under Article 323B, but 323B is giving the power to the Parliament and the state legislature. Is it clear to all of you? So only one type of tribunal under Article 323A, other type of tribunals under Article 323B. But whatever tribunal that can be established in our country, they are all considered to be statutory bodies. They are not constitutional bodies. Clear? So then the member of CAT are drawn from both judicial and administrative streams. Is it true? This is not only with regard to the administrative tribunal. The general principle that is followed by law in our country is that they will have both judicial experts as well as technical experts related to that particular matter. So that is also true. So the member of the CAT are drawn from both judicial as well as administrative matters. So this is true, this is wrong, because this is under the leadership of Mr. Rajiv Gandhi. So which of the statements given above are correct? Two only, option B. Consider the following statements. Justice V.R. Krishna Iyer was the Chief Justice of India. This is again a factual statement. Sometimes they can randomly pick. UPSC has asked this particular question. Now why? Because they wanted to ask question on public interest litigation. Justice V.R. Krishna Iyer was considered to be one of the pioneer of what is called as a public interest litigation. So he in fact entertained a number of cases as a part of what is called as public interest litigation. But he is one of the most respected judges in our country, Supreme Court judge, but he was never the Chief Justice of India. So what is the answer here? So Justice V.R. Krishna Iyer was a Chief Justice of India. No, that is wrong. Justice V.R. Krishna Iyer is considered to be one of the progenitors, pioneers of public interest litigation in the Indian judicial system. This is true. So which of the statements given above are correct? Two only. Okay, let me see how many of you are able to answer this question. How many high courts in India have jurisdiction over more than one state, excluding the union territories? Don't take the union territories, only for the states. 3, 2, 4. I want the states also, not just the answer. Tamil Nadu? Tamil Nadu, Madras High Court does not have over Andaman. Tamil Nadu High Court has over Puducherry, but anyways you don't have to take into account the union territories. I have clearly mentioned it here. How many high courts in India have jurisdiction over more than one state? Only the state. Union territories not to be included. 2 or 3? 3? Yes, what are the 3? Can you recollect? Bombay High Court, which has jurisdiction over Goa also, state of Goa, yes, 1. Assam High Court. Assam High Court has got jurisdiction over, I think, the state of Nagaland, Arunachal Pradesh and Mizoram. Okay, yes, so Assam Guwahati High Court, true, 2. Very good. Punjab and Haryana High Court. So therefore, when it comes to the state, it is only 3. So what is the answer here? Only 3. Very good. So how many of you got this answer? Only 3. But don't stop it here. Also see as to how many high courts having jurisdiction over the union territories as well. So they can ask that also. Can you quickly answer this particular question? So which High Court is having jurisdiction over the union territory of Puducherry? It is the Madras High Court. Which High Court is having jurisdiction over Andaman and Nicobar Islands? It is Kolkata High Court. Which High Court is having jurisdiction over Lakshadweep? Kerala High Court. Very good. Which union territory is having jurisdiction over Dadra and Nagar Haveli and Daman and Diu? It is Bombay High Court. And of course, it is a Punjab and Haryana High Court, which is also having jurisdiction over Chandigarh. And there are few union territories, they have a High Court of their own. There are two union territories which has got a High Court of own. One is National Capital Territory of Delhi, having a High Court of its own. Jammu and Kashmir has a High Court of its own. If any union territory is to have a High Court of its own, so who has authority to allow for allow a union territory to have a High Court of its own? The Parliament by a way of a law. It is a Parliament that can create a High Court of its own. Okay. So come to the next question. Consider the following statements. The mode of removal of a judge of a High Court in India is same as that of the removal of the judges of the Supreme Court. Is it true? In fact, there is no change. Article 124 talks about the removal of the judges of the Supreme Court, and Article 217 talks about the removal of the judges of the High Court. But if you read Article 217, it says as it is for the judges of the Supreme Court. So what is the ground on which the judges of the Supreme Court and High Court can be removed? Either on the grounds of misbehavior or incapacity. Again, the removal part becomes very important. Removal and transfer, this here I feel is very important, because recently there was a allegation against a Delhi High Court judge who has been transferred to Uttar Pradesh, and there is also an internal inquiry that is going on. So therefore all these things can be very relevant for your examination. So what is the ground on which they can be removed? It is either on the grounds of misbehavior or incapacity. Is the term misbehavior incapacity defined in the Constitution? No. So to prove that, it has to be done through an inquiry process. And how the inquiry has to happen? It is based on the Judges Inquiry Act. And it also provides for a procedure as to how this inquiry has to be happened. But however, what the Constitution says, after this inquiry, if at all a judge is to be removed, a removal motion has to be introduced, and it has to be passed with what majority in both houses of the Parliament? Special majority. And what is a special majority? Not less than 2/3 of the members present and voting, and absolute majority as well. And it has to be passed with special majority in both the houses in the same session. And then subsequently he can be removed by the President of India. So therefore, who is the removal authority for the judges of the Supreme Court and High Court? President or the Parliament? There should be no doubt in this regard. It is the President who is the removal authority, not the Parliament. Just because the Parliament has passed a motion by special majority, the judges cannot be removed unless and until it is approved by the President of India. But the President cannot do so unless and until it is passed by both houses of the Parliament. But ultimately, who is the removal authority? It is the President who can remove them. Okay, so with that, you please come to the information question. The mode of removal of the judge of High Court in India is same as the removal of a judge of a Supreme Court. Is it true? Of course, it is true. No change. Come to the next part of the question, that after the retirement of office, a permanent judge of High Court cannot plead in any of the court or before any authority. So some of the students asking, does it not amount to violation of his fundamental right? It is not about when his right is violated, he can file a case. Basically, when you say that he cannot plead in any court, he cannot practice as a lawyer subsequent to that, because he is also from a legal profession. Can he practice himself as an advocate in any of the court? So there is no complete ban for a judge of High Court. A judge of High Court can practice as an advocate in the Supreme Court or in any of the other High Courts from which he has not retired, but not in the same High Court where he has retired. So therefore, see the answer for this particular question. After retirement from the office, a permanent judge of High Court cannot plead or act in any court before any authority in India is an absolute statement. That is wrong. So this is applicable for the judges of the Supreme Court. A Supreme Court judge cannot plead anywhere within the territory of India, but a High Court judge can plead He can plead in the Supreme Court or in any of the other high courts. So this is wrong. So which of the statements given above are correct? It is one only. So these are all very random questions. So sometimes they can ask questions from the district. This also. This is in fact a previous year question. So that's why I picked it. So the judges, the highest criminal court of a district is the court of district and session judge. Is it true? He is in fact called as the highest court in the district is called as a court of district and sessions judge. Now why? Because the same person, when he is hearing the civil case, he is considered to be what is called as a district judge. And the same judge, when he is hearing a what is called as a criminal case, he is called as a session judge. So therefore this particular statement is right only. Okay. The court is the same. It only depends upon the type of case he is hearing. The district judge are appointed by the governor in consultation with the high court. Is it true? Yes, the district judge are appointed by the governor in consultation with the high court, but the high court judges are appointed based on the recommendation of the collegium by the president. When the session judge awards a death sentence, it must be confirmed by the high court before it is carried out. This is true as per the criminal procedure code in our country. Whenever a death punishment is given by a sessions judge, automatically the matter will be reviewed by the high court. Whether the individual wants it or he does not want it, automatically the matter will be reviewed by the high court, just to make sure that there is no error in the lower court. So once it is confirmed by the high court, then only it can be executed. Okay. But however, this is not there in the constitution. It is only as per the criminal procedure code, which has been renamed right now. Whatever is the name of the law, as per the law, it is the case. Which of the statements given above are correct? What is the answer? All the statements 1, 2 and 3. Under which article of the Indian Constitution did the President make a reference to the Supreme Court to seek the court's opinion on the constitutional validity of Elections Commission decision on differing? So this is not important. The only thing is, under which article of the Constitution did the President can make a reference to the Supreme Court? Which article? Article 143. Just now we have seen. So can the President make a reference on a question of fact? Not just on a question of law. On a question of fact also he can make a reference. But in any case it is not mandatory except if it is a pre-constitutional matter. But in any case it is not binding upon the President of India. Come to the next question. The salaries, allowances of the judges of the High Court. The salary allowances of the judges of the High Court are charged upon what? They are all salary allowances only. It is not the pensions. So therefore it is charged where? It is charged on the consolidated fund of that particular state. The concept of public interest litigation originated where? The concept of public interest litigation originated not in United Kingdom, in United States of America. Because you cannot say United Kingdom because United Kingdom does not have a written constitution in the first place. So the concept of public interest litigation has originated where? In United States of America. If you see two judiciaries which are more or less similar, it is only the Constitution of India and the Constitution of United States of America. They almost exercise similar judicial review. But there is a vast amount of difference between the judicial review powers of India and that of United Kingdom. So therefore they work on an entirely different line, which is again a very important topic. In fact, the same question, this is a very simple prelims question, but it was asked in UPSC mains examination also. How is the power of judiciary, or to what extent the judiciary in India converge and diverge from that of the judiciary of United Kingdom? The basic element of divergence is because of the power of judicial review. There is one more question I will discuss when I come to that particular question. But anyways, what is the answer here? It is the United States of America. The power of the Supreme Court of India to decide the disputes between the center and the states. Very, very important area. What is the jurisdiction? Original jurisdiction. So can you please tell me what are the cases that falls under the original jurisdiction? Now please tell me yes or no. Any dispute between the center versus state? Any dispute between the center and the union territories? No or yes? No. Sure? Any dispute between the center and the union territory is not a federal dispute, because union territory is part of the union government, the central government. So therefore it is not a federal dispute. Any dispute between an union territory and a state? Yes, yes, because union territory is part of the center and state is a state. So therefore it is a federal dispute. Any dispute between two or more states? Any dispute between two or more states with regard to interstate river water disputes? It is a federal dispute but does not fall under the original jurisdiction, because any interstate river water disputes can be challenged only in front of such an authority as determined by the law made by the parliament. So therefore the interstate river water disputes can go only in front of a tribunal which is already established for that particular purpose. But if a tribunal passes an order but still there is no implementation, can any affected state still go to the Supreme Court? Yes, they can go to the Supreme Court, but not under the original jurisdiction, but as a special leave petition under Article 136. So please be very clear. Original jurisdiction means what? Where there is a federal dispute. Okay, so that is what is original jurisdiction. Under which article this original jurisdiction is given to the Supreme Court? Very good. Article 131 of the Constitution. This is just an extra information. Okay, come to question number 28. When the Chief Justice of a High Court acts in an administrative capacity, this is very important. When a Chief Justice of a High Court acts in an administrative capacity, will he fall within the definition of state? So if he falls within the definition of state, then he is subject to what? Then he is subject to the writ jurisdiction of any other judge in the High Court. So is that possible? Yes, because he falls within the definition of state. So therefore his action should not be violative of the fundamental rights. And if it violates the fundamental rights of anybody else, they can move an application to any of the other judges and they can pass a writ against the Chief Justice of the High Court. So this is definitely true. So the answer is option A. Which one of the following comes under the jurisdiction of both the High Courts and the Supreme Court? Which will fall? Dispute between center and state? No. Dispute between state interest, that is between two states. Protection of the fundamental rights? Yes. Article 32 gives a power to the Supreme Court. Article 226 gives a power to the High Court. So therefore the answer is option C. Come to the next question. Which of the following is true with regard to the power of the Supreme Court under Article 142 of the Constitution? So you should be very clear about Article 141, 42, 43, because you should not get confused. So can anyone tell me what is Article 141, 42 and 43? What is Article 141? The Supreme Court judgment is binding upon all the courts in India. Article 143, the Supreme Court is seeking the advice of the President, the President is seeking the advice of the Supreme Court. What is Article 142? Article 142 is talking nothing will prevent the Supreme Court in passing any kind of order or judgment in ensuring complete justice in a particular matter. That means nothing in the ordinary law will prevent the Supreme Court of India in passing any orders in order to ensure what is called as complete justice. In fact, I have given one example to the students where the Supreme Court has allowed for the medical termination of pregnancy of a rape victim after 24 weeks. Because as per the law in our country, if somebody has to terminate the pregnancy, till what point of time they can terminate the pregnancy? Only normally up to 20 weeks. In certain exceptional cases, it can go up to 24 weeks, but not beyond 24 weeks. But in this case, the rape victim, she was not aware that she was pregnant, and she was aware only the time was already over. Then still she moved an application to the Supreme Court, where the Supreme Court has allowed for the termination of the pregnancy in order to ensure complete justice. So Article 142 of the Constitution, it gives an extraordinary power in the hands of the Supreme Court to ensure what is called as complete justice. Is that clear? This is just one example. There are a number of other cases for you to remember. So what is the answer here? It is a power in the hands of the Supreme Court to pass any order or decree in order to ensure complete justice in a matter pending before it. Okay. Come to the next question. Recently, the National Judicial Appointments Commission Bill 2022 was introduced. Recently also the government tried to introduce this particular bill in the houses of the Rajya Sabha, which is related to the system of appointment of judges in the higher courts. In this context, consider the following statements. Presently, the system of appointment of judges to the Supreme Court and High Court is based on collegium system. Is it true? Yes. And who constitutes collegium today in the Supreme Court? Chief Justice of India plus 4 senior most judges of the Supreme Court. In fact, there is one more thing that you have to remember. It is Chief Justice of India plus 4 senior most judges normally, but if none of those 4 senior most judges will become the next Chief Justice of India, because let us assume the Chief Justice of India is much junior in age to all these judges. Then if none of these 4 senior most judges will next become the Chief Justice of India on the term on the present Chief Justice of India getting retired, then the next person who will be becoming the Chief Justice of India will also be part of the collegium. But if any of the Chief Justice or any of the 4 senior most judges is likely to become the Chief Justice, then it is only Chief Justice of India plus 4 senior most judges. Okay. So in general, it is Chief Justice of India plus 4 senior most judges, because whatever I am talking about is a very exceptional case. Statement 2, the collegium consists of Chief Justice of India plus 4 senior most judges in case of appointment of Supreme Court and 2 senior most judges of the Supreme Court in addition to the Chief Justice of India in case of appointment to High Courts. Is it true? The collegium is little different. For the appointment of judges to the Supreme Court, it is Chief Justice of India plus 4 senior most judges, and for the appointment of judges to the High Court, it is Chief Justice of India plus 2 senior most judges. What about transfer of judges from one High Court to another High Court? That is very important this year. That is also on the basis of collegium. And who is authority to transfer the judges of High Courts? It is a president, not the collegium. For the appointment also, not the collegium. The collegium is only a recommendatory body. But however, here the recommendation is binding, but the appointing authority is only the president. The transferring authority is also the president. Okay, and the president will transfer the judges of the High Court based on the recommendation of the Supreme Court collegium, that is Chief Justice of India plus 4 senior most judges. So therefore, this particular statement is also true. The collegium recommendation is binding on the president provided there is a larger consensus of the collegium before the name is forwarded. Yes, because the Supreme Court said if among the collegium, if even 2 senior most judges have a dissenting opinion, then that is not, should not be forwarded, and even if it is forwarded, it is not binding. Therefore, it requires a larger consensus. So this is true. So choose a correct answer from the code given below. All are right? Okay, so the answer is all of the above. So I'll try to wind up the class by 4:50. Okay, I think there's another class, so probably I'll leave it 10 minutes earlier. But before that, I'll try to cover more than 300 questions. Okay. Consider the following statements. Yes. Consider the following statements regarding the jurisdiction of the Supreme Court. So how many of the students were also likely to attend the next class? Most of you. Okay, so I'll leave it 10 minutes earlier. Consider the following statements regarding the jurisdiction of the Supreme Court. Statement 1. All matters relating to the violation of fundamental rights of any individual residing in the Union Territory shall be petitioned only under the writ jurisdiction of the Supreme Court. All matters relating to the violation of fundamental rights of any individual residing in the Union Territory shall be petitioned only under the writ jurisdiction of the Supreme Court. Is it true? He may go to the Supreme Court or he may go to the High Court which is having jurisdiction over that particular Union Territory. So it is not necessarily only in the Supreme Court. So therefore, this particular statement is what? It is wrong. Any dispute between the Union Territory and the Union Government will be directly falling under the Supreme Court. Is it true? It is not under the original jurisdiction. Okay, so therefore not directly under the Supreme Court. It can go to the Supreme Court by way of an appeal, but not directly to the Supreme Court. So which of the statements given above are correct? Neither one nor two. Which of the following is are true with regard to the removal of the judges of the Supreme Court? Which of the following is true? The Constitution provides for a detailed procedure for investigation on the introduction of motion for the removal of the judges. Is it true? The detailed procedure is not given. The detailed procedure has to be brought in by way of a law that is made by the Parliament. And what is the law that we have right now? The Judges Enquiry Act, which talks about an enquiry committee has to be appointed. 3 members will be part of the enquiry committee. They will inquire, they will give the report. So this is all the detailed procedure which is only in the Enquiry Act, not in the Constitution. The judges can be removed only on the grounds of proved misbehavior or incapacity. Is it true? Yes. Is it defined in the constitution? Misbehavior incapacity? No. The removal motion has to be passed by special majority and has to be approved by the president in the same session. Is it true? Yes, this is true. So which of the statements given above are correct? What is the answer? 2, 1, 3 only. Come to the next question. Consider the following statements. In case of lack of quorum in the Supreme Court, the Chief Justice of India, with the prior consent of the President and with the consultation of the Chief Justice of the High Court, can appoint a judge of a High Court to act as an ad hoc judge. But here, what is this quorum in case of Supreme Court? Is it mentioned in the Constitution? What constitutes quorum? There is nothing which is fixed as per the law or in the Constitution. It only means when the Chief Justice of India feels that there are not sufficient judges in the Supreme Court to administer justice effectively. So whenever he feels that there is lack of judges, so then he can call for what is called as an ad hoc judge, a temporary judge. So this is true. In case of lack of quorum, the Supreme Court Chief Justice of India, with the prior consent of the President and with the consultation of the Chief Justice of the concerned High Court, can appoint a judge of High Court as an ad hoc judge. This is in general true, but one more information you should know. Not any judge of High Court, but a judge of High Court who is eligible to be appointed as a judge of a Supreme Court. That is actually missing in the statement, but be clear about it, okay? So any judge of High Court would not be the right thing. A judge of High Court who is eligible to be appointed. In fact, I framed this particular thing. It was there in my mind, so but it has been missed. So I'll make it correct, but you try to be very clear that it should be someone who is eligible to be appointed as a judge of a Supreme Court. So which High Court judge is eligible to be appointed as a judge of a Supreme Court? Only a person who has already served as a judge of High Court for minimum 5 years. Okay. So then it becomes the right thing. Anyways, I am making it correct, but you be aware of that also. But the way the question I have framed is not to check that, it is only to see the general procedure. Okay. So therefore I am making it right. The Chief Justice of India, with the prior consent of the President, can request a retired judge of a Supreme Court or High Court to act as a Supreme Court judge. Is it true? The Chief Justice of India, with the prior consent of the President, can request a retired judge of a Supreme Court or a High Court. So here also, a retired judge of High Court who is eligible to be appointed as a judge of a Supreme Court, only he can be called. And not only the consent of the President, the consent of the concerned judge is also required. Okay. But anyways, the question is not talking about that. In general, this particular statement is also true. So which of the statements given above are correct? So both 1 and 2. Consider the following. The Central Administrative Tribunal is a constitutional body established under Article 323A. Is it a constitutional body? No, it is not a constitutional body, it is a statutory body. The decision of the Administrative Tribunal can be challenged in the High Courts. Is it true? Yes, the Supreme Court has made it very clear in L. Chandrakumar case that the decision of the tribunal shall be subject to judicial review by the High Courts, and then subsequent judicial review can be also be done by the Supreme Court of India. So it is subject to what is called as judicial review. It can be challenged in what is called as the High Courts. So this is definitely true. So what is the answer? Which of the statements are incorrect? What is incorrect? 1 only is incorrect. Which of the following best explains the concept of judicial review? What is the concept of judicial review? It is a power of the courts to review the actions of the other 2 organs of the state. What are the other 2 organs? Legislature and the executive, in reference to what? In reference to the, not the fundamental rights, in reference to the constitution, not necessarily the fundamental rights. So in general, whatever law that they make or whatever the executive action, it should not be in violation of the constitution. So therefore, the judiciary is nobody to question the wisdom of the other 2 organs, as long as it is not in violation of the constitution. So sometimes a law can be bad, but unless and until it is violative of the constitution, the Supreme Court cannot declare that to be invalid. So judicial review is strictly in relation to what? Strictly in relation to the provisions in the constitution. So therefore, what is the answer in this case? What is the best answer? So it is a power of the courts to declare the action of only the legislature. So I talked about the general principle, but you applied it to this particular question. So when you apply it to this particular question, it is a power of the court to declare actions only of the legislature. So it is not only of the legislature. So therefore you can eliminate this. It is a power of the judiciary to question the wisdom of the legislature. No, it is not to question the wisdom of the legislature. So you can eliminate that also. It is a power of the courts to declare the action only of the executives. So again you can declare that to be invalid. It is a power of the courts to declare the actions of both the legislature and the executives as void if they are violative of the fundamental rights. This is just a subset of the concept of judicial review. This is right in this particular question. But in general, what is judicial review? Not necessarily the fundamental rights if they are violative of any provisions of the constitution. Okay, so therefore the answer is option D. Consider the following statements regarding the position of public interest litigation. What is public interest litigation? It's a litigation that is filed in front of a court of law by a person not for his own interest, but for the interest of some other people in the society. Somebody else is getting affected, so therefore he is filing a litigation. That's a public interest litigation. So therefore the first statement is the principle of locus standi strictly applies in case of public interest litigation. It is exactly opposite. The principle of locus standi does not apply because it is not filed by a person who is affected himself. The public interest litigation can be used to challenge the violation of fundamental rights by any social action group or a public spirited individual, although they may not be directly have any interest in the case. Is it true? In fact, the Supreme Court has categorically said that public interest litigation can be filed as a writ petitions. That means public interest litigation can be used as a tool to challenge the violation of the fundamental rights, not necessarily by the affected person, but by any social action group. What does it mean by social action group? So for example, NGO is an example of a social action group. It is working for the welfare of the people. So that is a social action group. So yes, this particular statement is true. The term public interest litigation is well defined in the constitution. Is it defined in the constitution? It is not defined, it is not even mentioned in the constitution. So which of the statements given above are incorrect? What is the answer? 1 and 3 only. What is the provision to safeguard the autonomy of the Supreme Court of India? What is the provision to safeguard the autonomy? So what are the provisions which will safeguard the autonomy and the independence of the Supreme Court? While appointing the Supreme Court judges, the President has to consult the Chief Justice of India. Is it true? Now, don't per se see that the collegium and all those things. It is only to see whether the autonomy is there. So among the given things, is the Chief Justice to be consulted? Yes, which means in fact based on their opinion only they have to be appointed. Okay. So this is yes protecting. It is in fact a UPSC question. The Supreme Court judges can be removed by the Chief Justice of India only. No. Who can remove them? The President, not the Parliament, the President. The salaries of the judges are charged on the consolidated fund of India, which the legislature does not have the power to vote. Does it increase their autonomy? Yes. All appointments and the officers and staffs of the Supreme Court of India are made by the government only after consulting the Chief Justice of India. As per Article 146 of the Constitution, all the appointments to the officers and staffs of the Supreme Court are made by the Chief Justice of India or any of the judges the court may decide, not the government of India. So therefore, this is not wrong. So this is not right. So what is the answer if you eliminate these two? What is the answer? Correct interpretation. So all the officers and the servants of the Supreme Court shall be appointed by the Chief Justice of India or any of the judge as decided by the Supreme Court. So not by the government. So what is the answer here? 1 and 3 only. The power to increase the number of judges in the Supreme Court is listed in The Parliament of India. So who can increase? So presently what is the strength of the Supreme Court? 33 plus 1 Chief Justice of India. But who can increase it in the future? The Parliament can make an ordinary law, and by that law they can increase it. Which of the following are included in the original jurisdiction of the Supreme Court? 1. The dispute between the government of India and one or more states. Yes, yes, it is there. The dispute regarding election to either houses of the Parliament or the state legislature of a state. The dispute regarding the elections to the houses of the Parliament or that of the state legislature. Where this matter will go? It will go to the High Court concerned. So the High Court will have original jurisdiction in this regard, not the Supreme Court. A dispute between Government of India and Union Territory? No. A dispute between 2 or more states? Yes. So what is the answer? 1 and 4 only. Consider the following statement. Statement 1. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. Can High Court declare the central law to be invalid? Now try to understand the kind of judiciary in India is what is called as an integrated judiciary. We do not have a separate judiciary to look into the central laws. So therefore the district court can also look into central laws, the High Court can also look into central laws, the Supreme Court can also look into the central laws. Okay, so normally this matter can be taken up by the High Courts, because High Courts may have original jurisdiction in this particular regard. So the High Court shall have the jurisdiction to declare a central law to be constitutionally invalid. Yes, they have the power to declare it invalid. But the problem is, if a High Court is declaring a particular judgment, it may not have application throughout the territory of India. So where it may have applications? Only in that particular state. So if a High Court is declaring a central law to be invalid, the law might be applied differently in different states. So in that particular case, who is a party to this? If a central law is declared to be invalid, the central government is a party to this. So therefore immediately the central government will move an application to the Supreme Court, and then the Supreme Court will decide the final verdict, or provide the final verdict. But can the High Court declare a central law to be invalid? Of course they can. So that is definitely true. So no High Court, so then it is wrong. Okay, so no High Court shall have the power, so it is wrong. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Then who will call them into question? It is only the Supreme Court of India. Okay, so this is also wrong. So which of the statements given above are correct? It is neither 1 nor 2. But what is the ground on which the Supreme Court can declare a constitutional amendment to be invalid? On the grounds of violation of the basic structure of the Constitution, not merely on the grounds of the fundamental right, but on the grounds of violation of the basic structure. With reference to the Indian judiciary, consider the following statements. A retired judge of a Supreme Court of India can be called back to sit and to act as a Supreme Court judge by the Chief Justice of India with a prior, this I think we have seen it. Okay, so any retired judge of a Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with a prior permission of the President of India. Yes, but also with the consent of the concerned judge. So then it becomes correct. Can High Court judge, retired High Court judge can also be called? Yes, a retired High Court judge can also be called, provided he is eligible to be appointed as a judge of a Supreme Court with his consent and the consent of the President. A High Court in India has a power to review its own judgment, as the Supreme Court does. Does the Supreme Court in India have the power to review their own judgment? Students get confused between the concept of judicial review and review powers. Judicial review means it is a power of the courts to look into the action of other two organs. Review powers of the courts means to review its own judgment. Does the Supreme Court has the review powers under the Constitution? Yes, the Supreme Court has got review powers under the Constitution under Article 137 of the Constitution. So it is not only having the review powers, on top of the review powers, they also have what is called as curative powers. So these two things are directly given in the Constitution. In fact, review is directly given, but the Supreme Court of India said that they also have what is called as curative powers. But what about the high courts? Do the high courts have the power to review their own decisions? Yes or no? Is it given in the constitution? It is not directly given in the constitution, because most of the powers of the high courts are derived from the ordinary laws made by the parliament and the laws made by the state legislature. Accordingly, the civil procedure code does give the review powers to the high courts. The high courts do have the power to review their own judgment. So that is definitely there. But it is not there in the constitution. If it is saying constitution, that is wrong. But here it is not saying as per the constitution. They are merely asking that whether this particular statement is right or wrong. So what is the answer here? Which of the statements given above are correct? Both 1 and 2. $298. Okay, what is the doubt? Which one? A dispute between Government of India and Union Territory. Yes, it is not a federal dispute. No, it is only the federal dispute is under the original jurisdiction. So if it is not a federal dispute, then it will not go to the Supreme Court. Only the federal dispute falls under the original jurisdiction. So here the question is asking which of the following are included in the original jurisdiction. To be part of the original jurisdiction, it should be a federal dispute. So therefore, where this dispute will go? If there is a dispute between Government of India and the Union Territory of Delhi, it will go to the High Court of Delhi. So there they can challenge it, and further appeal will lie in the Supreme Court because it is not a federal dispute. Clear? If suppose there is a dispute between, let us assume, Union Territory of Delhi and Haryana, so there in this case the dispute will go where? It will go to the Supreme Court because it is a federal dispute. Okay, this question just try to solve this. This is a UPSC question. I will just take the class for another 7 minutes. Okay, so I will try to cover 5 questions because then I can tomorrow complete up to 400 questions. Okay, so consider the following statements. The motion to impeach a judge of a Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per the Judges Enquiry Act. It is again subject to the discretionary power of the presiding officers. So not just the Speaker, if they want to introduce in the Rajya Sabha, the Rajya Sabha chairman can also reject it. So here it is saying cannot be rejected, so therefore it is wrong. The Constitution of India defines and gives details of what constitutes incapacity and misbehavior. No. The details and the process of impeachment of the judges of the Supreme Court of India are given in the Judges Enquiry Act. Is it true? Yes, it is given in the Judges Enquiry Act. So this is true. If the motion for the impeachment of a judge is to be taken up for voting, the law requires a motion to be backed by each House of Parliament and supported by a majority of a total membership of the House and not less than 2/3 of the members present and voting in the House. Is it true? Yes. This is the majority with which it has to be passed. So what is the answer in this case? 3 and 4 only. With reference to the Constitution of India, consider the following statements. Statement 1. The government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from the recognition of advocates. Who shall be recognized as a practicing advocate or who is recognized as an advocate in our country is based on Advocates Act. Now, as per the Advocates Act, only an individual can be recognized as an advocate, not a firm. So a firm can have a number of lawyers, but the firm itself cannot be recognized as an advocate. So therefore, this area makes this particular statement wrong. The Bar Council of India has a power to lay down the rules relating to the legal education and the recognition of law colleges. What is the status of the Bar Council of India? It is a statutory body established by the Advocates Act, and it is a Bar Council of India which will give recognition with regard to the colleges, and also it will determine the curriculum for the law degree and all those things. So this is definitely true. So what is the answer here? The answer is option B, 2 only. The Bar Council of India has recently made some rules The Bar Council of India can make rules under the Advocates Act. Now recently they have made rules allowing even the foreign advocates to come and practice in India. So they wanted to establish foreign law firms in our country, and they wanted to liberalize the profession of law in our country. So therefore this has been done. So I have framed one question that is related to current affairs, which will come at a little later stage. Consider the following statements pursuant to the report of H.N. Sanyal Committee. H.N. Sanyal at that point of time, before 1971, was the Solicitor General of India. So pursuant to the report of H.N. Sanyal Committee, the Contempt of Court Act 1971 was passed. Is it factually true? This is factually true. You cannot do anything about it if they ask such things. It is factually true. I also do not know who such this H.N. Sanyal, but I have to search, then find out the answer. So therefore, these are all the questions that we should not be concerned about. So this is true, but there are certain areas you should be aware of in this case. The Constitution of India empowers the Supreme Court and the High Court to punish for the contempt of themselves. Is it true? Yes, of course, they can punish for the contempt. These two courts are considered to be court of contempt, or they are court of records. Now, which article gives this contempt power to the Supreme Court? Article 129 of the Constitution. Which article gives the High Court the contempt powers? Article 215 of the Constitution. So both the courts can punish for their contempt. So this is definitely true. This you should be aware of. The Constitution of India defines civil and criminal contempt. The Constitution of India only gives a contempt power. It nowhere defines as to what is contempt, and therefore it does not define what is civil and criminal contempt. So all these things are given only as per the Contempt of Court Act. It is a Contempt of Court Act which classifies contempt into civil and criminal contempt. In India, the Parliament is vested with the powers to make laws on contempt of court. Is it true? Because contempt of court is an item in the union list. So therefore, who will have the power to do this? Only the Parliament will have the power to do this. So therefore, what is the answer here? What is the answer? Answer is B. 3 is wrong, remaining are right. Okay, so the answer is option B. Consider the following statements. The term misbehavior and incapacity is well defined in the Constitution, which is a ground for removal of the judges of the Supreme Court and High Court. Partially true, partially wrong. So therefore, the statement is wrong. The Parliament is authority to remove the judges of the Supreme Court. Who is authority? The President of India, not the Parliament. Okay, sorry. As per the Constitution, every state in India should have a High Court of its own. The Constitution is saying that every state shall have a High Court. It is not saying that every state shall have a High Court of its own. That means every state should come under the jurisdiction of a particular High Court, not necessarily a separate High Court for itself. So therefore, this particular statement is also wrong. So what is the answer here? Which of the statements given above are incorrect? What is the answer? 3 only. Come to the next question. Consider the following statements. The number of judges in case of the High Court is determined by an act of Parliament. Is a Parliament will determine the number of judges? In case of Supreme Court, it is determined by the Parliament. In case of High Court, it is determined by a presidential order. So these are all the areas you should be very clear. So sometimes we are carried away. We see that whatever is for the union, we consider to the state. Whatever for the Supreme Court, we consider to be the High Court. No. So here it is only done by the President of India. The President can pass an order, and through that order they will determine the number of judges. The additional judges in case of High Court may be appointed by the Chief Justice of the concerned High Court in consultation with the President. Now try to remember this as a principle. In case of ad hoc judges, and when somebody is called upon, the retired judges to called upon to attend the proceedings in the Supreme Court, in both the cases it is done by the Chief Justice of India in consultation with the President and the concerned judge. But in case of the Constitution, when it comes to the appointment of the acting judges or the ad hoc judges or the temporary judges, here as it is said, or additional judges or the acting judges in case of the High Court, it is always done by the President of India. So, who will appoint the additional judge and the acting judges in the High Court? It is the President, and anybody who is appointed as such a judge shall not hold on to the office for more than 62 years. So, these two things you try to remember. So, therefore, the additional judge in case of High Court may be appointed by the Chief Justice of the concerned High Court in consultation. The President is wrong. So, who appoints the judges? It is a President who will appoint these judges. So, that is wrong. The High Courts have original jurisdiction on all civil and criminal matters. Is it true? The High Court does not have original jurisdiction in case of criminal matters. The High Courts have no original jurisdiction with regard to criminal matters. All the criminal matters shall go where? Only to the subordinate judiciary. But after the punishment is given, then they can come to the High Court for a way of an appeal. So, therefore, no original jurisdiction when it comes to what is called as criminal matters. But yes, there can be some original jurisdiction in case of civil matters. That depends upon the law that is made by the Parliament. Definitely no original jurisdiction in criminal matters. So, therefore, this statement is wrong. So, what is the answer here? Which of the statements given above are incorrect? So, it is 3 only. But before I proceed to that, I just want to make a correction in the previous thing. Please come to question number 300, the previous question that you have discussed yesterday. I think I just failed to look into a particular point. I think overlooked this area. Have you all come to question number 300? Okay. Online students, can you hear me? Okay. So, please come to question number 300. With reference to the Indian judiciary, consider the following statements. A retired judge of a Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with the prior permission of the President of India. That is true. There is no problem in that. Come to statement number 2. A High Court in India has a power to review its own judgment. Well, if this is a statement, the statement is right. A High Court has a power to review its own judgment. Because although the High Court does not have the power under the Constitution, but there are various laws that is enacted by the Parliament give this power. So, therefore, the High Court does not have any power to review its own judgment as per the Constitution, but through the ordinary laws. But the statement is saying a High Court in India has a power to review its own judgment as the Supreme Court does. The Supreme Court has a power to review its own judgment, but for the Supreme Court, the power is coming from the Constitution of India. So, when you say as the Supreme Court does, because the Supreme Court is getting the power from the Constitution, but that is not the case with the High Courts. So, therefore, the statement B should be wrong. Okay. Article 137 of the Constitution. In the last class, I have discussed that. Were you there in the last class? Okay. So, last class I have discussed that. Under Article 137, they have the review powers. Not only the review powers, we have also seen that the Supreme Court has got the curative powers. But although the curative powers are not explicitly mentioned in the Constitution, only the review powers are explicitly mentioned in the Constitution. Alright, so please make a note of that correction. Online students, I am sure that you also make a note of that particular thing. So, in general, if a question comes, does the High Court has got the review powers? Yes, but not as the Supreme Court does. But if a question comes as the High Court has the review powers under the Constitution, then it is no. Is that clear? Okay. Sometimes it is better to make mistakes so that we remember that. So, if you make it correct also, sometimes you again go and make a mistake. So, making a mistake so that we will remember it, so that we are not going to make a mistake. Alright, so please come to the question number 306. Okay, consider the following statements. The High Courts can issue writs for the protection of both fundamental rights and legal rights. Yes, under Article 226 of the Constitution, the High Court has the power to issue, it's right. The High Court has the power to issue writs for the protection of both fundamental rights and the legal rights. But have anyone thought why the High Court is given wider writ powers than the Supreme Court? In terms of the matters on which they can issue the writs. The Supreme Court is the highest court in India, but it has a power to issue writs only in case of what? Fundamental rights. Now, does it not look contrary? Well, the Supreme Court is the highest court, but its writ powers are less. Because the Supreme Court cannot be burdened with ordinary legal rights. So, it is the highest court which will look only into the important right, that is the fundamental right. Okay. The Supreme Court can be empowered by a law of Parliament to issue writs for the protection of legal rights. Is it possible? Yes. Under Article 139 of the Constitution,
the Parliament is empowered by the Constitution. But no such law has been made by the Parliament till this point of time. But however, if in the future the Parliament wants to make a law, empower the Supreme Court to issue writs for the protection of the legal rights also, it can be done. But till this point of time, there is no such law. The judges of subordinate judiciary are appointed by the governor of the concerned state. Is it true? The judges of the subordinate judiciary are appointed by the governor. For the students who are coming late, I have made a correction in question number 300. Okay. So you can just check with the others, or if time permits, I will again discuss it in the end. So what is the answer here? Which of the statements are incorrect? So none is the answer. Please come to question number 307. Consider the following statements. The number of judges in case of the Supreme Court is determined by an act of Parliament. Is that true? So who is authority to determine the number of judges of the Supreme Court? The Parliament. And it can be subsequently increased by a simple act of Parliament. The judges of the High Court may request to attend. A judge of a High Court may be requested to attend the sitting of a Supreme Court as an ad hoc judge by the Chief Justice of India with a prior consent of the Chief Justice of the concerned High Court. What about this particular statement? With the prior consent of the President of India. Okay, so therefore this particular statement is wrong. President? No, it is only in case of the retired judges the consent of both is required. So here you cannot call upon a judge of a High Court, a sitting judge of High Court, his consent is not required because he is still in the service. If a retired judge is called upon, then only the consent of the President and the consent of the retired judge is also required, not in this particular case. The Supreme Court has got original jurisdiction in all civil and criminal matters. Is it true? In fact, they have no original jurisdiction in criminal matters, so this is not possible. And in certain civil cases, they may have original jurisdiction, not in all the civil cases. So anyways, this particular statement is wrong. So how many of the statements given above are incorrect? 2 only. Did we discuss this question earlier? Okay, maybe it. Which way? Okay, Supreme Court. Okay, Supreme Court has got original jurisdiction. So Supreme Court also does not have original jurisdiction. It is same for the High Court also. The Supreme Court also does not have original jurisdiction in any of the civil as well as in the criminal cases. So anyways, this particular statement is wrong. So what is the answer here? Which of the statements given above are incorrect? Incorrect, 2 only. A judge of High Court may be requested to attend the sitting of a Supreme Court. That means here a judge of High Court means a sitting judge of High Court. Can he be requested to by the Supreme Court? Yes, he can be requested by the Chief Justice of India, but with the consent of whom? With the consent of the President of India, not by the Chief Justice of the concerned High Court. Consultation is different, consent is different. Permission is what is consent. Okay, so therefore the consent is always from whom? From the President of India in this particular case. Okay, so come to the next question. Who shall determine the salaries and allowances of the judges of the Supreme Court? What is the answer? It is the Parliament who shall determine the salaries and allowances of the judges of the Supreme Court. Who is authority to empower the Supreme Court of India to issue writs for the protection of legal rights? The Parliament. We have already seen this under Article 309 of the Constitution. Who shall make rules for regulating the general practice and procedure of the Supreme Court? What is the answer here? Can anyone tell me? Is it the Supreme Court, the Chief Justice of India, the President of India, the Parliament? What is the answer? It is the Supreme Court. It is not the Chief Justice of India. Article 145 of the Constitution is giving the power to the Supreme Court, not to the Chief Justice of India. Okay, is that clear? So therefore, the Supreme Court has got a Supreme Court committee for this particular matter, which is headed by the Chief Justice of India and the other judges. But the authority is only with the Supreme Court of India, and that is exercised by a committee on behalf of the Supreme Court. So as per the Constitution, the right answer is the Supreme Court. And which article says this? Article 145 of the Constitution. How many of you got this right? How many of you thought it is Chief Justice of India? It is the Supreme Court.
Which article confers a contempt powers upon the High Court? Article 215, and for the Supreme Court it is Article 129 of the Constitution. Try to remember certain articles. So in this case it is Article 215, but is the term contempt defined in the Constitution? No, it is only the Parliament which has made a law and defined contempt. And in fact, the Contempt of Court Act, which was enacted by the Parliament, classifies contempt into civil as well as criminal contempt. Alright, so contempt is an item in the union list, so therefore who will have the power to make law? Only the Parliament will have the power to make laws in this regard. So this is a very important area. Who is authority to transfer the judges of the High Court as per the Constitution of India? Who is authority? President, but on the recommendation of the Collegium. And who constitutes the Collegium here? Chief Justice of India plus 4 senior most judges, but you should be aware of the procedure also, because recently a judge from the Delhi High Court is transferred to the Uttar Pradesh High Court. Now what is the procedure to transfer a judge of High Court? The recommendation is given by the Collegium, where the Collegium consists of Chief Justice of India plus 4 senior most judges. But however, before this Collegium gives a recommendation to the President, the Collegium in turn has to make an internal consultation. So whom they have to consult? They have to consult the Chief Justice of the concerned High Courts. Okay, so whoever is the Chief Justice of the concerned High Court, they may be consulted, and after getting a written recommendation from them, then only they can give the report to the President of India. Then only the Collegium can make the recommendation to the President. So therefore, in this case, whose authority as per the question? It is the President. Consider the following statements. Statement 1, the High Courts have the power to issue writs for the protection of, the High Courts have the power to issue writs for the protection of both fundamental rights and legal rights, whereas the Supreme Court can issue writs only for the protection of fundamental rights. What are the relevant articles in this question? Article 226 and Article 32 of the Constitution. So these are the relevant articles. The High Courts shall have the power of superintendence over all the courts and tribunals throughout the territory of India, which it has jurisdiction without any exception. That means if a High Court is having jurisdiction over the territory of the entire state, that means will it have the power of superintendence over all the tribunals and all the courts, which is the power of the High Court under Article 227. Is it correct or wrong? So what is the key word in this particular statement? Without any exception, making it as an extreme statement. And what is the general rule when it is an extreme statement? Mostly it is wrong, but it can be right also. So whether here it is right or wrong, that's the question. Without any exception. So does the High Court have power of superintendence over all the courts, all the tribunals within the territory of that particular, wherever it is having a jurisdiction? So for example, if it is a Madras High Court, it will be the state of Tamil Nadu and the Puducherry, because both the areas it has got jurisdiction. So can this statement be seen as true? The High Court does not have jurisdiction over the Armed Forces Tribunal. If an Armed Forces Tribunal is there within its jurisdiction, there it does not exercise any power of superintendence. Therefore, an extreme statement here is wrong, because there is an exception to this. Okay, so in general, if they ask, will it have jurisdiction? Yes. But if it is asking without any exception, then that is not right. Is it clear to all of you? What is the answer here? Which of the statements given above are incorrect? So it is option 2 only. Consider the following statements. The salary, allowances and the pensions payable in respect of officers and servants of the High Court are charged upon the consolidated fund of the state. Is it true? Why? It is not for the judges, it is for the officers and servants of the High Court. So judges are different, officers and servants are different. It is only for the judges of the High Court, their pensions are charged upon the consolidated fund of India. But in case of officers and servants, their salaries, their allowances, their pensions, everything is charged upon the consolidated fund of the respective state. So this is exactly, I thought the student will make a mistake, so you have made a mistake. So officers and servants are different, the judges are different. Is it clear to all of you? So in this case, is it true or false? Yes, so this particular statement is true. The Parliament by a law can extend the jurisdiction of a High Court to any union territory. Is it possible? Now these are all few important things that you have to remember. Who has authority to extend the jurisdiction of the High Court to any of the other
places to any of the other state or union territory, it is a parliament. Who has authority to establish a high court of its own for any union territory? It is a parliament. Okay, so it is a parliament which has got that authority for all these things. So this is also true. Which of the statements given above are correct? What is the answer? It is both 1 and 2. Who has the power to establish a common high court for 2 or more states? Parliament. Who has authority to establish a high court for a particular union territory? Parliament. Who has authority to extend the jurisdiction of a high court to an other union territory? Parliament. Okay. So with that we are done with judiciary also. Judiciary you can expect 1 question. At the max probably 2 questions. Nothing more than this has been asked. So now we are completely covered almost 10 to 12 questions. So now we will move to the next part, that is center state relationship. Again 1 question is the possibility. Okay, so quickly come to the center state relationship. 1 question is a possibility here. Consider the following statements. The Rajya Sabha alone has a power to declare that it would be in national interest for the parliament to legislate with respect to the matters in the state list. Is it true? Who alone has the power to do this? Only the Rajya Sabha. The Rajya Sabha alone has a power to declare. It is not having the power to make law. The law has to be made by the parliament, but on the basis of a resolution that is passed by Rajya Sabha. So which article is giving this power to the Rajya Sabha? Very good. Article 249 of the Constitution is giving this power to the Rajya Sabha. And what is the majority with which the resolution has to be passed by Rajya Sabha? What is the majority? But there are different types of special majority. So what is a special majority in this case? The special majority is not less than 2/3 of what? Present and voting. So whenever a resolution is passed by Rajya Sabha under Article 249 of the Constitution, how long do you think that this resolution will be in force? This resolution will be in force for 1 year, and within this period of 1 year the law has to be enacted. The law cannot be enacted after this. So within this time the law has to be enacted. Is that clear? And if the law is enacted within this 1 year time, how long the law can continue? Or in other words, if the Rajya Sabha passes a resolution and if a law is made by the parliament by virtue of Article 249, is this law a permanent law or a temporary law? This law is only a temporary law. Very good. This law is only what? It's a temporary law. So my question is, how long this law can continue if it is only a temporary law? This law can continue to exist only for a period of 6 months after the 1 year time is over. Is that clear? Come to the statement number 2. The resolution approving the proclamation of emergency are passed by the Lok Sabha. The resolution approving the proclamation of emergency are passed by the Lok Sabha is okay, but the question is passed only by Lok Sabha. It has to be passed only by Lok Sabha. In fact, any type of emergency, it has to be approved by both the houses of the parliament, not just only by the Lok Sabha. So therefore this is wrong. So which of the statements given above are correct? 1 only. Consider the, come to the next question at 317. Which one of the following articles of the Constitution of India says that the executive power of every state shall be so exercised as to not to impede or prejudice the exercise of the executive power of the union? That means it is saying that the executive power of the state should not be in any way obstructing the executive power of the union. So that is what is this particular question. So which article is giving this condition in the Constitution? Article 257, not Article 256. Article 256 is only saying that the executive power of the state has to be carried in accordance with the law that is made by the parliament. It is not saying that it should not impede the executive powers of the union. Article 256 is saying, however the executive power is carried out, it should be in accordance with the law. But Article 257 is specifically saying that the executive power of the union should not prejudice the executive power of the state should not prejudice the executive power of the union. Okay, so this is under Article 257 of the Constitution. So what is the answer here? What about Article 355? This is also again an important article. It is the responsibility of the center to protect the state from internal disturbance and also external aggression. What about Article 356? President rule. What is Article 258?
Union can confer certain powers upon the states, but the state cannot do so. The union can confer some of its powers and the state can request the union also. Okay. So these are all some of the important provisions probably you'll have to remember. So please come to the next thing. Which one of the following articles of the Indian Constitution provides that it shall be the duty of the union to protect the state against external aggression or internal disturbance? Which article? Article 355. Very good. What about Article 215 in the Constitution? Contempt powers of the high courts. What about Article 275? The statutory grants that can be given by the center to the states on the recommendation of the Finance Commission. That is there under Article 275. What about Article 325 of the Constitution? Okay, so do you want me to repeat any area? Article 215 is related to the contempt powers. Article 275 is related to the statutory grants, granting aids that is provided by the center to the states. And the statutory grant is given by the center to the state on the recommendation of the Finance Commission. What about Article 325? That no one shall be discriminated when it comes to right to vote on the grounds of religion, race, caste, sex. So in fact, Article 325 talks about no discrimination when it comes to right to voting. Article 355 is the internal disturbance. So try to remember some of these articles also. Not many questions may come here, but you never know. Sometimes they can ask because each and every single question can make a lot of difference. So that is why if I want to go easily, I can just say the answer and go, but I am giving an explanation so that it will also be a revision for all of you. The Parliament can make any law for whole or any part of India for implementing international treaties. Is it true? Yes. So in this case, can the Parliament do without the approval of the state, without the consent of the state legislature? Yes. So this is a power that is given to the Parliament, but such powers are not there to the state legislature. That is why we say that the entire Constitution of India is quasi-federal, or there is a federal supremacy under the Constitution of India. But which article is giving this power to the Parliament? Article 253 of the Constitution. So here it can be done without the consent of any state. So Article 253 of the Constitution is giving this power. Okay, now tell me, if a law is made by the Parliament to give effect to any international treaties without the consent of the state, will this law be a permanent law? Yes, it is a permanent law. This law is a permanent law. Okay, one of the questions from the online student is, what is the curative powers of the Supreme Court? We have studied about what is the review power of the Supreme Court. What is the review power of the Supreme Court? To review their own judgment. If there is any error in the judgment, they can review it. So what is the curative power? There is no difference between review powers and curative powers. There is an extra option available on top of the review powers. You cannot directly go for a curative petition. On top of the review petition, still if you feel that the justice is not done, on top of the review petition, the affected individual can again file a curative petition. It is merely a procedural difference. You do not have to worry about the procedural difference. So because the Supreme Court can make rules with regard to how the petition shall be filed in the Supreme Court. So who has the power to regulate the rules with regard to how these things can be done? The Supreme Court itself. Just now we have seen. So the Supreme Court has already made a rule. On top of the review petitions, you can file what is a curative petition. But whenever a curative petition is filed to the Supreme Court, it has to be countersigned by a senior advocate, whoever is designated as a senior advocate. In other type of cases, petitions, it is not required. But when you go for a curative petition, because it is the highest level of petition, that is the last remedy that you have got in the Supreme Court. Therefore, it has to be countersigned by a senior advocate. So who will designate someone as a senior advocate in the Supreme Court? Who will? The Bar Council of India has no authority in this regard. Because if the Bar Council of India is to do, then there is a clear conflict of interest. Because the Bar Council of India is of lawyers. The lawyers themselves cannot designate someone as a senior advocate. So who is supposed to designate someone as a senior advocate? It is the Supreme Court of India who will designate the senior advocates of the Supreme Court. And the high courts of the states, they can designate the senior advocates practicing in the high courts. There is no hard and fast rule, but it is based on the standing of that particular council and how he is effective and how he is able to influence the judges. So based on the respect that he commands from the judges, the court will honor them as what is called as a senior advocate.
Okay, so without, okay, come to the next question. Consider the following statements. The federal disputes between the states directly fall under the original jurisdiction of the Supreme Court. Is it clear? Under which article they fall under the original jurisdiction? Article 131. What about a dispute between an union territory and a state? What about dispute between union and a union territory? What about the interstate river water disputes? Okay, it shall go only to the tribunal. The idea of having a body like an interstate council is to take up such matters and to resolve the differences without going to the courts. Is it true? First of all, you should know, it should not confuse us with interstate river water dispute. It is interstate council, and the interstate council can be established under which article in the constitution? Very good, article 263 of the constitution. Who will head the interstate council? The prime minister himself. If it is appointed, the president can appoint an interstate council, and the prime minister himself will head the he is the chairman of the interstate council. The interstate council is in fact the highest executive body in the country, but it is not properly functional. But if at all the interstate council is established, the chairperson will be the prime minister himself, along with 6 union cabinet ministers decided by the prime minister. And then apart from that, it will have chief ministers of all the states in our country. And apart from that, it will have chief ministers of all the union territories wherever there is a chief minister. And apart from that, it will have the administrators or the lieutenant governors of all other union territories. That means all the top executives will be part of the interstate council. So what is the objective of having such a body is to resolve the differences of opinion between the center and the states or between different states, especially where there is a federal dispute. So therefore, to that extent, this particular statement is true. Come to the next thing, the zonal councils are statutory bodies established under the State Reorganization Act. Is it true? That is true. So under the State Reorganization Act, how many zonal councils are there? 5 zonal councils are there. We have a northern zone, central zone, we have a southern zone, eastern zone, western zone. Apart from that, we also have what is called as a northeastern council zone or a northeastern zone, but that is not established under the State Reorganization Act. It is established by Northeastern Councils Act. Okay, so therefore try to understand that. But however, this particular statement is true. It is established by a statutory body. It's a statutory body established by a statute. Here also the objective is the same. The objective is to resolve the differences at a zonal level, not at the all India level. But here who will head all the zonal councils? The Union Home Minister will head all the zonal councils, and the chief ministers of all the states will be part of it. Is that clear? So this is what we'll have to understand about this. So what is the answer here? Which of the following are correct? All of them. Consider the following regarding the interstate river water disputes in our country. The interstate river water disputes can be challenged only in the river water tribunals that is established under the Act of Parliament. Is it true? So which article is providing for this particular provision? Very good. Article 262 of the Constitution is saying that in case of interstate river water disputes, they cannot go to the Supreme Court, although it is a federal dispute. Where they can go? They can go only in front of an authority as established by a parliamentary law. And the parliamentary law, what is a parliamentary law? Interstate River Water Disputes Act 1956, and based on which an ad hoc tribunal can be created whenever there is an interstate river water dispute. So therefore, this particular statement is true. The order passed by the tribunal is final and binding and cannot be challenged in the Supreme Court under any of its jurisdiction. So in fact, the law says the order that is passed by the tribunal is final and binding. But if the question is coming that it cannot be challenged in the Supreme Court under any of the jurisdiction, is it right? So can it be challenged in the Supreme Court under the appellate jurisdiction? What is appellate jurisdiction? Appellate jurisdiction is normally you are making an appeal from a lower court to a higher court. So tribunal is a lower court or an upper court to the Supreme Court. Tribunal is a lower court. So can we make an appeal against order of the tribunal? How many of you think that you can make an appeal? You can go to the Supreme Court, but not under the appellate jurisdiction. You can only go to the Supreme Court under the special leave jurisdiction under Article 136 of the Constitution, because the law explicitly prohibits the Supreme Court from entertaining these cases.
But however, whatever is the law says is overruled by the constitutional provisions. And what is Article 136 of the Constitution is saying, which is talking about the special leave jurisdiction of the Supreme Court, which is also called as SLP petitions. If you look into the SLP petitions or Article 136 of the Constitution, Article 136 of the Constitution says that even if an individual cannot go to the Supreme Court under any of the jurisdiction, still nothing prevents the Supreme Court from entertaining a particular case, from granting a leave to a particular case. That means accepting a particular case. So therefore, that is why it is called as an extraordinary jurisdiction of the Supreme Court. That means who will decide whether to accept the case or not? It is the Supreme Court. Nothing can prevent the Supreme Court from entertaining any case under the special leave jurisdiction. But who is the final authority to decide that? The Supreme Court of India itself. That is why even the Supreme Court has said that this power has to be used very sparingly by the Supreme Court, because it is an extraordinary jurisdiction. Now with that, come to the question. The order passed by the tribunal is final and can't be challenged in the Supreme Court under any of its jurisdiction. Is it true? False. But if the question is saying it cannot be challenged under the original jurisdiction, is it true? If the question is saying it cannot be challenged in the appellate jurisdiction, that is also true. But to say under any of the jurisdiction is a wrong thing. Okay. So what is the answer here? Which of the following statements given above are incorrect? It is 2 only. The Parliament of India acquires the power to legislate on any item in the state list. Under which article? So what is the answer? Okay, the Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution is passed to that particular effect by what is the answer? By Rajya Sabha by not less than 2/3 of the members present and voting. Article is 249. Which one of the following is not a feature of Indian federalism? So which one of the following is not a feature of Indian federalism? An independent judiciary, is it a feature of Indian federalism? In fact, it is must to ensure what is called as federalism. So this is definitely there. Powers have been divided clearly between the center and the states. Has the powers been clearly divided? Is it divided? Then why we are calling it as quasi-federalism if the power is clearly divided? Quasi-federalism does not mean that the power is not clearly divided. It only means that more power has been given to the center. But whatever power that is given, that is clear between what is the power of the center and the states. A federating units have been given unequal representation in the Rajya Sabha. Is that true? Yes, the representation in the Rajya Sabha is based on population rather than equal representation. So this is also part of our federalism. It is a result of agreement among the federating units. It is not a result of any agreement among the states, but it is only a holding together federation rather than what is called as a coming together federation. Okay. So therefore, what is the answer here? It is option D. Consider the following statements. Under the Constitution, the center can give directions to the state to ensure compliance with the law made by the Parliament. Is it true? Under which article they can give directions? Under Article 256. With regard to a law, they should ensure compliance, and if there is no compliance with regard to a law that is made by the Parliament, when it comes to the state executives, so the direction can be given under Article 256. So therefore, is it right for any state to say that they will not implement the Citizenship Amendment Act 2019? So Citizenship Amendment Act is passed by the Parliament, and some of the states protested that, saying that they will not implement this law. I am not getting into the merit of the law. Okay, let us not have a debate on the merit of the law. That is for the Supreme Court to decide. But some of the states said that they are not going to implement the Citizenship Amendment Act 2019. So is it constitutionally right for the states to say? Because the executive power of the state has to be exercised in accordance or in order to ensure compliance with the law made by the Parliament. And in case if they are not showing compliance, then the center can give directions. Okay, you are not showing the compliance, so give the compliance. All these things can be done under Article 256. Okay, once a direction is given under Article 256, still if there is no compliance, then Article 365 will come into effect. What is Article 365? Then the president can come to a conclusion that the administration of the state is not carried out in accordance with the provisions of the constitution, that is as a constitutional breakdown. And if the constitutional breakdown is the situation, then Article 356 kicks in. What is Article 356? That the president rule can be imposed in a particular state. Therefore, under which article the president rule can be imposed in a particular state? Under which article the president rule can be imposed? 256, 365, 356. Under how many articles the president rule can be imposed? Under which article? Only one article, that is Article 356. Okay, so do not have any confusion in this regard. It is only under Article 356 the president rule can be imposed. So what is the answer in this case? Have we discussed it? Have we discussed this question? Under the constitution, the center can, okay, first statement, it is Article 256. The states must share their revenues with the center as per the constitution, as per the recommendation of the Finance Commission, as per the constitution. Is it true? It is rather vice versa. It is only the center that has to share their revenue with the states, and not the states will share their revenue with the center, as per the recommendation of the Finance Commission. Under which article the Finance Commission is established? Article 280 of the Constitution. So this is wrong. So which of the statements given above are correct? What is correct? One only. Come to the next question. Which of the following special powers have been conferred on the Rajya Sabha by the Constitution of India? Statement 1, to change the existing territory of a state and to change the name of the state. The Rajya Sabha has no power in this regard. It is a power of the Parliament and not that of the Rajya Sabha. Under which article they can do that? Under Article 3 of the Constitution. To pass a resolution empowering the Parliament to make laws in the state list and to create one or more All India service. Is that right? To pass a resolution empowering the Parliament to make laws in the state list and to create one or more All India service. Okay, anyways, let me go to the other statement also. To amend the election procedure of the president and to determine the pensions to the president after his or her retirement. It is a power of again the Parliament, not that of the Rajya Sabha alone. Okay, so what is the last statement? So while A and C are wrong, what is D? To determine the functions of the Election Commission of India and to determine the number of election commissioners. What about this? To determine the number of election commissioners is not even the power of the Parliament. Who will determine the number of election commissioners? The president may determine that from time to time. But to determine the functions of the election commission, that can be determined by the law made by the Parliament, a Representation of People Act. So anyways, this particular statement is also not completely right. So we are left out with what? We are left out with only option B. So here the understanding you should have is based on this particular statement. It is only saying based on the resolution that is passed by Rajya Sabha, the Parliament can make a law. So, but who is empowered to make the resolution? For the Parliament to make a law on an item in the state list and also to create a new All India service, it is the Rajya Sabha. Okay, so under which article the new All India service can be created? Under 312, sure, under Article 312 of the Constitution. So how many All India services we have presently? No All India service. How many All India service? 3 All India services are there. What are the 3 All India services? Indian Administrative Service, Police Service, and Indian Forest or Foreign? Forest Service. Foreign Service is a central service. It is not an All India service. So if at all in the future new All India service is to be created, so who is authority to create a new All India service? It is a Parliament, but based on the resolution that is passed by the Rajya Sabha. But my question is, why do you think that the Rajya Sabha has to pass a resolution to create a new All India service? Because creating new All India service means it is affecting the federal interest. So therefore the states have to give the consent to go for a new All India service. How do you think creating a new All India service will affect the federal interest?
So, so, so therefore, if a question comes, which of the above are the federal features of the constitution? If the All India service comes, is it part of a federal feature? It is not a part of a federal feature. It is more unitary in character. Because All India services, once you will get into All India services, you will realize that though all India service officers serve in the states at the highest position, but the state government has no control over these officers. Who will have control over the All India service officers? The center. So therefore, it goes against the federal interest. Okay. So anyway, so what is the answer in this case? It is option B. So come to the next question. Consider the following statements. Only the parliament can make laws on the items mentioned in the union list. Is it true? It is always only the power of the parliament. So in this case, the extreme statement is right. No other authority will have the power to make laws on the items in the union list, which means, will the state legislature have the power to make law on the union list? No, it is only the power of the parliament. Only the state legislature is empowered to make laws on all the items in the state list under all circumstances. Is it true? It is not under all circumstances. Under certain circumstances, the parliament is empowered to make a law. Parliament is also empowered. So can anyone tell me what are the circumstances under which the parliament is empowered? Article 249, when the Rajya Sabha passes a resolution in national interest. Okay, what is the other article? Okay, when two or more states pass a resolution, when two or more state legislature pass a resolution under Article 252. Anything else? Article 250 is related to what? Article 250 is related to president rule. Article 250 allows a parliament to make a law on an item in the state list when there is a proclamation of national emergency. But national emergency can be proclaimed under Article 352 of the Constitution. So therefore, when a national emergency is proclaimed under Article 352 of the Constitution, then Article 250 comes into effect. So Article 250 empowers a parliament to make a law on an item in the state list. Is that clear? So this is while national emergency is in force. While the national emergency is forced. What are the other articles? Article 253 is to give effect to international treaties. And then the last thing is when there is a president rule in a particular state. When the president rule is imposed in a particular state, we know that the legislative assembly will be dissolved. Once the legislative assembly will be dissolved, who will make law on an item in the state list? The parliament will make law on an item in the state list. So this is during what is called as president rule. Okay, one last question that I wanted to ask. Let me see how many of you are able to answer this correctly. The important thing is, in all these cases, whenever the parliament makes a law on an item in the state list, under what circumstances among all these things, under what conditions, if a law is made by the parliament, it would be considered to be a permanent law. Not in all the cases the law made by the parliament is a permanent law. Under what circumstances it is a permanent law? What about law made under Article 249? It is only a temporary law. So this is temporary. What about law made under Article 252, two or more states? It's a permanent law. Very good. It is a permanent law. What about Article 250 during national emergency? Permanent or temporary? During national emergency, understand it is a temporary law. And how long this law can continue to exist? 6 months after the revocation of the national emergency. That's a maximum time. Okay, 6 months after the revocation of national emergency. Therefore, it is temporary. What about under Article 253? It's a permanent law. It's a permanent law. What about Article 356? Permanent or temporary? It's a permanent law. Okay, so here also it is a permanent law. So, but however, understand in this case, here it is a permanent law under Article 356. In this case, the state legislature is free to amend this law.
So when the new government is formed and when the state legislature comes, they are free to amend this law. But however, in this case, when I talked about 252, so in this case, the state legislature cannot amend this law. It is only the power of the parliament. Okay, so try to understand that. And to, any international treaties also, the state legislature does not have any power. Okay, so try to remember about all those things. The questions can come from any dimensions. Shall I move to the next question? So what is the answer? Have we completed the questions? Okay, one more statement is there. What about this particular statement? So this particular statement is wrong. Come to question number 3. Both the parliament and the state legislature can make a law on an item in the state list. However, in case of conflict, both the parliament and the state legislature, just make a small correction. Okay, I made a mistake here. I think I just overlooked. Both the parliament and the state legislature can make a law on a concurrent list. Let me make it as a concurrent list. Okay, please make a correction. On a concurrent list, both parliament and the state legislature can make a law on an item in the concurrent list. But however, in case of conflict between these laws, the law made by the parliament will prevail in all cases. Yes or no? In all cases is an extreme statement. So therefore, extreme statement is correct or wrong? There is no general rule, but here is it correct or wrong? But 90% of the times you can, going by the UPSC language, not only for the subject polity, for other things also, you can, if you want to attempt this, you go for a something to be negative if you are not aware of it. But in this case, it is right or wrong? It is wrong. It is not in all the cases. Why? What is the exception? Very good. If there is any conflict between the law made by the parliament and the law made by the state legislature, but however, if the bill is assented by the President of India, if the governor has reserved this bill for the consideration of the President and the President gives the assent to this particular bill, then the law made by the state legislature will prevail over the law made by the parliament. Is that clear? So not in all the cases, sorry. So what is the answer here? One only. Which one of the following doctrine is related to resolving the center state disputes? Okay, before saying the answer, what is this doctrine of eclipse? What is this doctrine of eclipse? Article 13 of the Constitution is saying any law, if it is in violation of fundamental rights, that law shall be declared to be invalid. But the question is, what if it is a pre-constitutional law? So in case of a pre-constitutional law, the law will not be struck down from the statute, or any portion of the law which is violative of the fundamental rights will not be struck down, but it will be eclipsed by the fundamental rights. That is what is called as doctrine of eclipse. But however, if it is a post-constitutional law, which doctrine will apply? Doctrine of severability. Doctrine of severability means that portion of the law which is in violation of the fundamental right will be struck down, will be cut from the law. But whereas in case of a pre-constitutional law, it will not be struck down, it will be only eclipsed by the fundamental rights, or in other words, those portion of the law which is in violation of the fundamental rights will remain dormant as long as the fundamental right is there. But in the future, if the fundamental right is amended and therefore there is no conflict between the law and the fundamental right, and the law will automatically come into force. But that is not the case with what is called as a post-constitutional law. Now, why do you think that the doctrine of eclipse is followed in case of a pre-constitutional law, and whereas the doctrine of severability is followed in the post-constitutional law? Because when the pre-constitutional law was made, the fundamental right was not there in the first place. So therefore, who made that law, they were not aware of the fundamental rights in the first place. So therefore, it is not their mistake to make such a law. But whereas in case of a post-constitutional law, it was a first place, it was a mistake to make that law in that way, because it is in violation of the fundamental right. That is why different doctrines apply. So anyways, this is not related to the center state relationship, it is only related to the fundamental laws in violation of the fundamental rights. Rarest of rare doctrine is related to the center state relationship. It has nothing to do with the center state relationship. It is only, this doctrine is applied in awarding what is called as capital punishment by the Supreme Court. This was also in the newspaper for some reasons. So before giving capital punishment to any individual in a case, the Supreme Court has said that the court should be convinced of this particular doctrine, that is rarest of rare doctrine, that is only in the rarest of rare cases the individual should be given the capital punishment by taking into account both the aggravating as well as the mitigating factors. So, what is an aggravating and the mitigating factors? Very quickly, I am not going very deep into this. Aggravating and mitigating factors should be taken into account. So, the rarest of rare doctrine always wanted the judges to look into the facts of that particular case. What are aggravating and mitigating factors? Mitigating factors will help the judge to reduce the punishment. So, for example, his state of mind at that point of time, the threat that was there before he was committing that particular offence, what was the pain that was inflicted by the other party when he committed that particular offence, because out of fear somebody does a murder. So, it is a mitigating factor. Aggravating factors are those factors how he has actually done that particular offence, who was affected because of that particular offence committed against a woman, offence committed against children. So, these are all aggravating factors. Okay, so, we will have to see what is a mitigating and aggravating factor. So, anyways, this is not related to center state relationship. What about doctrine of pith and substance? Yes, doctrine of pith and substance is related very much to what is called as the center state relationship. So, what is this doctrine of pith and substance? It is a doctrine that was innovated by the Supreme Court to resolve any dispute between two legislatures. That is, if the parliament and the state legislature come before the Supreme Court, that one legislative body is trying to encroach the legislative authority of another body, then the Supreme Court will use this particular doctrine to resolve this particular dispute. So, therefore, it is directly related to what is called as center state relationship. So, this is true, but can anyone explain me what is this doctrine of pith and substance? Pith means the essence of this particular law, essence, or what is the objective of this particular law, or what is the objective based on which this particular law is made. And substance means what is the subject matter on which, or what is the item on which the law is made. What is the subject matter or the item on which the law is made? On top of that, the essence is more important. What is the objective for which this particular law is made? So, applying this particular doctrine, the Supreme Court can come to a conclusion whether the law is a valid law or an invalid law. For example, in 1950s, a law was made by state of Bombay to prohibit the sale and consumption of alcohol, and the prohibition of sale and consumption of alcohol was an item in the state list. But the center challenged this particular law because this law also had some impact on the import and export of goods, but import and export is an item in the central list. So, therefore, this law was challenged by the center. So, then the Supreme Court applied the doctrine of pith and substance. So, then first they looked into the subject matter. The subject matter is directly related to whom? It is related to the state. And then they also looked into the objective. The objective of the state to make this particular law is not to create any problem with regard to import and exports, but their objective was only to prohibit the sale and consumption of alcohol. But even then it had an unintentional encroachment upon the powers of the center, that is an incidental encroachment upon the powers of the center. So, by applying this particular doctrine, if the Supreme Court is convinced, if a law is on a particular subject matter and the objective is to only to regulate whatever is the subject matter which is under a particular legislature, but even in this case, if it is an unintentional encroachment upon an item in the other list, still the law would be considered to be a valid law. Okay, so this is basically what is called as doctrine of pith and substance. So, in this case, the law made by the state of Bombay was considered to be valid. Okay. So, what is the answer here? It is 3 only. As per the constitution, 2 or more states can request the parliament to make a law on the state list by passing a resolution in the concerned state legislature by, what is the majority with which they have to pass a resolution? Simple majority. They have to pass a resolution by simple majority. Here it is only simple majority. Is it possible for the other states to adopt this law? And they have to pass a resolution again by a simple majority. So, they do not even have to send it to the parliament. They have to just pass a resolution and they can adopt this law. But once the law is adopted, in the future, the law will apply in those states as well. And who will have the power to amend this law? It is only the power of the parliament henceforth. Which article in the Constitution of India empowers the Parliament to make laws relating to interstate river water disputes? Article 262 of the Constitution. Which of the following is true regarding the granting aids from the centre to the states allowed under Article 275 of the Constitution? Which of the following is true? They are statutory grants. What does it mean by statutory grants? It requires a law based on which it can be done. So, under Article 275 of the Constitution, while the granting aids can be given to the states from the centre, which is apart from whatever is the allocation that is given. So, for example, based on the 15th Finance Commission, how much amount of revenue of the centre should go to the states? 41% of the divisible pool of revenue, not the entire taxation, because certain tax exclusively goes only to the centre. Say for example, cess, surcharge, these are all exclusively only to the centre. But apart from that, there are certain taxes which is collected by the centre comes under the divisible pool. So, in the divisible pool, among the divisible pool, the 15th Finance Commission said 41% revenue shall go to the states, but that is a vertical distribution. Again, this 41% will be horizontally distributed among different states based on the recommendation of the Finance Commission. Now, if you see, apart from this, if the centre wanted to give some granting aids to specific states, not to all the states, they can give. Under which article they can give it? Under Article 275 of the Constitution. But this is only a statutory grant, which means it requires a law before a grant is given to that particular state. And this is also done on the basis of what is called as the recommendation that is given by the Finance Commission. Okay, so whenever the money is given to the states, it has to come from the Consolidated Fund of India. So, when the money is coming from the Consolidated Fund of India, either it has to be a made expenditure or a charge expenditure. So, therefore, the next question is whether the granting aids that is given to the states under Article 275 of the Constitution, is it a made expenditure or a charge expenditure? Made or charged? It is a charged expenditure and not a made expenditure. So, therefore, what is the first statement? The first statement, it is a statutory grant, it is a charge expenditure, it is not a made expenditure. So, what is the answer here? 1 and 2 only. So, what is the difference between a made and a charge expenditure? The AC is, I think, is on the little higher side, no? So, what is the answer? It is 1 and 2 only. Yes, what happened? So, sometimes it happens like that. So, you have to persist for some time before the luck can favor you. So, this happens when we travel also. We go to one toll booth, suddenly we change other place, then that stops. So, it is better to wait for some time before taking a decision. Okay. Okay. Which of the following are the functions of? Okay, come to the next thing. Which of the following are the functions of the GST Council? Now, tell me, what is the position of this GST Council? It is a constitutional body. It is directly established under which article? 279. Very good. 279A of the Constitution. So, just try to remember this Article 279A, and it is having a constitutional status. So, what is this GST Council as far as you know? What is the purpose for which this GST Council is established? Now, today this GST Council is apex body to take all decisions regarding GST in our country. Any dispute arising between the centre and the state, that will also be heard by the GST Council. And the GST Council has representation from both centre as well as the states. Who heads the GST Council? Union Finance Minister. And there is also representation from the states. Either the Finance Minister of the state or his deputy, that is the Minister of State, can represent the states. And they have all the powers to decide with regard to different tax rates for different goods and services in our country. What are the goods and services that may be exempted? So, these are all some of the things that is decided by what is called as GST Council. You try to have a broader idea at least So just come to this particular question. Which of the following are the functions of the GST Council? Determining the tax rates under the goods and services tax. Yes, so they will determine for the various goods and services what shall be the tax rates. Goods and services that are exempted from the GST regime, they are the authority to decide that also. Suggesting measures for periodic reforms relating to the direct tax code. They have nothing to do with the direct taxation because GST is an indirect tax reform. So therefore, they have nothing to do with the direct tax. Okay, so this is definitely wrong. This is not part of their functions. Does any know what constitutes? As per the constitution, the GST council can function only when there is a quorum. Without quorum, the GST council cannot function. Does any know what constitutes quorum in GST council? Not less than half of the members, not less than 3/4 of the members, yes, 3/4 of the members, not less than 1/10 of the members, not less than 1/5 of the members. Okay, so the answer is not less than half of the members. 50% of the members constitute quorum in the GST council. 3/4 is not the right answer. 3/4 is to arrive at any decision. So the number of value of votes that has to support is minimum value should be 3/4. So that is the value that they have to arrive at any decision, of which again 1/3 weightage is given to the center and 2/3 weightage is given to the states. How that is calculated, you don't have to worry, but just remember all these factual information. So what is the answer in this case? It is 1 and 2 only. Come to the next question. Okay, this is part of your current affairs. Very important question. I feel that at any time they can ask you from this area. The term general consent recently reported in the newspaper is related to. So the term general consent is related to what? CBI. How many of you think it is related to CBI? It is related to the CBI. So the CBI today in our country, is it a constitutional body, statutory body, body established by an executive order or an executive body? How many of you think it is an executive body? Anybody who thinks it's a statutory body or a constitutional body? Anybody who thinks it's a statutory body? CBI is not a statutory body, not a constitutional body. The CBI is only an executive body. You will have to see how the body is established. How the body is established? CBI is established only by a resolution that was passed by the Home Ministry. Initially when it was established in 1960s, I think 1963 to be very specific. Now today CBI is under the administrative control of which ministry? Today it is not under the Home Ministry, today it is under the Department of Personnel and Training. It is the Department of Personnel, Pensions and Public Grievances. To be very specific, under the Department of Personnel and Training. So even today it continues to be what is called as an executive body, but this body continued to derive its power from the Delhi Special Police Establishment Act. So do not think it is a statutory body, because if it is a statutory body, it has to be established by a statute. But CBI was not established by a statute, it was established by a resolution passed by the Union Cabinet and kept under Home Ministry initially, today under Department of Personnel and Training. But this body continued to derive its power from the Delhi Special Police Establishment Act, passed in 1946, DPSC, DS, Delhi Special Police Establishment Act, 1946. So if you look into this act, when it was established, the CBI today continued to derive this power from this particular body. So as per this particular act, CBI today can investigate into the cases only within the territory of National Capital Territory of Delhi. But if the CBI is to investigate on any cases outside the National Capital Territory of Delhi, then in that particular case they have to take the consent of the states. But however, to enable the process easier, to make the procedure so easy, it would be very difficult for CBI to take the permission of the states for each and every case which they want to investigate beyond this particular territory. Therefore, there is a provision in Delhi Special Police Establishment Act, which is also called as Section 6 of the Delhi Special Police Establishment Act, which allows the states to give what is called as general consent. If the states give general consent to the CBI, this general consent is usually valid for 6 months. That means for the 6 months, the CBI doesn't have to take a permission case to case basis. So at the end of 6 months, an automatic approval is again given. So therefore, the CBI can go directly and investigate the cases in the other states beyond the National Capital Territory of Delhi. But of late, you can understand that there is a lot of problem that is happening between the center and various states. And various state governments are accusing the center that the CBI is being misused, or it is used as a political tool to corner the opposition parties. So many states have withdrawn the general consent. And recently it was in news because the state of Karnataka has withdrawn the general consent, because the center has used the CBI against the Chief Minister of Karnataka also. We are not sure whether the allegation is true or not, let us not get into that, but anyways, here it is part of your current affairs. So therefore, the state of Karnataka has withdrawn the general consent, and many states, not only state of Karnataka, I think Punjab has withdrawn it, West Bengal has withdrawn it, Tamil Nadu has withdrawn it, Telangana has withdrawn it, now Karnataka has also withdrawn it, some of the northeastern states have also withdrawn it. So this is what is related to the general consent. But however this matter then subsequently, because this is a long standing issue, so the matter was taken by the CBI to the Supreme Court of India also. So the Supreme Court of India has said that while the general consent is required, and if the general consent is not there, if the CBI is to investigate in the territory of the states, then they have to take the permission of the states on a case to case basis. But the states cannot prevent the CBI from investigating cases related to the central government employees, even if it is outside the territory of the Delhi. Central government employees, and if any matter is referred to the Supreme Court by the High Court and the Supreme Court, because as per the Supreme Court directions, High Court can also refer certain matters to the CBI. The Supreme Court also refers certain matter to the CBI. So wherever the matters are referred by the Supreme Court and High Court directly to the CBI to investigate, there even if they have to investigate outside Delhi, there they don't have to take the permission of the states. Is that clear? So these things you please keep it in your mind. So anyways, what is the answer in this particular case? The term general consent recently reported in news is related to what? States approval to the center to allow CBI to investigate in the states without requiring case specific approval. So if the general consent is not there, then also they can investigate, but for every case they have to specifically take the approval. Yes. It's okay. CBI is under the control of whom? Center. So that is why it is center. Okay. CBI is directly under the charge of Department and Personnel and Training, and which is the part of the central government. Suppose if it is a constitutional body, I would not use the word central government, but it is just an executive body which is under the control of the center. So the general consent, normally there is a clause that it is an automatic approval. So normally it is a formality, but the states have to give the approval. Then at any time the states can withdraw it. It is not that definitely they have to give the approval. Okay, so the states have the power to withdraw it. Okay. Okay, come to question number 333. Consider the following statements. The GST Council was established. GST Council was established by the 101st Constitutional Amendment Act 2016. Is it true? Yes. This we have seen. The council has representatives from both union and the state executives. Yes. 1/10 of the members of the GST Council constitutes quorum. It is not 1/10, it is only half. Half of the members of the GST Council. Okay. So constitutes what is called as quorum in the meeting. So what is the answer here? 1 and 2 only. Which of the following amendments transferred significant number of items from the state list to the concurrent list? 42nd Constitutional Amendment Act, which has transferred 5 items from the union list to the, from the state list to the concurrent list. Article 226 of the Constitution of India allows for the establishment of what? Consolidated Fund of India and the states, and it also allows for what is called as the public accounts of India and of these states, and not the contingency fund of India and these states. Contingency fund of India is established under which article? It is not established under Article 267. Article 267 is only giving the power to the Parliament, and then therefore the Parliament can make a law and they can establish it. But yes, you can see the genesis of the contingency fund from Article 267, but not directly under Article 267. So what is the answer here? 1 and 2 only. Alright. So with that we are done with the center state relationship as well. So very important, you can expect one question. Majorly if you see the center state relationship, the questions are revolving around those 5 articles that I discussed most of the times. Article 249, Article 250, Article 252, 53 and Article 356, okay. And sometimes I can ask from this Article 355, 256, 257, so try to cover all these things, okay. So remember all these things. So come to the local bodies, again one question from this particular area. Very simple questions are usually asked from the local bodies, we will try to quickly touch upon that also. Which one of the following authorities make recommendations to the governor of a state as to the principles for determining the taxes and duties which may be appropriated by the panchayat in a particular state? Who will do that? The State Finance Commission. It is a State Finance Commission who will make the recommendation, not any of these things. Okay, the State Finance Commission will make the recommendation. Who appoints the State Finance Commission? Who appoints the chairman and the members of the State Finance Commission? The governor of that particular state. But what about the qualification of the members of the State Finance Commission? Who will decide that? Is it mentioned in the Constitution? What about the composition? Is it mentioned in the Constitution? The composition is not mentioned for the State Finance Commission. And their qualification, is it mentioned in the Constitution? Is not mentioned. If it is not mentioned, then who is going to decide it? Both the composition as well as their qualification are to be determined by the law made by the concerned state legislature. So that is very important. But however, how is it different from the Union Finance Commission? In Union Finance Commission, who appoints the chairman and the members of Union Finance Commission? It is the president who does that. Clear? Okay, president does it. But what about the qualification and the composition of these members? Composition is directly given in the Constitution, but what about the qualification? Qualification is based on the law that is made by the Parliament. Okay, so this is the answer. Come to the next question. If a panchayat is dissolved, the elections has to be held. That is what, within what time the elections has to be held to that panchayat? 6 months. What is the maximum time? It is 6 months. But if the panchayat is prematurely dissolved, let us assume, where the remainder of the time is less than 6 months, in that case there is no need to conduct the panchayat because anyways elections are coming. But if the remainder of the term is more than 6 months, then definitely they have to conduct the election within what is called as 6 months. So the answer is here. And one more question is, what if a panchayat is prematurely dissolved? If the panchayat is prematurely dissolved, the new panchayat that is constituted will be for a full 5-year term, or it is only for the remainder of the term? It is only for the remainder of the term. Is it clear? The 73rd Constitutional Amendment Act refers to. So can you give me the answer for this question? The 73rd Constitutional Amendment Act, it is not related to any generation of employment. So definitely that is not the answer. Generation of employment to able-bodied adults, no. Laying foundation for strong and vibrant Panchayati Raj institutions in the country. Is it true? Okay, can you tell me which of the committees have recommended for the constitutional status? If you see the Lakshmikant book, they are given about some of the committees. They are not very important, Maybe you can just read it once, not more than that. So no question is likely to come from that particular area, except one area they can ask you which of the committees have recommended the constitutional status to Panchayati Raj. So which of the committees have given constitutional status? L.M. Singhvi has given, Ashok Mehta committee has given, Balwant Rai has not given the constitutional status. L.M. Singhvi has given the constitutional status. I think there is one more committee, P.K. Tungan committee. So that has also given the constitutional status. So just go and refer it once, which of the committees has given the constitutional status. But anyways, I don't think UPSC will focus on that, because UPSC is only going to focus on the constitution, not from the other areas, but in case, just to be on the other side. So just to see which of the committees, I think 4 committees there which has given the constitutional status. What is the last committee? No, after Tangan committee there was one more committee, G.V.K. Rao committee. I think G.V.K. Rao committee has also recommended constitutional status. So all these 4 committees have recommended the constitutional status. Okay. So what is the answer? Sorry, the answer is C. Guarantee life and liberty. So this is not related. This is not related. Not related. Which one of the following is not a provision of the 73rd Constitutional Amendment Act in the area of Panchayati Raj? 33% seats to all the elected rural bodies will be reserved for women candidates at all levels. It is there? Yes. It is there at all the levels for the women, including at the Panchayat, including all the levels, okay, but the village level, at the intermediate as well as at the district level. The states will constitute their finance commission to allocate resources to the Panchayat Raj institution. It is also a provision, yes. The Panchayat Raj elected functionaries will be disqualified to hold their offices if they have more than 2 children. This is not there in the constitution. The constitution does not provide for it, okay. Some of the states wanted to bring in such legislation. They should have some education, functional toilet, number of child, but that is not in the constitution of India. The elections will be held in 6 months in time if the Panchayat bodies are suspended or dissolved by the state government. Is it true? Yes. So therefore, what is the answer here? It is C, which is the answer. Come to the next question. What is the system of governance in the Panchayati Raj setup? What is the system right now? Single tier structure of local government at village level, 2 tier system of local governance at the village and block levels, 3 tier structure of self-government at village, block and the district level. Yes. So this is a system that you have got. So before the 73rd Constitutional Amendment Act, the structure was not uniform. And one thing that was done by the 73rd Constitutional Amendment Act is it has brought in uniformity with regard to the structure. Who can be called as the father of local government in India? It was Lord Ripon. So way back, even before India became independent, he has brought in lot of changes, both with regard to Panchayat and municipalities. So most of the system that we follow today, except for uniformity in structure, was already put in place. And who has been very influential in all those things? It was Lord Ripon, especially in the area of municipalities. The right answer is Lord Ripon. Consider the following statements with regard to the Panchayat system in India. Statement 1. Presently, the Panchayat election to all the states has to happen at the same time to ensure uniformity. Is it true? Presently, the Panchayat election to all the states has to happen uniformly. Is it true? Not necessarily. It is not that for all the states it has to happen uniformly. Within a state, it has to happen at the same time. Okay. Because even after the 73rd and 74th Constitutional Amendment Act, there was certain time limit for the states to establish the Panchayat system. It is not done at the same time. Therefore, there is no need to have it uniformly. So that is definitely not the requirement. All state governments should transfer minimum fixed amount of their taxes to the Panchayat as provided in the Constitution. Is it true? giving finances, devolving finances from the states to the panchayat is a prerogative of the states, which will be determined by the law that is passed by the concerned state legislature. One of the major concern is that devolution of finances is a prerogative of the state. So therefore, this is also wrong. The reservation of seats in panchayat to the other backward caste is mandatory in proportion to the population as per the constitution. It is not mandatory, it is only a voluntary provision. Only some of the states have given reservation to the other backward caste. I think Maharashtra is one such state which has brought in reservation to the other backward caste. Most of the states in India has not given any reservation to the other backward caste in panchayats, because it is not a mandatory provision, it is only a voluntary provision. So for women it is mandatory, for the scheduled caste and scheduled tribe also it is mandatory, but not given specifically in the constitution. It is only saying by a law in proportion to the population they can give it. So which of the statements given above are correct? So none of the above is correct. For the scheduled caste, in case of members it is mandatory, in case of chairpersons by a way of a law that is made by the concerned state legislature. Which of the following is the objective of giving constitutional status to the panchayat and municipalities under the 73rd and 74th Constitutional Amendment Act? Among the thing, so which of the following are the objective? To ensure direct democracy. How many of you think to ensure direct democracy? It is not the direct democracy. The objective is not to provide what is called as direct democracy. What is direct democracy? The people get to decide and do everything, but in the panchayat also it is not the people who will get to decide and do everything. Who will do the things? It is only the elected representatives. Don't confuse panchayat with Gram Sabha. Gram Sabha is just one aspect of the Panchayat Raj system, and in fact the Gram Sabha is not given any direct powers under the constitution. The constitution only says that there should be a Gram Sabha at the village panchayat, and that too Gram Sabha is not there at the other levels of panchayat. Therefore, the idea of panchayat is not to bring in direct democracy. The very important objective of the panchayat is to bring in what is called as people's participation in the system of governance. Do people participate in the system of governance? Because it is the elected representatives who have to take care of certain functions at the panchayat level. So therefore, the people's participation is there. To ensure accountability, of course it will ensure accountability. See, in UPSC there was one question which is talking about political accountability. So political accountability is different from what is called as mere accountability. Accountability means that they can just go and question. So of course it will ensure a system of what is called as accountability. So it has to be seen for each and every question. So yes, it is going to ensure accountability, because of course the local representatives who are elected may be questioned by the local people if they are not doing the job. So therefore it ensures accountability. To implement universal adult suffrage, universal adult suffrage was already there even before the 73rd Constitutional Amendment Act was brought into place, before it was given a constitutional status. So therefore, what is the right answer in this particular case? It is, okay, so the option, I think based on the options you are confused. Okay, so the right answer is only 2 and 3. I will just make 2, 1. Okay, so this, let it be 1 and 2. I will make a correction here, 2 and 3. So what is the option here? It is option C. Have you made note of certain corrections that you are making? Because when you revise it, you should not get confused. The state election commissioners can be removed by whom? The state election commissioner can be removed only by the President of India. Though the state election commissioner is appointed by the governor, the state election commissioner can be removed in the same manner as that of a judge of a high court. And how a judge of high court is removed? The judge of high court is removed in the same manner as that of a judge of a Supreme Court. So in both the cases, the motion has to be passed in the parliament and then subsequently approved by the President of India. So who is authority to remove the state election commissioner? It is the President of India. Consider the following statement. Statement 1. The minimum age prescribed for any person to be a member of panchayat is 25 years. What is the minimum age? 21 years, not less than 21 years. So therefore, this particular statement is wrong. The Panchayat constituted after the premature dissolution continues only for the remainder of the term. Is it true? Yes, it is true. Which of the following is our mandatory provisions under the 73rd and 74th Constitutional Amendment Act? So this is very, very important. You should have an understanding of what is mandatory and what is voluntary. Can you solve and give the answer? Then I will discuss about it. What is the answer? Which of the following is, I will complete 350 questions and then I will take some doubts from the online students. Which of the following is our mandatory provision under the 73rd and 74th Constitutional Amendment Act? Regular elections, is it mandatory? Yes, every 5 years there should be election to the Panchayat and the municipalities. This is there. Reservation for OBCs in the local bodies, that is a voluntary provision. Reservation to women in local bodies, yes, that's a mandatory provision. Devolution of powers and finances, both giving powers and finances, they are not mandatory provision, it is only a voluntary provision. Based on what? Based on the law that is passed by the concerned state legislature. So the law made by the state legislature will decide this. So therefore, you will have to make it very clear in your mind that the Panchayat in different states in our country might have different functions and they may exercise access to different amount of finances. But who is going to decide all those things? The law made by the concerned state legislature. Okay, so there is no uniformity in this regard. So what is the answer here? It is 1 and 3 only. The local government in India can be best explained as an exercise in what? The best way that it will explain is democratic decentralization. There's just we are bringing one more step of what is called as decentralization, democratic decentralization. Again, not direct democracy. Direct democracy means ruled by people directly. So in the local democracy, in the local government also, it is not the people themselves get to decide everything. It is only an exercise of democratic decentralization. That means we are constitutionally recognizing the local bodies. The 73rd Amendment Act 1992, the Constitutional 73rd Amendment Act 1992, which aims at promoting the Panchayat Raj institutions in the country, provides for which of the following? Constitution of district planning committees. Is there constitution of district planning committees? So it is there in the 74th Constitutional Amendment Act. State Election Commission to conduct the Panchayat elections. Yes. Establishment of State Finance Commission. Yes. What is the answer? 2 and 3 only. So option C is the right answer. So how many of you are confused with this district planning committee? So you have to be very careful. Okay, it was there in the 74th Constitutional Amendment Act. Who shall constitute the State Finance Commission as per the Constitution? The governor of the particular state. Consider the following statements. 1. The conditions of service of the state election commissioner shall not be varied to his disadvantage during the term of office. Yes, it shall not be varied. This protection is given in the Constitution itself. The governor of the state shall make necessary staffs available for the state election commission to carry out the election to the local bodies. Is it true? Yes, it is a governor who has to make the necessary staffs available to carry out the election to the local bodies, which is there under the Constitution. For carrying out the election to the Lok Sabha and to the state legislative assemblies, who has to make the necessary staffs available? To the Election Commission of India. The president and the governors both have to make it. So the central government employees will be deputed by the president of India to the election commission, and the state government employees will be done by the governor. But when it comes to the local bodies, the governor has to make the necessary staff available. The state legislature is free to make laws relating to the election of the local bodies subject to the provisions in the constitution. Is it true? Who will make laws as to how the local body election is to be carried out? State legislature, of course, and it is subject to the provisions in the constitution. The state legislature cannot make a law and say that the state election commission will carry out the election every 10 years. That is not possible, because the constitution says the election has to happen every 5 years. So, it is subject to the provisions in the constitution. Who will make the law? The state legislature will make the law. So, therefore, how the local body election happens in our country might vary from state to state depending upon the law made by whom? Depending upon the law made by the concerned state legislature. Is that clear to all of you? So, the answer here, what is the statement here? So, this is true. So, what is the answer? It is option C. Okay, I will just take a couple of minutes. There are some questions from the online students, and if you have any doubt, you can also ask me. Let me just take a couple of minutes. Sir, can you please explain the collegium system for the transfer of High Court judges? So, what constitutes the collegium for the transfer of High Court judges? It is Chief Justice of India plus 4 senior most judges. So, they are the collegium, and they will recommend the President of India with regard to the transfer of judges. But this collegium, that is Chief Justice of India plus 4 senior most judges, this collegium, before recommending for the transfer of the judges of the High Court, they in turn have to make a written, they in turn have to consult and take a written recommendation of the Chief Justice of the both the High Courts. Say for example, in the recent current affairs, a judge was transferred from the Delhi High Court to Uttar Pradesh High Court. So, therefore, the collegium, before making the recommendation, they have to take the written recommendation of Chief Justice of Delhi High Court and the Chief Justice of Uttar Pradesh High Court, and then they can make the recommendation to the President of India. Okay, so there is one more question. Sir, in the Shreya single case, the doctrine of eclipse, only a portion of the law will be struck. The Shreya single case, if you remember, it was challenged on the grounds of what? That the Information Technology Act, section 66A of the Information Technology Act was violative of the right to freedom of speech and expression. So, the Information Technology Act, that is section, to be very specific, section 66A of the Information Technology Act, is it a pre-constitutional law or a post-constitutional law? Post-constitutional law. So, therefore, the doctrine of eclipse will apply or the doctrine of severability will apply. Doctrine of severability. So, therefore, the portion, that particular portion of section 66A was struck down from the law. Is that clear? There is no doctrine of eclipse in case of Shreya single case. Okay, whenever I say it is appointed by the governor, the State Finance Commission is appointed by the governor is an appointing authority. It does not mean that the governor has a discretionary power. The governor acts on the aid and advice of the Council of Ministers. What is question number 339? Any doubt in question 339? %33% of the seats is reserved for the women, so that is given in the constitution. Okay, 30 is given. So, then will you arrive at any of the right answer? Panchayati Raj elected functionaries will be qualified to hold their offices if they, oh, so it is there. It should be 33, I think some mistake is there. It should be 33%. So, just make a small correction. Option C is very abrupt. So, therefore, that is the right thing, some mistake is there, that is 33%. It is not 30%, it is 33%. What is the question? 339. In option A, it is given 30%, so it should be 33%. Again, if the Rajya Sabha passes a resolution, the Parliament just cannot make a law. Again, a resolution has to be passed by the Rajya Sabha in national interest, and whenever the resolution will be passed by the Rajya Sabha, then that resolution will be in force for 1 year, and within the period of 1 year, a law has to be made by the Parliament, and that law will be again in force only for a period of 6 months, after the resolution ceases to exist. That is in case of appointment of judges of High Court. Only for the appointment of judges of High Court, that is the collegium. Okay, so I think we are done with the local bodies also. So this is the question, just to attempt one question from this particular area. So now come to the next topic, that is emergency provision. Every year there is a question on emergency provisions as well. Very, very important. Shall I move to the emergency provisions? Yes. Okay, shall I move? Okay, so come to the question, next question, that is article 351. So we'll have to complete at least up to 400 questions, so please cooperate. Okay, I'll have to, I think, leave 5 minutes early. Today also you have a class? Okay, so I'll try to leave a little early. So come to question number 351. Consider the following statement in respect of the financial emergency under article 360 of the Indian Constitution. With regard to financial emergency, few things that you have to remember. Who can declare the financial emergency? The President, on the recommendation of the Parliament, on the recommendation of the Council of Ministers. But this financial emergency, once approved by the President, is not final. It has to be placed for the approval of the Parliament. Both the houses of the Parliament has to give the approval within a period of 2 months. And once it is approved, it can continue indefinitely. There is no need for any further approval by the Parliament. Once approved, it continues indefinitely till the time it is revoked by the President of India. And the President can revoke it at any time, again based on the aid and advice of the Council of Ministers. But whenever the financial emergency is imposed, there can be few consequences. What are the consequences? That the President can tell the states to how they have to spend their money. The President can give direction to reserve all the financial bills for the consideration of the President. The Union government can reduce the salaries and allowances of all classes of central government employees, including the judges of the Supreme Court. So similarly, the state government can also reduce the salaries and allowances of the state government employees, including the judges of the High Court. So these are all the possible consequences. And under what condition the financial emergency can be imposed is when the credit and the stability, financial credit and the stability of India is threatened, but we have no precedent for what is called as a financial emergency. So quickly come to the question. The proclamation of financial emergency issued shall cease to operate at the expiration of 2 months unless before the expiration of that period it has been approved by a resolution of both houses of Parliament. Is it true? It is true. It has to be approved by both houses of the Parliament, and it has to be approved within a period of 2 months. So this particular statement is true. Come to statement 2. If any proclamation of financial emergency is in operation, it is competent for the President of India to issue directions for the reduction of salaries and allowances of all or any classes of persons serving in connection with the affairs of the Union, but excluding the judges of the Supreme Court and High Court, including the judges of the Supreme Court and High Court. So this is definitely false because nobody is excluded here. Okay, so this was wrong. So what is the answer here? 1 only. Come to the next thing. The term of Lok Sabha cannot be extended under any circumstances, can be extended by 6 months at a time, can be extended 1 year at a time during the proclamation of national emergency. Yes, it can be extended 1 year at a time, but how long it can be extended? Indefinitely. And who is authority to extend? The Parliament by a law, they can extend it. Very good. So the answer is can be extended. Consider the following statements regarding the consequences that may arise as a result of proclamation of national emergency by the President of India. Under which article the President can proclaim national emergency? Article 352. And the President can do so how? Can he do it on his own? Only on the written recommendation of the Cabinet. That is very, very important. The written recommendation of the Cabinet. The only article where the word Cabinet is mentioned is article 352 of the Constitution. The Parliament is empowered to make laws on all the items including the state list in the 7th schedule of the Constitution. Is it true? Yes, they can make laws on all the items in the state list. Nothing prevents the Parliament to do so. Okay. But however, this law is a temporary law. We have already seen that. But that is not the question here. But remember that. The President is empowered to suspend the enforcement of fundamental right, including Article 21 of the Constitution. Is it true? presently it is not possible. Okay, before 1978 it was possible, but assuming that it is a present situation, it is not possible. Now, in this extent, you will have to understand very quickly about Article 358 and Article 359 of the Constitution, because suspension of fundamental rights is related to both the things. So, can anyone tell me what is the difference between Article 358 and Article 359? Here, the first important thing is there is an automatic suspension. Automatic suspension of fundamental rights, that is what is very important. Suspension of fundamental rights. When you say automatic suspension of fundamental rights, that whenever the national emergency is there, automatically the fundamental rights stand suspended. Fundamental rights stand suspended means the right does not exist in the first place. And what fundamental right can be suspended? Only Article 19. It's only Article 19 which can be suspended. So, automatic suspension, that means Article 19 does not exist. It means as if there is no Article 19 in the Constitution during the time of emergency. And this can happen only in case of what? For external reasons. If the emergency is for external reasons, what are the external reasons? It is because of what is called as war or external aggression. Okay, so these are the things. But here there is no automatic, it is only done by a presidential order. A presidential order is required provided there is a national emergency. After the national emergency, a presidential order is required, and to the presidential order, the president can specify the fundamental rights, what he is going to suspend, but not the fundamental right is suspended per se. The enforcement of the fundamental rights is suspended. So, here he can do so by a presidential order, except which articles? Except 20 and 21. And which constitutional amendment act made this particular change? The 44th Constitutional Amendment Act 1978. So, all the changes related to the emergency is 44th Constitutional Amendment Act, because the Janata Party came, they made all the changes after the emergency. So, except 20 and 21, any of the other fundamental right, their enforcement can be suspended. What does it mean by their enforcement can be suspended? That means the article continues to exist. I said here it is assumed that the article does not exist, but here the right is there, but Article 32 stands suspended in relation to these articles. That means this right is there, but what is Article 32 of the Constitution? Article 32 gives us a constitutional remedy. When our right is violated, we can go to the court. But Article 32 in relation to these articles, which is issued by the presidential order, stands suspended. Therefore, we will not be able to go to the court and get it enforced. But after the emergency is over, we can go to the court and get it enforced. Okay, and here it can be for any reason. So, it can be for any reason. When I say it can be an external reason or an internal reason, it does not matter. Okay, so that is basically what you will have to understand. Now, with that, just come to this question. The president is empowered to suspend the enforcement of any of the fundamental rights, including Article 21 of the Constitution. No, Article 20 and Article 21 is not possible. The union government can unilaterally alter the distribution of revenue between the center and the state. Is it possible during national emergency? Of course, yes. Don't confuse this with a financial emergency. During national emergency, the union government can unilaterally alter the distribution of revenue between the center and the states. So, normally what is the distribution of revenue between the center and the states is based on the recommendation of the Finance Commission. But during national emergency, the union government has nothing to listen to what the Finance Commission says, and they can unilaterally distribute the revenue between the center and the states. But if at all they disturb this distribution of revenue between the center and the states, how long they can unilaterally change the distribution of revenue between the center and the states? It can continue till the maximum time of the end of the financial year in which the emergency is revoked. In whichever financial year the emergency is revoked, even after the emergency is over, the altered distribution of revenue can continue till the end of that particular financial year. Okay, so that is what is given in the Constitution. But here, can the union government unilaterally alter the distribution of revenue? Yes, so this is true. So what is the answer here? 1 and 3 only. Come to the next question. Which of the following are the immediate consequences of the imposition of resident rule in a state? immediate consequences. Whenever you have any doubt, come to the options, and that is how you should do in the UPSC also. Don't just jump into conclusion, don't put right in here and then check this. Any doubt, come here, from here you go there, okay. So whenever you know something is completely wrong, then just eliminate those options. From the question, from the options you go to the question. Which of the following are the immediate consequences of imposition of the president rule? What will immediately happen after the president rule is imposed? Dismissal of the Council of Ministers. So this is definitely there. So there is no doubt in this regard. And then the dissolution of the local bodies in the state. The president rule has nothing to do with the local bodies. It has only to do with what is called as a state government. Okay. So this is definitely not the answer. Suspension of fundamental rights. President rule has nothing to do with fundamental rights. Financial emergency has nothing to do with fundamental rights. The only emergency is the national emergency. So anyways 3 and 4 is not there. So 4 you eliminate. So 3 also you eliminate. Okay. So what we are left with? 1 only and none of the above. So dissolution of legislative assembly, this will happen, but it is not an immediate consequence, because immediately it will be kept only under suspended animation. But once the parliament gives the approval, so whenever a president rule is imposed in a particular state, that is not a final thing, then it is placed for the approval of the parliament. Within how much time the parliament has to give the approval? Within a period of 2 months the parliament has to give the approval, and once the parliament gives the approval, then only the legislative assembly can be dissolved. So till the time it is kept under only what is called as suspended animation. Now what is the majority with which the parliament has to give the approval? What is the majority the both houses of the parliament has to give the approval? It has to give the approval with simple majority. For national emergency is the only case where there is a need for a special majority. But whereas in case of president rule as well as in case of financial emergency, the majority that is required is simple majority. So what is the answer? 1 only. The national emergency under the Constitution of India can be extended how long? How long the national emergency can be extended? Indefinitely, provided the parliament makes a law every year and extend it by 1 year at a time. Okay, sorry, the national emergency, I am not talking about the Lok Sabha. The national emergency can be extended indefinitely provided the parliament gives the approval every 6 months. Okay, so every 6 months they have to give the approval. And what is the majority with which they have to give the approval? Here it is the special majority. What was the provision in the original constitution? In fact, this provision was brought in only by the 44th Constitutional Amendment Act in 1978. What was the provision in the original constitution with regard to this? Once it is approved by both houses of the parliament within a period of 2 months, now it is 1 month, within a period of 2 months in the original constitution, then it continues indefinitely till it is revoked by the president. Okay. So there in the original constitution it can be revoked only by the president, but presently if the national emergency is brought to an end, what are the ways by which it can be brought to an end? It can be revoked by the president on the advice of the Council of Ministers. Alternatively, if the Lok Sabha passes a resolution, that is also binding upon the president. And what is the majority with which the Lok Sabha has to pass a resolution? Simple majority. If the President of India exercises power under Article 356 of the Constitution in respect of a particular state, then the Assembly of the state is automatically dissolved. The Assembly does not get automatically dissolved because it has to be approved by the Parliament, so there are some procedures. The power of the legislature of the state shall be exercisable by or under the authority of the Parliament. Is it true? So whenever we have seen that in a state a president rule is imposed, once the legislative assembly is dissolved, then who will take up the power? Even otherwise also, even if it is not dissolved also, the assembly will be kept under suspended animation. So who will take up the power to make laws? Parliament. And the parliament can delegate this power to other authorities as well, including the president, but it does not directly go to the president. It is only the parliament who has got the power from the constitution. Article 19 stands suspended? No. no relation. The president can make laws relating to that. That does not happen automatically, provided the parliament gives the power. But who takes the power? It is only the parliament which has got the power. So what is the answer? Option B. Consider the following statements. During the state emergency, the fundamental rights can be suspended, while it cannot be suspended in case of national emergency. Rather, it is vice versa. So therefore, this particular statement is wrong. The state emergency can be extended indefinitely with the approval of the parliament every 6 months. The state emergency can be maximum for a period of 3 years. But however, even for that, lot of conditions are there. So normally the state emergency is usually for a period of 1 year. But at a time it is 6 months. Again, if the parliament gives approval, another 6 months. But if the state emergency is to be extended in any state beyond a period of 1 year, then 2 conditions has to be satisfied. What are the 2 conditions? First of all, the national emergency should be in the entire country or in any part of that particular state. And secondly, on account of the emergency, the election commission certifies it is not possible to carry out the elections. Only under such a condition, it can be extended beyond a period of 1 year up to how much years? Up to 3 years. So which of the statements given above are correct? Neither 1 nor 2. Once declared, who has the power to extend the financial emergency? Once declared, who has the power to extend the financial emergency? There is no need to extend the financial emergency, because once it is brought in, it is likely to continue till the time it is revoked. So therefore, what is the answer? None is the answer. What is the question number? Okay, so none for 358. Come to article 359. During national emergency, the parliament can make laws. During normal times, what the parliament can make law on item in the union list as well as in the concurrent list. But during national emergency, they can make laws on union list, state concurrent list as well as the state list. So therefore, what is the answer? The parliament can make laws, union list, state and the concurrent list. Option B. Which of the following are not necessarily the consequences of proclamation of president rule in a state? Dissolution of state legislative assembly. Okay, anyways, we'll see from the options. Dissolution of local bodies. No, local bodies does not. Removal of council of ministers. Of course, it is likely to happen. There is no other doubt. So wherever there is a 3, just strike it out. So dissolution of state legislative assembly. Okay, not necessarily. Okay, so not necessarily. Okay, for not necessarily, we will try to see that. Which of the following not necessarily the consequences of the national emergency, consequences of the president rule. So dissolution of local bodies, no, does not happen. So okay, so this has no impact. So definitely this should be part of the answer. So 1 and 3 has to be there. Removal of council of ministers, it is definite consequence. So it should not be part of our answer. So we will eliminate wherever there is 2. So 1 and 3 only. Now why this way also? This is in fact an UPSC question. So why it is very important for you to understand going from the options that they are given, because they are asking not necessarily a consequence of proclamation of president rule, because once a president rule is imposed, it has to be placed for the approval of the parliament. Until the time the state legislature will be kept only under suspended animation. What if the parliament does not give the approval? Then anyways the state legislative assembly will not be dissolved. So therefore not likely a consequence in all the cases. So that is why this the way the UPSC has asked this particular question. So what is the answer here? It is 1 and 3 only. Come to the next part, that is constitutional, statutory and the executive bodies, where also you can expect 1 question from this particular area as well. Shall we move to the next part? Okay. Which among the following commission, is it 361? Okay. Which one among the following commission was set up in pursuance of a definite provisions under the article of the Constitution of India? What is answer? Very simple. Which article under the Election Commission? 324 of the Constitution. What about University Grants Commission? What is the status? It's a statutory body. University Grants Commission Act is there, so it's a statutory body. National Human Rights Commission, Human Rights Act is there, it's a statutory body. Central Vigilance Commission, CVC Act is there, it's a statutory body. So the right answer is only option C. Come to next question. Consider the following: the superintendent's direction and conduct of fair elections, preparation of electoral rolls for all election to the president, state legislature, the office of president and vice president, giving recognition to the political parties and allotting election symbols to the political parties and individuals contesting the election. Which of the above is a function of the Election Commission of India? Which of the above is a function? All are the function. So this is directly given in the Constitution, this is there in the respective acts, the President Vice President Election Act and the Representation of People Act. This is again there in the Representation of People Act. Which of the above are the functions of the Election Commission of India? It is all of the above. Answer the following statements. The functions of the Finance Commission is to allow the withdrawal of money from the Consolidated Fund of India. It is definitely not the function of the Finance Commission, it is for the function of the Parliament to allow for the appropriation of money from the Consolidated Fund of India. The Finance Commission has nothing to do with this. The approval of the Parliament is required, not the Finance Commission. To allocate between states the shares of proceeds of taxes, yes, that is talking about the horizontal distribution of the states. So the Finance Commission has two functions, not only the vertical distribution from the center to the states, but also between the states. So this is definitely there. To consider application of granting aids from the states, no states can make any application to the Finance Commission with regard to the granting aids. It is for the Finance Commission to make a recommendation to the Union government. So the states are not empowered to make any application to the Finance Commission in this particular regard. Okay. So this is not one of the terms and references of the Finance Commission. So this is wrong. To supervise and report on whether the union and the state government are levying taxes in accordance with the budgetary provisions. What about this? This is not the function of the Finance Commission. This is in a way you are making the executives accountable, how they are collecting the taxes. This is the function of the Parliament to see this, and it is not the function of the Finance Commission. Okay. So this is definitely not there. So which of the statements given above are correct? What is the answer? No options. Which of the options are correct? Only 2 is not there. How come? Okay, any closest option? What about the incorrect? 2, 3, 4 is there, that is also not there. To allow for the withdrawal of money from the Consolidated Fund of India, no. To allocate between the states their share of proceeds, yes, that is definitely there. To consider application for the granting aids, no, that is not the case. Which of the statements given above are correct? So the answer is, okay, just make a small correction, it is only 2. Only 2 is the answer. The other things are not the right thing. Is it clear to all of you? See, the functions of the Finance Commissions will come from 2 areas. One which is directly given in the Constitution. What is directly given in the Constitution? First and foremost is the distribution of tax between the center and the states. The second is to recommend for the granting aids to the states. Third is that they can also give some recommendation to the states with regard to augmenting the finances of the states. So therefore, they can give more finances to the local bodies. And then any other function which may be entrusted by the President of India also. So these are the 4 functions which is given in the Constitution. Accordingly, the President can make the terms of references to the Finance Commission. So this terms of reference might vary from year to year. So sometimes it may be specifically asked, but otherwise most of the times the question is going to come from what is there in the Constitution of India. So from the Constitution of India, other things are not the functions. It is only to allocate between the states the share of their proceeds. Which of the following is or correct? In fact, this is a UPSC question. That's why I'm thinking why the options are not matching. It's a previous year UPSC question, some few years back. To supervise a report on whether the union and the state government are levying taxes, so definitely 4 is not there. That is not their function. Union and the state governments are levying taxes in accordance with the budgetary provisions. So definitely you can rule out both the things. To allow for the withdrawal of money from the Consolidated Fund of India, so this is also wrong. So maybe I'll just verify this once again, okay. So maybe it is based on the terms and references. So probably if there is to consider application from the grantee aids, so this I'll have to verify, okay. So please give me some time. So this I'll just verify. So please someone remind me about this question 363, okay. The closest answer, if at all it can be possible, is option 2 and 3. The remaining things are definitely wrong. So 3, it might be on the basis of terms of reference. Article B. Okay, so what it is saying? That is okay, but it is saying to consider application for grant of aids. To consider application, I assume to consider application means the states are making some request to the Finance Commission. Article 275. So what is the clause? Okay. 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 Anyways, so granting aid the center has to give to the state is okay. To consider applications for granting aid. So anyways, I think as per the UPSC key, the closest answer is 2 and 3, but you just give me some time, I'll confirm this, okay. So as of now, you can make it doubtful, but you can put 2 and 3 only, because apart from that, the other things are not right, but I'll confirm this. It's a very old UPSC question. I think it came in somewhere in 1970s. It's a very old UPSC question. I'll verify this, okay. Chose 2 and 3 from where? So true, so okay, 2003 may be repeated. Okay, I think it should be 2 and 3 most likely, but anyways, I'll verify this, okay. Okay, come to the next question. Consider the following statements with reference to India. The Chief Election Commissioner and the other election commissioners enjoy the equal powers but receive unequal salaries. Is it true? So they receive equal, do they have equal powers? Their powers are also same and their salaries are also same, okay. So this is definitely wrong. The only difference between the Chief Election Commissioner and the other election commissioner is with regard to the removal of the Chief Election Commissioner. So the Chief Election Commissioner can be removed in the same manner as that of a judge of a Supreme Court. The Chief Election Commissioner is entitled to the same salary as provided to a judge of a Supreme Court. Is it true? The Chief Election Commissioner is entitled to the same salary as that of a judge of a Supreme Court. This is not given in the Constitution, but under the Election Commissioners Act. So this is true. The Chief Election Commissioner shall not be removed from his office except in manner like that of the grounds of a judge of a Supreme Court. Is it true? Yes. So he can be removed in the same manner. So that means what is the ground on which he or she can be removed? Misbehavior or incapacity, and then a motion has to be passed in both the houses, passed by special majority in the same session, approved by the President of India. The term of office of the Election Commissioner is 5 years from the date upon which he assumes his office till the time he attains 62 years of age. Is it true? It is 6 years or 62 years, sorry 65 years, whichever is earlier. So this is wrong, 6 years or 65 years, not given in the constitution but as per the act, Election Commissioners Conditions of Service Act, 6 years or 65 years. So which of the statements given above are correct? 2 and 3 only. I think the previous statement, the application from the states, the way that the examiner has given that particular word. So definitely yes, it is the responsibility of the Finance Commission to allocate funds to the states with regard to granting aids. So the application from the states, I assume that the states can directly make an application to the Finance Commission, which I have not come across anywhere. But is that the meaning, or it is giving a meaning of whether they have to look into how application also means what is the conditions or what is the basis on which the center can allocate states to the center can allocate granting aid to the states. So if that meaning is there, so definitely 3 is also right. But anyways, right now we just mentioned as 2 and 3. Come to the next question. Which of the following is not performed by the Comptroller and Auditor General? So what is the article that allows for establishment of the CAG? Article 148 of the Constitution. And what are the functions of the CAG? To audit and to report all expenditures from the consolidated fund? Yes. So this is definitely there. So here they are asking not. So we will see. To audit and report all the expenditure from the contingency fund and public accounts? From the public accounts? Yes, because that is also done at the disposal of whom? At the disposal of the executives. So that will also be audited. Okay. Whatever that is done by the Government of India, all the accounts of the Government of India will be audited. To audit and to report all trading, manufacturing, profit and loss accounts of the government run enterprises. This will also be audited by the CAG. So CAG is an external auditor for the public sector undertaking. To control the receipt and issue of public money and to ensure the public revenue is lodged in the exchequer. So will it be done by the CAG? In fact, I said that the CAG in India is different from the CAG in United Kingdom. In fact, in India, he is only an auditor general. He is not the comptroller. What is the function of the comptroller is to see whether the money is taken away with his permission only they can take out money, and he will also see whether all the money is getting properly credited into the public accounts. That is not the role of the CAG. Okay, so here this is definitely no. So he has no control over the receipts and the issue of public money. Who will have control over the receipts and issue of public money? The Parliament has no authority over the issue of public money or the receipt of public money. It is done by the executives. The Finance Ministry is responsible. To some extent, the RBI will also have a check over all those things, mostly by the Finance Ministry. Okay, so this is what is you should remember. Consider the following statement regarding the National Human Rights Commission. What is the status of Human Rights Commission? It's a statutory body. Statement 1. Its chairman must be a retired Chief Justice of India or a retired judge of a Supreme Court. Is it true? Yes. Initially, when the law was brought in, the chairman is only a retired Chief Justice of India. But then the problem is there were not enough retired Chief Justices of India to become the chairman of NHRC. So they amended the law and they made it either the Chief Justice of India or any judge of a retired judge of a Supreme Court. So presently this is the law. It has formations in each state as a state human rights commission. Is it true? If you look into the National Human Rights Commission, the Human Rights Commission Act says that there shall be a National Human Rights Commission, and the states may have their own state human rights commission. So it is not mandatory to have a state human rights commission, and there are many states in our country which does not have a state's human rights commission. Most of the northeastern states does not have a state human rights commission. It has formation in each state as a state human rights commission is wrong. So it is not mandatory in the states. Its powers are only recommendatory in nature. Is it true? Yes, they are only a recommendatory body. It is mandatory to appoint a woman as a member of the commission. There is no such mandate under the law. So which of the statements given above are correct? What is the answer? So the answer is option D is the right answer. Which of the following is correct in respect of the commencement of the election process in our country? Please tell me the answer. Okay, tell me what comes first. Is it the election notification or is it the election schedule? Notification or the schedule? And also tell me who issues the election notification. Who issues the election notification for the Lok Sabha elections? Notification in the press conference. Now, who issues the election notification? Is it the Election Commission of India? So, the election to the Lok Sabha is issued by the President of India on the recommendation of the Election Commission of India. So, this is very, very important. As per the Representation of People Act, who has to issue the election notification? The President. Who will issue the notification to the state legislature? The Governor on the recommendation of the Election Commission of India. So, this is what the law says. Okay, now coming to the second question, what comes first, the election schedule or the election notification? First, what comes into place is the election schedule and then comes the notification. So, now the third question is, what about the model code of conduct? Does the model code of conduct has a legal enforceability? Okay, so most of you might know that. But when does the model code of conduct comes into force? Does it comes into force after the election notification or does it comes into force after the election schedule is announced? Notification, schedule. The model code of conduct comes into force immediately after the election schedule is announced and continues to be in force till the election results are announced. Okay, so these are all something that you have to remember. Okay, come to this particular question. Schedule, I told. First the schedule, then the notification. First the election schedule is given by the Election Commission of India. After that the President will notify only on the recommendation of the Election Commission of India. Okay, so come to the question here. Which one of the following is correct in respect of the commencement of election process in India? So, what is the answer? The recommendation for election is made by the government and the notification is issued by the Election Commission. No, the notification is not issued by the Election Commission. The recommendation for election is made by the Election Commission of India and the notification is issued by the Home Ministry in the center and Home Departments in the state. No, the recommendation for election is made by the Election Commission and the notification for election is issued by the President and the Governors concerned. Is it true? Yes. Option C is the answer. No, there is no need for any women to be mandatory as a part of. I think you might be confusing with certain other things. There are certain things where there is mandatory requirement for representation from the certain commissions. So, there is no need for any women member per se as a part of this. Okay, so it is not mandatory to appoint a woman as a member of the commission. So, in that case we do not have an option. This is again a previous year question. So, even let us assume that if women is to be mandatory, do you have any option to say it right? So, women member is not mandatory, you can just verify that. As per which provisions in the law? You will have to check and you have to say it. If you say it something like this, then it is going to disturb everyone in the class, okay? You have to say with which provision in the law, as not in the internet, that is not, you will have to say in the specific law, that is in the Human Rights Act. You will have to go and in which clause, in which section it has been mentioned, then only it is a valid thing. If you just check in the internet, anybody can write in the internet with the different sources. Therefore, it is going to create unnecessary confusion. So, whenever you are saying something, you just verify it and then you can come and say it. I am willing to change, it is nothing, but there is no other option if you see it here. If there is a specific clause, specific section in the Human Rights Act, then yes, then we will have to look for the other answer. Okay, come to the next question. Which of the following are among the functions of the Election Commission of India? So, what is the answer? Statement 1. Conduct of election for the post of Speaker and the Deputy Speaker, Lok Sabha and the Deputy Chairman and the Rajya Sabha. Is it the function of the Election Commission of India? Why it is not the function? Okay, so they don't have nothing to do with the election of the Speaker and the Deputy Speaker. Conduct of election to corporation and municipalities. So this is done by the State Election Commission. Deciding on all doubts and disputes about arising out of elections. Which of the quotes given below? Deciding about the doubts and disputes of elections means there are many elections. Nothing is given specifically related to what elections. In fact, they have nothing to do with the state elections. They have nothing to do with what is called as the presidential election. So all doubts and disputes. So this is also wrong. So what would be the answer here? None of the above. Consider the following statement. Statement 1. The member of UPSC or the State Public Service Commission is not eligible for any employment either under the state or union government or ceasing to be such members. What about this? The member of UPSC and State Public Service Commission is not prohibited from further employment, they are only prohibited from reappointment. That means they cannot be appointed to the same post, but there is certain element of further employment is possible. So where they can be appointed? While a member of UPSC can be appointed as a chairman of UPSC, while the member of State Public Service Commission can be appointed as a chairman of a State Public Service Commission or a chairman of some other State Public Service Commission or a member of UPSC. So all these things are possible. So therefore, to say that eligible for any employment, not eligible for any employment is wrong. A member of the State Public Service Commission are appointed and removed by the governor. Is it true? While the appointment is done by the governor, the removal is done by the President of India. So who removes them? It is only the President. So therefore, this is wrong. So what is the ground on which they can be removed? You know what is the grounds on which the members of the Public Service Commission can be removed? What are the grounds on which they can be removed? Proved misbehavior and incapacity is one of the ground. Unsound mind, and if they have become an undischarged insolvent, and if they have engaged in paid employment outside the office. So these are all the grounds on which they can be removed. But however, in one case, the removal has to be referred to the Supreme Court, and only on the basis of the opinion of the Supreme Court they can be removed. What is the ground? Misbehavior or incapacity. So if the question says that they are removed on the same manner as that of a judge of a Supreme Court or High Court, that is not the case. It is only just referred to the Supreme Court for the opinion. The member of UPSC or the State Public Service Commission are removed on the same manner as that of a judge of a Supreme Court. Is it true? No. They are not removed on the same grounds. So this is wrong. So which of the given statement is incorrect? What is incorrect? All of the above. We will try to reach 400. So just I will try to be little faster. Which of the following are the grounds on which the Comptroller and Auditor General can be removed from his office? What is the ground? The Comptroller and Auditor General on only one ground, that is misbehavior or incapacity. Okay. So here misbehavior is there. Okay. So if you say differently, it is misbehavior and incapacity, both the things. So what is the answer? 1 and 2 only. Adjudged and insolvent is not a ground for him. Consider the following statements regarding the Finance Commission of India. The composition of Finance Commission is fixed in the Constitution. Yes, 1 plus 4 members, that is fixed in the Constitution. The qualification of members of the Commission is to be determined by the President from time to time. The qualification is determined by the law made by the Parliament. One of the main functions of the Commission is to determine the sharing of revenue between the centre and the states. Is it true? Yes. So what is the answer? Which of the are incorrect? So it is 2 only. So this is one area, very simple question. They just want you to identify whether it is a constitutional body or something. Which of the following is a constitutional body? Tell me, what about the National Commission for Scheduled Caste? Yes. National Commission for Scheduled Tribe? Yes. National Commission for Backward Classes? National Commission for Minorities? National Commission for Women? No. So what is the answer? 1, 4 and 5 only, which is not a constitutional body. What is the article? 338? 338A and 338B. Consider the following. So, there are certain terms of references based on which the Finance Commission would decide how the horizontal distribution has to happen. So, here what are the parameters followed by the 15th Finance Commission? Demographic performance, yes. Forest and ecology, yes. Governance reforms, stable government, tax and fiscal efforts, yes. Apart from that, what are the other grounds? Population, area and income distance. Now, what are those things? I am not explaining because there is no time, but if you have any doubt, you can ask me after the class, okay. So, therefore, what is the answer in this case? Only 3. Come to the next question. Consider the following statements. The Election Commission of India is a 5-member body. Is it true? The Election Commission of India is a 3-member body. Is it true? The Election Commission of India is not a 3-member body nor a 5-member body. The Election Commission of India members will be determined by the President from time to time. Suppose if they are asking the Election Commission of India is presently a 3-member body, okay. But what is there in the Constitution? The composition is not fixed. It is determined by the President from time to time. So, therefore, this particular statement is wrong. The Union Home Ministry decides the election schedule. No, who decides the election schedule? The Election Commission of India. The Election Commission resolves a dispute relating splits and mergers of the recognized political parties. Is it true? Yes, that is one of the function of the Election Commission as per the Representation of People Act. So, what is the answer here? 3 only. Come to the next question. Which of the following statements are true regarding the office of Comptroller and Auditor General? The service of Comptroller and Auditor General shall be determined by an act of Parliament and shall not be varied to his disadvantage during his term of office. Is it true? Yes, it shall not be varied to his term of office. The Comptroller and Auditor General shall not be eligible for further employment either under the Government of India or under the state. Yes, constitutionally it is true. He is not eligible for any further employment. That means someone who is retired as a Comptroller and Auditor General, he shall not be appointed in any capacity either under the central government or under the state government. So, that is a constitutional requirement. Okay, so this is also true. So, what is the answer here? Both 1 and 2. But however, similar restriction is not there for the Election Commission of India. Okay, so it is only for the CAG which is there. Which of the following statements are true regarding the National Commission for Backward Classes? Presently, the National Commission for Backward Classes enjoys a constitutional status by virtue of 102nd Constitutional Amendment Act. Is it true? That is by virtue of Article 338B. After the Commission was given a constitutional status, it has taken away the right of the states to determine their own backward. It has taken away the rights of the states to determine their own list of backward classes, which may not be entitled to get who may be entitled to get reservation in the government jobs. Is it true? Few years back it was true. But after the 105th Constitutional Amendment Act, the situation has changed. So, therefore, to answer this question presently, this statement is wrong. So, choose the correct answer. So, what is the answer? 1 only. Answer the following statements. While the National Investigation Agency NIA, what is the position of the NIA? Is it a constitutional body, statutory body, executive body? It's a statutory body, not extra constitutional. There's a National Investigation Agency Act. Well, the National Investigation Agency has a jurisdiction over the entire country, whereas a Central Bureau of Investigation cannot investigate into the cases in the states without the consent of the states. Is it true? Yes, the NIA doesn't have to take any permission. That's why this NIA Act was also challenged in the Supreme Court, that it is infringing upon the powers of the state, but the law was upheld by the Supreme Court based on the substance, based on the pith and substance, based on the objective of this law. Okay. So, this is true. While the National Investigation Agency is a statutory body, the Central Bureau of Investigation is only a body established by executive order. True? Yes. So what is the answer? Sorry, it is incorrect. So neither 1 nor 2. Answer the following statements regarding the model code of conduct circulated by the Election Commission of India during elections. The model code of conduct is a legally enforceable for its violation as it has a strong statutory backing. Does it have a statutory backing? It has no statutory backing. There is no law related to the model code of conduct. That is why it is also criticized as moral code of conduct. The codes come into force as soon as the election notification is issued and remains in force till the conclusion of election. It comes into force after the election schedule is announced by the Election Commission of India and remains in force till the results are announced. Which of the following are incorrect? Sorry, both 1 and 2. Come to the next question. Which of the following are true regarding the National Commission for Scheduled Tribes under the Constitution of India? The commission is established under Article 338A of the Constitution with an objective of safeguarding the rights of the scheduled tribe people. Is it true? It is 338A, not 338B. Yes. So therefore, the statement 1 is wrong. The chairperson. So presently, it is wrong. Before the amendment has happened, it was Article 338A and there was only one commission, that is National Commission for Scheduled Caste only, which was looking both the functions, but now it is a separate body. The chairperson and the members of the commission are appointed by the central government on the recommendation of the Parliamentary Committee on Tribal Affairs. Why would the government listen to a committee says in the parliament? So anyways, this is wrong. The appointment is made by the president on the aid and advice of the Council of Ministers. So therefore, this particular statement is wrong. Which of the following are correct? It is neither 1 nor 2. Answer the following statements regarding the Bar Council of India. What is the status of Bar Council? It is a statutory body. The Bar Council of India is established by an executive resolution that regulates the legal profession in our country. Is it true? It is established not by an executive resolution but by law made by the parliament. And what is the act? Which act? Advocates. It was established by the Bar Council of India Act or the Advocates Act. I think it is established by the Bar Council of India Act only, but there is a separate act. Just check it. There is a separate act, Advocates Act, for which also they can make rules. Advocates Act. Okay, it is established by the Advocates Act. Okay, so no doubt. It is established. Anyways, it is not an executive body, it is a statutory body. So recently the Bar Council of India has framed rules that enables foreign lawyers and law firms to practice in India. What about this? It is part of your current affairs. So recently the Bar Council of India had made rules under the Indian Advocates Act, wherein they are trying to liberalize the foreign law firms also to come and do their practice in our country, and including the foreign lawyers. So this is true. So which of the statements given above are correct? What is right? 2 only. Okay, so please quickly come to the next topic. So we are done with the constitutional bodies also. Now we are entering into the political themes. Again, very, very important. One question is likely to come definitely from this particular area. The Indian parliamentary system is different from the British parliamentary system. How it is different from the British parliamentary system? So in both the cases, there are real and nominal executives. There is a monarch there, here we have a president. A collective system of responsibility. In both the cases, there is collective system of responsibility. Bicameral legislature. In both the cases, there are bicameral legislature. Even if you do not know the answer, by ruling out, you can arrive at an answer. What is the answer? system of judicial review. How the system of judicial review in India is different from the judicial review in UK? In India, the judiciary can review both the executive actions as well as the legislative actions. Whereas in UK, there the judiciary can review only the executive actions, not the legislative actions. Now, why they cannot review the legislative action? Whatever law that is made by the British Parliament becomes part of their constitution. So, therefore, they cannot say the constitution itself is wrong. So, they cannot review the legislative actions. What they can review is only the executive action. So, come to the next question. Which one of the following determines that the Indian constitution is federal? A written and a rigid constitution, an independent judiciary, vesting of residuary powers with the center, distribution of power between the center and the states. Please read all the options, which is most appropriate. It is distribution of power between the center and the state, but that is protected by an independent judiciary. That's a different thing. But the most appropriate thing is what? Distribution of power between the center and states. Come to the next thing. Which one of the following is a feature common to both the Indian Federation and the American Federation? What is common to both Indian Federation and American Federation? A single citizenship, is it common? They have dual citizenship, we have single citizenship. 3 lists in the constitution. In India, we have 3 lists, they have only 2 lists. Okay, so therefore that is not common. Dual judiciary, they have dual judiciary, but we have integrated judiciary. So that is also not common. So what is the answer? A federal Supreme Court to interpret the constitution. We have Supreme Court of India, they have a court similar to that Supreme Court to interpret the constitution. So therefore option D is the answer. In a parliamentary system, the executives are accountable to, executives are responsible to the legislature. That is very simple answer. So this is the very essence of parliamentary democracy. In fact, this is one area in the last 20 years, at least 15 times they have asked the same thing. What is the essence of parliamentary democracy? In one way or the other, they have asked this particular question. So what is the very essence of parliamentary democracy? That the executives are accountable to the legislature. India is a federal state because, what is the answer? Because there is share of power between the center and the states. Which of the following reflects the most appropriate relationship between law and liberty? Which of the following? So what, for which we will have to have an understanding of what is liberty. Liberty means what? Freedom, if that is qualified in nature, that means if it comes with certain restrictions. So in order to ensure that everybody is having certain rights, so therefore we call that to be what is called as liberty. Now what would be the most appropriate option? You will just try to rule out each and everything. If you are confused also for such things, you try to rule out. If laws are changed too often, liberty is in danger. Does it make any sense? It depends upon the type of law. We do not know what law it is. Maybe the law is enhancing our liberty also in a democracy. So it depends upon what type of law, who is making that law, but that information is not very clear. So therefore you can rule out this. If there is liberty, laws have to be made by for the people. It in fact does not establish any relation between law and liberty. So it is like a separate statement. If there is liberty, laws has to be made by the people. So it does not make any sense. Who is going to make the law? By the people. So nothing is very clear. It's a very vague statement. Rule out this. If there are more laws, there is less liberty. Sometimes more laws means more liberty also. Again, it depends upon the law. So again, you can rule out this. If there are no laws, there is no liberty. Is it true? If there are no laws, then I can do anything. Nobody can punish me for that. If I am powerful enough, I can do anything. I can take away the rights of others. Therefore, laws has to be there in a civilized society to protect the liberty of the people. Okay, so that is very important. So if there are no laws, then there is no liberty. So this clearly reflects the relationship between law and liberty. Okay, somebody has asked me a question of what is the difference between negative liberty and positive liberty. So what is the difference between negative liberty and positive liberty? Does anyone know? Well, negative liberty is seen as some element of protection from the authority of the state. That is negative in character, that is negative for the state. But positive liberty is positively which is allowing an individual to develop himself. That is what is considered to be positive liberty. Okay. So the answer is option B here. Democracy's superior virtue lies in the fact that it calls into activity what? What is the answer? Intelligence and character of ordinary men and women. That is what is democracy. So it is intelligence and character of ordinary men and women. So that's the most appropriate thing for democracy. That means everybody shall have the right to vote, everybody shall have equality. So that is what is about democracy. In the context of polity, which one of the following would you accept as the most appropriate definition of liberty? So what is the most appropriate definition of liberty? Absence of restraint. So absence of restraint. So liberty is not absence of restraint. There can be reasonable restrictions. So this is not the answer. Opportunity to do what one likes, whatever one likes, then there is no restriction in it. So that is also not the thing. Opportunity to develop oneself fully. This is more similar to the concept of what is called as positive liberty that just now I discussed. Positive liberty. But anyways, we have to rule out. This is the right answer, but you'll have to rule out option A also. Protection against the tyranny of political rulers. Now, protection against the tyranny of political rulers will not only amount to what is called as liberty, because liberty means an individual should also be protected not only from the rulers or someone who is in position of authority, but from the social sanctions also, from the social pressures also. So it is not talking about all those things. So here the most appropriate thing which talks about liberty is the statement D. So therefore this is also wrong. I have left out. What is 387? The intelligence and the character of ordinary men and women that we have already discussed. Okay, come to the next question, 388. Out of the following statements, I am just checking how much time we have got. Okay. Out of the following statements, choose that one brings out the principle of underlying the cabinet form of government. What is cabinet form of government? Cabinet is basically a collective decision making body. So the very idea of having cabinet in a parliamentary democracy to ensure what is called as the collective decision making. The most important decisions of the government are collectively made. It is not for any other purpose, and therefore collective decision making will also enhance the accountability of the government. It is not to speed up the decision making. It is, in fact, it can delay the decision making, collective decision making, but it will make the system more accountable. Okay. So what is the answer? A mechanism in a parliamentary democracy to ensure collective responsibility, and therefore the system becomes more accountable to the people. No, ask. No, even with the council of ministers and cabinet, if you see, the cabinet is no way going to speed up the process. If the council of ministers system, we follow a portfolio system. So in a portfolio system, who is supposed to be in charge of a particular ministry? A particular minister. So therefore, in that case also a particular minister can easily take the decision rather than taking up the matter for the cabinet. The cabinet has to come, meet, discuss. Therefore, anyways, a cabinet is not much faster than the council of ministers also. But still we follow the cabinet system. It is because to make the system more accountable. That is the idea of the cabinet system. We come to the next question. In the context of India, which one of the following is the characteristics appropriate for bureaucracy? So which is the character appropriate for bureaucracy? It has nothing to do with widening the scope of parliamentary democracy, nothing to do with the strengthening federalism, nothing to do with also agency for political stability or economic growth. The most important function is to implement the public policy. So tomorrow when you become part of bureaucracy, what is the important function? To implement the decision that is taken by the political executives, be it laws or any of the other policies. First you will have to implement. This is the most appropriate thing. It may have an effect on certain other things also, but what is your primary responsibility is this. A parliamentary system of government is one which What is the answer? The government that is responsible to the parliament and can be removed by it. Okay. A government which is responsible to the parliament and can be removed by it. Okay. Do you have any confusion with the other options? Political parties in the parliament are represented, not all the political parties are represented. The government is elected by the people, this is true, but not removed by the people. So therefore it is wrong. The government is chosen by the parliament but cannot be removed by it before the completion of the fixed term. Can they be removed? Yes, they can be removed even before the completion of the fixed term. A constitutional government means, what is the answer? What is a constitutional government means? A government which is limited by the constitution. So basically, what is a constitutional government or what is constitutionalism? Is a government which functions as per the constitution. That is, the constitution is implemented in letter and spirit. And in most of the democratic constitution, if you see, there is limitation upon the powers of the states. That is one of the important features to restrict the functions of the government. So what is the answer here? Government that is limited by the state. This is also one question which is repeated 4 or 5 times in the last few years. A constitutional government is a limited government. Answer the following statements. A constitutional government is one which places effective restrictions on the individual liberty in the interest of the state authority. No, rather it should be vice versa. So it is not restricting of the individual liberty in the interest of state authority, but it places effective restrictions on the authority of the state in the interest of the individual liberty. So what should be the answer? 2 only is the answer. Which of the following best explains the concept of liberty? Freedom to do whatever one wishes to do, then that becomes freedom, which is absolute in character. So therefore that is not the answer. Set of rights and privileges given to the members of a society subject to arbitrary restrictions. It cannot be arbitrary restrictions, it should be reasonable restrictions. Set of rights and privileges exercisable member of a society subject to reasonable restrictions. Yes. So the answer is option C. Which of the following is not a representative system of checks and balances? Okay, there is a difference between separation of powers and the system of checks and balances. Can anyone tell me what is the difference between system of separation of powers and checks and balances? Okay, no problem. So what is the difference between separation of powers and checks and balances? I think you are trying to explain the difference between separation of powers and division of powers. Okay. How they are interconnected to one another? Are they interconnected? One organ has some element of control over the other organ. Okay, so the next question is, do you think in India there is a complete separation of powers? Our system, is it based on a strict separation of powers? Our constitution is not strictly based on the idea of separation of powers. That does not mean that there is no concept of separation of powers, but most importantly it is based on the principle of checks and balances. Now why separation of powers mean what? Separation of power means different organs, they have the respective domain, respective functions, and one shall not interfere with the functioning of other. So in order to prevent and to control one authority to become too arbitrary or too powerful, there is some element of control which one organ can exercise over the other organ. That is basically what is called as checks and balances. So the Constitution of India is not strictly based on the principle of separation of powers, but rather it is relying upon the idea of what is called as checks and balances. Now why there is no strict separation of powers? Because there is overlap with regard to functioning of certain organs. Where there is an overlap? Legislature and the executive. In fact, in all the parliamentary democracy, there will be an overlap between the legislature and the executive. because the executive ultimately come from where? From the legislature. So therefore that overlap is there. But even between the legislature and executive, there is a system of checks and balances. How the checks and balances are there? Because the executives are accountable to the legislature. Only for the legislature there is no much problem, but the legislature, the members of the parliament can also be disqualified by the president. So who can disqualify them? The president can disqualify them. So there is a system of checks and balances. See that the law made by the parliament can be struck down by the court, and if you see the judges are functioning arbitrarily, they can be removed by the president, by the parliament, and then of course by the president. So in this way there is some element of what is called as checks and balances. So now come here. So with that you just try to answer here, which one of the following is not a representative system of checks and balances under the Constitution of India? What is the answer? So somebody has answered C, then you have got the idea of what is checks and balances. So checks and balances is always control of one organ over the other organ. Some students are asking me, why sir, anyways the council of ministers are having control over the president, but both are executives here. That is the idea. So checks and balances should be one organ over the other organ. Okay. So shall I move to the next question? Come to the next question. So remaining, I think it is very clear in the other question. Executive accountable to the legislature, two organs are there. Removal of judges by the president, two organs are there. Judicial review of courts over the legislature and executive, different organs are there. The only thing where there are only executives is option C. Okay, so therefore this is not the right answer. Okay, come to the next question. Which of the following is true regarding the concept of judicial review? So how is judicial review different from the review powers? Clear? So judicial review is the power of the judiciary to look into the action of other two organs. Review power, its own judgment. Which article is for judicial review powers? 137, which also provides for what is called as curative powers. What is article 136? Special leave petition. Okay. So what is the answer in this case? It is a power of the judiciary to question both the actions of the legislature and the executive for violating the provisions of the constitution. Consider the following. Schedule 7 of the constitution, all India services, integrated judiciary, parliament unilateral power to create or admit new states, state public service commission. Which of the above are reflecting the principles of federalism under the Constitution of India? So what are the factors that reflect federalism? What about schedule 7? Yes, it provides for division of powers, all India service. It's an unitary feature, we already discussed this. Integrated judiciary is also one unitary feature. Independent judiciary is a federal feature, but integrated judiciary is a unitary feature. Parliament unilateral power to create or to admit new states, that is not a federal feature. In fact, the states are not given any power in this regard. State Public Service Commission, how many of you think it is a State Public Service Commission? State Public Service Commission allows the state to recruit their own agency, but there is some element of criticism there also. Although they recruit the officers for the state, I would say this is right here, but anyways, even for the members of the State Public Service Commission, they can be removed only by the President of India. So states do not have any authority in this regard, but anyways, considering the nature of function, it is a federal provision. So what is the answer here? It is 1 and 5 only. Both independent and integrated. So that I have many times explained in the class. So what is the difference between independent and integrated judiciary? Independent judiciary means the judiciary is independent from the other two organs of the state, that is from the legislature and the executive, that is independent. While integrated judiciary means there is a single hierarchy of judiciary. So at the apex we have the Supreme Court, and then below that we have high courts, and then below that we have the subordinate courts, and all these courts are free to interpret both the state laws as well as the central laws. That is basically what is called as integrated judiciary. An independent judiciary, while the judiciary is performing their functions, they are free from control of the other two organs of the state. That is independent judiciary. Is it clear? Okay, come to question number 399. Which of the following best explains the term democracy? Which explains best the term democracy? Direct rule by people, is it democracy? That is also democracy, but it does not explain, because there is indirect democracy also. It does not completely explain. Rule by legitimate authority. In North Korea, there is also some ruler is ruling. So that is a legitimate authority there. But all legitimate authority cannot be considered to be what is called as democracy. The government in which supreme authority is vested in the people and exercisable by them either directly or indirectly. So this is the complete definition of democracy. So come to the last thing, last question. Which one of the following best explains the term secularism in the Indian context? Which explains secularism best in the Indian context? Complete separation of state from religious matters. Is it true? So in India, we do not have a strict separation. State have official religion but treat every religion equally. We do not have any state religion. State respect all the religion equally but can make positive interventions in the matters of religion. Is it true? Yes, the state can make positive intervention, none of these. So the right answer, the most appropriate answer is option C. So with that, we have done with what is called as the political themes as well. So just give me a couple of minutes. So what are the themes that you have covered from the beginning? Starting, we have covered from the Constituent Assembly, we have covered the Preamble, we have covered the Union and its territories, we have covered Union and its territories, then we have covered the citizenship, fundamental rights, DPSP, fundamental duties, and then we have covered the entire executives, we have covered the entire legislature, judiciary is done. What else has been done? Center state relationship is done, and after center state relationship, local bodies are done, municipalities and panchayats, and then you have done constitutional bodies, then we have done emergency provisions also, political themes are also done. Almost 13 to 14 questions are covered. But what is still pending that I wanted to do is, especially one is this historical underpinnings. There is a possibility of one question that is coming from that particular area. Schedules, important articles, amendments, schedules, and then certain miscellaneous topics. But however, this is my last class, so probably I am not sure that I will be able to take that, but what I can do is, if it is permitted, I am ready to do it, but as far as whatever has been informed me, this would be my last class. So probably what I will do is, I will share the entire question paper with the answer key. You please go through those things, and in any case, any questions for any of those things, you can reach out to me. I will give the answer for that particular question. Okay.